Terms for curing default. In event of default as set forth above under default terms, user can cure user's default and avoid strict foreclosure of any remainder of user's former property that is neither in the possession of secured party, nor otherwise disposed of by secured party. Only by tendering payment within 20 days of user's default and only by payment in full of the balance of the sum certain amount owed by user as noticed user in invoice that is not already paid by secured party's possession, sale, liquidation, and the like of user's former property and interest in property pledged as collateral for securing user's obligation. Terms of strict foreclosure. User's non-payment in full of all unauthorized use, fees itemized in invoice within said 20-day period for curing default as set forth above under terms for curing default, authorizes secured parties immediate non-judicial strict foreclosure on any and all remaining property and interest in property formerly pledged as collateral by user, now property of secured party, which is not in the possession of nor otherwise disposed of by secured party upon expiration of said 20-day default curing period. Ownership subject to common law copyright and UCC financing statement and security agreement filed with the UCC filing office. Record owner, English common law spelling and pronunciation, John Henry Doe, superscripted copyright symbol, autograph, common law, copyright, superscripted copyright symbol, 1973. Should any provision of this notice by written communication be unenforceable, said unenforceable provision is hereby severed from this notice by written communication, but every remaining provision continues in full force and effect, and this notice by written communication is deemed modified in a manner that renders this notice by written communication in full force and effect. In all cases, secured party continues without liability and is held harmless. Any prior communication, written document, and the like by and between user and secured party containing any mistake of secured party is invalidated, thereby and of no force and effect, and may be relied upon by user against secured party in this matter. No consent of any kind is granted, nor otherwise given, any matter offered /alleged /asserted by user, and the secured party withholds all consent. Secured party will consider granting consent in favor of user only upon user's full disclosure of any and all consequences of any such granting of consent, accompanied by user's commensurate attendant liability for the veracity, relevance, and verifiability of any such disclosure, which liability is borne by user in the form of an unauthenticated security agreement, wherein user is debtor and English common law spelling and pronunciation John Henry Doe superscripted copyright symbol is secured party, that self-executes, effective the moment of secured party's confirmation of any material inconsistency /deviation /discrepancy in the aforementioned resultant consequences avowed by user as determined solely by secured party and secured party's sole discretion. Alleged debtor, i.e. all capital letters ends legis John H. Doe superscripted copyright symbol, does not take issue with the amount of any alleged debt. Rather, alleged debtor asserts that the alleged debt is not valid. Secured party holds a claim /security interest greater than any claim alleged by user, a certified copy of which UCC financing statement evidencing such supreme claim and security interest is attached herewith, made fully part hereof, and included herein by reference, and, as stated above, secured party is neither a surety nor an accommodation party for alleged debtor, and may not be construed as functioning in such capacity under any circumstances. Further, this is a request for a validation of any alleged debt, and is not a request for a copy of any invoice, statement, bill, agreement, alleged agreement, contract, alleged contract, and the like. Nor is it a request for a copy of any notification of assignment, negotiation /transfer of rights, nor is it a request for a copy of any other unverified document /presentment referencing said alleged debt. This request for validation of any alleged debt is a request for bona fide verification of any alleged debt in accordance with law. Only duly sworn /affirmed affidavits, oaths, and depositions qualified as a verification of the lawful existence of a bona fide debt. Absent such verification validating the alleged debt, and absent proof of a claim greater than that of a secured party, user fails to state a claim which relief can be granted. Wherefore, in accordance with the Fair Debt Collection Practices Act, effective immediately upon user's receipt of this notice by written communication, user must cease all collection /prosecution efforts against alleged debtor, secured party, and secured party's secured private property. User is hereby notified of the following Privacy Act notice. Privacy Act notice. This written notice by written communication constitutes user's due process notice and opportunity for being heard. Absent compliance with all requirements set forth herein, user is barred from using any defensive immunity from prosecution for user's actions, as well as the actions of user's agents. By this notice, by written communication, user, as well as user's agents and principals, shall comply with the provisions of the Privacy Act of 1974, as lawfully amended, 12 U.S.C. Statute 3401, the Right to Financial Privacy Act of 1978, as lawfully amended, 5 U.S.C. Statute 552A, and the Third Party Summons Act, Special Procedures 26 U.S.C. Statute 7609, as lawfully amended, for assisting secured party in keeping inviolate certain constitutional protected privacy rights. By this notice by written communication, user, as well as user's agents and principals, shall comply with this demand. User shall provide secured party with a copy of any express written authorization from secured party whereby user is authorized for disclosing /revealing /divulging /sharing with any third party in any manner, as well as by any means of communication, any information, documentation, data, property, effects, and the like, alleged debtor, in all capital letters, ends legis, John H. Doe, superscripted copyright symbol, nor secured party for using, revealing /disclosing /divulging /sharing with any third party any secured information, documentation, data, property, effects, and the like of secured party. This notice by written communication is binding upon every principal and agent the subject matter set forth herein, and each principal and each agent is a. Barred from providing any credit reporting agency any derogatory credit information regarding the above alleged debt. B. Prohibited from contacting alleged debtor by mail, by telephone, as well as in person, both at alleged debtor's residence as well as at alleged debtor's place of employment. And C. Prohibited from contacting any other third party regarding the above referenced alleged debt until user establishes the existence of a superior claim, greater than that of secured parties, and until said alleged debt is verified as indicated above and alleged debtor is provided with any such verification. Note: the Fair Debt Collection Practices Act at 15 U.S.C. Statute 1692 E.T. SEQ states in relevant part that a debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt, which includes the false representation of the character or legal status of any debt, as well as the threat to take any action that cannot legally be taken, all of which constitute violations of law. Therefore, user as well as any assignee is prohibited from filing any lawsuit, notice of lien, notice of levy, and the like, as well as any other legal action against alleged debtor, as well as against any of secured parties' secured private property, which is exempt from lien and exempt from levy. 15 U.S.C. Statute 1692E8 states, communicating or threatening to communicate to any person credit information which is known or which should be known to be false, including the failure to communicate that a disputed debt is disputed, is a violation of Statute 1692E. Further, users above referenced written communication, if valid, constitutes an issue of public currency, and alleged debtor hereby requests from user, in accordance with the fundamental principles of American jurisprudence and law, bona fide documentary evidence that establishes the lawful basis for user's issue of said public currency and user's claim for payment of the alleged debt liability referenced within user's written communication using the public currency and stating the claim, i.e., a bona fide identification of any person making request for payment by, all capital letters ens legis, John H. Doe, superscripted, copyright symbol, including a copy of said person's bona fide, handwritten, legible, and notarized signature, and the thumbprint from either hand of said person making request for payment by, all capital letters ens legis, John H. Doe, superscripted, copyright symbol. B. Bona fide evidence of any said person's authority for making request for payment by, all capital letters ens legis, John H. Doe, superscripted, copyright symbol, if said person is acting on behalf of another, and C. Exhibition of the bona fide instrument, i.e., the bona fide commercial contract bearing the bona fide signature which supports user's demand for payment of alleged debt by, all capital letters ens legis, John H. Doe, superscripted, copyright symbol, that, operating publicly, establishes user's issue of public currency allegedly collectible from any of 1. Alleged debtor, 2. Alleged debtor's assets, 3. Secured party, 4. Secured party, secured private property, and D. Positive law in support of user's written attempt at collecting alleged debt that, operating publicly, establishes user's issue of public currency collectible from any of 1. Alleged debtor, 2. Alleged debtor's assets, 3. Secured party, 4. Secured party, secured private property. Alleged debtor and secured party can and will lawfully construe user's failure, complying with and satisfying essential requirements of the Fair Debt Collection Practices Act and the above 4 requests, i.e., A, B, C, and D, in the paragraph immediately above, within a reasonable time, i.e., 21 days following user's receipt of this written communication, as user's self-invalidation of user's demand for payment, verification of the alleged debt and satisfaction of the aforementioned 4 specific requests must be duly sworn / affirmed in the form of one of the following: A. Affidavit, B. Oath, C. Deposition, until the alleged debt is verified in accordance with the Fair Debt Collection Practices Act, and said verification is sent alleged debtor and received by alleged debtor. Each and every contact in violation of the Fair Debt Collection Practices Act constitutes harassment and defamation of character and makes user, as well as any and all agents and principals who take part in such harassment and defamation, a subject of liability for damages, as well as statutory damages and legal fees for each and every violation in private capacity. User, all capital letters ens legis Jack Jones, tactfully consents and agrees that, all capital letters ens legis Jack Jones, has a duty for preventing this alleged account from damaging both alleged debtor and secured party, and further consents and agrees that alleged debtor and secured party each reserve the right for initiating a counterclaim against any of the following: all capital letters ens legis Jack Jones's bond, all capital letters ens legis Jack Jones's guarantor, and any of, all capital letters ens legis Jack Jones's principals, agents, and assignees whose acts, omissions, result in either of the following: A. Tort damages against alleged debtor, B. Tort damages against secured party, Due process of law is guaranteed both alleged debtor and secured party at Debt Collector's Office of Risk Management and is codified at 18 U.S.C. Statute 1581, 242, 241, 4 at 15 U.S.C. Statute 1692, and elsewhere. The attachment, written communication as respondent's response. Ray user's attempt, via written communication, in collecting an alleged debt. This notice by written communication /security agreement is herewith executed this 28th day of the 3rd month in the year of our Lord 2002 by and between the undersigned parties. Debtor, all capital letters and legis, Jack Jones. Debtor signature, all capital letters and legis, Jack Jones. Secured party accepts debtor's signature in accord with UCC 1-20139 3-401. Secured party, common law, English, spelling, and pronunciation, John Henry Doe, superscripted copyright symbol. Secured party signature, John Henry Doe, superscripted copyright symbol. Autograph, common law, copyright, superscripted copyright symbol, 1973 by English, common law, spelling and pronunciation, John Henry Doe, superscripted copyright symbol. All rights reserved. No part of this autograph, common law, copyright may be used, nor reproduced in any manner without prior express written consent and acknowledgement of secured party as signified by secured party signature in red ink. Unauthorized use of English, common law, spelling and pronunciation, John Henry Doe, incurs same unauthorized use fees as those associated with, all capital letters and legis, John Henry Doe, superscripted copyright symbol. As set forth above in paragraph 1 under self-executing contract /security agreement in event of unauthorized use, enclosed published copyright notice. John H. Doe, superscripted copyright symbol, P.O. Box 9999, Los Angeles, California 90010. Respondent's Private International Administrative Remedy Demand Number, JHD-032802-JJ. This Private International Administrative Remedy Demand Number, JHD-032802-JJ, is binding upon every principal and agent, Ray, the subject matter set forth herein below. Date, March 28, 2002, via USPO Registered Mail Article Number RR7778889999 US, to, all capital letters and legis, Jack Jones, DBA, a debt collector, hereinafter debt collector, all capital letters, Chase Man and Hat Mortgage Corporation, 5143 Tunnel Vision Drive, Columbus, Ohio, 43222. Ray, debt collector's written communication hereinafter, presentment, dated March 15th, 2002, referencing alleged creditor, all capital letters, Chase Man and Hat Mortgage Corporation, alleged account number 001-234567889-96, alleged amount due $1,035,458.21. Subject tender of payment of notice of reservation of right for initiating a counterclaim and for filing claim against bond. 1. Be it known by these presents that, all capital letters and legis, John H. Doe, superscripted copyright symbol, respondent, is in receipt of debt collector's above referenced presentment, a true and correct copy of which is attached herewith, made fully part hereof, and included herein by reference. 2. Respondent hereby gives debt collector notice that this written communication is not a refusal for paying the alleged debt implied by presentment, but constitutes express written notice that a. The above referenced alleged debt is not valid. B. Debt collector's claim is disputed. C. Respondent does not take issue with the amount of alleged debt claim, and that D. Upon receipt of this notice, debt collector must cease all collection activity, the alleged account / debt, until respondent is sent the herein requested verification as required by the Fair Debt Collection Practices Act. Tender of payment. 3. Respondent, without waiver of any defense, and for the purpose of resolving this matter in good faith, hereby tenders payment in the form of a certified promissory note, also known as an offer of performance, both of which are attached herewith, made fully part hereof, and included herein by reference, for the purpose of discharging the alleged debt as stated within debt collector's above reference presentment. 4. Respondent retains original of debt collector's presentment as proof respondent has not dishonored debt collector's instrument, nor in any way acted in bad faith. 5. Respondent gives debt collector notice that, in accordance with law as codified at 15 U.S.C. Statute 1692 G, Section B, if the consumer notifies the debt collector in writing within the 30-day period described in subsection A of this section that the debt, or any portion thereof, is disputed, or that the consumer requests the name and address of the original creditor, the debt collector shall cease collection of the debt, or any disputed portion thereof, until the debt collector obtains verification of the debt or a copy of a judgment, or the name and address of the original creditor, and a copy of such verification or judgment, or name and address of the original creditor, is mailed to the consumer by the debt collector, in parentheses, underline emphasis added by respondent. 6. Be advised that verification is defined, in parentheses, in Black's Law Dictionary 6th edition as follows: confirmation of correctness, truth, or authenticity by affidavit, oath, or deposition. Affidavit of truth of matter stated, and object of verification is to assure good faith in averments or statements of party. 7. Debt collector is further noticed that this is not a request by respondent for a photocopy of any invoice, statement, bill, summary, agreement, and the like, and that any future communication received by a respondent from debt collector, in written as well as any other form, absent the above cited requisite verification of the debt, irrespective of the inclusion of any photocopy of any related invoice, statement, bill, summary, agreement, and the like, constitutes debt collector's tacit admission, confession, and agreement that debt collector has no lawful, bona fide, verifiable claim the alleged account. 8. Respondent also includes with this written communication debt collector disclosure statement for the purpose of ensuring that debt collector's verification of the debt is executed in accordance with law as codified at 15 U.S.C. Statute 1692 G, and must be completed in full by debt collectors and received by respondent within 21 days of debt collector's receipt of this written communication. Notice of reservation of right for initiating a counterclaim and filing a claim against official bond. 9. If debt collector, such as by commission, omission, and otherwise, a. fails in giving respondent full disclosure the nature and cause of debt collector's claim concerning the hereinabove referenced alleged debt, b. makes a false representation of the character of the hereinabove referenced alleged debt, c. makes a false representation of the legal status of the hereinabove referenced alleged debt, d. makes any threat of action that cannot legally be taken in violation of any applicable law, such as the law codified at the Fair Debt Collection Practices Act. Respondent may initiate a counterclaim and claim against the official bond of debt collector, as well as the bond of any principal, agent, and assignee of debt collector, whose acts, as well as omissions, result in respondent sustaining any tort injury. 10. Debt collector is also hereby given notice that A. Debt collector's unsubstantiated demands for payment, a scheme or artifice caused to be delivered by mail, may constitute mail fraud under state and federal laws. In parentheses, debt collector may wish to consult with competent legal counsel before originating any further communication with respondent. And B. Debt collector's failure in providing respondent with the requisite verification validating the above referenced alleged debt within the requirements of law as codified in the Fair Debt Collection Practices Act and the corresponding laws of each state signifies that debt collector tacitly agrees that 1. Debt collector has no lawful bona fide verifiable claim the above referenced alleged account. 2. Debt collector waives any and all claims against respondent. And 3. Debt collector tacitly agrees that debt collector will compensate respondent for all costs, fees, and expenses incurred in defending against this and any and all continued collection attempts the above referenced alleged account. 11. This is also an attempt for determining the nature and basis of a case / counterclaim against debt collector, and any information contained within debt collector disclosure statement, as well as any information obtained otherwise, such as by debt collector's commissions, omissions, and the like, will be used for that purpose. 12. Due process of law is guaranteed both alleged debtor and secured party at Debt Collector's Office of Risk Management and is codified at 18 U.S.C. Statute 1581, 242, 241, 4, at 15 U.S.C. Statute 1692, and elsewhere. Handwritten, all capital letters, Ens Legis John H. Doe, superscripted copyright symbol. All capital letters, John H. Doe, superscripted copyright symbol, respondent. Enclosures, offer of performance, certified promissory note, verification of tender of payment, notice of reservation of right for initiating counterclaim / filing claim against bond, debt collector disclosure statement. Date, March 28th, 2002. Recording requested by and when recorded returned to. In care of Post Office Box 9999, Los Angeles 90010, California Republic. English Common Law Spelling and Pronunciation, John Henry Doe. Respondent's Private International Administrative Remedy Demand Number, JHD-032802-JJ. This notice is binding upon every principal and agent the subject matter set forth herein. Via United States Post Office Registered Mail Article Number RR777888-999 U.S. For all capital letters, Ens Legis Jack Jones, DBA, a debt collector, hereinafter debt collector. All capital letters, Chase, Mann, and Hat Mortgage Corporation, 5143 Tunnel Vision Drive, Columbus, Ohio, 43222. Alleged creditor, all capital letters, Chase, Mann, and Hat Mortgage Corporation. Alleged account number 001-234567889-96. Alleged amount due $135,458.21. Subject offer of performance. Offer of performance. 1. This offer of performance is tendered in good faith as full satisfaction of the claim referenced above, with the intent of extinguishing any alleged debt, duty, obligation, liability, and the like intended as obligating respondent, Ens Legis, all capital letters, John H. Doe, superscripted copyright symbol, named in the herabove referenced presentment, a copy of which is attached herewith, made fully part hereof, and included herein by reference. 2. Concerning this offer of performance, hereinafter, offer, alleged account 001-234567889-96. Debt collector may, A. accept this offer, B. Reject this offer. C. Object regarding the mode of this offer. 3. This offer of payment of that certain sum of money that debt collector alleges / asserts via presentment constitutes respondent's debt, duty, obligation, and liability, including interest and penalties, is made dependent upon performance by debt collector of conditions precedent concerning which respondent / offeror is entitled by the fundamental principles of American jurisprudence and law, namely provision by debt collector of verification of the alleged debt, accompanied by documentary evidence establishing the factual basis for debt collector's claim for payment asserted within debt collector's above referenced presentment, i.e., validation of debt collector's right for collecting the alleged debt by providing the requisite verification, including A. Copies of all agreements and assignment, negotiation, transfer of rights, and the like, and indicating whether debt collector is the current owner, assignee, holder in due course, etc., with evidence of respondent's consent with any such agreement if a novation. B. All relative commercial instruments, contracts, and the like containing respondent's bona fide signature (subjective theory). C. Any evidence of an exchange of a benefit, as well as exchange of a detriment (implied contract). D. Any evidence of any series of external acts giving the objective semblance of agreement (objective theory). E. All other documentary evidence between respondent and debt collector that debt collector relies upon in making debt collector's presumptive claim. F. Name and address of original creditor. And G. A certified copy of any judgment. 4. Respondent / offeror expects a response this offer within a reasonable period of time of receipt of this offer, which is hereby set at 21 days, not counting day of service. 5. Respondent / offeror does not waive timeliness. If additional time is needed, however, debt collector must make a request in writing before expiration of said 21-day period described above in paragraph 4. Setting forth debt collector's reasons for requesting such extension of time with good cause shown. Respondent / offeror will consider any such request for extension of time, the granting of which, however, is conditioned solely upon the decision of respondent / offeror. 6. Respondent / offeror hereby gives debt collector notice that as an operation of laws codified at California Civil Code Statute 1485 and California Code of Civil Procedure Statute 2074, respectively. A. An obligation is extinguished by an offer of performance made in conformity with the rules prescribed and with the intent of extinguishing the obligation. B. An offer in writing for paying a particular sum of money, as well as for delivering a written instrument / specific personal property, is, if not accepted, the equivalent of the actual production and tender of the money / instrument / property. 7. In event that debt collector does not respond this offer within the prescribed time limit for response, and there has likewise been no request for extension of time, with good cause shown therein, within said time period, then debt collector tacitly agrees that debt collector has no bona fide lawful verifiable claim this alleged account. That debt collector waives any and all claims against respondent, and that debt collector tacitly agrees that debt collector must compensate respondent for all costs, fees, and expenses incurred defending against any collection attempts by debt collector the above reference alleged account. 8. Respondent also expressly includes with this offer of performance. Debt collector disclosure statement. Attached herewith, made fully part hereof, and included herein by reference, for ensuring that debt collector clearly and conspicuously makes all required disclosures in writing in accordance with applicable portions of Truth in Lending, in parentheses Regulation Z, 12 CFR 226, debt collector disclosure statement must be completed by debt collector and received by respondent within 21 days of debt collector's receipt of this offer of performance if debt collector wishes debt collector's claim considered by respondent. 9. Debt collector also tacitly consents and agrees that debt collector has a duty for preventing this alleged account for damaging respondent in any way. Debt collector confesses judgment and respondent reserves the right for A. Initiating a counterclaim against debt collector. B. Filing claim against the bond of any responsible party, including debt collector and all principals, agents, and assignees of debt collector, whose acts/omissions result in tort damages against respondent/offeror. 10. Due process of law is guaranteed both alleged debtor and secured party at Debt Collector's Office of Risk Management and is codified at 18 U.S.C. Statute 1581, 242, 241, 4, at 15 U.S.C. Statute 1692, and elsewhere. Date, March 28, 2002. Signed, all capital letters, Ens Legis, John H. Doe, superscripted, copyright symbol, respondent/offeror. Witness, autograph, Bill Peters. Witness, Amy Cogburn. Certified promissory note. Note number JHD-032802-JJ. Date, March 28, 2002. Paid to the order of Chase, Man, and Hat Mortgage Corporation. $1,035,458.21. $135,458.21/$100. This instrument is tendered by the undersigned respondent, all capital letters Ens Legis, John H. Doe, hereinafter, maker, in good faith and in accordance with the law, as codified at UCC Statute 1-103, 1-104, 1-201, Section 4, Section 28, Section 30, 3-103, Section A, Section 6, 3-104, Section A, Section B, and public policy at House Joint Resolution 192 of June 5, 1933, as full satisfaction of alleged debt claimed and allegedly owed in favor of payee herein, i.e. Chase, Man, and Hat Mortgage Corporation, DBA, a debt collector, as per payee's debt collector's presentment. Alleged creditor, Chase, Man, and Hat Mortgage Corporation. Alleged account number 001-234567889-96. Alleged amount due $135,458.28. A true and correct copy of presentment is attached hereto, made fully part hereof, and included herein by reference. This statement constitutes maker's promise for paying this instrument upon presentment and endorsement at maker's location. As an operation of law, payee/debt collector tacitly consents and agrees that there is accord and satisfaction by use of this instrument for satisfying payee's/debt collector's claim, and maker is hereby discharged from liability on this alleged account, and the obligation is suspended in accordance with law as codified at UCC Statute 3-310, Section B, 3-311, and 3-603. Maker does not waive timeliness. However, if payee/debt collector needs additional time, payee/debt collector must present Maker with a written request for additional time within a reasonable time, setting forth the reasons payee/debt collector requests an extension of time with good cause shown. The acceptability of any such request received by Maker from payee/debt collector is conditional upon approval by Maker. In the event this instrument is not presented for payment within a reasonable period of time, and there has been no request for an extension of time with good cause shown, payee/debt collector tacitly consents and agrees that payee/debt collector has no bona fide verified claim raid this alleged account. Payee/debt collector tacitly consents and agrees that debt collector has a duty for preventing this alleged account from damaging Maker in any way, and that debt collector confesses judgment and Maker reserves the right for initiating a counterclaim against debt collector and for filing a claim against the bond of any responsible party, including debt collector and all principals, agents, and assignees of debt collector whose acts/omissions result in tort damages against Maker, dated March 28, 2002. All capital letters ends legis, John H. Doe, superscripted copyright symbol. All capital letters ends legis, John H. Doe, superscripted copyright symbol. Respondent/Maker. Witness, Bill Peters. Witness, Amy Cogburn. Authorized person endorsed below. Print name and official title when presenting this instrument for payment. Government issue ID with photograph required, i.e., only the following types of ID accepted: state-issued driver's license, state-issued identification card, passport. Blank, printed name of endorser. Blank, form of photo identification. Blank, official title of endorser. Blank, form of official identification. Blank, date of presentment and endorsement. Blank, signature of endorser. Recording requested by and when recorded returned to, all capital letters, John H. Doe, superscripted copyright symbol. P.O. Box 9999, Los Angeles, California 90010. Date, blank. Blank box right thumbprint. Introductory certification. The undersigned, all capital letters ends legis, John H. Doe, superscripted copyright symbol hereinafter, declarant, does herewith solemnly swear, declare, and state that 1. Declarant can competently state the matters set forth herewith. 2. Declarant has personal knowledge of the facts stated herein. 3. Declarant has read and signed this verification of tender of payment and notice of reservation of right for initiating counterclaim and for filing claim against bond, hereinafter, tender and reservation of right. Plain statement of facts. 4. This tender and reservation of right is not interposed for purpose of delay. 5. This tender and reservation of right does not prejudice, all capital letters, Chase, Man, and Hat Mortgage Company, in this matter. 6. Declarant does not join in any merits of presentment of, all capital letters ends legis, Jack Jones, DBA, a debt collector. Verification and certification. 7. The undersigned declarant, all capital letters ends legis, John H. Doe, superscripted copyright symbol, i.e., declarant, does herewith swear, declare, and affirm that declarant executes this tender and reservation of right with sincere intent that declarant can competently state the matters set forth herein, that the contents are true, correct, complete, and certain, not misleading, and the truth, the whole truth, and nothing but the truth, as per the best of declarant's knowledge and understanding. Further, declarant saith not, dated March 28th, 2002. Signed, English Common Law Spelling and Pronunciation, John H. Doe, superscripted copyright symbol. Witness, Bill Peters. Witness, Amy Cogburn. Debt Collector Disclosure Statement. Ray, Offer of Performance. This statement and the answers contained herein may be used by respondent, if necessary, in any court of competent jurisdiction. Respondent's private international administrative remedy demand number JHD-032802-JJ. Notice: this debt collector disclosure statement is not a substitute for, nor the equivalent of, the hereinabove requested verification of the record, i.e., confirmation of correctness, truth, or authenticity by affidavit, oath, or deposition, in parentheses, Black's Law Dictionary, 6th edition, 1990. Ray, the alleged debt, and must be completed in accordance with the Fair Debt Collection Practices Act, 15 U.S.C. Statute 1692, G, applicable portions of Truth in Lending, Regulation Z, 12 CFR 226, and demands as cited above in offer of performance. Debt collector must make all required disclosures clearly and conspicuously in writing. Ray the following: 1. Name of debt collector. 2. Address of debt collector. 3. Name of alleged debtor. 4. Address of alleged debtor. 5. Alleged account number. 6. Alleged debt owed. 7. Date alleged debt became payable. 8. Ray this alleged account. What is the name and address of the alleged original creditor, if different from debt collector? 9. Ray this alleged account if debt collector is different from alleged original creditor. 9. Ray this alleged account if debt collector is different from alleged original creditor. Does debt collector have a bona fide affidavit of assignment for entering into alleged original contract between alleged original creditor and alleged debtor? Yes or no? 10. Did debt collector purchase this alleged account from the alleged original creditor? Yes, no, N/A, in parentheses, non-applicable. 11. If applicable, date of purchase of this alleged account from alleged original debtor and purchase amount. Date and amount. 12. Did debt collector purchase this alleged account from a previous debt collector? Yes, no, N/A. 13. If applicable, date of purchase of this alleged account from previous debt collector, the purchase amount, date and amount. 14. Regarding this alleged account, debt collector is currently the A. Owner, B. Assignee, C. Other, explain. 15. What are the terms of the transfer of rights Ray this alleged account? 16. If applicable, transfer of rights Ray this alleged account was executed by the following method: A. Assignment, B. Negotiation, C. Novation, D. Other, explain. 17. If the transfer of rights Ray this alleged account was by assignment, was there consideration? Yes, no, non-applicable. 18. What is the nature and cause of the consideration cited in number 17 above? 19. If the transfer of rights Ray this alleged account was by negotiation, was the alleged account taken for value? Yes, no, not applicable. 20. What is the nature and cause of any value cited in number 19 above? 21. If the transfer of rights Ray this alleged account was by novation, was consent given by alleged debtor? Yes, no, not applicable. 22. What is the nature and cause of any consent cited in number 21 above? 23. Has debt collector provided alleged debtor with the requisite verification of the alleged debt as required by the Fair Debt Collection Practices Act? Yes or no? 24. Date said verification cited above in number 23 was provided alleged debtor. 25. Was said verification cited above in number 23 in the form of a sworn and affirmed oath, affidavit, or deposition? Yes, no. 26. Verification cited above in number 23 was provided alleged debtor in the form of oath or affidavit or deposition. 27. Does debt collector have knowledge of any claims / defenses raid this alleged account? Yes or no? 28. What is the nature and cause of any claims / defenses raid this alleged account? 29. Was alleged debtor sold any products / services by debt collector? Yes or no? 30. What is the nature and cause of any products / services cited above in number 29? 31. Does there exist a verifiable, bona fide, original commercial instrument between debt collector and alleged debtor containing alleged debtor's bona fide signature? Yes or no? 32. What is the nature and cause of any verifiable commercial instrument cited above in number 31? 33. Does there exist verifiable evidence of an exchange of a benefit or detriment between debt collector and alleged debtor? Yes or no? 34. What is the nature and cause of this evidence of an exchange of a benefit or detriment as cited above in number 33? 35. Does any evidence exist of verifiable external acts giving the objective semblance of agreement between debt collector and alleged debtor? Yes or no? 36. What is the nature and cause of any external acts giving the objective semblance of agreement from number 35 above? 37. Have any charge-offs been made by any creditor or debt collector regarding this alleged account? Yes or no? 38. Have any insurance claims been made by any creditor or debt collector regarding this alleged account? Yes or no? 39. Have any tax write-offs been made by any creditor or debt collector regarding this alleged account? Yes or no? 40. Have any tax deductions been made by any creditor or debt collector regarding this alleged account? Yes or no? 41. Have any judgments been obtained by any creditor or debt collector regarding this alleged account? Yes or no? 42. At the time of alleged original contract was executed, were all parties apprised of the meaning of the terms and conditions of said alleged original contract? Yes or no? 43. At the time the alleged original contract was executed, were all parties advised of the importance of consulting a licensed legal professional before executing the alleged contract? Yes or no? 44. At the time the alleged original contract was executed, were all parties apprised that said alleged contract was a private credit instrument? Yes or no? Debt collector's failure, both intentional and otherwise, in completing / answering points 1 through 44 above and returning this debt collector disclosure statement, as well as providing respondent with the requisite verification validating the hereinabove referenced alleged debt, constitutes debt collector's tacit agreement that debt collector has no verifiable, lawful, bona fide claim the hereinabove referenced alleged account, and that debt collector tacitly agrees that debt collector waives all claims against respondent and indemnifies and holds respondent harmless against any and all costs and fees heretofore and hereafter incurred and related any and all collection attempts involving the hereinabove referenced alleged account. Declaration. The undersigned hereby declares, under penalty of perjury of the laws of this state, that the statements made in this debt collector disclosure statement are true and correct in accordance with the undersigner's best first-hand knowledge and belief. Date. Printed name of signatory. Official title of signatory. Authorized signature for debt collector. Debt collector must timely complete and return this debt collector disclosure statement, along with all required documents referenced in said debt collector disclosure statement. Debt collector's claim will not be considered if any portion of this debt collector disclosure statement is not completed and timely returned with all required documents, which specifically includes the requisite verification made in accordance with law and codified in the Fair Debt Collection Practices Act at 15 U.S.C. 1692 at Sec. And which states in relevant part, quote, a debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt, which includes the false representation of the character or legal status of any debt, and the threat to take any action that cannot legally be taken, all of which are violations of law. If debt collector does not respond as required by law, debt collector's claim will not be considered, and debt collector may be liable for damages for any continued collection efforts, as well as any other injury sustained by respondent. Please allow 30 days for processing after respondent's receipt of debt collector's response. All capital letters, ens legis, Doe, John, Henry, superscripted copyright symbol, P.O. Box 9999, Los Angeles, California, 90010. Invoice. Verified statement of account. Non-negotiable. Private between the parties. Account debtor. All capital letters, ens legis, Lawrence D. Mitchell, Mitchell and Green LLP, 9500 Wilshire Boulevard, Beverly Hills, California, 90212. Account creditor. Common law English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, in care of Post Office Box 9999, Los Angeles, 90010, California Republic. In accordance with notice and terms contained within that certain private, consensual contract by and between account debtor, all capital letters, ens legis, Lawrence D. Mitchell, and account creditor, common law English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, i.e., notice by written communication / security agreement, dated March 14th, 2002, received and executed by all capital letters, ens legis, Lawrence D. Mitchell on March 15th, 2002, and on March 20th, 2002, respectively. An accounting of unauthorized use fees insured by all capital letters, Lawrence D. Mitchell, current as of the date of this notice, Ray, all capital letters, ens legis, Lawrence D. Mitchell's use of account creditor's private common law copyright property is set forth as follows. Principal amount, $500,000. Unauthorized use locator. Written communication dated March 11th, 2002, signed by, all capital letters, Lawrence D. Mitchell. Occurrences of use, 3. Extended amount, $1,500,000. $500,000. Notice of Liz Pendens, dated April 22nd, 2002, signed by Lawrence D. Mitchell. Occurrences of use, 3. Extended amount, $1,500,000. $500,000. Complaint to foreclose mortgage and enforce lost loan documents, dated April 22nd, 2002, signed by, all capital letters, ens legis, Lawrence D. Mitchell. 9. $4,500,000, grand total of $7,500,000. The total amount of this invoice is $7,500,000 United States dollars. $7,500,000. This is now due and owing. Payment in full is herewith demanded. Remit to common law spelling and pronunciation, John Henry Doe, superscripted copyright symbol, in care of Post Office Box 9999, Los Angeles 90010, California Republic. This invoice is dated the 29th day of the 4th month in the year of our Lord 2002. The undersigned, common law, English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, does herewith swear, declare, and affirm that the undersigned has examined this invoice and any accompanying schedules, statements, and documents, and that, in accordance with the best of the undersigned's knowledge and belief, this statement of account is true, correct, and complete. This declaration of common law, English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, is based on all information of which common law, English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, has any knowledge. Signed, Affidavit of John Henry Doe, by special visitation. Affiant, who goes by the appellation common law English spelling and pronunciation John Henry Doe, superscripted copyright symbol, a living, breathing, flesh and blood man under the laws of God, being of sound mind and over the age of 21, whose advocate is Jesus the Christ, reserving all rights, being unschooled in law, and who has no bar attorney, is without an attorney, and having never been represented by an attorney, and not waiving counsel, knowingly and willingly declares and duly affirms, in accordance with law and special visitation, in good faith, with no intention of delaying nor obstructing, and with full intent for preserving and promoting the public confidence in the integrity and impartiality of the judiciary, that the following statements and facts by special visitation in the matters in re case number CR 021234 JSS and any matter relating to this are of affiant's own first-hand knowledge, does solemnly swear, declare, and depose that affiant is competent to state the matters set forth herein, that affiant has personal knowledge and belief of the facts stated herein, and that all the facts stated herein are true, correct, complete, and certain. This declaration of facts is based on affiant's own first-hand knowledge and belief. Mark affiant's words. 1. Affiant goes by the appellation common law English spelling and pronunciation John Henry Doe, superscripted copyright symbol. Affiant is a living, moral being endowed with unalienable rights to life, liberty, property, papers, and effects, and all substantive rights of California state. 2. Affiant owns the name common law English spelling and pronunciation John Henry Doe, superscripted copyright symbol, and the trade name, all capital letters, ends legis John Henry Doe, superscripted copyright symbol, as well as any and all derivatives and variations in the spelling of said trade name, and speaks only for common law English spelling and pronunciation John Henry Doe, superscripted copyright symbol, and is no other, and is surety for no other, and speaks for no other person, juristic person, entity, individual, group, organization, association, voluntary association, joint stock association, company, copartnership, firm, order / society, both aggregate and part of any aggregate / automatic aggregate / public utility aggregate, organized and incorporated / not incorporated, and is not misrepresenting affiant, and has not duly granted, ratified, bargained for, gifted, sold, optioned, donated, and the like any power of appointment, special power of appointment, general power of appointment in trust, nor any general nor special franchise, nor elective franchise of name, character, living body, and the like in favor of any other for any consideration, including but not limited by any option / opting, any promises, implied promise, successive promises, agreement, supposed agreement, fiction, forbearance, grace, creation, modification, destruction, and the like of a legal relation, trade name, trademark, service mark, title, titles, return promise, and the like, bargained for and given in exchange for a promise, privileges or benefits, reciprocity, any indemnity, mutual indemnification, any future interest, and the like. 3. Affiant is a sovereign who takes up housekeeping in the geographic region known as California Republic. 4. Affiant is neither a surety nor an accommodation party for any juristic person. 5. Affiant neither granted, all capital letters ens legis, Judas S. Squire, permission for using, nor authorized, all capital letters Judas S. Squire's, use of the name, all capital letters ens legis, John Henry Doe, superscripted copyright symbol, also known by any and all derivatives and variations in the spelling of said name except common law English spelling and pronunciation, John Henry Doe, at any time without consideration for the use of said name. 6. Affiant neither granted, all capital letters ens legis, Rachel M. Stewart, permission for using, nor authorized, all capital letters ens legis, Rachel M. Stewart's use of name, the name, all capital letters ens legis, John Henry Doe, superscripted copyright symbol, also known by any and all derivatives and variations in the spelling of said name except common law English spelling and pronunciation, John Henry Doe, at any time without consideration for the use of said name. 7. Affiant neither granted, all capital letters ens legis, David A. Cooper, permission for using, nor authorized, all capital letters ens legis, David A. Cooper's use of the name, all capital letters ens legis, John Henry Doe, superscripted copyright symbol, also known by any and all derivatives and variations in the spelling of said name except common law English spelling and pronunciation, John Henry Doe, at any time without consideration for the use of said name. 9. Affiant neither granted County of Los Angeles permission for using nor authorized County of Los Angeles's use of the name, all capital letters ens legis, John Henry Doe, superscripted copyright symbol, also known by any and all derivatives and variations in the spelling of said name except common law English spelling and pronunciation, John Henry Doe, at any time without consideration for the use of said name. 10. Affiant neither granted, all capital letters, State of California, permission for using, nor authorized, all capital letters, State of California's use of the name, all capital letters ens legis, John Henry Doe, superscripted copyright symbol, also known by any and all derivatives and variations in the spelling of said name except common law, English, spelling and pronunciation, John Henry Doe, at any time without consideration for the use of said name. 11. Affiant neither granted, all capital letters, Superior Court of the State of California, permission for using, nor authorized, all capital letters, Superior Court of the State of California's use of the name, all capital letters ens legis, John Henry Doe, superscripted copyright symbol, also known by any and all derivatives and variations in the spelling of said name except common law English spelling and pronunciation, John Henry Doe, at any time without consideration for the use of said name. 12. Affiant did inform all parties involved in this matter that Affiant's papers and effects were private property, and that Affiant's private papers and effects could not be used by any of the parties in any manner without consideration. 13. Affiant states no commercial consensual encounter took place even if so construed by any of the parties, and Affiant apologizes for any such construction, for it was a mistake. 14. Affiant neither disturbed the peace nor the dignity of the County of Los Angeles, nor, all capital letters, County of Los Angeles, at any time. 15. Affiant neither disturbed the peace nor the dignity of the State of, nor State of California, at any time. 16. Affiant neither disturbed the peace nor the dignity of the United States, nor, all capital letters, United States, at any time. 17. Affiant neither disturbed the peace nor the dignity of the United States of America, nor, all capital letters, United States of America, at any time. 18. Regarding any and all documents other than those initiated / put forth by Affiant, i.e., documents such as this affidavit, Affiant states that any and all ink marks appearing within the signature space of any and all such documents, Ray, case number CR 02-1234 JSS, do not compromise Affiant's signature, as Affiant's signature appears only where knowingly, willingly, and voluntarily executed following full disclosure of all terms and conditions of any and all contracts / commercial agreements, as well as all terms and conditions of any unrevealed contract / commercial agreement. 19. Affiant states that jurisdiction is neither conferred nor implied nor granted by Affiant Ray case number CR 02-1234 JSS. 20. Currently, Affiant is unjustifiably threatened by fraud, and irreversible harm continues accruing against Affiant. 21. All of the above cited actions by the aforementioned trusted public servants are against the peace and dignity of Affiant. Any man, as well as any woman, who intends rebutting this affidavit of common law spelling and pronunciation John Henry Doe, shall do so in the manner of this affidavit by signing any such affidavit using Christian name / baptismal name / name given at birth, given upper and lower case format, not set in all capital letters, being a fully liable living breathing man / woman, responsible / liable for everything that such man / woman says and does. Any such affidavit must be sent so as to be received by the notary public named at the address given below within 5 days, lest a judgment of non pros be obtained with a notice claim of triple damages. Non pros is an abbreviation of non prosecutor, which is a judgment at common law entered at instance of defendant when plaintiff at any stage of proceedings fails to prosecute his action or any part of it in due time. Affiant, common law, English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, common law, trade name / trademark, copyright, superscripted copyright symbol, 1973, a living, breathing, flesh and blood man, does swear and affirm on Affiant's own unlimited commercial liability that Affiant has scribed and read the foregoing facts contained in this affidavit, and that, in accordance with the best of Affiant's first-hand knowledge and conviction, such are true, correct, complete, and not misleading, the truth, the whole truth, and nothing but the truth. This affidavit is dated the first day of the 3rd month and the year of our Lord 2002 by autograph, common law, copyright, superscripted copyright symbol, 1973 by English, common law, spelling and pronunciation, John Henry Doe, superscripted copyright symbol, EID number 1234-56789. All rights reserved. No part of this autograph, common law, copyright may be used, nor may said copyrighted property be reproduced in any manner without prior, express, written consent and acknowledgement of English, common law, spelling and pronunciation, John Henry Doe, superscripted copyright symbol, as signified by common law, English spelling, John Henry Doe, superscripted copyright symbol, signature in red ink. Unauthorized use of common law, English spelling and pronunciation, John Henry Doe, incurs same unauthorized use fees as those associated with all capital letters and legis, John Henry Doe, superscripted copyright symbol. Mail recipient and address for return correspondence, Beverly L. McDonald, Notary Public, 123 Elm Street, Los Angeles, California, 90033. Certification of non-response. The undersigned, all capital letters, Beverly L. McDonald, a notary public for the state of California, hereby certifies that as of this date, November 12, 2001, the undersigned has received No correspondence for English, common law, spelling and pronunciation John Henry Doe from any of the following parties. All capital letters ens legis, Judas S. Squire. All capital letters ens legis, Rachel M. Stewart. All capital letters ens legis, David A. Cooper. The undersigned swears under penalty of perjury of the laws of the state of California that the foregoing is true, correct, and complete in accordance with the undersigned's best first-hand knowledge and belief. All capital letters ens legis, Beverly L. McDonald, Notary Public. State of California, County of Los Angeles, SS. How to sign your signature without liability. An overview. Big Brother's master plan to subjugate the entire human race is utterly dependent on people continuing to volunteer for and finance their own enslavement. Without such largesse from the public, the chosen masters face certain calamity and exposure for their crimes. Heretofore, system operatives have been overwhelmingly successful at duping unwitting victims into volunteering for virtually every kind of financial hell imaginable. And make no mistake, it is purely voluntary. The system is working exactly as it is designed to do, and the chroniclers of chaos proudly trumpet their statistics as they inch forward in their dreams of total world domination. Bankruptcy filings reach record 1.5 million. New York, bankruptcy filings surged 19% to a record 1.5 million last year, as businesses and consumers struggled under heavy debt loads during the economic slowdown. Consumer bankruptcies, which accounted for 97% of all filings, jumped 19%, while business bankruptcies rose 13%, according to data released Tuesday by the Administrative Office of the U.S. Courts. In parentheses, USA Today, February 20th, 2002. It is no coincidence that the introduction and popularity of the real estate board game Monopoly parallels the history of the money changers' financial conquest of America, culminating with its copyright by Parker Brothers in 1935, the same time that we converted over from a substance, in parentheses gold, backed currency to a belief, in parentheses credit, backed currency. The game's logo even confesses the caricature of a white mustachioed English banker, complete with top hat, tails, and cane. The objective in the board game of Monopoly trademark is to drive into bankruptcy all other players, an arrangement otherwise known as tontine wagering scheme. And so it is in real life. If you examine the nature of economics in America today, you will see that everyone is competing for the same rationed amount of monopoly money, called Federal Reserve Notes, FRNs, and attempting to stay above water and avoid bankruptcy. This is by definition a de facto state of war between participants. And both the board game and the game of life, the only way to stay in the game of Monopoly and avoid bankruptcy is to obtain more Monopoly money from other players. The only way to stay in the game of life and avoid bankruptcy is to somehow obtain more FRNs from the other players around you. In both, the outcome is inevitable. The longest-running game of Monopoly trademark lasted 70 days, but still ended the same way as all others before and since, with one player acquiring all the wealth and all the other players bankrupt. Unfortunately, there can be no other final conclusion in the Federal Reserve Note game of life either, no matter how long you stretch it out, unless, of course, you simply stop volunteering to play the game. Notes. Largesse, generous, giving, gift, bounty. The Bankruptcy Act of 1938, America's first such legislation, followed shortly thereafter as well. Tontine, Italian, tontina, after its inventor, Lorenzo Tonti, a Napolitan. A financial arrangement in which a group of participants share in the arrangement's advantages until all but one has died or defaulted, at which time the whole goes to that survivor. All money is borrowed into existence, and the more money is owed than physically exists because of the requirement for making interest payments on the principal amount loaned. The principal comprises all the money there is, but interest payments have to come from somewhere, thus the depletion of the money supply. How to sign your signature without liability. Volunteering. The most devastating form of volunteering occurs when someone promises, and people do this unflinchingly every single day, to be responsible for and pay the debt of another party. Believe it or not, this is how every unwary soul has sealed his fate. The trade name game, i.e., that which the content of this book is dedicated to exposing, untangling, and rectifying, has an evil twin that works in concert with it. As you will discover toward the end of this article, the legal masters of the world are factually eminently aware of the distinction between your true name and trade name, and have come up with an incredibly ingenious device for exploiting the difference without tipping their hand. The reason that every complaint unfailingly cites the defendant's/respondent's name in all capital letters, the reason the name on every license is set in capital letters, the reason the name on every Social Security card has been converted from English, in parentheses as originally written on the application, into legalese. The reason that all banks insist on listing all accounts not in the true name of the party who walks in and fills out the forms, but in the artificial trade name associated therewith, is the same to conduct business with you via an unknown, invisible, corporately colored artificial person that is subject to all statutory regulation and therefore under their complete control and power. The same applies equally when either of the two names is called out verbally. Remember, differently constructed names comprise distinct items of property. However similar, filing a UCC financing statement is the first step in releasing yourself from these bonds. The second is cessation of volunteering to be responsible for the trade name's obligations by signing it on its behalf. When someone signs his name on a commercial instrument listed in his straw man's trade name, he finalizes his financial obligations in that particular transaction and also contributes just that much more in the chosen master's designs for a new world order. That order is an economic pecking order, with them owning literally everything at the top, and you and your family and friends owning nothing, in parentheses, including your labor, at the bottom. Article 3, in parentheses, negotiable instruments, of the Uniform Commercial Code has been written to augment the liabilities that come with signing on behalf of another, but has also been encrypted to keep curious slaves from finding out how they are being duped. Because the legal masters of the world cannot bind us into perpetual servitude without also offering a route for escape, we have remedy in the UCC. Unraveling the mystery. The key entry point into Article 3 on the subject of signatures is this. The general rule is that a signature is an endorsement if the instrument does not indicate an unambiguous intent for the signer not to sign as an endorser. Intent may be determined by words accompanying the signature, the place of signature, or other circumstances. UCC P.3-204, Note 1, Paragraph 2. Even without defining the key term endorser, the meaning is clear. In the absence of indicating an unambiguous intent, a signature can be construed as an endorsement. Endorser means a person who makes an endorsement. UCC 3-204, Section B. Endorsement means a signature other than that of a signer as maker, drawer, or acceptor, that alone or accompanied by other words is made on an instrument for the purpose of 1. Negotiating the instrument, 2. Restricting payment of the instrument, or 3. Incurring endorser's liability on the instrument. But regardless of the intent of the signer, a signature and its accompanying words is an endorsement unless the accompanying words, terms of the instrument, place of the signature, or other circumstances unambiguously indicate that the signature was made for a purpose other than endorsement. For the purpose of determining whether a signature is made on an instrument, a paper affixed to the instrument is a part of the instrument. UCC 3-204, Section A. Makers, drawers, and acceptors are the primary types of signers of negotiable instruments. Maker means a person who signs or is identified in a note as a person undertaking to pay. UCC 3-103, Section 5. Drawer means a person who signs or is identified in a draft as a person ordering payment. UCC 3-103, Section 3. Acceptor means a drawee who has accepted a draft. UCC 3-103, Section 1. Drawee means a person ordered in a draft to make payment. UCC 3-103, Section 2. Accommodation parties. How could one sign a negotiable instrument, in parentheses, irrespective of the signer's awareness that what he is signing is a negotiable instrument, and incur liability as anything other than a maker, drawer, or acceptor? Answer: as an accommodation party. Accommodation party is described in Note 1 under UCC 3-419. An accommodation party is a person who signs an instrument to the benefit the accommodated party either by signing at the time value is obtained by the accommodated party or later, and who is not a direct beneficiary of the value obtained. An accommodation party will usually be a co-maker or anomalous endorser. In the UCC, one of the meanings of value is essentially credit. You qualify on this point because you have been the sole source of credit for your trade name since inception, birth, and are not a direct beneficiary of the value given. In parentheses, what you get is liability. The meaning of co-maker can be deduced from the definition of maker above, but is nevertheless a subordinate identifier in respect of accommodation party. Anomalous means departing from the common rule, irregular. The UCC defines anomalous endorsement as follows. Anomalous endorsement means an endorsement made by a person who is not the holder of the instrument. An anomalous endorsement is made by a party that is not the holder of the instrument, in parentheses, i.e., no rights in the instrument, and qualifies, nevertheless, as a valid endorsement, in parentheses, even though not specifically that of maker, drawer, or acceptor, and would not adversely affect the negotiability of the instrument. That this section is imbued with vagueness opens the door for other factors to enter in, but we are not told what those factors might be, in parentheses, the purpose of codes. Summing up the accommodation party, someone who signs on behalf of another for the purpose of benefiting that party. and who also is not a direct beneficiary of the value obtained by the accommodated party. An accommodation party is not a maker, not a drawer, and not an acceptor, but has an anomalous role in the endorsement process. Apparently, an accommodation party bears full liability for the accommodated party, but stands to gain nothing by participating. This is obviously the most inferior status one can have, because he is completely out of control of his own destiny, based on the mischief that the trade name gets into and the misadventures that follow thereafter. Wrapping up on the accommodation party, the worst kiss of death has been saved for last. An accommodation party is always a surety. UCC 3-419, Note 3, Paragraph 2. As you know from the curse of co-suretyship in Section 3, a surety is utterly responsible for anything and everything that the principal debtor is responsible for, including both payment and specific performance. An accommodation party is automatically and always a surety for the accommodated party. When you, the flesh and blood, man and woman, sign an instrument, in parentheses, even if you do not know that you are signing a negotiable instrument, such as a traffic ticket, bearing the straw man's trade name, you are signing as an accommodation party and bear full personal responsibility and accountability for whatever the straw man has gotten itself into, including the potential for incarceration. Remember, a surety is an equal of the principal. The creditor is authorized to treat the surety exactly as though the surety were the principal debtor, and extract both payment and specific performance. Since your straw man is rather difficult to locate and identify, in parentheses, no physical existence, you and your body serve nicely. Light at the end of the tunnel. Now for the $64 question. How can you avoid ever being considered as an accommodation party? Your signature ever being construed as an accommodation signature? The answer is found in Notes 1 and 2 of Section Statute 3-402. 1. Subsection A states when the presented person is bound on an instrument if the instrument is signed by a representative. If under the law of agency, the represented person would be bound by the act of the representative in signing either the name of the represented person or that of the representative, the signature is the authorized signature of the represented person. 2. Subsection B. 1. States that if the form of a signature unambiguously shows that if it is made on behalf of an identified represented person, in parentheses, for example, P by A, treasurer, the agent is not liable. This is a workable standard for court to apply. Translation. You are removed from the realm of liability of being construed as a maker, drawer, or acceptor, or accommodation party, in parentheses, and therefore as a surety, by unambiguously identifying your signature as that of authorized representative. Signing in this fashion removes all doubt, in parentheses, unambiguously indicates, the exact identification of the signing party. It also relieves the signer of all legal liability for the principal's, in parentheses, represented person's, obligation. The key is to be as unambiguous and as expositional as you can, to reveal as much as possible about your agency status and however little space you have to work with on the instrument. Writing above and below works also, as long as it is unambiguous. Some interchangeable examples of workable signatures. All capital letters ends legis, John Henry Doe, superscripted copyright symbol by common law English spelling, John Henry Doe, superscripted copyright symbol, authorized representative. All capital letters ends legis, John H. Doe, superscripted copyright symbol, by common law English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, authorized rep. all capital letters, ends legis, John Doe, superscripted copyright symbol, by common law, English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, agent. By order of, all capital letters, ends legis, John Henry Doe, superscripted copyright symbol, by common law, English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, authorized representative. By order of, all capital letters, ends legis, John H. Doe, superscripted copyright symbol, by common law, English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, auth, rep. By order of, ends legis, capital letters, John Doe, superscripted copyright symbol, by common law, spelling and pronunciation, John Henry Doe, superscripted copyright symbol, agent. By common law, English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, authorized representative. By common law, English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, auth, rep. By common law, English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, agent. By order of, all capital letters, ends legis, John Henry Doe, superscripted copyright symbol, by common law, spelling and pronunciation, John Henry Doe, superscripted copyright symbol, authorized representative. By order of, all capital letters, ends legis, John H. Doe, superscripted copyright symbol, by common law, English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, auth, rep. By order of, all capital letters, ends legis, John Doe, superscripted copyright symbol, by common law, English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, agent. Also, inserting the words authorized signature in a conspicuous, unambiguous manner, in parentheses such as below the signature line, helps in indicating signer's agency status. Total confirmation from Big Brother and the validity of what we are doing. The final segment of this short essay reveals something that will convince even the fiercest naysayer, in parentheses, at least those who are not on Big Brother's payroll, of the correctness of your hunches and the criminal intent of the legal masters of the world. Looking at Note 3 of the UCC 3-402, which has to do with checks, we find Subsection 3 is directed at the check cases. It states that if the check identifies the represented person, in parentheses SIC, the agent who signs does not have to indicate agency status. Virtually all checks used today are in personalized form, in parentheses SIC, which identify the person on whose account the check is drawn. In this case, nobody is deceived into thinking that the person signing the check is meant to be liable. Therefore, apparently, when the name of the represented person is printed on the face of the check, any agent signing for the represented person need not indicate agency status. Virtually all checks used today are personalized to identify the account holder, and, since virtually all checks used today are personalized, nobody is deceived into thinking that the person signing the check is meant to be liable if he is signing as an agent. Follow this procedure. Go online and pull up www.deluxe.com. Under Personal Checks, click on Browse our full line of checks design. Wait a few moments while the next page, Deluxe Personal Checks Catalog, comes up. Click on About Checks, and then scroll down to Check Security Features, and observe the arrow marked Micro Printing and pointing at the signature line of the check. Next, take out one of your personal, in parentheses not business, checks and place it under a magnifying glass or microscope. Place it so the signature line is directly under the lens. Below is a blow-up of what you will see when you scrutinize the line. Authorized signature, authorized signature, authorized sig. Editing Note 3 of UCC 3-402 from above. In this case, nobody, in parentheses except the signer, is deceived into thinking that the person signing the check is meant to be liable. Deluxe openly prints out the words authorized signature underneath the signature line on business checks, but disguises the same proclamation on personal checks. The reason the signature line on a personal check is made up of the words authorized signature is because it is a physical impossibility that the account holder will ever sign the check. The account holder is an artificial person, e.g., all capital letters, ens legis, John Henry Doe, and exists in name only. The Fed knows that every signature appearing on a personal check is the signature of the flesh and blood agent, the authorized representative. However, this fact must be concealed in order to cause the signer to believe that he is the principal, when he actually signs on as an accommodation party, i.e., surety, and therefore 100% liable for everything the principal is liable for. This applies in every signature on every document, not just personal checks. Deluxe and other check manufacturing companies must do this if they want to sell personal checks to Fed customers. Apparently, this is how the Fed justifies their deceit and duplicity. Quote, "We told them. We put it right there on the check leaf. We can't help it if they're too stupid to know that they are the authorized representative when they decided to accept responsibility as the accommodation party for the account holder. They did so voluntarily. We can't help it if they volunteer to do something. We did everything we could to make it easier for them. We even personalized the checks with the account holder's name and spelt out authorized signature right there on the signature line to save them the headache of having to write out authorized representative every time they signed a check. We can't be blamed for their ignorance." We were not supposed to find out about this device, but its existence is a full-blown confession and acknowledgement and validation of everything propounded in this book. Ray, the distinction between true name and trade name. Big Brother knows precisely what it is doing. Ray, subjugating us via the names. Welcome to the real world. Your signature. If UCC delineated check signing procedures are so important for Federal Reserve owners and the manufacturers of checks used within that system, it should be important for you as well. The overwhelming significance of Fed acknowledgement of the difference between the names by virtue of the inclusion of this artifice on every check cannot be exaggerated. In fact, this discovery alone is conclusive proof of their deceit in every controversy involving the trade name. Remember, the Fed literally owns the government, and therefore everything in America. This is confirmed in Senate Document 43, 73rd Congress, First Session. The message. You do not have to continue to volunteer to be responsible for the trade name's obligations, financial and otherwise. You can begin affixing your signature in the proper fashion now that you know the truth. You can always prove that you are nothing more than the authorized representative merely by pointing out the statement made on the signature line of your checking account. This phenomenon has unlimited application in your life. It is so profound that if someone were to be arrested and subsequently asked to sign a bond, he could do so as set forth above and incur zero liability for ever having anything to do with either the bond or the criminal charge associated therewith. The distinction between the parties is undeniable. In closing, the check signature line subterfuge can be used to prove the legal correctness of what we are doing with anyone, including a stubborn Secretary of State who refuses to file a financing statement based on the hackneyed ruse that you are contracting with yourself. If there were no difference between trade name and true name, the Fed would not have taken such extreme measures to conceal the fact that the signer of a personal check is only the agent. This revelation should bring about a sharp improvement in the lives of, in parentheses, former slaves whenever a signature is required. Helpful notes for pressure situations. Strategic thought. The best solution for courtroom situations is to try to conduct your life so none of its officers ever feel a need nor ever have a reason to speak with you about anything. Doing business with these characters on their terms is not much different than falling into quicksand. The entire system, from top to bottom, inside and out, has been constructed over the millennia with a mind for treachery and deceit, and is corrupt literally beyond your present comprehension. It is a self-aggrandizing enslavement system designed for the express purpose of punishing all outsiders for the crime of being an outsider. You need to take every possible precaution to avoid slipping into its clutches. You are the declared enemy in war of those who own and dictate over the system. As long as you know this, you have a decent chance of survival. You will suffer in direct proportion to the degree you believe is not to be true. Once you have fallen prey, there is precious little you can do to escape its wrath. Fact. There are more Americans in jail, on probation, and on trial per capita than in any other country in the world, including communist China, where 15 to 20 people are executed every day. What you see in America is not what you get. America has been converted into a movie set with false fronts and phony actors pretending to be your friend. Trust Big Brother with any information about yourself, and it will be used against you, no matter the pledge used to extract it, without exception. So the basic message here is, don't do anything illegal, reduce all unnecessary traffic with Big Brother, and do not do anything to excite its curiosity or animosity, both behaviorally and financially. Do the right thing at all times. Tactical thought. For those who have had the misfortune to be dragged into Big Brother's meat grinder, the following ideas are offered. You are not your name. Names are property, and your name is your property, no matter what form it appears in. Your trade name, superscripted copyright symbol, is common law copyright. Your true name, superscripted copyright symbol, is autograph common law copyright. Any name used by anyone in the system to identify/reference you is your property and cannot be lawfully taken without incurring the obligation of compensating you. Your name is not copyrighted statutorily because you are a flesh and blood man, not a corporation, and deal exclusively in the common law. Since the law cannot compel impossibilities, you only have one option, common law, which you have accessed by copywriting your property. The entire issue revolves around someone using your property without compensating you. As in all other commercial transactions in life, if someone wants to use your property, he has to pay. Publishing your copyright notice and obtaining an affidavit of publishing from the newspaper, and then recording an original copy of the affidavit, in parentheses, after having made a few certified copies via copy certification by document custodian, cements your standing in law, in parentheses, common law, and your supreme claim, your property. They are holding the wrong guy. Per your hold harmless and indemnity agreement, you have a statement from the trade name, superscripted copyright symbol, indemnifying true name, superscripted copyright symbol, and holding that party harmless for whatever trouble comes his way. Trade name, superscripted copyright symbol, acknowledge that you are neither a surety nor an accommodation party for the trade name, superscripted copyright symbol, which has indemnified you for any of its misadventures. They kidnapped you and are holding you for ransom because of his alleged troubles. You are neither the guy that's in trouble, nor are you responsible in any way for the guy that is allegedly in trouble. The judge, in parentheses, Mr. last name or Sir, has taken your property and is using it without your authorization and without compensating you. Following notification of the terms of the use of your property, the judge consents and agrees with granting you a security interest in all his assets, land, and property for the purpose of securing payment from him for the obligation incurred. In the event he elects to execute the contract, you already have a signed security agreement from him. His all-caps trade name signature appears on the signature line of the security agreement in typewritten form. Valid signature per UCC Statute 1-201, Section 39 and 3-401. Note: the same type of mechanism that IRS uses to sign on your behalf is used to obtain the typewritten signature of the agent principal using your trade name for financial gain without compensating you. 26 U.S.C. 6020. Notice of deficiency. Refund for fraud. Ordering a meal in a restaurant incurs a common law obligation to compensate the provider of the food and executes the contract without signature. Voluntary use of the trade name after having been noticed of fees for its use likewise executes the contract and incurs the obligation of paying without signature. The unauthorized user's signature on the security agreement authorizes the filing of a UCC-1 financing statement, a claim against everything the unauthorized user owns, and cannot be invalidated. In parentheses, obligation of contracts is inviolate. The contract is purely private and purely consensual. Many, even at higher levels of government, have tried to remove /disqualify /invalidate -negate such filings, all unsuccessfully so. The only reason you are on their turf is for the purpose of doing business. Even though it is all a case of mistaken identity and they have the wrong guy in custody, since they do not have your authorization for using your property, you must enforce the terms of the consensual contract regarding payment. Before using techniques outlined below, you should be very familiar with the concepts as set forth in the two sets of sample dialogue between judge and sovereign, and motorist and policeman, respectively, as set forth in Section 1, Maintaining Fiscal Integrity. When your trade name is called, in parentheses, $500,000 for each use, both verbal and written, speak up and convey any of these thoughts as well as you can at any particular time that seems appropriate. The name you just called out is common law copyrighted property, and I am the holder of the copyright, the secured party in all transactions concerning unauthorized use thereof. You may address me as secured party, in parentheses, respond to no other name. The party you call the defendant, the party you call a person, is a registered copyright, i.e., my copyrighted property. You do not now have, nor have you ever had, my permission to use my private property. You have been properly noticed of the fee for each unauthorized use of my property, so I can interpret your actions in no other way than you want to do business. Repeated use after notifications of fees removes it from the realm of error. You do not have my authorization to use my property at any time without compensating me. If you want to withdraw from the consensual contract at this point in time and cease using my property in any manner, and guarantee that none of your associates will likewise ever use my property again for any reason, I would be amendable to forgiving all unauthorized use fees incurred heretofore. However, any instance of additional use of my property at any time by either you or any of your associates confirms and executes the consensual contract and security agreement now in your possession concerning our business arrangement. The terms of our consensual contract reflect everything I am saying here. The only reason I am here is to do business, because you are holding the wrong party and holding him against his will. If you want to do business, then let's do business. Otherwise, let's call off the whole thing right now and go home. Since you insist on using my property, you have two options. 1. You can show me the law that allows you to take my private property without compensating me, or 2. You can pay me. If you cannot produce the law that supports your actions, let's do business. The first thing I want to know is, how are you going to pay me? Do you understand the charges as set forth in our agreement? You can read our consensual contract if you are not familiar with the terms of the strict foreclosure, which will be enforced. As soon as you execute the agreement and the security interest attaches, any transfer of title of anything you own is fraudulently conveyance, and any such transaction will be reversed. If the judge uses the property one more time after proper notice has been given, since you are going forward with the use of my private property without my authorization, we are now under contract, and I demand to be paid, with or without your cooperation. Your only option is to show me the law that allows you to take my private property and use without compensating me in accordance with our agreement. If you are having second thoughts about our agreement, you can still do something about it while I am here. But once I walk through that door, the deal is sealed. What do you want to do? If the judge ever asserts that there is no contract, let the record show that the judge has asserted that there is no contract between him and me. If this statement is true, then there is no reason for me being held here against my will, and I request the order of the court be released to me immediately. What's it going to be? Do we have an agreement or not? Do you understand? The judge will try everything in his power to get you into contract with him on his terms, in parentheses statutory. Literally, the only reason you are consenting to be there is to do business. If he uses any derivative, in parentheses alteration of name, of your property, he enters the contract and you must demand payment as just compensation for its use. You can also bring up the following at any time. You have counterfeited my property, and I am entitled to treble damages for whatever harm you have caused, in parentheses 15 U.S.C. 1117, Section B. You are holding the wrong guy. It appears that you have kidnapped me and are now holding me for ransom based solely on this alleged misconduct. Is this true? Am I in debtor's prison? Are you going to put me in debtor's prison? You have trespassed on my private property and now have a fiduciary responsibility to investigate what I have told you concerning ownership of the property that you have trespassed against before you proceed any further. Note: acceptance and registration of the private contract by the Secretary of State proves that you are not the trade name, because it is unlawful for someone to contract with himself, and the Secretary of State does not accept bogus filings. There are two different parties involved here, and the name they are going after is the trade name, not you. In closing, it can be fatal to corner a judge and embarrass him in front of his contemporaries, however right you may be. With this philosophy in mind, try to temper your comments and demands so as to open the door to possible reconciliation. You most certainly are holding all the aces concerning all property registered in the name and the Social Security account number of that judge's trade name. The more confident, self-assured, and well-spoken you are, the better the chance the judge will have a realizing that you can do what you say. If you invoke his ire, he may victimize you just to get even, no matter what penalties he may face down the road. The judge has so many crimes against people, in parentheses, hence the need for official immunity, that he can lash out automatically, without no more reason in the act than a compulsion to strike back. Realize that you are on enemy turf. Respect your enemy for who he is and the power that he has, and make the best of it. Part 3, Section 11, Appendix. Postmaster, please post in a conspicuous place. James A. Farley, Postmaster General. Under Executive Order of the President, issued April 5th, 1933, all persons are required to deliver, on or before May 1st, 1933, all gold coin, gold bullion, and gold certificates now owned by them to a Federal Reserve Bank, branch or agency, or to any member bank of the Federal Reserve System. Executive Order forbidding the hoarding of gold coin, gold bullion, and gold certificates, by virtue of the authority vested in me by Section 5B of the Act of October 6, 1917, as amended by Section 2 of the Act of March 9, 1933, entitled An Act to Provide Relief in the Existing Emergency in Banking, and for other purposes, in which a mandatory act Congress declared that a serious emergency crisis, I, Franklin D. Roosevelt, President of the United States of America, do declare that said national emergency still continues to exist, and pursuant to said section, do hereby prohibit the hoarding of gold coin, gold bullion, and gold certificates within the continental United States by individuals, partnerships, associations, and corporations, and hereby prescribe the following regulations for carrying out the purposes of this order. Section 1. For the purposes of this regulation, the term hoarding means the withdrawal and withholding of gold coin, gold bullion, or gold certificates from the recognized and customary channels of trade. The term person means any individual, partnership, association, or corporation. Section 2. All persons are hereby required to deliver on or before May 1st, 1933, to a Federal Reserve Bank or branch or agency thereof, or to any member bank of the Federal Reserve System, all gold coins, gold bullion, and gold certificates now owned by them or coming into their ownership on or before April 23rd, 1933, except the following. A. Such amount of gold as may be required for legitimate and customary use in industry, professions, or art within a reasonable time, excluding gold prior to refining and stocks of gold and reasonable amounts for the unusual true requirements of owners mining and refining such gold. B. Gold coins and gold certificates in an amount not exceeding in the aggregate $100 belonging to any one person, and gold coins having a recognized special value to collectors or rare and unusual coins. C. Gold coin and bullion earmarked or held in trust for a recognized foreign government, in parentheses, or foreign central bank, or the Bank for International Settlements. D. Gold coin and bullion licensed for other proper transactions, in parentheses, not involving hoarding, including gold coin and bullion imported for re-export or held pending action on application for export licenses. Section 3. Until otherwise ordered by any other person becoming the owner of any gold coin, gold bullion, or gold certificates after April 23, 1933, shall within 3 days after receipt thereof deliver the same in the manner prescribed in Section 2, unless such gold coin, gold bullion, or gold certificates are held for any of the purposes specified in paragraphs A, B, or C of Section 2, or unless such gold coin or gold bullion is held for purposes specified in paragraph D of Section 2, and the person holding it is, with respect to such gold coin or bullion, a licensee or applicant for license pending action thereon. Section 4. Upon receipt of gold coin, gold bullion, or gold certificates delivered to it in accordance with Sections 2 or 3, the Federal Reserve Bank or member bank will pay, therefore, an equivalent amount of any form of coin or currency coined or issued under the laws of the United States. Section 5. Member banks shall deliver all gold coin, gold bullion, and gold certificates owned or received by them, in parentheses, other than as exempted under the provision of Section 2, to the Federal Reserve banks of their respective districts and receive credit or payment therefor. Section 6. The Secretary of the Treasury, out of the sum made available to the President by Section 301 of the Act of March 9, 1933, will, in all proper cases, pay the reasonable cost of transportation of gold coin, gold bullion, or gold certificates delivered to a member bank or Federal Reserve Bank in accordance with Sections 2, 3, or 5 hereof, including the costs of insurance, protection, and such other incidental costs as may be necessary upon production of satisfactory evidence of such costs. Voucher forms for this purpose may be procured from Federal Reserve banks. Section 7. In cases where the delivery of gold coin, gold bullion, or gold certificates by the owners thereof within the time set for the above will involve extraordinary hardship or difficulty, the Secretary of the Treasury may, in his discretion, extend the time within which such delivery must be made. Applications for such extensions must be made in writing under oath, addressed to the Secretary of the Treasury, and filed with a Federal Reserve Bank. Each application must state the date to which the extension is desired, and the amount and location of the gold coin, gold bullion, and gold certificates in respect of which such application is made, and the facts showing extension to be necessary to avoid extraordinary hardship or difficulty. Section 8. The Secretary of the Treasury is hereby authorized and empowered to issue such further regulations as he may deem necessary to carry out the purpose of this order and to issue licenses thereunder, through each offices or agencies as he may designate, including licenses permitting the Federal Reserve banks and member banks of the Federal Reserve System in return for an equivalent amount of other coin, currency, or credit, to deliver, earmark, or hold in trust gold coin and bullion to or for persons showing the need for the same for any of the purposes specified in paragraphs A, C, and D of Section 2 of these regulations. Section 9. Whoever willfully violates any provision of this executive order or of these regulations or of any rule, regulation, or license issued thereunder may be fined more than $10,000, or if a natural person may be imprisoned for not more than 10 years, or both, and any officer, director, or agency of any corporation who knowingly participates in any such violation may be punished by and like fine, imprisonment, or both. This order and these regulations may be modified or revoked at any time. Franklin D. Roosevelt, The White House, April 5, 1933. Further information, consult your local bank. Gold certificates may be identified by the words Gold Certificate appearing thereon. The serial number and the Treasury seal on the face of a gold certificate are printed in yellow. Be careful not to confuse gold certificates with other issues which are redeemable in gold but which are not gold certificates. Federal Reserve notes and United States notes are redeemable in gold but are not gold certificates and are not required to be surrendered. Special attention is directed to the exceptions allowed under Section 2 of the Executive Order. Criminal penalties for violation of Executive Order. Code of Federal Regulations, Title 27, Volume 1, Parts 1 to 199, revised as of April 1st, 1999. Site 27 CFR 72.11. Title 27, Alcohol, Tobacco Products, and Firearms. Chapter 1, Bureau of Alcohol, Tobacco, and Firearms, Department of the Treasury. Part 72, Disposition of Seized Personal Property, Table of Contents. Subpart B, Definitions, Meanings of Terms. Section 72.11. As used in this part, unless the context otherwise requires, terms shall have the meanings ascribed in this section. Words in the plural form shall include the singular, and vice versa, and words importing the masculine gender shall include the feminine. The terms includes and including do not exclude things not enumerated which are in the same general class. ATF Officer, an officer or employee of the Bureau of Alcohol, Tobacco, and Firearms. ATF, duly authorized to perform any function relating to the administration or enforcement of this part. Appraised value. The value placed on seized property or carriers by the appraiser or appraisers designated for the purpose of determining whether the property or carriers may be forfeited administratively. Carrier. A vessel, vehicle, or aircraft seized under 49 U.S.C. Chapter 11 for having been used to transport, carry, or conceal a contraband firearm or contraband cigarettes, vessels, vehicles, or aircraft seized under the provisions of applicable laws shall be considered personal property. Commercial crimes. Any of the following types of crimes, in parentheses, federal or state, offenses against the revenue laws: burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, in parentheses, including soliciting, procuring, pandering, white slaving, keeping house of ill fame, and like offenses, extortion, swindling, and confidence games, and attempting to commit, conspire to commit, or compounding any of the foregoing crimes. Addiction to narcotic drugs and use of marijuana will be treated as if such were commercial crime. Contraband cigarettes. Any quantity of cigarettes in excess of 60,000 if a. The cigarettes bear no evidence of the payment of applicable state cigarette tax in the state where the cigarettes are found. B. The state in which the cigarettes are found requires a stamp, impression, or other indication to be placed on packages or other containers of cigarettes to evidence payment of cigarette tax. And C. The cigarettes are in the possession of any person other than any person who is 1. Holding a permit issued under 26 U.S.C. Chapter 52 as a manufacturer of tobacco products or as an export warehouse proprietor. 2. Operating a customs bonded warehouse under 19 U.S.C. 1311 or 1555. 3. An agent of a tobacco products manufacturer, an export warehouse proprietor, or an operator of a customs bonded warehouse. 4. A common or contract carrier transporting the cigarettes involved under a proper bill of lading or freight bill which states the quantity, source, and designation of the cigarettes. 5. Licensed or otherwise authorized by the state where the cigarettes are found to account for and pay cigarette taxes imposed by the state, and who has complied with the accounting and payment requirements relating to the license or authorization with respect to the cigarettes involved. Or 6. An agent of the United States, of an individual state, or of a political subdivision of a state, and having possession of cigarettes in connection with the performance of official duties. 7. Operating within a foreign trade zone established under 19 U.S.C. 81b, when the cigarettes involved have been entered into the foreign trade zone under zone restricted status, or when foreign cigarettes have been admitted into the foreign trade zone but have not been entered into the United States. Contraband firearm. A firearm with respect to which there has been committed a violation of the National Firearms Act, in parentheses, 26 U.S.C. Chapter 53, or any regulation issued thereunder. Director. The Director, Bureau of Alcohol, Tobacco, and Firearms, the Department of the Treasury, Washington, D.C. Equity. As used in administrative action on petitions for remission or mitigation of forfeitures, shall mean that interest which a petitioner has in the personal property or carrier petitioned for at the time of final administrative action on the petition. But such interest shall not be considered to include any unearned finance charges from the date of seizure or the date of default. If later, any amount relatable on account of paid insurance premiums, attorney fees for collections, any amount identified as dealer's service, or any amount in the nature of liquidated damages that may have been agreed upon by the buyer and the petitioner. Person. An individual, trust, estate, partnership, association, company, or a corporation. Reappraisal. An up-to-date statutory appraisal to determine the present value of the property or carrier involved in a petition for remission or mitigation or forfeiture made in the same manner as the original appraisal, and performed at the written request of the petitioner whose petition in regard to the property or carrier has been allowed and who, for reasonable cause, is not satisfied that the original appraisal represents the present value of the property or carrier. Region. A Bureau of Alcohol, Tobacco, and Firearms Region, USC, the United States Code. in parentheses, TD, ATF 48, 43, FR 13535, March 31, 1978, 44, FR 55841. September 28, 1979, as amended by TD ATF 65 45 FR 8593, February 8, 1980, TD ATF 183 49 FR 37061, September 21st, 1984. Ray Prisoners, Prisons, and Courts. Statute 7102. Definitions and Index of Definitions. 1. In this division, unless the context otherwise requires: A. Bailee, in parentheses, U.S. Marshal, means the person who by a warehouse receipt, bill of lading, or other document of title acknowledges possession of goods and contracts to deliver them. B. Consignee, in parentheses, Judge, means the person named in a bill to whom or to whose order the bill promises delivery. C. Consignor, in parentheses, Prosecutor, means the person named in a bill as the person from whom the goods have been received for shipment. E. Document, in parentheses, Minimus paper, means document of title as defined in the general definitions in Division 1, in parentheses, Section 1201. F. Goods, prisoner, means all things which are treated as movable for the purposes of a contract of storage or transportation. G. Issuer, in parentheses, clerk of court, means a bailee who issues a document. Issuer includes any person for whom an agent or employee purports to act in issuing a document. If the agent or employee has a real or apparent authority to issue documents, notwithstanding that the issuer received no goods or that the goods were miscredited, or that in any other respect the agent or employee violated his instructions. H. Warehouseman, in parentheses, warden, is a person engaged in the business of storing goods for hire. 2. Other definitions applying to this division or to specified chapters thereof, and the sections in which they appear are: duly negotiate, Section 7501. Person entitled under the document, Section 7403. 4. 3. Definitions in other divisions applying to this division and the sections in which they appear are: contract for sale, Section 2106. Overseas, Section 2323. Receipt of goods, Section 2103. 4. In addition, Division 1 contains general definitions and principles of construction and interpretation applicable throughout this division. In parentheses, Stats 1963, C. 819, Statute 7102. Notes: Mittimus, in parentheses, law, Latin, we send, a court order or warrant directing a jailer to detain a person until ordered otherwise. Black's 7th edition. In criminal practice, the name of a precept in writing, issuing from a court or magistrate, directed to the sheriff or other officer, commanding him to convey to the prison the person named therein, and to the jailer, commanding him to receive and safely keep such person until he shall be delivered by due course of law. Black's Law Dictionary, 1st edition. All capital letters: Betty H. Richardson, United States Attorney, United States Attorney's Office, Box 32, Boise, Idaho, 83707. Telephone, in parentheses, 208 334-1211. All capital letters, Richard R. Ward, Trial Attorney, Tax Division, U.S. Department of Justice, P.O. Box 683, Ben Franklin Station, Washington, D.C. 20044-0683. Telephone, parentheses, 202-307-5867. Attorneys for the United States of America. In all capital letters, the United States District Court for the District of Idaho. Diversified Metal Products, Inc. Plaintiff vs. T. Bow Company Trust, Internal Revenue Service, and Steve Morgan, defendants. Dwayne Harry Danton, 118202. Civil number 93-405-E-EJL, United States Answer and Claim. The United States of America, through undersigned counsel, hereby responds to the numbered paragraphs of plaintiff's complaint as follows. 1. The United States is without information or knowledge sufficient to form a belief as to the truth of the allegations contained in paragraph 1 and, on that basis, denies the allegations. United States Answer and Claim 1. 2. The United States is without information or knowledge sufficient to form a belief as to the truth of the allegations contained in paragraph 2 and, on that basis, denies the allegations. 3. The United States is without information or knowledge sufficient to form a belief as to the truth of the allegations contained in paragraph 3 and, on that basis, denies the allegations. 4. Denies that the Internal Revenue Service is an agency of the United States government, but admits that the United States of America would be a proper party to this action. Admits that the IRS has served a notice of levy on plaintiff for funds owed to defendant Steve Morgan. 5. Admits that the IRS has made a demand on plaintiff for payments of funds owed to Steve Morgan. The United States is without information or knowledge sufficient to form a belief as to the truth of the remaining allegations, and on that basis denies the remaining allegations. 6. Admits that Exhibits A and B are attached and are, respectively, a copy of a letter from Lonnie Crockett and a copy of a notice of levy served by the IRS. 7. The United States is without information or knowledge sufficient to form a belief as to the truth of the allegations contained in paragraph 7 and, on that basis, denies the allegations. United States Answer and Claim 2. 8. Admits that copies of 2 checks in the amounts of $504 and $345.60 are attached to the complaint as Exhibit C. 9. The United States is without information or knowledge sufficient to form a belief as to the truth of the allegations contained in paragraph 9 and, on that basis, denies the allegations. 10. Paragraph 10 contains allegations of law to which no response is required. 11. Paragraph 11 contains allegations of law to which no response is required. First defense. Plaintiff is not entitled to an award of attorney fees or costs that would diminish the recovery of the United States. Second defense. The Internal Revenue Service is not a proper defendant and the United States should be substituted in its place. Third defense. The United States has not waived its sovereign immunity to suit. Fourth defense. Plaintiff's complaint should be dismissed for insufficient service of process on the United States. Fifth defense. Plaintiff's complaint fails to state a jurisdictional basis for suit. United States Answer and Claim number 3. Claim of the United States. 1. This claim is made pursuant to 26 U.S.C. sections 7401 and 7403 at the direction of the Attorney General of the United States, with the authorization and at the request of the Chief Counsel of the Internal Revenue Service, a delegate of the Secretary of the Treasury of the United States. 2. On May 29, 1989, a delegate of the Secretary of the Treasury made an assessment of unpaid personal income taxes against Stephen and Corrine Morgan in the amount of $516.50, including penalties and interest for the taxable period ending December 31st, 1988. 3. Notice of and demand for payment of the taxes described in paragraph 1 above was given to and made on Stephen and Corrine Morgan in accordance with 26 U.S.C. Statute 6303. 4. Notice of federal tax lien with respect to the assessment described in paragraph 1 above was filed with the Madison County Recorder, Rexburg, Idaho on August 30th, 1993. 5. On May 31st, 1993, a delegate of the Secretary of the Treasury made an assessment of unpaid personal income taxes against Stephen Morgan in the amount of $2,565.21, including penalties and interest for the taxable period ending December 31st, 1989. 6. Notice of and demand for payment of the taxes described in paragraph 4 above was given to and made on Stephen Morgan in accordance with 26 U.S.C. Statute 6303. United States Answer and Claim 4. 7. Notice of federal tax lien with respect to the assessment described in paragraph 4 above was filed with the Madison County Recorder, Rexburg, Idaho on August 30th, 1993. 8. On May 31st, 1993, a delegate of the Secretary of the Treasury made an assessment of unpaid personal income taxes against Stephen Morgan in the amount of $2,393.28, including penalties and interest for the taxable period ending December 31st, 1990. 9. Notice of and demand for payment of the taxes described in paragraph 7 above was given to and made on Stephen Morgan in accordance with 26 U.S.C. Statute 6303. 10. Notice of federal tax lien with respect to the assessment described in paragraph 7 above was filed with the Madison County Recorder, Rexburg, Idaho on August 30th, 1993. 11. Despite notice and demand, Stephen Morgan has failed to pay the taxes assessed, and there remains due and owing to the United States the sum of $5,474.99, plus accrued interest, penalties, and other statutory additions. 12. On or about August 3rd, 1993, the Internal Revenue Service served a notice of levy on Steve Morgan's employer, Diversified Metal Products Incorporated, requesting payment of all monies owed to Steve Morgan by Diversified Metal Products. 13. The interpleaded fund contains money that is owed to Steve Morgan by Diversified Metal Products Incorporated, to which the federal tax lien attaches. United States Answers and Claim 5. 14. The United States claims priority to the interpleaded fund and such amount remaining after satisfaction of the claims of competing claimants to the fund who are entitled to priority over the United States. Wherefore, the United States of America prays the court. 1. Adjudged and decreed that the defendant, the United States of America, has valid and subsisting liens in the amount of $5,474.99, plus accrued interest, penalties, and other statutory additions. 2. Determine the rights, titles, and interest of the parties to the fund. And 3. Grant the United States its costs and such other further relief that is just and proper. Respectively submitted this 18th day of November, 1993. Betty H. Richardson, United States Attorney. Richard R. Ward, Trial Attorney, Tax Division, U.S. Department of Justice. P.O. Box 683, Ben Franklin Station, Washington, D.C. 20044-0683. Telephone 202-307-5867. The demise of the American Constitutional Republic. Between 1916 and 1933, both Federal Reserve notes in parentheses (FRNs) and United States notes were redeemable in gold. Gold and silver is the money of sovereigns for reasons such as 1. Gold and silver are substance, not pieces of paper with ink/printing on them, and constitute portable allodial land titles, signifying absolute ownership and rights to property. 2. When a debt is paid with gold or silver coin, it is completed and finalized absolutely. No vestige of the debt remains. The creditor-debtor relationship is dissolved. In order to establish people as permanent debtors, and thereby in perpetual legal incapacity and indentured servitude, it is essential to bar access to sovereignty, genuine law, title to substance, and freedom from indebtedness. This cannot occur if the money used for financial transactions in society is substantive, sound, not created by debt, and free of any compelled performance for using it. One can be ruled, exploited, and enslaved only if this free, sovereign situation, in parentheses gold and silver, is replaced with legal obligation to use debt notes belonging to one's creditors. One is then rendered a permanent debtor, barred from access to his lawful estate as a free sovereign being, and rendered obligated in perpetuity to the owner of the currency he uses in commercial transactions and the valuable consideration he tenders in contracts. It is clear that if someone buys things with property that does not belong to him and pledges FRNs as valuable consideration on contracts through which he benefits by receipt of goods, services, and specific performance, he has forfeited all right to claim true ownership and standing in law, in parentheses, real rights in substantive law. Such a person is contractually obligated to the owner of the currency that he uses to buy, sell, trade, and carry on his commercial/financial life. This situation was brought about in America through a series of organized steps that have occurred unceasingly since the founding of the country. In essence, every law, act, and action instituted by those who would conquer, subjugate, and rule nations and make the people thereof slaves to be permanently fleeced, plundered, and exploited, has been to bring about this very objective. The goal is to establish a new world order, securing complete conquest of the world. A few of the crucial milestones on this road to serfdom is: 1. The Civil War was fermented under the slavery issue in order to bring the U.S. under the control of the bankers. Since President Jackson vetoed the renewal of the charter of the Rothschild Second Bank of the United States in 1838, America had had no foreign-owned paper money central bank. This was an intolerable situation to the bankers, resulting in the Civil War under the pretext of slavery. The real reason for the war was to conquer both North and South, with the victor being Washington, D.C. Once having conquered the free and independent nation states via the Civil War, one then had merely to capture Washington, D.C. to tie up everything into one neat package. 2. To centralize power whereby ironclad rulership could be exercised by one man in a jurisdiction owned by the financial powers. All that was required was for the president, as commander-in-chief of the military, to be established in a legal position to rule everything via executive orders, in parentheses, fiat/dictatorship. If such is established in a jurisdiction of martial law rule, wherein all law is suspended due to the emergency, then all that is required is to own the office of president. A crucial aspect of this occurred on March 27, 1861, when 7 southern states walked out of Congress, leaving the entire legislative branch of government without a quorum. The Congress of the Constitution was dissolved for inability to disband or reconvene. Lincoln issued an executive order in April 1861, Reconvening Congress at gunpoint in executive emergency martial law rule jurisdiction. Since that time, there has been no de jure Congress, and everything has functioned under color of law through executive order under authority of the war powers, i.e., emergency, i.e., law of necessity. The law of necessity means no law whatsoever as per such maxims of law as necessity knows no law. In parentheses, the law forbidding killing is voided when done in self-defense. In time of war, laws are silent. Cicero. 3. To establish the underlying debt of the government to the bankers, to create corporate entities that are legally subject to the jurisdiction in which they exist, and to create the jurisdiction itself correctly. The so-called, in parentheses, fraudulent and unratified 14th Amendment was proclaimed as passed in 1868. This is a Sesta Trust, incorporation in a military, private, international, commercial, de facto jurisdiction created by and belonging to the money power, existing within the emergency of the war powers, and the only operational jurisdiction since the dissolution of Congress in 1861. Through the 14th Amendment, an artificial person, corporate entity, franchise entitled Citizen of the United States was born into private, corporate, limited liability. Section 4 of the 14th Amendment states, the validity of the public debt of the United States, in parentheses, to the bankers, shall not be questioned. 4. Within the above referenced private jurisdiction of the international bankers, the private and foreign-owned Congress formed a corporation, commercial agency, and government for the District of Columbia on February 21st, 1871, Chapter 62, 16, Statute 419. This corporation was recognized June 11th, 1878, Chapter 180, 20, Statute 102, and renamed United States Government. This corporation privately trademarked the names United States, U.S., 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 U.S.A, USA, and America. 5. In 1912, when the bonds that were floating the U.S. government, owned by the bankers, came due and the bankers refused to refinance the debt, the colorable martial law rule Congress was compelled to pass the Federal Reserve Act of 1913. This act surrendered, in parentheses, exclusively delegated, constitutional authority to create, control, and manage the entire money supply of the United States to a handful of private, mostly foreign bankers. This placed exclusive creation and control of the money within the private, commercial, foreign, and military jurisdiction of 1861 in corporate limited liability. 6. Through paying interest to the Federal Reserve Corporation in gold, the U.S. Treasury became progressively depleted of its gold. America's gold certificates, coin, and bullion were continually shipped off to the coffers of various European banks and power elite. In 1933, when the Treasury was drained and the debt was larger than ever, in parentheses, a financial condition known as insolvency, Roosevelt proclaimed the bankruptcy of the United States. Every 14th Amendment citizen of the United States was pledged as an asset to finance the Chapter 11 reorganization expenses and pay interest in perpetuity to the creditors, in parentheses, Federal Reserve bankers, on the national debt, in parentheses, which shall not be questioned. With the government's bankruptcy, law became public policy, i.e., Federal Reserve reinsurance policy, now operating exclusively within the jurisdiction of corporate limited liability insurance. The Federal Reserve switched its requirements 180 degrees and foreclosed the possibility to pay interest in gold, requiring payments on the debt and reorganization to be made in FRNs. Ownership of gold by the bankrupted, conquered citizens made into the enemy by the Amendatory Act of March 9, 1933, was made illegal, and the bankers set about confiscating as much of the private gold as possible that had not already been shipped to the European Federal Reserve banks as interest payments on the FRNs printed into circulation. After 1933, FRNs became increasingly unbacked until Nixon closed the silver window and removed the final vestige of backing in 1968. By being duped into functioning as a citizen of the United States, everyone was foreclosed from access to genuine law, substance, sovereignty, real law, and constitutional due process, confined to operating in law and commerce, the banker's private commercial, military, limited liability jurisdiction. American survival came to depend on acting as if they were citizens of the United States and inseparably united with and bound to their all capital letters name. This is the core of the con. It revolves around the meaning and significance of the words used and the processes involving them, especially the name. A few crucial facts concerning the name are: 1. In law, every word, letter, punctuation, and capitalization utilized in legal documents and proceedings has legal import and significance. Law means the rules revolving around the use of deadly force. The ultimate legal consequence of every word used in law is life and death. This fact imparts to law its unique importance. Law is not simply another academic pursuit, but a field bearing on one's very survival. In parentheses, hence this manual. 2. Your name is a flag, per the law of the flag, proclaiming your rights, standing in law, applicable law, and jurisdiction. When set forth in upper and lowercase letters, in accord with the established rules of English grammar, your name is called a true name. In law, such a name signifies the real you, the living flesh and blood, sentient being with free will and unbounded spiritual dimension, absolute in parentheses unalienable rights, full standing in law, and access to the substance and content of genuine law. When set forth in all capital letters, both law and English grammar mandate that such an assemblage of letters be considered something entirely different than your true name, and all the content that your true name signifies. Such deception now comprises the foundational legal device used to control not only America, but the population of the entire world. A memorandum of law on the name. Many people are involved in diligent research concerning the use of all capital letters for proper names, e.g., all capital letters ens legis, John Paul Jones, as a substitute for English common law spelling and pronunciation John Paul Jones in all court documents, driver's licenses, bank accounts, birth certificates, etc. Is the use of all capital letters to designate a name some special English grammar rule or style? Is it a contemporary American style of English? Is the use of this form of capitalization recognized by educational authorities? Is this an official, judicial, or U.S. government rule and / or style of grammar? Why do attorneys, court clerks, prosecutors, judges, banks, credit card companies, utility companies, etc. always use all capital letters when writing a proper name? What English grammar experts say. One of the foremost authorities on American English grammar, style, composition, and rules is the Chicago Manual of Style, the latest 14th edition, published by the University of Chicago Press, is internationally known and respected as a major contribution to maintaining and improving the standards of written or printed text. Since we can find no reference in their manual concerning the use of all capitalized letters, with a proper name or any other usage, we write to the editors and ask this question: is it acceptable, or is there any rule of English grammar to allow a proper name to be written in all capital letters? For example, if my name was, in common law English spelling and pronunciation, John Paul Jones, can it be written as all capital letters ens legis, John Paul Jones? Is there any rule covering this. The editorial staff of the University of Chicago answered, "Writing names in all caps is not conventional. It is not Chicago style to put anything in all caps. For instance, even if all capital letters Gone with the Wind appears on the title page all in caps, we would properly render it Gone with the Wind in a bibliography. The only reason we can think of to do so is if you are quoting some material where it is important to the narrative to preserve the casing of the letters. We're not sure in what context you would like your proper name to appear in all caps, but it is likely to be said as a bit odd. Law is precise. Every letter, capitalization, punctuation mark, etc. in a legal document is utilized for a specific reason and has legal, in parentheses, i.e., deadly force, consequences. If, for instance, one attempts to file articles of incorporation in the office of a Secretary of State, if the exact title of the corporation, down to every jot in title, is not exactly the same each and every time the corporation is referenced in the documents to be filed, the Secretary of State will refuse the filing. This is because each time the name of the corporation is referenced, it must be set forth identically in order to express the same legal entity. The tiniest difference in the name of the corporation identifies an entirely different legal person. It is therefore an eminently valid and possibly crucial question as to why governments, governmental courts, and agencies purporting to exist in parentheses in some undefined, unproved manner within the jurisdiction of this state always insist on capitalizing every letter in a proper name. Mary Newton Bruder, Ph.D., also known as the Grammar Lady, who established the Grammar Hotline in the late 1980s for the Coalition of Adult Literacy, was asked the following question. Why do federal and state government agencies and departments, judicial and administrative courts, insurance companies, etc., spell a person's proper name in all capital letters? For example, if my name is common law English spelling and pronunciation John Paul Jones, is it proper at any time to write my name as all capital letters Enslegius John Paul Jones? Dr. Bruder's reply was short and to the point. It must be some kind of internal style. There is no grammar rule about it. It seemed that these particular grammatical experts had no idea why proper names were written in all caps. So we began to assemble an extensive collection of reference books authored by various publishers, governments, and legal authorities to find the answer. What English grammar reference books say. Manual on Usage and Style. Manual on Usage and Style. One of the reference books we obtained was the Manual on Usage and Style, 8th edition, ISBN 1-8786744-51-X, published by the Texas Law Review in 1995. Section D, all capital letters, capitalization, paragraph D, 1, 1, states, quote, always capitalize proper nouns, block parentheses, proper nouns, independent of the context in which they are used. Refer to specific persons, places, or things, in parentheses, e.g., Dan Austin, Rolls-Royce, end quote. Paragraph D, 3, 2 of Section D states, quote, capitalize people, state, and any other terms used to refer to the government as a litigant, in parentheses, e.g., the people's case, the state's argument. But do not capitalize other words used to refer to litigants, in parentheses, e.g., the plaintiff, defendant Mason, end quote. Either no attorney, judge, or law clerk in Texas has ever read the recognized law style manual that purports to pertain to them, or the act as a deliberate violation of the rules for undisclosed reasons. In either ignorance, in parentheses, ignorance of the law is no excuse, or violation, in parentheses, one violating the law he enforces on others is acting under title of nobility and abrogating the principle of equality under the law. Of law, they continue to write plaintiff, defendant, in all capital letters, the state of Texas, and proper names of parties in all capital letters on every document. The elements of style. Another well-recognized reference book is The Elements of Style, 4th edition, ISBN 0-205-30902-X, written by William Strunk, Jr. and E.B. White, published by Allen and Bacon in 1999. Within this renowned English grammar and style reference book is found only one reference to capitalization, located within the glossary at, quote, proper noun, page 94, where it states, the name of a particular person, in parentheses, Frank Sinatra, place, in parentheses, Boston, or thing, in parentheses, Moby Dick. Proper nouns are capitalized. There's an obvious and legally evident difference between capitalizing the first letter of a proper name as compared to capitalizing every letter used to portray the name. The American Heritage Book of English Usage. The American Heritage Book of English Usage, a practical and authoritative guide to contemporary English, published in 1996 at Chapter 9, Email, Conventions and Quirks, Informality, states, quote, to give a message special emphasis, an emailer may write entirely in capital letters, a device emailers refer to as screaming. Some of these visual conventions have emerged as a way of getting around the constraints on data transmission that now limit many networks. End quote. Here is a reference source within contemporary modern English that states it is an informal manner to write every word of specifically an electronic message, aka email, in capital letters. They say it is screaming to do so. By standard definition, we presume that is the same as shouting or yelling. Are all judges, as well as their court clerks and attorneys, shouting at us when they corrupt our proper names in this manner? If so, what happened to the decorum of a court if everyone is yelling? Is the insurance company screaming at us, paying for the increased premium on our policy? This is doubtful as to any standard generalization, even though specific individual instances may indicate this to be true. It is safe to conclude, however, that it would also be informal to write a proper name in the same way. Does this also imply that those in the legal profession are writing our Christian names informally on court documents? Are not attorneys in the courts supposed to be specific, formally writing all legal documents to the letter of the law? If the law is at once both precise and not precise, what is its significance, credibility, and force and effect? New Oxford Dictionary of English. Oxford University Press publishes the New Oxford Dictionary of English, considered the foremost authority on the British English language. This dictionary is also designed to reflect the way language is used today through example sentences and phrases. We submit the following definitions from the 1998 edition. Proper noun, in parentheses, also proper name. Noun, a name used for an individual person, place, or organization, spelled with an initial capital letter, e.g., proper English common law spelling and pronunciation, Jane, London, and Oxfam. Quote, name, noun, 1. A word or set of words by which a person, animal, place, or thing is known, addressed, or referred to. My name is English Common Law Spelling and Pronunciation, Parsons, John Parsons. Kalkwasser is the German name for lime water. Verb 3. Identify by name. Give the correct name for the dead man has been named as John McIntosh. Phrases 2. In the name of. Bearing or using the name of a specified person or organization. A driving license in the name of William Sanders. Newberry House Dictionary of American English. From the Newberry House Dictionary of American English, published by Monroe Allen Publishers, Incorporated, 1999. Name. A word by which a person, place, or thing is known. Her name is, in common law English spelling and pronunciation, Diane Daniel. We can find absolutely no example in any recognized reference book that specifies or allows the use of all capitalized names, proper or common. There is no doubt that a proper name, to be grammatically correct, must be written with only the first letter capitalized, with the remainder of the word in a name spelled with lowercase letters. U.S. Government Style Manual. Is the spelling and usage of a proper name defined officially by the U.S. government? Yes. The United States Government Printing Office in their Style Manual, March 1984 edition, in parentheses, the most recent edition published as of March 2000, provides comprehensive grammar, style, and usage for all government publications, including court and legal writing. Chapter 3. Capitalization at Statute 3.2 prescribes rules for proper names. Quote, proper names are capitalized. In box parentheses, examples given are Rome, Brussels, John Macadam, Macadam family, Italy, Anglo-Saxon. At Chapter 17, Court Work, the rules of capitalization, as mentioned in Chapter 3, are further reiterated. 17.1. Court work differs in style from other work only as set forth in this section. Otherwise, the style prescribed in the preceding sections will be followed. After reading Statute 17 in entirety, we found no other references that would change the grammatical rules and styles specified in Chapter 3 pertaining to capitalization. At Statute 17.9, this same official U.S. government manual states, quote, in the titles of cases, the first letter of all principal words are capitalized, but not such terms as defendant and appellee. This wholly agrees with Texas Law Review's Manual on Usage and Style as referenced above. Examples shown in Statute 17.12 are also consistent with the aforementioned Statute 17.9 specification, that is, all proper names are to be spelled with capital first letters, the balance of each spelled with lowercase letters. Grammar, punctuation, and capitalization. The National Aeronautics and Space Administration, in parentheses, NASA, has published one of the most concise U.S. government resources on capitalization. NASA, publication SP-7084, Grammar, Punctuation, and Capitalization, a handbook for technical writers and editors, was compiled and written by the NASA Langley Research Center in Hampton, Virginia. At Chapter 4, Capitalization, they state in 4.1, Introduction, quote, first we should define terms used when discussing capitalization. Bullet point 1. All caps means that every letter in an expression is capital, in all capital letters like this. Bullet point 2. Caps in LC means that the principal words of an expression are capitalized, like this. Bullet point 3. Caps and small caps refer to a particular font of type containing small capital letters instead of lowercase letters. Quote, elements in a document such as headings, titles, and captions may be capitalized in either sentence style or headline style. Bullet point 4. Sentence style calls for capitalization of the first letter and proper nouns, of course. Bullet point 5. Headline style calls for capitalization of all principal words, in parentheses, also called caps and LC. Quote, modern publishers tend toward a down style of capitalization, that is, toward use of fewer capitals rather than an up style. Here we see that in headlines, titles, captions, and in sentences, there is no authorized usage of all caps. At 4.4.1, capitalization with acronyms, we find the first authoritative use for all caps. Quote, acronyms are always formed with all capital letters. Acronyms are often coined for a particular program or study and therefore require definition. The letters of the acronym are not capitalized in the definition unless the acronym stands for a proper noun. Quote, wrong. The best electronic publishing systems combined, what you see is what you get. Quote, in parentheses, WYSIWYG, features. Correct. The best electronic publishing system combined of what you see is what you get. In parentheses, WYSIWYG, features. But Langley is involved with the National Aerospaceplane, in parentheses, NASA program. This cites, by example, that using all caps is allowable in an acronym. Acronyms are words formed from the initial letters of successive parts of a term. They never contain periods and are often not standard, so that definition is required. Could this apply to lawful proper Christian names? If that were true, then all capital letters Enslegius John Smith would have to follow a definition of some sort, which it does not. For example, only if all capital letters Enslegius John Smith were defined as common law English spelling and pronunciation John orally holistic nutrition of the Smith Medical Institute to holistics, in parentheses, all capital letters Enslegius John Smith, would this apply? The most significant section appears at 4.5, Administrative Names. Official designations of political divisions and of other organized bodies are capitalized. Bullet point 1, Names of political divisions. Bullet point 2, Canada, New York State. Bullet point 3, United States Northwest Territories. Bullet point 4, Virgin Islands, Ontario Province. Bullet point 5, Names of governmental units, U.S. Government Executive Department, U.S. Congress, U.S. Army. And bullet point 6, U.S. Navy. According to this official U.S. government publication, the states are never to be spelled in all caps, such as, all capital letters, quote, New York State. The proper English grammar and legal style is Common Law English Spelling and Pronunciation, New York State. This agrees once again with Texas Law Review's Manual on Usage and Style. Legal fiction doctrine allows the courts to presume/assume anything. The Real-Life Dictionary of the Law. The authors of the Real-Life Dictionary of the Law, Gerald and Kathleen Hill, are accomplished scholars and writers. Gerald Hill is an experienced attorney, judge, and law instructor. Here is how the term legal fiction is described. Legal fiction. Noun. A presumption of fact assumed by a court for convenience, consistency, or to achieve justice. There is an old adage, fictions arise from the law, and not law from fictions. Oren's Dictionary of the Law. From Oren's Dictionary of the Law, published by the West Group 1999, within the definition of fiction is found that of legal fiction. A legal fiction is an assumption that something that is, in parentheses, or may be, false or non-existent is true or real. Legal fictions are assumed or invented to help do justice. For example, bringing to lawsuit to throw a non-existent common law spelling and pronunciation, John Doe, off your property used to be the only way to establish a clear right to the property when legal title was uncertain. Merriam-Webster's Dictionary of the Law. Merriam-Webster's Dictionary of Law. Merriam-Webster's Dictionary of Law, 1996 states, legal fiction, something assumed in law to be fact, irrespective of the truth or accuracy of that assumption. Example, the legal fiction that a day has no fractions. Fields v. Fairbanks, North Star Borough, 818, page 2D, 658, in parentheses, 1991. This is the reason behind the use of all caps when writing a proper name. The U.S. and state governments are deliberately using a legal fiction to address the lawful, real flesh and blood man or woman. We say this is deliberate because their own official publications state that proper names are not to be written in all caps. They are deliberately not adhering to their own recognized authorities. In the same respect, by identifying their own government entity in all caps, they are legally assuming / presuming it to be so. As stated by Dr. Mary Newton Bruder in the beginning of this report, the use of all caps for writing a proper name is an internal style for what is apparently a predetermined usage and, at this point, unknown jurisdiction. The main key to a legal fiction is assumption, as noted in each definition above. Conclusion. There are no official or unofficial English grammar style manuals or reference publications that recognize the use of all caps when writing a proper name. To do so is by juristic license of arbitrary presumption or assumption, irrespective of the facts pertaining. Arbitrary right of assumption is a self-serving fiction of the law. An important issue concerning this entire matter is whether or not a proper name written in all caps can be substituted for a lawful Christian name or any proper name, such as, all capital letters, State of Florida, for, in common law English spelling and pronunciation, State of Florida. Is the assertion of all capital letters names legal? If so, from where does this practice originate and what enforces it? Legal fiction may be employed when the name of a person is not known by using the fictitious name, common law English spelling and pronunciation, John Doe. This is understood by all and needs little explanation. If there is no way to identify someone, common law English spelling and pronunciation, John Doe, or common law spelling and pronunciation, Jane Doe, is presumed or assumed to identify the unknown party until the proper name can be discovered. In all cases, a legal fiction is an assumption of purported fact without having shown the fact to be true or valid. Legal fictions can be applied to many different situations. Conversion of a true name to an all caps version is one of them. It is an acceptance with no proof. Simply to assume is to pretend. Oren's Dictionary of the Law says that the word assume means 1. To take up or take responsibility for, to receive, to undertake. See assumption. 2. To pretend. 3. To accept without proof. These same basic definitions are used by nearly all of the modern law dictionaries. It should be noted that there is a difference between the meanings of the second and third definitions with that of the first. Pretending and accepting without proof are of the same understanding and meaning. However, to take responsibility for and receive, i.e., assumption, does not carry the same meaning. Oren's defines assumption as, quote, formally transforming someone else's debt into your own debt. Compare with guarantee. The assumption of a mortgage usually involves taking over the seller's mortgage debt when buying a property, in parentheses, often a house. End quote. Now, what happens if all the meanings for the word assume are combined? In a literal and definitive sense, the meaning of assume would be the pretended acceptance without proof that someone has taken responsibility for, has guaranteed, or has received a debt. Therefore, if we apply all this in defining all caps usage, such artifice is an assumption or pretension that the juristic person / legal entity named has received and is responsible for a debt of some sort. Use of the name all capital letters ens legis John P. Jones in place of the proper name, proper English common law spelling and pronunciation John Paul Jones, implies an assumed debt guarantee without any offer of proof. The danger behind this is that if such an unproven assumption is made, unless the assumption is proven wrong, it is considered valid. Please go no further until you understand and comprehend exactly what the above paragraphs have stated. If necessary, reread the above until you have a full understanding of what is involved in the meaning of a name spelled in all capital letters. An assumed debt is valid unless proven otherwise, in parentheses, an unrebutted affidavit, claim, or charge stands as the truth in commerce. This is in accord with the Uniform Commercial Code, valid in every state and made a part of the statutes of each state. A name written in all caps, resembling a proper name but grammatically not a proper name, is being held as a debtor for an assumed debt. Did you incur that debt? If so, how and when? Where is the contract of indebtedness you signed and the proof of default thereon? What happens if the proper name, i.e., common law English spelling and pronunciation John Paul Jones, answers for or assumes the fabricated name, i.e., all capital letters ens legis, John P. Jones? The two become one and the same. This is the crux for the use of the all caps name by the U.S. government and the states. It is the way that they can bring someone into the de facto venue and jurisdiction that they have created. By implication of definition, this also is for the purpose of some manner of assumed debt. Why won't they use common law spelling and pronunciation, the state of Texas, or English common law spelling and pronunciation John Doe in their courts or on driver's licenses? What stops them from doing this? Obviously, there is a reason for using all caps names, since they are very capable of writing proper names, just as their own official style manual states. The reason behind this practice is found within the definitions as cited above. At this point, this should be very clear to every reader. The legalities of all capital letters names. We could go on for hundreds of pages citing the legal basis behind the creation of the use of all capital letters names. In a nutshell, fabricated legal persons such as all capital letters ens legis, state of Texas, can be used to fabricate additional legal persons. Bastard legal persons originate from any judicial / government actor that wishes to create them, regardless of whether he / she / it is empowered by law to do so or not. However, a law can never originate from a fictional foundation that doesn't exist. The generic and original U.S. Constitution was validated by treaty between individual nation-states, in parentheses, all of which are artificial, corporate entities, since they exist in abstract idea and construct. Contained within it is the required due process of law for all the participating nation-states of that treaty. Representatives of the people in each nation-state agreed upon and signed it. The federal government is not only created by it, but it is also bound to operate within the guidelines of constitutional due process. Any purported law that does not originate from constitutional due process is a fictional law without validity. Thus, the true test of any American law is its basis of due process according to the generic U.S. Constitution? Was it created according to the lawful process or outside of lawful process? Executive orders and directives. For years, we have researched the lawful basis for creating all caps juristic persons and have concluded that there is no such foundation according to valid laws and due process. But what about those purported laws that are not valid and have not originated from constitutional due process? There's a very simple answer to the creation of such purported laws that are really not laws at all. Executive orders and directives. They are color of law, without being valid laws of due process. These executive orders and directives have the appearance of law and look as if they are laws, but according to due process, they are not laws. Rather, they are laws based on fictional beginnings and are the inherently defective basis for additional fictional laws. They are regulated and promulgated by administrative code, rules and procedures, not due process. Currently, executive orders are enforced through the charade known as the Federal Administrative Procedures Act. Each state has also adopted the same fatally flawed administrative laws. Lincoln establishes executive orders. 85 years after the independence of the United States, 7 southern nation states of America walked out of the second session of the 36th Congress on March 27, 1861. In so doing, the constitutional due process quorum necessary for Congress to vote was lost, and Congress was adjourned, sine die, or without day. This meant that there was no lawful quorum to set a specific day and time to reconvene which, according to Robert's Rule of Order, dissolved Congress. This dissolution automatically took place because there were no provisions within the Constitution allowing the passage of any congressional vote without a quorum of the states. Lincoln's second executive order of April 1861 called Congress back into session days later, but not under the lawful authority or lawful due process of the Constitution. Solely in his capacity as Commander-in-Chief of the U.S. military, Lincoln called Congress into session under authority of martial law. Since April of 1861, Congress has not met based on lawful due process. The current Congress is a legal fiction Congress based on nothing more holy than, so what? What are you going to do about it? Legal fiction laws, such as the Reconstruction Acts and the Lieber Code, were instituted by Lincoln soon thereafter and became the basis for the current laws in the U.S. thereby. Every purported act in effect today is based on colorable fictitious entities created arbitrarily and without verification, lawful foundation, or lawful due process, all originating from and existing in military, martial law jurisdiction. Military martial law jurisdiction equals jurisdiction of war, equals win/lose interactions consisting of eating or being eaten, living or dying, equals food chain, equals law of necessity, equals suspension of all law other than complete freedom to act in any manner to eat, kill, or destroy, or avoid being eaten, killed, or destroyed, equals no law, equals lawlessness, equals complete absence of all lawful basis to create any valid law. Contractually, being a victim of those acting on the alleged authority granted by the law of necessity equals no lawful object, valuable consideration, free consent of all involved parties, absence of fraud, duress, malice, and undue influence, equals no bona fide, enforceable contract, equals no valid enforceable nexus, equals absolute right to engage in any action of any kind in self-defense equals complete and total right to disregard any alleged jurisdiction and demands from self-admitted outlaws committing naked criminal aggression without any credibility, and right to demand allegiance and compliance from anyone. Every president of the United States since Lincoln has functioned by executive orders issued from a military, martial law jurisdiction, with the only law being the law of necessity, i.e., the war powers. The war powers are nothing new. Indeed, they have been operational from the instant the first man thought he would hide from God, try to cheat ethical and natural law by overreaching, invade the space and territory of others, covet other people's land or property, steal the fruits of their labors, and attempt to succeed in life by win/lose games. All existing authority in the United States today derives exclusively from the war powers. Truman's reaffirmation of operational authority under the war powers begins. All capital letters, quote, "Now therefore I, Harry S. Truman, President of the United States of America, acting under and by virtue of the authority vested in me by Section 5, subsection B, of the Trading with the Enemy Act of October 6, 1917, 40, Statute 415, as amended, in parentheses, Section 5, subsection B of Appendix to Title 50, and Section 4 of the Act of March 9, 1933, 48 Statute 2. SIC transits right, substance, truth, justice, peace, and freedom in America, the land of the free and the home of the brave." The abolition of the English and American common law. Here's an interesting quote from the 1973 session of the U.S. Supreme Court. "The American law in this country, the law in effect in all but a few states until mid-19th century, was the pre-existing English common law. It was not until after the war between the states that legislation began generally to replace the common law." Roe v. Wade, 410 U.S. 113. In effect, Lincoln's second executive order abolished the recognized English common law in America and replaced it with laws based on a fictional legal foundation, i.e., executive orders and directives executed under authority of the war powers. Most states still have a reference to the common laws within their present-day statutes. For example, in the Florida statutes, in parentheses 1999, Title I, Chapter 2 at Statute 2.01, Common Law and certain statutes declared in force, it states, "The common and statute laws of England, which are of a general and not a local nature, with the exception hereinafter mentioned, down to the 4th day of July, 1776, are declared to be of force in this state, provided the said statutes and common law be not inconsistent with the Constitution and laws of the United States and the acts of the legislature of the state." History. S. 1 November 6, 1829, R.S. 59, G.S. 59, R.G.S. 71, C.G.L. 87. Note that the basis of the common law is an approved act of the people of Florida by resolution on November 6, 1829, prior to Lincoln's Civil War. Also note that the subsequent laws, as a result of acts of the Florida legislature and the United States, now take priority over the common law in Florida. In April 1861, the American and English common law was abolished and replaced with legal fiction law, aka statutes, rules, and codes based on executive order and not the due process specified within the organic constitution, existing and functioning under the law of necessity, ab initio. They are all non-law and cannot validly assert jurisdiction, authority, or demand for compliance from anyone. They are entirely rules of rulership, i.e., organized piracy, privilege, plunder, and enslavement, invented and enforced by those who would rule over others by legalized violence in the complete absence of moral authority, adequate knowledge, and natural law mechanics to accomplish any results other than disruption, conflict, damage, and devastation. Applying it all to current laws. Title 3, Pleadings and Motions. Rule 9, Section 8, Capacity. Federal Rules of Civil Procedures states, in part, quote, when an issue is raised as to the legal existence of a named party, or the party's capacity to be sued, or the authority of a party to be sued, the party desiring to raise the issue shall do so by specific negative averment, which shall include supporting particulars. End quote. At this juncture, it is clear that the existence of a name written in all caps is a necessity-created entity. This is surely an issue to be raised, and the supporting particulars are outlined within this article. Use of the proper name must be insisted upon as a matter of abatement, correction, for all parties of an action of purported law. However, the current courts cannot correct this, since they are all based on presumed / assumed in parentheses fictional law, and must use artificial juristic names. Instead, they expect the lawful Christian man or woman to accept the all caps name and agree by silence to be treated as if he or she were a fictional entity invented and governed by mortal enemies. They must go to unlimited lengths to deceive and coerce this compliance, or the underlying criminal farce would be exposed, and a worldwide plunder / enslavement racket that has held all of life on this planet in a vice grip for millennia would crumble and liberate every living thing. At this point, they would be required to succeed in life by honest, productive labors, the way those upon whom they parasitically feed off are forced to conduct their lives. Oklahoma statutes. Since the entire game functions on the basis of people's failure to properly rebut a rebuttal presumption, the issue then becomes how to properly rebut their presumption that you are knowingly, intentionally, and voluntarily agreeing to be treated as if you were the all caps name. One angle of approach is found in the requirement for proper names to be identified in any legal dispute. This includes a mandate to correct the legal paperwork involved when proper names are provided. In regard to criminal prosecution, this is clearly set forth in the Oklahoma Statutes, Chapter 22, Statute 403. Quote, when a defendant is indicted or prosecuted by a fictitious or erroneous name, and in any stage of the proceedings his true name is discovered, it must be inserted in the subsequent proceedings, referring to the fact of his being charged by the name mentioned in the indictment or information. American jurisprudence. In general, it is essential to identify parties to court actions properly. If the alleged parties to an action are not precisely identified, then who is involved with whom or what and how? If not properly identified, all corresponding judgments are void, as outlined in Volume 46, American Jurisprudence 2D at Judgments. Quote, Statute 100, Parties. A judgment should identify the parties for and against whom it is rendered, with such certainty that it may be readily enforced, and a judgment which does not do so may be regarded as void for uncertainty. Such identification may be achieved by naming the persons for and against whom the judgment is rendered. Technical difficulties in the naming of the persons for and against whom judgment is rendered can be corrected if the parties are not prejudiced. A reference in a judgment to a party plainly liable, followed by an omission of that party's name from the language of the decree, at least gives rise to an ambiguity and calling for an inquiry into the court's real intention as reflected in the entire record and surrounding circumstances. The current scene in America. Quote, legal person. One of the terms used predominantly by the present civil governments and courts in America is legal person. Just what is a legal person? Some definitions are: A. Legal person, a body of persons or an entity in parentheses as a corporation, considered as having many of the rights and responsibilities of a natural person, and especially the capacity to sue and be sued. Merriam-Webster's Dictionary of Law, 1996. Person. 1. A human being, in parentheses, a natural person. 2. A corporation, in parentheses, an artificial person. Corporations are treated as persons in many legal situations. Also, the word person includes corporations in most definitions in this dictionary. 3. Any other being entitled to sue as a legal entity, in parentheses, a government, an association, a group of trustees, etc. 4. The plural of person is persons, not people, in parentheses, see that word. Oren's Dictionary of the Law, West Group, 1999. Person. An entity with legal rights in existence, including the ability to sue and be sued, to sign contracts, to receive gifts, to appear in court either by themselves or by lawyer, and, generally, other powers incidental to the full expression of the entity in law. Individuals are persons in law unless they are minors or under some kind of other incapacity, such as a court finding of mental incapacity. Many laws give certain powers to persons, which, in almost all instances, includes business organizations that have been formally registered, such as partnerships, corporations, or associations. Duhame's Law Dictionary. Person. Noun. Person. In block parentheses, Latin persona. Said to be compounded of per, through or by, and sonus, sound, a Latin word signifying primarily a mask used by actors on the stage. End block parentheses. Webster's 1828 Dictionary. A corporation incorporated under de jure law, i.e., by bona fide express contract between real beings capable of contracting, in parentheses, a phenomenon that went extinct almost 70 years ago, is a legal fact, using the self-styled juristic artifice, in parentheses, legal fiction, of right to presume, irrespective of the law or the facts, implied contracts, constructive trusts, and other entirely different entities can be created using the name of the bona fide, legally and grammatically correct name of the corporation by corrupting that name into an all capital letters format, or by abbreviating names in parentheses within the complete proper name. The corporation exists in law, but has arbitrarily been assigned a different name. No such corporation nor any valid law can be created under the law of necessity, i.e., under no law. Likewise, the arbitrary use of the legal fiction artifice of right of presumption, in parentheses, over unwary, uninformed, and usually blindly trusting people, can be legitimately exercised under no law. Maxims of law describing necessity include: bullet point 1. Necessity has no law. Plowed, period, 18, comma, and 15, VIN, period, ABR period 534 semicolon 22 ID period 540 period. Bullet point 2. In time of war, laws are silent. Cicerio. Non-existent law equals no lawful basis upon which anything can be created, be made to transpire, or upon which allegiance and obedience can be legitimately demanded. Acting under the law of necessity, i.e., lawlessness, allows complete and total right of everyone to disregard any and all alleged assertions of any lawful, verifiable, and legitimate jurisdiction over anything or anyone. Anyone acting against anyone under such non-law is self-confessing to be a naked criminal aggressor, and a con man who has forfeited all credibility and right to demand allegiance, obedience, or compliance with any jurisdiction he might assert. If you, as a real being, are in real law, and it is impossible for an attorney or judge to recognize or access it, you are not subject to their jurisdiction, and cannot be made subject to their jurisdiction by them. The crucial issue is then how to notice them of your position and standing so that they leave you alone. As mentioned above, an artificial person corporation created under de jure law, with the person's identifying name appearing as prescribed by law and in accordance with the rules of English grammar, is a legal fact. A corrupted alter ego version of that name manufactured under the legal fiction of right of presumption will have credibility only so long as the presumption remains unchallenged. The rule of the world is that anything and everything skates unless you bust it. Legal or lawful. It is crucial to define the difference between legal and lawful. The generic Constitution references genuine law. The present civil authorities and their courts use the word legal. Is there a difference in the meaning? The following is quoted from a Dictionary of Law, 1893. Quote, lawful, in accordance with the law of the land, according to the law, permitted, sanctioned, or justified by law. Lawful properly implies a thing conformable to or enjoined by law. Legal, a thing in the form or after the manner of law or binding by law, a writ or warrant issuing from any court under color of law is a legal process, however defective. See legal. Legal. Latin, legalis. Pertaining to the understanding, the exposition, the administration, the science, and the practice of law, as the legal profession, legal advice, legal blanks, newspaper, implied or imputed in law, opposed to actual, legal, looks more to the letter, form, / appearance, and lawful to the spirit, substance, / content, of the law. Legal is more appropriate for conformity to positive rules of law. Lawful, for accord with ethical principle. Legal imports rather that the forms, appearances, of law are observed, that the proceeding is correct in method, that rules prescribed have been obeyed. Lawful, that the right is actful in substance, that moral quality is secured. Legal is the antithesis of equitable and the equivalent of constructive. 2 Abbott's Law Dictionary 24. Legal matters administrate, conform to, and follow rules. They are equitable in nature and are implied, presumed, rather than actual, express. A legal process can be defective in law. This accords with the previous discussions of legal fictions and color of law. To be legal, a matter does not follow the law. Instead, it conforms to and follows the rules or form of law. This may help you to understand why the federal and state rules of civil and criminal procedure are cited in every court petition so as to conform to legal requirements of the specific juristic persons named, e.g., all capital letters, State of Georgia, or all capital letters, U.S. Federal Government, that rule the courts. Lawful matters are ethically enjoined in the law of the land, the law of the people, and are actual in nature, not implied. This is why whatever true law was upheld by the generic constitution has no bearing or authority in the present-day legal courts. It is impossible for anyone in authority today to access or even take cognizance of true law, since authority is the law of necessity. 12 U.S.C. 95. Therefore, it would appear that the meaning of the word legal is color of law, a term which Black's Law Dictionary, 5th edition, page 241, defines as color of law, the appearance or semblance without the substance of legal right, misuse of power possessed by virtue of state law and made possible only because wrongdoer is clothed with authority of state, is action taken under color of law. Executive orders rule the land. The current situation is that legalism has usurped and engulfed the law. The administration of legal rules, codes, and statutes now prevail instead of actual law. This takes place on a federal as well as state level. Government administrates what it has created through its own purported laws, which are not lawful but merely legal. They are arbitrary constructs existing only in law and are based on fictitiously created authority, i.e., no authority, and are authorized and enforced by legal executive orders. Executive orders are not lawful and never have been. As you read the following, be aware of the words code and administration. Looking at the United States Census 2000 reveals that the legal authority for this census comes from Office of Management and Budget, in parentheses, OMB, approval number 0607-0856. The OMB is a part of the Executive Office of the President of the United States. The U.S. Census Bureau is responsible for implementing the National Census, which is a division of the Economics and Statistics Administration of the U.S. Department of Commerce, in parentheses, USDOC. The USDOC is a department of the executive branch. Obviously, Census 2000 is authorized, carried out, controlled, enforced, and implemented by the President, aka the executive branch of the federal government, functioning as it has been since 1861 in the lawless realm of necessity, in parentheses, which is now even more degenerate than when it commenced under Lincoln. In fact, the executive office of the president controls the entire nation through various departments and agencies effecting justice, communications, health, energy, transportation, education, defense, treasury, labor, agriculture, mails, and much more, through a myriad of executive orders, proclamations, policies, and decisions. Every U.S. president since Lincoln has claimed his authority for these executive orders on Article 2, Section 2 of the U.S. Constitution. Quote, "The President shall be Commander-in-Chief of the Army and Navy of the United States, and of the militia of the several states. When called into the actual service of the United States, he shall have power, by and which the advice and consent of the Senate, to make treaties, provided 2/3 of the senators present concur, and he shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers, and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may, by law, vest the appointment of such inferior officers as they think proper, and the President alone, in the courts of law, or in the heads of departments." End quote. In reality, the Congress is completely bypassed. Since the Senate was convened in April 1861 by Presidential Executive Order No. 2, not by lawful constitutional due process, there is no United States Congress. The current Senate is, like everything, colorable, in parentheses, color of Senate, under the direct authority of the executive office of the President. The President legally needs neither the consent nor a vote from the Senate, simply because the Senate's legal authority to meet exists only by executive order. Ambassadors, public ministers, consuls, federal judges, and all officers are of the, all capital letters ens legis, United States, are appointed by and under authority of the executive office of the President. The Federal Register is an executive functionary. The first official act of every incoming president is to reaffirm the war powers. He must do so, or he is devoid of power to function in office. The war powers are set forth in the Trading with the Enemy Act of October 6, 1917, and the Amendatory Act of March 9, 1933, in parentheses, the Banking Relief Act. In the Amendatory Act, every citizen of the United States was made an enemy of the government, i.e., the Federal Reserve /IMF, ETAL, creditors in bankruptcy who have conquered the country by their great paper money banking swindle. For the past 65 years, every presidential executive order has become purported law simply by its publication in the Federal Register, which is operated by the Office of the Federal Register, in parentheses, OFR. In 1935, the OFR was established by the Federal Register Act. The purported authority for the OFR is found within the United States Code, Title 44 at Chapter 15, Statute 1500-06, Administrative Committee of the Federal Register, established in composition, powers, and duties. The Administrative Committee of the Federal Register shall consist of the Archivist of the United States or acting archivist, who shall be chairman and officer of the Department of Justice, designated by the Attorney General, and the public printer or acting public printer. The Director of the Federal Register shall act as Secretary of the Committee. The Committee shall prescribe, with the approval of the President, regulations for carrying out this chapter. Notice that the entire Administrative Committee of the Federal Register is comprised of officers of the federal government. Who appoints all federal officers? The President does. This act also gives the President the authority to decree all the regulations to carry out the act. By this monopoly, the executive establishes, controls, regulates, and enforces the federal government without need for any approval from the Senate. How could anyone possibly call this lawful? In 1917, President Woodrow Wilson couldn't persuade Congress to agree with his desire to arm United States vessels accessing hostile German waters before the United States entered World War I. So, Wilson simply invoked the policy through a presidential executive order. President Franklin D. Roosevelt issued Executive Order No. 9066 in December 1941, forcing 100,000 Americans of Japanese descent to be rounded up and placed in concentration camps while all their property was confiscated. Is it any wonder that the Congress, the President, legally controls, did not impeach President William Jefferson Clinton when the evidence for impeachment was overwhelming. On that note, why is it that the attorney presidents have used executive orders the most? Who but an attorney would know and understand legal rules the best? Sadly, they enforce what's legal and ignore what's lawful. In fact, they have no access to what is lawful, since the entirety of their authority, which is ethically and essentially specious, derives from the war powers. How debt is assumed by persons with all caps names. We now refer back to the matter of assumption, as already discussed, with its relationship to arbitrarily created juristic persons, e.g., all capital letters, State of California, all capital letters and legis, John P. Jones. Since an assumption, by definition, implies debt, what debt is assumed by the newly created artificial person? Now that we have explored the legal executive basis of the current federal and state governments, it is time to put all this together. The government use of all caps in place of proper names is absolutely no mistake. It signifies an internal, in parentheses legal, rule and authority. Its foundation is pure artifice, and the results have compounded into more deceit and the form of created, promulgated, instituted, administrated, and enforced rules, codes, statutes, and policy, i.e., the laws that appear to be but are not, never were, and never can be. Qui sentit, commandum, sentire debet et onus. He who enjoys the benefit ought also to bear the burden. He who enjoys the advantage of a right takes the accompanying disadvantage. A privilege is subject to its condition or conditions. Bouvier's Maxims of Law, 1856. The birth certificate. Since the early 1960s, state governments themselves specially created juristic corporate persons, signified by all caps names, have issued birth certificates to persons with all caps names. This is not a lawful record of your physical birth, but rather the birth of the juristic all caps name. It may appear to be your true name, but since no proper name is ever written in all caps, in parentheses either lawfully or grammatically, it does not identify who you are. The birth certificate is the government's self-created document of title for its new property, i.e., the deed to the juristic name. Artificial person whose all caps name mirrors your true name. The birth certificate brings the new all capital letters vessel into colorable Admiralty / maritime law, the same way a ship is birthed. One important area to address before going any further is the governmental use of older data storage from the late 1950s until the early 1980s. As a leftover from various teletype-oriented systems, many government data storage methods used all caps for proper names. The IRS was supposedly still complaining about some of their antiquated storage systems as recent as the early 1980s. At first, this may have been a necessity of the technology at the time, not a deliberate act. Perhaps when this technology was first being used and implemented into the mainstream of communications, some legal experts saw it as a perfect tool for their perfidious intentions. What better excuse could there be? However, since local, state, and federal offices primarily used typewriters during the same time period, and birth certificates and other important documents, such as driver's licenses, were produced with typewriters, it's very doubtful that this poses much of an excuse to explain all caps usage for proper names. The only reasonable usage of the older data bank all caps storage systems would have been for addressing envelopes or certain forms in bulk, including payment checks, which the governments did frequently. Automated computer systems with daisy wheel and pin printers used prevalently in the early 1980s emulated the IBM electric typewriter Courier or Helvetica fonts in both upper and lowercase letters. Shortly thereafter, the introduction of laser and inkjet printers with multiple fonts became the standard. Ray, the past 15 years, there can be no excuse that government computers will not accommodate the use of lowercase letters unless the older data is still stored in its original form, i.e., all caps, and has not been translated due to the cost of re-entry. But this does not excuse the entry of new data, only legacy data. In fact, on many government forms today, proper names are in all caps, while other areas of the same computer-produced document are in both upper and lower case. One can only conclude that now, more than ever, the use of all caps in substitution for the writing of a proper name is no mistake. When a baby is born, the hospital sends the original, not a copy, of the record of live birth to the State Bureau of Vital Statistics, sometimes called the Department of Health and Rehabilitative Services, in parentheses, HRS. Each state is required to supply the United States with birth, death, and health statistics. The state agency that receives the original record of live birth keeps it and then issues a birth certificate in the corrupted all caps version of the child's true name, e.g., all capital letters ends legis, James Wilbur Smith. Quote, certificate, noun, Middle English, certificat, from Middle French, from medieval Latin, certificatum, from late Latin, neuter of certificatus, past participle of certificare, to certify, 15th century, 3. A document evidencing ownership or debt. Merriam-Webster Dictionary, 1998. The birth certificate issued by the state is then registered with the U.S. Department of Commerce, the executive office, specifically through their own sub-agency, the U.S. Census Bureau, which is responsible to register vital statistics from all the states. The word registered, as it is used within commercial or legal-based equity law, does not mean that the all-caps name was merely noted in a book for reference purposes. When a certificate is registered with the U.S. Department of Commerce, it means that the all-caps legal person named thereon has become a surety or guarantor, a condition and obligation that is automatically and unwittingly assumed unless the presumption is effectively rebutted, i.e., notice to the effect of, it ain't me. Security, bond, security, I.A., something, in parentheses, as a mortgage or collateral, that is provided to make certain the fulfillment of an obligation. Example, used his property as security for a loan. L.B. surety. 2. Evidence of indebtedness, ownership, or the right to ownership. IBID, bond. A usually formal written agreement by which a person undertakes to perform a certain act, in parentheses, as fulfill the obligation of a contract, with the condition that failure to perform or abstain will obligate the person to pay a sum of money or will result in the forfeiture of money put up by the person for surety. One who acts as a surety. An interest-bearing document giving evidence of a debt issued by a government body or corporation that is sometimes secured by a lien on property and is often designed to take care of a particular financial need. Merriam-Webster Dictionary of Law, 1996. Surety. The person who has pledged him or herself to pay back money or perform a certain action if the principal to a contract fails, as collateral and as part of the original contract. Duhame's Law Dictionary. 1. A formal engagement, in parentheses, as a pledge, given for the fulfillment of an undertaking. 2. One who promises to answer for the debt or default of another. Under the Uniform Commercial Code, however, a surety includes a guarantor, and the two terms are generally interchangeable. Merriam-Webster's Dictionary of Law, 1996. Guarantor, a person who pledges collateral for the contract of another, but separately as part of an independent contract with the obligee of the original contract. Duhame's Law Dictionary. It is not difficult to see that a state-created birth certificate with an all-caps name is a document evidencing debt the moment it is issued. Once a state has registered a birth document with the U.S. Department of Commerce, the department notifies the Treasury Department, who takes out a loan from the Federal Reserve. The Treasury uses the loan to purchase a bond. In parentheses, the Fed holds a purchase money security interest in the bond from the Department of Commerce, who invests the sale proceeds in the stock or bond market. The Treasury Department then issues Treasury securities in the form of Treasury bonds, notes, and bills using the bonds as surety for the new securities. This cycle is based on the future tax revenues of the legal person whose name appears on the birth certificate. This also means that the bankrupt corporate U.S. can guarantee to the purchasers of their securities the lifetime labor and tax revenue of every citizen of the United States / American with a birth certificate as collateral for payment. This device is initiated simply by converting the lawful, true name of the newborn into a legal juristic name of a person. Dubaque rea patricinia pars principium est. The principal part of everything is in the beginning. In parentheses, well begun is half done. Legally, you are considered a slave or indentured servant to the various federal, state, and local governments via your state-issued, state-created birth certificate and the name of your all-caps person. Birth certificates are issued so that the issuer can claim exclusive title to the legal person created thereby. This is further compounded when one voluntarily obtains a driver's license or a Social Security account number. The state even owns your personal and private life through your state-issued marriage license / certificate issued in the all-caps names. You have no rights in birth, marriage, or even death. The state holds title to all legal persons the states creates via birth certificates until the rightful owner, the holder in due course of the instrument, i.e., you, reclaims / redeems it. The main problem is that the mothers / parents and then the 18-year-old man / woman have voluntarily agreed to this contrived system of plunder by remaining silent, comprising legal default, laches, and failing to assert our absolute rights. The maxim of law becomes crucially operative. He who fails to assert his rights has none. The legal rules and codes enforce themselves. There is no court hearing to determine if those rules are correct. Their law is self-regulating and self-supporting. Once set into motion, their laws automatically come into effect, provided the legal process has been followed. The various bankruptcies. The legal person known as the United States is bankrupt and holds no lawful constitutionally mandated silver or gold, coin or bullion, with which to take back any currency. All privately held and federally held gold coins and bullion in America was seized via executive order of April 5, 1933, and paid to the creditor, the private Federal Reserve, under the terms of the bankruptcy. Congress, still convening strictly under executive order authority, confirmed the bankruptcy through the joint resolution to suspend the gold standard and abrogate the gold clause, June 5, 1933, and House Joint Resolution, in parentheses HJR 192, June 5, 1933, 73rd Congress, First Session, Public Law 7310. This 1933 public law states in part, quote, every provision contained in or made with respect to any obligation which purports to give the obligee a right to require payment in gold or a particular kind of coin or currency, or in an amount in money of the United States measured thereby, is declared to be against public policy. The corporate U.S. declared bankruptcy a second time, whereby the Secretary of Treasury was appointed receiver for the bankrupt U.S. and Reorganization Plan Number 26, Title 5 U.S.C. 903, Public Law 94-564, Legislative History, page 5967. Since 1933, the only assets used by the United States to pay its debt to the Fed have been the blood, sweat, and tears of every American unfortunate to be saddled with a birth certificate and a Social Security account number. In parentheses, the U.S. government must conceal this fact from the American people at all costs. Their future labor and tax revenues have been legally pledged via the new all-caps juristic person names appearing on the birth certificates, i.e., the securities used as collateral for loans of credit, in parentheses, belief/heir, to pay daily operational costs, reorganization expenses in bankruptcy, insurance policy premiums required to float the bankrupt government, and interest on the ever-increasing wholly fraudulent debt. All caps legal person verse the lawful being. Just who or what is the all caps person, i.e., all capital letters ens legis, John Paul Jones, all capital letters ens legis, John P. Jones, or some other all capital letter corruption thereof? It is the entity the government created to take the place of the real being, i.e., English common law spelling and pronunciation, proper name John Paul Jones. The lawful Christian name of birthright has been replaced with a legal corporate name of deceit and fraud. If the lawful Christian name answers when the legal person is addressed, the two are recognized as being one and the same. However, if the lawful being distinguishes himself/herself as another party than the legal person, the two are separated. As a result of the federal bankruptcy was the creation of the all capital letters United States, which was made a part of the legal reorganization. The name of each state was also converted to its respective all caps legal person, e.g., all capital letters, State of Delaware. These new legal persons were then used to create more legal persons, such as corporations with all capital letters names as well. Once this was accomplished, the con really began to pick up speed. In all areas of government and all alleged courts of law are de facto, color of law and right institutions. The Circuit Court of Wayne County and the U.S. District Court can only recognize and deal with other legal persons. This is why your lawful name is never entered in their records. The all caps legal person is used instead. Jurisdiction in such sham courts covers only other artificial persons. The proper jurisdiction for a lawful being is a constitutionally sanctioned common law venue court. Unfortunately, such jurisdictions was shelved in 1938 and is no longer available. The only courts today are statutory courts. Note: the Federal Reserve Bank, i.e., the central bank, places government IOUs, i.e., Treasury notes, on deposit in the Federal Reserve Bank, credits the government account for the amount of the IOU, charges interest to the government in parentheses paid by taxpayers, and the government has checkbook money to spend. The cost to the bank for these bookkeeping entries is nothing. Laches, L-A-C-H-E-S. Unreasonable delay or negligence in pursuing a right or claim, almost always an equitable one, in a way that prejudices the party against whom relief is sought. Black's Law, 7th edition. The Schnetzer's effect on English law. A law of the Jews becomes the law of the land. The rational study of law is still to a large extent the study of history. Holmes, The Path of the Law. 1. Introduction. English law, like the English language, is an amalgam of diverse cultural influences. The legal system may fairly be seen as a composite of discrete elements from disparate sources. After the conquest of 1066, the Normans imposed on the English an efficiently organized social system that crowded out many Anglo-Saxon traditions. The Jews, whom the Normans brought to England, in their turn contributed to the changing English society. The Jews brought a refined system of commercial law, their own form of commerce, and a system of rules to facilitate and govern it. These rules made their way into the developing structure of English law. Several elements of historical Jewish legal practice have been integrated into the English legal system. Notable among these is the written credit agreement. Shetar, or star, as it appears in English documents, the basis of the shetar, or Jewish gauge, was a lien on all property, in parentheses including realty, that has been traced as a source of the modern mortgage. Under Jewish law, the shetar permitted a creditor to proceed against all the goods and land of the defaulting debtor. Both movable and immovable property were subject to distraint. In contrast, the obligation of knight service under Anglo-Norman law barred a land transfer that would have imposed a new tenant, in parentheses, and therefore a different knight owing service, upon the lord. The dominance of personal feudal loyalties equally forbade the attachment of land in satisfaction of a debt. Only the debtor's chattels could be seized. These rules kept feudal obligations intact, assuring that the lord would continue to be served by his own knights. When incorporated into English practice, the notion from Jewish law that debts could be recovered against a loan secured by all property, movable and immovable, was a weapon of socio-economic change that tore the fabric of feudal society and established the power of liquid wealth in place of land holding. The Crusades of the 12th century opened an era of change in feudal England. To obtain funds from Jews, nobles offered their land as collateral. Although the Jews, as aliens, could not hold land in fee simple, they could take security interests of substantial money value. That Jews were permitted to hold security interests in land they did not occupy, expanded interests in land beyond the traditional tenancies. The separation of possessory interest from interest in fee contributed to the decline of the rigid feudal land tenure structure. At the same time, the strength of the feudal system's inherent resistance to this widespread innovation abated. By 1250, scutage had completely replaced feudal services. Tenant obligations had been reduced to money payments, and as the identity of the principals in the landlord-tenant relationship became less critical, a change in the feudal rules restricting alienability of interests in land became possible. One catalyst for this change may have been the litigation surrounding debt obligations to Jews secured by debtors' property. The Jews in Norman England had a specified legal status. They alone could lend money at interest. They were owned by the king, and their property was his property. The king suffered their presence only so long as they served his interests, primarily as a source of liquid capital. Because money lending by Christians was infrequent, English law had not established its own forms of security. The Jews operated within the framework of their own legal practice, which was based on Talmudic law developed over centuries of study. The peculiar status of the Jews as the crown's de facto investment bankers encouraged the king to direct his courts to enforce the credit agreements made by Jews under their alien practice. This nourished the growth of Jewish law in a way that blurred the absolutes of feudal land tenure. Previously, inalienable rights in land gave way to economic necessities, and the English ultimately adopted the Jewish practices. This note examines a moment of contact between two peoples when necessity, proximity, and social upheaval prompted a cultural exchange between the Jewish merchants and money lenders and those they served. The note describes the effect on English law brought about by the king's Jews as they executed and registered debt instruments, assigned and enforced the underlying obligations, and generally survived by money lending, the only profitable occupation open to them. It first reviews the Jewish credit agreement and its function in Anglo-Norman feudal society. It then suggests a rational explanation for a development in medieval English law, heretofore perceived only as an anomaly, that the early writs of debt, which were for recovery of money, used terminology more appropriate to an action for recovery of land. This confusion now appears to be merely the linguistic expression of an innovation in the law due to the development of an action to recover alternative relief, repayment of money lent, or a ward of collateralized land. Finally, the note focuses on the incorporation of Jewish law into English practice through a series of 13th century cases involving the same Jewish litigant. Jewish debt procedure had by then become part of everyday business in England. Even as the Jews began to be excluded from money lending, their procedures were adopted into the general English law governing debt registration and collection. In 1275, the statute De Judaismo forbade the Jews usurious practices. In 1285, the Statute of Merchants formalized creditor remedies that paralleled the provisions of the Jewish Shator. In 1290, the Jews were expelled, but their credit practices remained. 2. Jewish credit agreements in feudal England. A. The Shatar in Jewish law. The law of the Shatar, developed and elaborated by 500 A.D. in the Babylonian Talmud, antedates the Norman conquest by 6 centuries. Historically, the Shatal Hav, in parentheses or generally just Shatar, was an instrument that established formal obligation, either in contract or in debt. At the moment that a debtor acknowledged his indebtedness through a Shatar, a general lien was established, encumbering all the debtor's property as security for ultimate repayment. In case of default, the creditor could proceed not only against movable and immovable property held by the debtor, but also against encumbered land that the debtor had transferred to a third party. The debt attached to the land, and the creditor's lien had priority over subsequent alienations. Because of the severe obligations imposed by the Shatar, the contents of the instrument followed a standard form designed to ensure authenticity and precision. Each Shatar recited standard clauses of obligation, the creditor's right to customary modes of execution, and a final phrase stating that the document was not merely a form but a statement of an express contract. Inserted into the form language were the names of the parties, the sum and the currency of the debt, and the date of the obligation, thereby indicating the creation of the lien. To prevent fraud, the document was signed by 2 witnesses who knew the parties. A nation of wanderers, and adapting to a variety of cultures, determined that the language in which the Shatar was written should be irrelevant to its legal validity. Thus, in dealings with a surrounding Gentile populace, Jews were content that loan agreements be formalized in Latin or in the Norman French of early England. Generally, The Jewish parties and witnesses would attest in Hebrew, and the Christians in French or Latin. Although neither party may have understood the other's language, the document had the full force of law in both communities. The crucial limitation on debt collection under Jewish law was that a creditor had a lien against the debtor's land, but not against the debtor's person. Personal freedom was not to be diminished by a debt obligation, and a creditor could not enslave one who was unable to repay him. The origin of this practice was the biblical protection of the dignity of debtors, as embodied in the injunction not to enter the debtor's home to receive a pledge, but rather to wait outside for the debtor to bring it out. This was the structure of the law of obligation that the Jews brought with them to England. B. Normans in England, a centralizing monarchy. Unique among its feudal neighbors, the Norman duchy was governed as a centralized unit, with no barons strong enough to challenge the duke's authority, although the Norman duke owed fealty to the King of France. The king lacked effective power over his vassals, who independently governed their own territories. In Normandy, however, feudalism was strictly territorial. A pyramid of land tenure embodied a system of military obligations ascending from knight through baron to duke, from whom all land and authority derived. On the continent, and later in England, William the Conqueror set out to maintain and strengthen this Norman system of centralized governance. With the conquest, the Normans introduced to England a well-organized central authority system. He avoided the system's tendency toward decentralization and disintegration that had sapped the power of the French kings. He limited the power of his tenants-in-chief by granting each of them land holdings scattered over the realm instead of large, contiguous tracts. He governed the counties through sheriffs who depended on him for their power. He maintained a national militia, thereby shunning total reliance on the loyalty of his tenants-in-chief. And he had all significant landholders swear an oath of primary allegiance to him. This consecration of power and the monarch grew during the successive reigns of a series of strong kings who increasingly assumed more power, military, legislative, and judicial, over the nation. C. Jews under the Norman kings. Outsiders in feudal society, both Anglo-Norman and continental, the Jews were a part of the network of land-based obligations. They could not own land. On the continent, they were owned as chattels by the local lords, who he held for the ultimate use of his lord. The Jews in Norman England, however, were within the exclusive domain of the king's personal control, living at his sufferance and according to his wishes. The first settlement of Jews in England came in the wake of William the Conqueror. William determined that he should be the sole owner of Jews in England. Others could own Jews only with the king's permission as expressed by royal grant. The Leges Edwardi Confessories, a 12th century compilation and translation into Latin of laws attributed to Edward the Confessor. Side note quote, 53, W. Stubbs Supra Note 51 at 85-91, 54 ID at 90-91, 55 ID at 88, 56 ID at 86, 57 ID at 84, 58 ID at 117-18. The dates of the Normans and Angevin kings from the conquest to the expulsion of the Jews in 1290 are: William I, 1066 through 1087, William II, 1087 through 1100, Henry I, 1100 through 1135, Stephen, 1135 through 1154, Henry II, 1154 to 1189. Richard I, 1189 to 1199. John, 1199 to 1216. Henry III, 1216 to 1272. Edward I, 1272 to 1301. D. Walker, Supra Note 17 at 1317. 59 F. Lincoln, Supra Note 13 at 8-9, as administrator of the realm. The Continental King had interstitial power in the areas where no vassal could substantiate a rival claim. Upon this theory, the king had asserted special authority over widows and orphans, aliens, Jews, lunatics, etc. E. Jenks, Supra Note 12 at 90-91. 60 F. Lincoln, Supra Note 13 at 10. 61 H. G. Richardson, Supra Note 11 at 1. 62 F. Lincoln, Supra Note 13 at 10. 63 1 F. Pollock and F. W. Maitland, Supra Note 3 at 103. Pollock and Maitland believe that the laws of Edward the Confessor are of dubious authority, as descriptions of historical fact, perhaps reflecting some unknown 12th century author's hopeful imagination. End quote, and side note. Contains a statute that, if not that ancient, adequately describes the Norman period. Be it known that all Jews, wheresoever they may be in this realm, are of right under the tutelage and protection of the king. Nor is it lawful for any of them to be subject himself to any person of wealth without the king's license. Jews and all their chattels are the king's property, and if anyone withhold their money from them, let the king recover it as his own. As chattels of the king, the Jews retain their own property at his pleasure. In the 13th century, Henry de Bracton wrote, quote, "A Jew cannot have anything of his own, because whatever he acquires not for himself, but for the king, because they do not live for themselves, but for others, and so they acquire for others, and not for themselves. They lived where the king permitted, and when they died, their property vested in the king, because the ecclesiastical courts could proceed only against Christians. The Jews operated free of the church's usury prohibitions. The civil authorities openly permitted the Jews to lend money at interest and enforced their credit contracts, both for principal and interest. As the Jews prospered, the king did too, extracting them from the fruits of their monopoly on usury. Because it was worthwhile to protect Jewish subjects for their potential money value, successive sovereigns clarified the status of Jews. Charters of Henry I and Henry II granted individual Jews rights to reside in England, to buy and sell goods, and to possess all lands, fiefs, purchases, and pledges coming into their hands, subject to estate taxes. Jews were permitted to inherit property and loans. Richard I's Charter, granted in 1190, confirmed these rights. John affirmed the early charters in 1201, extending their coverage to all Jews and adding the right to hold mortgages. Under John's charter, a Jew was free, quietly to sell his gage where it be certain that he has held it for a full year and a day. The charter further clarified that in suits between Jews and Christians, litigation rights were explicit and, in some cases, advantageous to the Jews. The bare oath on the Torah of a Jewish defendant sufficed to rebut a charge against him by a Christian plaintiff accompanied by witness. A Christian defendant similarly situated might be required to wage his law with compurgators, A suit against a Jewish defendant was tried by a jury of his peers, and although a Jewish plaintiff could use a writ to substitute for a required witness, a Christian plaintiff could not. Trials involving Jews and Christians could be held only in the king's courts, while jurisdiction of disputes between Jews remained with the Jewish courts. But the Jews had fewer rights in themselves and in their possessions than did the least vassal to the king. The underlying reality was that the Jews were no more than the embodiment of the king's accounts receivable. Jews were subject to periodic tillage and tithing when the king required them to turn over money that was held, ultimately on his behalf. The king preserved the Jews and their investments as presenting his own financial future. The royal charters, in effect, permitted the Jews usufruct of money, much as their Christian neighbors were permitted use of the land. At the king's pleasure, they could derive a livelihood by lending money at interest. Because Jews could lend money at interest, they were available to finance excursions to continental Europe and on crusade. In addition to the extraordinary fiscal demands of the Crusades, the nobles still owed knight service. Tax-paying began to replace personal service in the practice of scutage, money assessed from landowners in lieu of knight fees. For this, too, the Jews' assets were liquid and available for a fee. It was convenient to the realm to have a source of credit. It was further convenient that the profits from the loan arrangements forbidden to Christians be available to the king via his Jews, and it was the king's advantage to enforce the contracts of credit made by Jews. 3. The Jewish presence in the developing law of commerce. A. In the king's court. The most striking development in English law during the 12th century was the expansion of the royal courts. Under Henry II, the king's court assumed an increased share of litigation that previously had been heard only by local courts. This was done through the issuance of royal writs, originally executory commands to the sheriff, but with time, increasingly representing a formal summons initiating action in the royal courts. Glanville's treatise, written at the close of the reign of Henry II, is in part a form book of writs instructing the proper method of litigation and procedure. The categories of writs reflect the precise boundaries of the then recognized forms of action. Among the writs developed during this formative period was the writ of debt. Initially, litigants most commonly used the writ to collect loans of money. Because the Jews were the predominant money lenders, they would have been the predominant users of the early writ. But the Jews were not merely the unintended beneficiaries of a fortuitous royal innovation. Taken together, the coincident circumstances of the Jews' relation to the king, the then unique form of relief afforded them by their shatars, and certain peculiarities in the wording of the early writs all suggest that the Jews contributed in heretofore unexplained ways to the development of the early writ of debt. In accord with their traditional practice, when the Jews lent money, they did so written under credit agreements documented in the traditional form of the shatars. Because of his relation to the Jews, the king had manifold interests in enforcing these shatars, and because what the Jews held, they held for the king. What the Jews lost through litigation or to an evasive debtor was lost to the king. Nor were these losses small. The Jews accumulated immense wealth through their money lending, and the king's exchequer relied heavily on the Jews as an important source of tax revenues. And the king had an even more immediate stake in the revenues from the court costs. When the debtor refused to pay, the king enforced the Jewish contracts through his royal court, at a cost of 1/10 to 1/6 of the sum at issue. Yet, despite the royal interest, the questions posed by litigation of the shatar were not questions that English practice was designed to solve. When a Jew sought to enforce a shatar, he asked alternative forms of relief, payment of the money owed, or award of the land and chattels securing the debt. But this request, apparently, was an aberration from English practice of the early 12th century. A Jew's request tracked the terms of his unique contract. Only a Jewish creditor of a defaulting debtor would be forced to seek either money or security, because only his alien procedure left the debtor in possession of the land pledged to secure the debts. It appears likely that, at that time, a Christian litigant asked for only a single remedy, either a thing or money. A Christian creditor took and kept possession of the land until the debt was satisfied. In case of default, therefore, his suit would be for money only. If the debtor wrongfully put him out of possession of the land securing the debt, English practice barred the Christian creditor from bringing an assize of novel decision to recover the land. The English system relegated him to a suit only for the underlying debt. Conversely, the debtor regained the possessory rights to his property once the underlying debt was satisfied. If the creditor refused to return the security, the debtor's suit would be limited to return of the pledged property. A Jewish creditor was apparently the only person in the realm who would seek execution on a significant personnel obligation by either transfer of a thing or payment of a sum. A Jewish creditor's ability to ask to reform of relief gave him more than the obvious advantage over a Christian creditor. Important procedural privileges inhered in the opinion of getting real relief for a personal obligation. The conventional litigant suing on a personal obligation and seeking only money could not get judgment if the defendant did not appear in court. In contrast, any litigant seeking an award of land would be awarded judgment if the defendant had been absent without excuse after 3 successive summonses. After the defendant's third unexcused absence, the land was seized into the king's hand for 15 days and then adjudged to the plaintiff. Consequently, only a litigant demanding land was assured complete relief regardless of a defendant's attempts to evade the court's power. Other litigants could gain access to defendant's property only through successful attempts to secure defendant's presence through distraint of chattels and lands. This disparate justice dissatisfied Bracton, who proposed that the courts grant relief to claimants of personal obligations who were faced with a defaulting defendant by the distraint and award of the defendant's property. But, because this solution was not generally adopted until 1832, a Jewish creditor's avenues of enforcement remained unique in medieval England, enabling him to pursue his claim to judgment even though the defendant did not appear to answer the writ. The Jews asked for a remedy that the English system was unaccustomed to offering. This challenge was met by the king, who himself commanded enforcement of the terms of the shatar. The king first manifested his interest in a command to pay in the form of a writ principi, which, if disregarded, conferred jurisdiction on the king's court. By the shatar's terms, the debtor had the choice of paying the debt or relinquishing the property which secured the obligation. To enforce this choice, the king's command would have had to reflect the divergent remedies, money or property. Eventually, this form of writ principi evolved into the writ of debt. The king's intervention on behalf of his Jewish moneylenders may explain and, in turn, have produced some Anomalous terminology in the early development of the writ of debts. The wording of the writ evidences the intrusion of land interests into personal litigation. In the writ, as exemplified in Glanville, the king ordered the sheriff to order N to give back justly and without delay to R 100 marks which he owes, and of which he divorces him unjustly. Professor Van Kinegem observes that this wording closely resembles that of the classic P.3 for land. Specifically, the writ of debt adopted the words unjustly divorces, in parentheses, unde e injuste divorciet. From the P.3, to divorce is to wrongfully withhold possession of land from one who is lawfully entitled to it. The impropriety of the transplanted terminology therefore lies in the same sense of the wrong conveyed by the words unjustly divorces, which calls for an immediate remedy for an egregious interference with land tenure. But the underlying complaint was default on a debt. Thus, the terms of the writ appear to ask for inappropriate relief, noting the apparent confusion. Van Kenegem indicates that Jews were the principal beneficiaries of the early writ. The misuse of the words unjustly divorces in the early writs conveys more than just the verbal conservatism of the early common law. Use of the term implies an underlying land obligation securing a certain sum, which strongly suggests the existence of an arrangement like the Jewish shatar. Here, however, the king himself compelled payment in money or in land to be made by the debtor found in breach of a private agreement. The term divorce then communicates the Jew's ability to circumvent the procedural limitations of personal actions. R. L. Henry has suggested, alternatively, that the writ used divorce to connote a breach of the king's peace as an empty incantation and the single purpose of lending substance to a claim of the king's jurisdiction. The king did not customarily intervene in private disputes. The purported fiction was that withholding payment on a debt breached the king's peace. Henry argues that the formalism was dropped once the action was well established and the fiction no longer necessary. But the invocation of the king's peace has another explanation derived from the unique relationship between the king and his Jews. Because the early actions at debt were principally on behalf of Jews, and because Jews claimed their rights in the king's name, all obligations owed to them were ultimately owed to him. Withholding a debt owed, even indirectly, to the king is a breach of the king's peace that requires no legal fiction. If the price of the writ was paid, the king's courts were ready to stand behind a Jewish creditor's complaint in debt. To enforce the debt was to restore peace to a small part of the realm. Use of the term divorcee symbolizes the court's interference with rights in land, used to imply breach of the peace. It invokes the image of the king's wrath. The otherwise puzzling formalism signaled an institutional conflict. In the courts of feudal England, land tenure had been distinct from personal rights in law. Jews were asking the courts to award land, to compel transfer of property to satisfy a personal obligation before final judgment. Because the king was, in effect, the real party in interest, the interference with land tenure was done with his consent and support. Lacking the king's hand, the action would have been impossible. Only the king's interest in enforcing Jewish creditors' remedies could make possible this invasion of land beyond the limits of relief in personal actions. The traditional Jewish procedure governing lien accompanied debt was an innovation in feudal society. The embryonic legal system lacked the terminology to describe a private judicial proceeding for money that jeopardized possession of land. From this came the hybrid use of the term divorce, divorcee, disappeared from the king's court shortly after the time of Glanville, approximately the time when Jewish litigation had been removed to the newly established exchequer of the Jews. In the signorial courts, the term fell in disuse by 1291, 1 year after the expulsion of the Jews from England. Though this may be adventitious, the decline of the phrase and its underlying royal obligation coincides with the decline of the Jews in England. When the king's Jew was no longer the creditor, default on a debt no longer implicated the interest of the royal treasury.
B. The exchequer of the Jews.
At no time during their 2-century presence in England were the Jews perceived as more than a necessary evil, a source of capital. The Jews, welcomed as money lenders, were despised as creditors. So long as the king enforced the Jews' debt instruments, the best way to avoid obligation was to attack the Jewish community, destroying people and records. Sporadic incidences culminated in riots against the Jews during the coronation of Richard I in 1189, and in the massacre at York in 1190. Besieged by the mob, hundreds of the York Jews chose death over baptism. The warriors, joining religious hatred to their economic motivation, were quick to destroy the deposits of shatars held within the Jewish community. At York, the riot was instigated by Richard Malabis, a nobleman deeply indebted to the Jews. After 500 Jews died in Citadel, Malabisi led the mob of the cathedral, where they destroyed the debt records which had been held for the safety in the chapter house. When the smoke cleared, both creditor and debt had been eradicated. Following his return from the Crusades and release from captivity, Richard I was displeased by the attacks on his Jewish money lenders. Because duplicates did not exist for many of the documents destroyed, the king was unable to collect debts that would otherwise have escheated to him. He was concerned with preserving a record of debts owed to ensure their payment. By 1200, this concern prompted the establishment of Archaea, in parentheses Registry of Bonds, and of the Exchequer of the Jews. Archaea were established in all towns with sizable Jewish populations. The registries consisted of chirograph, chests, and 4 chirographers, 2 Christians and 2 Jews, and their clerks. The chirograph procedures were strongly reminiscent of traditional Jewish practice. All bonds were to be formalized in the presence of the official witnesses and immediately duplicated. The original and duplicate were usually written on the same skin and were divided by an irregular cut, producing corresponding tallies. The RK retained the duplicate, which was called the pes, or foot, of the bond, while the creditor retained the original, with the debtor's seal affixed. When the debtor satisfied the debt, the creditor gave the debtor a deed of acquittance. The debtor could then prove satisfaction of the debt only by delivering the acquittance to the arca, for which he obtained the pes, which canceled the debt. No debt, acquittance, or assignment of debt was valid unless filed in the chirograph chest, which could be opened only by order of exchequer or in the presence of a majority of the chirographers. The king's exchequer oversaw the king's accounts. A contemporary treatise described its organization and duties. The Dialogue of the Exchequer. Litigation of Jewish debt instruments comprised a substantial portion of the exchequer's business, so much so that a separate branch was created to try Jewish causes. Beginning in 1198, custodes Judiorum, or wardens of the Jews, were appointed, subordinate to the exchequer. The Custodes Judaeorum were the first justices of the Jews. They exercised exclusive jurisdiction over all matters involving Jews and Christians, except those in which the Jew was criminally accused. During the 13th century, they were charged with enforcing the shatars of the Jews. This special branch of the exchequer could effectively ascertain the amounts due the king's treasury via the king's Jews. The chirograph chests preserved the bonds of debt and the deeds of acquittance, and the archaea preserved the chirograph chests. Many of the pleas brought before the exchequer of the Jews still survive, and a substantial body of legal paper memorializes the interaction of the 13th century British legal system with the Jewish law of the shatar. Surviving records indicate that the exchequer of the Jews presided over matters arising from the full range of interactions between Christians and Jews. The primary document offered to prove the transfer of interest in land and the establishment, transfer, or satisfaction of a debt was the shatar.
C. In the matters of Cockhagen.
The records of the exchequer reveal the tensions between several elements: the king's thinly disguised economic interest, the court's struggle between formalism and alien law, interreligious suspicions, and everyday venality within the pleas of the exchequer of the Jews, the appearances of one recurrent litigant, Cockhagen, sometime chief rabbi, serve as an exemplar of the cultural contact between Jew and Christian. Cock's changing fortunes illustrate not only the limits of the Jew's personal freedom in English society, but also the extensive reliance on Jewish legal practice in the king's court. Cock's first appearance was in 1272, when the Queen, through her clerk, claimed from him £100 in ready money. Instead of paying immediately, Cock acknowledged debts to the crown amounting to £100, but not in ready money, and asked that the king's council render judgment to support the queen's claim. The queen's agent appealed to the king's council. The queen's council and the eyewitnesses to the making of the agreement. Cock agreed to pay the debt in 2 installments and named 4 Jews as sureties. If he defaulted, they, equally with him, would be subject to distraint of their lands, debts owing, chattels, and their bodies. In 1273, Cock appeared with several others to pay a partial sum to delay the tallage addressed in the Easter term of the first year of Edward's first reign. They asked respite for the greater part owed, and agreed on a penalty that each would owe in default. Later that year, the court noted that the appointed date had passed without payment of tallage and penalty. The penalty was assessed and paid. 1 year later, Cockhagen appeared as co-surety to receive custody of Joyce Bundy, a Jew who was charged with lending money to Christians by blank tallies, leaving blank the amount due until after the debtor had signed. Additionally, Bundy was charged with having lived for some time in Raleigh without the king's license. For this offense, all Bundy's goods and chattels were forfeit to the crown. When Bundy failed to appear for his appointed court date, the court found Cockhagen and his co-surety in mercy. In 1275, the king notified his justices that he had granted all of Cockhagen's possessions as gifts to his dearest consort, Eleanor, Queen of England. She was to receive all of the Jew's debts, owing, and all of his goods and chattels. These were forfeit because Cockhagen was excommunicate for refusing to submit to trial, according to the law and custom of the Jewry. Edward conditioned this gift to Eleanor upon her making good to the king before Christmas. The arrears of the last tallage assessed upon him, the Jew, by 1282, and the 10th year of Edward's reign, Cock was again doing business, and that term, Cock summoned Roger de Ling to answer for the principal and interest owed on a debt presented by one chirograph, sworn to be duplicated in the London chirograph chest. In the same year, Koch's real estate deals apparently proliferated in return for a fee interest in a plot of land and a house in London. He exchanged a 9-year term on a farm in Essex in which he had a liveried interest. The farm had been obtained on account of diverse debts of the former owner, a knight. The prior agreement transferring the farm was duly enrolled at the Exchequer. For his new property, Cokehagen agreed to pay yearly, at Easter, 1 gillyflower to the former tenant and also to render to the capital lords of the fee the services due and wanted therefor, in discharge for all secular services, customs, and all things exacted and demanded. The two charters, granting respectively the properties to their new owners, contain the warranties, witness attestations, seals, and signatures required by the law of the Shatar. The court received these elements as proof of the agreement's validity. The court also recorded that the Queen's attorney was present to give her consent and acknowledgement to Cokehagen's document. Cokehagen's last appearance is as one of a group of descendants of Master Elias, joining together to acknowledge, by their Shatar, the acquittance of an ancient debt to their father. As his heir, they released the debtor from the creation to the end of the world. By spontaneous and unanimous consent, they discharged the debt as fully paid. The surviving records of the Exchequer of the Jews cover a limited period, in parentheses 1220 to 1284. Cokehagen's experience is representative in so far as it illustrates personal and religious disputes, shatars of property transfer, debt registration and acquittance, and a royal conveyance, whereby his goods and, arguably, he himself were granted to the Queen. The Exchequer enforced the law, according to the customs of the Jewry, for nearly a century until the expulsion in 1290. Over time, the alien ways of the Jews had become the subject of everyday litigation in the king's courts.
4. Conclusion. The Exodus and what the Jews left behind.
Ruling during an era of socio-economic change, in parentheses 1272 through 1307, Edward was wont to legislate accordingly. And Edward was weary of the Jews. Thus he issued laws forbidding the Jews from holding real property, denying them usurious practice, and ordering them to wear distinctive dress and identifying badges. Even as he restricted Jewish moneylenders, Edward expanded the universe of non-Jewish money lending. He had before him a model of secured debt contracts, enforced for centuries by the royal courts for the royal usurers. In the Statute of Merchants of 1285, Edward extended to creditors the forms of registry, remedy, and enforcement that had previously been substance of the Exchequer of the Jews. Under the statute, a debtor acknowledged the existence of his debt before the mayor and one of the recording clerks. The clerks recorded the debt in two rolls. Two remained with the mayor, one with the clerks. In his own recognizable handwriting, the clerk prepared a debt instrument, to which the debtor affixed his seal, and the officials affixed the king's seals. The instrument was given to the creditor, who would present it to the mayor and the clerks to prove his right if the debtor defaulted. More than the enrollment procedures paralleled the structures of the Exchequer of the Jews. The remedies also extended to Christian creditors the relief formerly available only to Jews. No longer was a Christian creditor's relief before judgment limited by the debtor's absence. If the Christian creditor presented to the mayor a matured, acknowledged debt instrument corresponding to an enrolled debt, he had established full right to relief. If the debtor did not pay, the creditor eventually obtained access to the debtor's lands, even as the Jews had done for years. And if the creditor were ejected from the debtor's lands, he could bring an assize of novel disseisin to be put back in possession. The Statute of Merchants expressly allowed merchants damages and all necessary and reasonable costs in their labors, suits, delays, and expenses. the same label that disguised otherwise usurious interest in Jewish contracts. Finally, the king assumed the duty of maintaining the roll of debts, affixing his seal next to the debtors and charging 1 penny for each pound of obligation. The new law expressly excluded Jews. 5 years after the Statute of Merchants, Edward I expelled the Jews from England. Religious hostility was rife. Repeated tallages had depleted the Jews' resources and lessened their value to the king's purse. No longer were the Jews the unique source of credit in England. By the Statute of Merchants, Edward had granted to all non-Jewish creditors the same remedies and procedural rights previously available to Jews. Debts were secured by land, and the security interest survived the death of the creditor and the alienation of the property. In addition to the property that escheated to the king on their departure, the Jews left behind a law of debtors and creditors developed in the Talmud, introduced in the Exchequer, and preserved in the laws of England. Traces the shatar procedure survived for centuries in English law. A sealed debt continued to be dischargeable only by a deed of release or by cancellation or destruction of the debt instrument. The practice of debt cancellation by requiring return of the pes of the chirograph continued from 1194 until its abolition by statute in 1833. Most important, the encumbrance of real property permitted by the Jewish law of the shatar had been adopted by English law. Bonds contained the traditional Hebrew formula pledging all my goods, movable and immovable. Creditors had the statutory right to execute against the debtor's land. No longer were personal obligations and rights in the land rigidly separate. Even while Edward was divesting himself of his Jewish money lenders, he made their legacy permanent, a small but significant principle of Jewish law, wherein personal debt superseded rights and real property, had become the law of the land. Judith A. Shapiro. State Bar of California, not a registered public corporation. The information displayed here is current as of February 15, 2002, and is updated weekly. It is not a complete or certified record of the corporation. For information about certification of corporate records, or for additional corporate information, please refer to corporate records. If you are unable to locate a corporate record, you may submit a request to this office for a more extensive search. Fees and instructions for requesting this search are included on the corporate records order form. Results of search for State Bar of California. Click on the name of the corporation for additional information. Corporation number, date filed, status, corporation name, agent for service of process. C2176529, 9/17/1999. Active. Bar None, Incorporated, which will do business in the state of California as Delaware Bar None, Incorporated, a Delaware corporation. CT Corporation System. C0033212, 5/18/1901. Inactive. California State Bar Association. C0017482, 5/18/1901. Term expired. California State Bar Association. C2107072, 4/24/1998. Active. Golden State Bar Grinding Incorporated. Richard LeBrun. C1636870, 3/13/1989. Active. The Foundation of the State Bar of California. James Pfeiffer. C1967571, 4/30/1996. Active. The State Bar Education Foundation. Pam Wilson. C2029478, 3/26/1998. Suspended. The Western State University College of Law Student Bar Foundation. Mark Bravo. 60 times magnification of signature line on personal checks. Authorized signature only. United States Code, Title 17, Copyrights. Chapter 1. Subject Matter and Scope of Copyright. U.S. Code as of 01/02/01. Section 107. Limitations on Exclusive Rights. Fair Use. Notwithstanding the provisions of Section 106 and 106A, the fair use of a copyrighted work, including such use by reproduction in copies or phone records, or by any other means specified by that section, for purposes such as criticism, comment, news, reporting, teaching, in parentheses including multiple copies for classroom use, scholarship, or research, is not an infringement of copyright. In determining whether the use made of a work in any particular case is a fair use, the factors to be considered shall include 1. The purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. 2. The nature of the copyrighted work. 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And 4. The effect of the use upon the potential market for or value of the copyrighted work. The fact that a work is unpublished shall not in itself bar a finding of fair use if such finding is made upon consideration of all the above factors.
UCC Filing Offices.
Alabama. Secretary of State, UCC Division, P.O. Box 5616, Montgomery, Alabama 36103-5616. Secretary of State, UCC Division 11 South Union Street, State House, Suite 200, Montgomery, Alabama 36104. Phone number 334-242-5231. Website www.sos.state.al.us/business/uniform.htm. Emails www.sos.state.al.us/webforms/mailform.cfm. Alaska. State of Alaska. Central UCC File System. Department of Natural Resources. State Recorder Office. 550 W. 7th Avenue, Suite 1210. Anchorage, Alaska 99501-3564. Phone number 907-269-8882. Website www.dnr.state.ak.us/ssd/. Email www.dnr.state.ak.us/pic/dnr directory.htm. Arizona. Secretary of State, UCC Department, Capitol West Wing, 7th floor, 1700 West Washington Avenue, Phoenix, Arizona 85007. Phone 602-542-6185. Website www.sosaz.com/services/ucc.htm. Email ucc@mail.sosaz.com. Arkansas. Secretary of State, UCC Division, State Capitol, Room 025, Little Rock, Arkansas 72207. Phone 501-682-5078. 888-733-0325. Website www.sosweb.state.ar.us/business.html. Email business@sosmail.state.ar.us. California. Secretary of State, UCC Division, P.O. Box 942835, Sacramento, California 94235-0001. Secretary of State, UCC Division, 1500 11th Street, Room 255, Sacramento, California, 95814. Phone 916-653-3516. Website www.ss.ca.gov/business/UCC/UCC.htm. Email lere@ss.ca.gov. Colorado, Secretary of State, UCC Division, 1560 Broadway Street, Suite 200, Denver, Colorado, 80202. Phone 303-894-2200, 800-869-3308. Website www.dosf.state.co.us/UCC/UCC index.stm. Email sos.business@state.co.us. Connecticut, Secretary of State, UCC Unit, P.O. Box 150470, Hartford, Connecticut 06115-0470. Secretary of State, UCC Unit 30, Trinity Street, Hartford, Connecticut 06106. Phone 860-509-6002. Website www.sots.state.ct.us/commercial recording/CRD form.html #UCC. Email crd@po.state.ct.us. Delaware, Secretary of State, Division of Corporations, UCC Section P.O. Box 793, Dover, Delaware 19903. Secretary of State, Division of Corporations, UCC Section Townsend Building 401, Federal State, Suite 4, Dover, Delaware 19901. Phone 302-739-3073. Website www.state.de.us/corp/UCC.htm. Email sdocweb@state.de.us. District of Columbia, Central Filing Office, Mayor's Office, Real Estate Filings, Recorder of Deeds, 515D, Street Northwest, Washington, D.C. 20001. Phone 202-727-5374. Website none as of this printing. Email none as of this printing. Florida, Department of State, Bureau of Commercial Recordings, UCC Filings, P.O. Box 5588, Tallahassee, Florida 32314. Department of State, Bureau of Commercial Recordings, UCC Filings, 401 East Gaines Street, Tallahassee, Florida 32399. Phone 850-222-8526. Website www.dos.state.fluc/fawucc.html. Email corphelp@mail.dos.state.fl.us. Georgia, no filings at Secretary of State. File with the Clerk of Superior Court. Phone 404-327-9058. Georgia Superior Court Clerks Cooperative Authority. Website www.gsccca.org/projects/aboutucc.html. Email www.gsccca.org/comments.html. Hawaii Department of Land and Natural Resources, Bureau of Conveyances, P.O. Box 2867, Honolulu, Hawaii 96803. Department of Land and Natural Resources, Bureau of Conveyance, 1151 Punch Bowl Street, Honolulu, Hawaii 96813. Phone 808-587-0152. Website www.state.hi.us/DLNR/BC/fee schedule.html. Email www.state.hi.us/DLNR/BC/GENINFO.html. Louisiana. File at County Recorder. Filings are data-based, tied in with state filings. Secretary of State. P.O. Box 94125, Baton Rouge, Louisiana 70804-9125. Phone 225-342-5542. State Assistance 1-800-256-3758. Website www.sec.la.us/comm.comm-index.htm. Email osc@sec.state.la.us. Maine, Secretary of State. UCC Filing Section, Bureau of Corporations and Elections, State Office Building, Room 221-101, State House Station, Augusta, Maine 04333-0101. Phone 207-787-4177. Website www.state.me.us/sos/corp/ucc.htm. Email ceccorporations@state.me.us. Maryland, Department of Assessments and Taxation, 301 West Preston Street, Room 809, Baltimore, Maryland 21201. Phone 410-767-1459. Website www.datweb/charter.html #UCC. Email www.datweb/feedback.html. Massachusetts, Secretary of State, UCC Division, 1 Ashburn Place, Room 1711, Boston, MA 02108. Phone 617-727-7860, 617-727-2800. Website www.state.ma.us/sec/coruccionf.htm. Email lori.flynn@sec.state.ma.us. Michigan, Department of State, UCC Unit, P.O. Box 30197, Lansing, MI 48909-7697. Department of State, UCC Unit, Secondary Complex, 7064, Crowner Plaza, Diamonddale, Michigan, 48821. Phone 517-322-1144. Website www.sos.state.mi.us/. Email nickersonj@state.mi.us. Minnesota, Secretary of State, UCC Division 180 State Office Building, 100 Constitution Avenue, St. Paul, MN 55155-1299. Phone 651-296-2803. Website www.sos.state.mn.us/uccd/index.html. Email ucc.dept@sos.state.mn.us. Mississippi, Secretary of State, Business Service Division, UCC Division 401, Mississippi Street, Jackson, MS 39201. Phone 601-359-6386. Website www.sos.state.ms.us/busser v/UCC/UCC.html. Email none as of this printing. Missouri, Secretary of State, UCC Division, P.O. Box 1159, Jefferson City, Missouri 65102. Secretary of State, UCC Division, 600 West Main Street, Room 302, Jefferson City, Missouri 65101. Phone 573-751-4936. 573-751-4179. Website www.mosl.sos.state.mo.us/. Email sosmain@mail.sos.state.mo.us. Montana, Secretary of State, Business Service Bureau, P.O. Box 202801, Helena, Montana 59620-2801. Phone 406-44-3665. Website www.state.mt.us/sos/business services/forms.htm #UCC forms. Email sos@state.mt.us. Nebraska, Secretary of State, UCC Division, 16th NK, P.O. Box 95104, Lincoln, Nebraska 68509. Phone 402-471-4080. Website www.no1.org/home/sos/htm/services/htm. Email sos07@no1.org. Nevada, Secretary of State, UCC Division, 200 North Carson Street, Carson City, NV 89701-4201. Phone 775-684-5708. Website www.sos.state.nv.us/rec/index.htm. Email nvcomrec@govmail.state.nv.us. New Hampshire, Secretary of State, UCC Office, Room 204, State House 107, North Main Street, Concord, New Hampshire 03301 4989. Phone 603-271-3276. Website www.state.nh.us/SOS. Email none as of this printing. New Jersey. New Jersey Department of Treasury, Central Filing, UCC Section, P.O. Box 303, Trenton, New Jersey 08625. New Jersey Department of Treasury, Central Filing, UCC, Section 225, State Street, West, 3rd floor, Trenton, New Jersey 08618. Phone 609-292-9292. Website www.state.nj.us/SOS/. Email feedback@sos.state.nj.us. New Mexico. Secretary of State, UCC Division 325, Don Gaspar, Suite 300, Santa Fe, NM 87501. Phone 505-827-3600. Website www.sos.state.nm.us/UCC/UCChome.htm. Email nmsos@state.nm.us. New York Department of State, 41 State Street, Albany, New York 12231-0001. Phone 518-474-4763. Website www.dos.state.ny.us/corp/corp www.html. Email corporation@dos.state.ny.us. North Carolina Secretary of State, UCC Division, P.O. Box 29626, Raleigh, North Carolina 27626-0622. Secretary of State, UCC Division 2, Salisbury Street, Room 302, Raleigh, North Carolina 27603-5909. Phone 919-807-2111. 919-807-2225. Website www.secretary.state.nc.us/UCC/. Email none as of this printing. North Dakota Secretary of State, UCC Division, Capitol Building, 1st floor, 600 East Boulevard Avenue, Department 108, Bismarck, ND 58505-0500. Phone 701-328-3662, 701-328-3663, 800-352-0867. Website www.state.nd.us/sec/central indexing UCC filings.htm. Email sosbir@state.nd.us. Ohio Secretary of State, UCC Division, P.O. Box 250, Columbus, Ohio 43216. Secretary of State, UCC Division, 180 East Broad Street, 16th floor, Columbus, Ohio 43215. Phone 614-466-3623, 877-767-3453. Website www.serv.soi.wdbci/wdbcoi.exe/report/report.home. Email buserv@sos.state.oh.us. Oklahoma Central Filing, 320 Robert S. Kerr Avenue, Suite 107, Oklahoma City, Oklahoma 73102. Phone 405-713-1521. Website www.sos.state.ok.us. Email www.sos.state.ok.us/feedback.htm. Oregon Secretary of State, Corporation Division, UCC Section, Public Service Building, 255 Capitol Street, Northeast, Suite 151, Salem, Oregon, 97310-1327. Phone 503-986-2200. Website www.sos.state.or.us/corporation/corphelp.htm. Email gary.i.johnson@state.or.us. Pennsylvania Department of State Corporation Bureau, UCC Section, P.O. Box 8721, Harrisburg, Pennsylvania 17105-8721. Department of State Corporation Bureau, UCC Section, Commonwealth Avenue and North Street, North Office Building, Room 308, Harrisburg, Pennsylvania 17120. Phone 717-787-1057. Website www.dos.state.pa.us/corps/corp.html. Email none as of this printing. Puerto Rico Department of State P.O. Box 9023271, Old San Juan, Puerto Rico 00902-3271. Phone 787-722-2121, 787-721-3173. Website www.estado.prstar.net. Email none as of this printing. Rhode Island Secretary of State, UCC Division, 100 North Main Street, Providence, Rhode Island 02903. Phone 401-222-3040. Website no UCC website as of this printing. Email corporation@sec.state.ri.us. South Carolina Secretary of State, UCC Division, P.O. Box 11350, Columbia, SC 29211. Secretary of State, UCC Division, Capitol Complex, Edgar Brown Building, 1205 Pendleton Street, STE 525, Columbia, SC 29201. Phone 803-734-2164. Website www.scsos.com/uniform commercial code.htm. Email www.scsos.com/feedback.htm. South Dakota Secretary of State, UCC Division, Central Filing, 500 East Capitol, Suite 204, Pierre, SD 57501-5077. Phone 605-773-4422. Website www.state.sd.us/sos/ucc.htm. Email dakotafastfile@state.sd.us. Tennessee Secretary of State, Division of Business Services, William R. Snodgrass Towers, 6th floor, 312 8th Avenue North, Nashville, Tennessee, 37243-0306. Phone 615-741-3276. Website www.state.tn.us/sos/service.htm #UCC. Email tstoval@mail.state.tn.us. Texas. Secretary of State, UCC Division, P.O. Box 13193, Austin, Texas 78711-3193. Secretary of State, UCC Division 1019, Brazos Street, Suite 505, Austin, Texas 78701. Phone UCC 1 Info 512-475-2700, 512-475-2703. UCC 3 Info 512-475-2704. UCC 11 Info 512-457-2705. Website www.sos.state.tx.us/UCC/index.shtml. Email mjackson@sos.state.tx.us. Utah. UCC Division, P.O. Box 146-705, Salt Lake City, Utah 84114-6705. UCC Division 160 East 300 South, 2nd floor, Salt Lake City, Utah 84110. Phone General Info 801-530-4849. Unusual Info 801-530-6025. Website www.commerce.state.ut.us/corporat/UCC page.htm. Email corpucc@br.state.ut.us. Vermont. Secretary of State, UCC Division, 81 River Street, Drar, 9, Heritage Building, Montpelier, Vermont 05609-1104. Phone 802-828-2386. Website www.sec.vt.us/corps/corp-index.htm. Email bpoulin@heritage.sec.state.vt.us. Virginia. State Corporation Commission, P.O. Box 1197, Clerk's Office, Richmond, Virginia 23218-1197. State Corporation Commission, 1300 East Main Street, Clerk's Office, 1st floor, Richmond, Virginia 23219. Phone 804-371-9733. Website www.soc.state.va.us/bio.htm. Email none as of this printing. Virgin Islands. Office of Lieutenant Governor, Corporation, UCC Division, P.O. Box 450, Congans Number 18, Charlotte Amalie, St. Thomas, Virgin Islands 00802. Office of Lieutenant Governor, St. Croix County Clerk, 1131 King Street, Suite 101, Christianstad, Virgin Islands 00820. Phone St. Thomas 340-776-8515. St. Crux 809-733-6449. Website www.gov.vi/html/gov.html. Email none as of this printing. Washington. Department of Licensing, UCC, Section P.O. Box 9660, Olympia, Washington 98507-9660. Department of Licensing, UCC, Section 405, Black Lake Boulevard, 500 Building 2, First Floor, Olympia, Washington 98501. Phone 360-664-1530, 360-664-1531. Website www.wa.gov/dol/bpd/UCC front.htm. Email ucc@dol.wa.gov. West Virginia, Secretary of State, UCC Department, State Capitol Building, Room W131, 1900 Kanawha Boulevard East, Charleston, WV 25305. Phone 304-558-6000. Website www.state.wv.us/sostemp/default.htm. Email wvsos@secretary.state.wv.us. Wisconsin Department of Financial Institutions, UCC Division, P.O. Box 7847, Madison, Wisconsin 53707-7847. Department of Financial Institutions, 345 Washington Avenue, 3rd floor, Madison, WI 53704. Phone 608-261-9548. Website www.wdfl.org/UCC/. Email info@dfi.state.wi.us. Wyoming Secretary of State, UCC Division, 110 Capitol Building, Cheyenne, Wyoming, 82002-0020. Phone 307-777-5372, 307-777-5334, 307-777-5342. Website www.soswy.state.wi.us/uniform/uniform.htm. Email corporations@state.wy.us.
UCC filing offices in Canada.
Alberta Registries, Personal Property Registry, 5th floor, J.E. Brownlee Building, P.O. Box 2022, 10365 97th Street, Edmonton, Alberta, T5J2P4. Phone 403-422-2362, 800-465-4009. British Columbia Office of the Registrar General and Office of the Registrar of Companies, 940 Blanchard Street, 2nd floor, Victoria, British Columbia, V8WSE6. Phone 604-387-6121, 800-663-7867. Manitoba Department of the Attorney General, Personal Property Registry, 15th floor, Woodsworth Building, 504 Broadway Avenue, Winnipeg, Manitoba, R3C3L6. Phone 204-945-3101, 204-945-3100. New Brunswick, Chief Registrar of Deeds. Attention, Chief Registrar, P.O. Box 1998, 985 College Hill Road, Fredericton, New Brunswick, E3B 5G4. Phone 506-457-3581. Newfoundland, Personal Property Registrar, Commercial Registration Division, Government Services, Department of Justice, P.O. Box 8740, Elizabeth Towers, St. John's, Newfoundland, A1B4J6. Northwest Territories, Registry of Bills and Sales, Credit Sales and Chattel Mortgages, P.O. Box 1320, 5009, 49th Street, First Floor, Yellowknife, Northwest Territories, X1A 2L9. Phone 403-873-7493. Nova Scotia, Registry of Deeds, P.O. Box 2205, 1660 Hollis Street, Halifax, Nova Scotia, B3J 3 S4. Phone 902-424-8571, 902-424-4203. Ontario, Personal Property Security Registrations, Central Registration Branch, 393 University Avenue, 3rd floor, Toronto, Ontario, M5G1E6. Phone 416-596-3766, 416-325-8847, 416-325-8782. Prince Edward Island, Department of Provincial Secretary, P.O. Box 2000, Consumer Division, Charlottetown, Prince Edward Island, C1A 77N8. Phone 902-368-6000. Quebec, Registry's Office, 150 René Levesque, 7th floor, Quebec City, Quebec, G1R 2B2. Phone 418-646-9606. Montreal, Registry, Division of Montreal, 1 Notre Dame Street, East Montreal, Quebec, H2Y1B6. Phone 516-393-2055. Saskatchewan, Department of the Attorney General, 1871 Smith Street, P.O. Box 7128, Regina, Saskatchewan, S4P3S5. Phone 306-787-6787, 306-787-8187. Yukon Territory, Government of Yukon, Department of Justice, Personal Property Security Registry, Consumer Corporation and Labor Affairs, P.O. Box 2703, White Horse, Yukon Territory, Y1A 2C8. Phone 867-667-5623, 867-667-5225.
Part 4, Section 12, Blank Forms and Form Letters.
Form 1, Information Request. Form 2, UCC Financing Statement. Form 3, UCC Financing Statement Addendum. Form 4, UCC Financing Statement Amendment. Form 5, UCC Financing Statement Amendment Addendum. Form 6, Filing Cover Sheet. In care of Post Office Box 9999, Los Angeles 90010, California Republic, March 1st, 2002. Celine Sanchez, State Registrar, New Mexico Vital Records and Health Statistics, P.O. Box 26110, Santa Fe, NM 87502-6110. Ray, Security of Property in your custody. Dear Miss Sanchez, this letter is written to you in your capacity as custodian of my property, i.e., my common law copyrighted name, in all its forms. As it appears on the security instrument in your custody identified as, in all capital letters, State of New Mexico Department of Health, Public Health Division, Bureau of Vital Records and Health Statistics, Certificate of Birth, File Number 55-2222-333, as well as may appear on any similar antecedent or subsequent birth record. As you are aware, protection of my personal right / property right in parentheses in respect of the aforementioned personal property and the security of my personal property are paramount obligations for you as custodian holding the office of state registrar. For the above reasons and others unnamed, the following are my instructions for you as custodian of my common law copyrighted property concerning your custodial obligations. Neither you nor all capital letters State of New Mexico Department of Health, Public Health Division, Bureau of Vital Records and Health Statistics, nor any other party within all capital letters State of New Mexico has my permission to divulge, reveal, confirm, release, transfer, relay, discuss, verify, or otherwise communicate or disseminate in any way my common law copyrighted property, i.e., my name, my personal information, and likewise any of my highly restricted personal information with any third party, including but not limited by any and all government employees, agents, officers, agencies, and organizations, as well as any and all private individuals, companies, and corporations. If you are in violation of my wishes as stated above, you will need to rectify the situation immediately by informing any and all appropriate parties of the private nature of my common law copyrighted property and the mistake made in releasing it from your custody. The property will need to be returned to your sole custodianship and avoid penalties. Since you are the sole custodian of my common law copyrighted property, as described above, you are the sole party responsible for its safekeeping. Please review the enclosed certified copy of the notice of the common law copyright on my name and guide yourself accordingly. Sincerely, Common Law, Common English Spelling and Pronunciation, John Henry Doe, superscripted copyright symbol. Enclosed certified copy of affidavit of publishing of copyright notice. Which will it be? The Uniform Commercial Code, quote, UCC, the subject of this manual, is transcendent paramount achievement of the efforts of a few thousands of intensely dedicated and single-minded collaborators, in parentheses, dare we call it conspiracy, over the last 2+ millennia. It is the culmination of an almost incomprehensibly complex, systematic, intricate, pervasive, and far-reaching agenda of strategic and tactical global planning to secure absolute legal, financial, social, ecclesiastical, and political, in parentheses military, dominance over the people of Earth. The fundamental medium chosen for accomplishing these inquisitive aims, commerce. The UCC, first introduced in 1954, has been developed across the centuries with microscopically excruciating and painstaking attention to detail for avoiding forever risk of detection and revelation of its true nature. It was fully expected that the code would never be cracked. Proof of this fact is the absence of any device / mechanism for the enforced reversal of the process and recapture of slaves who managed to break free. If you are a slave interested in breaking free, this manual has answers you have been searching for. Embarking on the pages of this volume, however, is comparable with taking the red pill, and so should be carefully considered by worshippers of Big Brother and the faint of heart. For with such knowledge also comes the innate urge to take responsibility, an unpleasant prospect for many. No matter your level of interest in the workings of the world around you and your commitment in making it a better place, if you decide on the red pill, you will never again see it the same way. The code has been cracked and awaits your decision. Which will it be? Cracking the Code, 3rd edition. Additions / updates, in parentheses, December 27, 2002. New entries in red. Page. Where to insert. Addition/update. 14. Before first paragraph. The Federal Reserve monetary system is designed to bankrupt every single non-insider who partakes in it, in parentheses including you, and, however gradually, is achieving its covert objective against the American people with undeniable regularity. Quote, bankruptcy filings reach record 1.5 million. New York bankruptcy filings surged 19% to a record 1.5 million last year as businesses and consumers struggled under heavy debt loads during the economic slowdown. Quote, consumer bankruptcies, which accounted for 97% of all filings, jumped 19%, while business bankruptcies rose 13%. According to data released Tuesday by the Administrative Office of the U.S. Courts, USA Today, February 20th, 2002. 16. Footnote, third paragraph, first line, after first usage of books. The more numerous the laws, the more corrupt the government. Tacitus, 100 A.D. 41. Before subheading Esquires, right to practice law, a British monopoly since 1178 A.D. The Crown's continuous control of, a monopoly over, the U.S. judicial system is confessed nowhere more eloquently than in the July-August 1976 edition of the Journal of the Missouri Bar, page 271, by Wade F. Baker, Executive Director of the Missouri Bar. Quote, it was almost 800 years ago, in 1178 A.D., during the reign of Henry II, that citizens of England, because of unscrupulous practices of untrained persons, petitioned the king for establishment of a trained body of men and women, learned and skilled in the law, whose character would be attested by the crown. The legal profession was thus formalized and given a monopoly by the crown to practice law for the public good. Quote, when the United States Constitution was adopted, it granted to each citizen the trial of all crimes by jury, and Amendment 6 to the Constitution confirmed the right of assistance of counsel in such trials. Each state's constitution has provided that citizens have the right to appear and defend in person and by counsel in criminal prosecutions. Quote, thus, for 8 centuries, the legal profession has been formally recognized and granted a monopoly to serve the public. Quote, courts are in the main managed by lawyers who hold judicial positions. 51. Revised footnote 30 as follows. Federal Reserve Chairman Alan Greenspan, Esquire, is the most recent recipient of honorary knighthood, in parentheses, in recognition of the benefit that the United Kingdom has received from the wisdom and skill of the Fed chief. Quoting Queen Elizabeth in Greenspan is given the royal treatment, LA Times, 9/27/2002. But apparently the past many American presidents also have been honored with knighthood. In parentheses, Sir, title of nobility, bestowed by the Queen. 56. New footnote, under Fair Debt Collection Practices Act, in parentheses, in middle of page, after first bulleted entry. Contacts regarding unpaid tax. All contacts from IRS, in parentheses, phone, mail, email, in person, are contacts regarding unpaid tax. Therefore, this simple admission is proof that IRS is not part of government, because all IRS tax collection activity is subject to FDCPA. 57. New footnote, second paragraph, fourth line after the phrase in the field. In the field. The words in the field imply military operations with a view to an enemy, and it has been said that in view of technical and common acceptation of the term, the question of whether an armed force is in the field is not to be determined by the activity in which it may be engaged at any particular time. Uniform Code of Military Justice Act of 5 May 1950, IRS agents, FBI agents, Secret Service agents, etc., are known as agents in the field. See also field warehouse receipt and glossary. 57. New footnote after last word, in parentheses WTO, of last paragraph, confirming China's role in the commercial conquest of Earth is the astronomical growth in the Esquire population in that country. The official Xinhua News Agency reported on July 7, 2002, that the All China Lawyers Association said that the number of attorneys in China stands at 110,000, up from a mere 200 2 decades ago, a 55,000% increase in only 20 years. The General Secretary of the association also confirmed that there are nearly 10,000 law offices in China. In parentheses, China's population of lawyers skyrockets. LA Times, Monday, July 8, 2002. 58. Place top paragraph and newspaper article quote with the inevitable denouncement of the clandestine love affair between Beltway commies and Chinese labor is portended nowhere more clearly than in an article from the October 21st, 2002 edition of the Los Angeles Times. China polishes off rivals in furniture production. Backed by cheap labor, the country has become the top exporter to the U.S. in less than 10 years. Dongguan, China, in a vast climate-controlled room far from the dust and dim of the wood-cutting machines, rows of young Chinese women create elaborate patterns from the thin strips of wood. Fingers flying, they shape veneer into complex patterns of contrasting grains and colors, wooden tapestries meant to transform mere cabinets into objects d'art. The workers who craft these designs are paid 40 cents an hour, which allows factory owner Samuel Kowal to make high-end furniture for American consumers for 30% less than his U.S. competitors can. In less than a decade, China has become one of the world's leading furniture producers and the top exporters to the U.S. Denouement, the final unraveling or solution of the plot of a play, novel or short story, issue, outcome, any final issue or solution. For the next 10 or 15 years, China will be the manufacturing base for all the world, said Kuwu. 47, whose lacquer craft manufacturing company ships 1,400 containers of furniture, the equivalent of 18,200 bedroom sets, to the United States each month. An outpouring of Chinese products is reshaping the global economy. Around the world, makers of everything from bicycles to bath towels are struggling to survive. Intense competition from inexpensive, high-quality Chinese goods. Thousands of factories have closed as production jobs have moved to China. We can't expand fast enough, said Michael Keith Estes, a managing director at Akzo Nobel. He predicted that 90% of the U.S. furniture production would move to China within 5 years. It's a sleeping dragon, and it woke up. 58. New footnote, next to last paragraph, third line, following the word consumers. The big question, Jeffrey E. Garton, Dean of the Yale of Management. Observed recently as whether the world economy is becoming so dependent on China as an industrial lifeline that it will soon be dangerously vulnerable to a major supply disruption. In other words, Garton wrote in the June 17 issue of Business Week, will China's importance to global manufacturing soon resemble Saudi Arabia's position in world oil markets? In parentheses, sleeping giant decides to rise and shine. Los Angeles Times, Wednesday, July 10th, 2002. 64. Before the subheading, Your Future.
The status quo.
As cited earlier, the Crown has enjoyed exclusive control of the legal profession since 1178 AD, using bar card-carrying urban guerrillas in three-piece suits called attorneys at law, rather than M16-toting mercenaries in government-issue camouflage. The Crown, and the banking interest behind it, has almost completely wrapped up its mission by successfully infiltrating and subjugating the government of nearly every country on earth. No longer do people in America lived their life under God, as originally intended at the inception of this country, but under the rule of law, as quoted directly from the mission statement and parentheses military objective of both Bar Association and judicial system. Even the so-called sham separation of church and state doctrine has been utterly debauched across the land, with officer of the state esquires dictating policy over tax-exempt slave of state religious corporations, hidden in plain sight on the pages of any major metropolitan newspaper in America on any given day as a status report on just how far down the primrose path we have been led by the honorable esquires that comprise approximately 58% the legislative, judicial, and executive branches of the U.S. government. Apparently, it is now common knowledge that black is really white and that up is really down. Men and women have earthly existence and can affect physical changes on the world around them. Corporations exist in name only and can neither think nor speak nor act in any way, but still are considered capable of it by the legislative branch, in parentheses, Congress, accused of it by the executive branch, in parentheses, prosecutors, and tried for it by the judicial branch, in parentheses, judges, every day. From a front page article in the June 16, 2002 edition of the LA Times entitled, Anderson Found Guilty of Obstruction. Quote, Houston, a federal jury convicted accounting firm Arthur Anderson of obstruction of justice Saturday, sending the firm to the brink of extinction and giving the Justice Department a crucial win in its probe of Enron Corporation. Quote, Jurors said the verdict arose not from Anderson's shredding of Enron documents, the crux of the government's case, but from the actions of an Anderson staff attorney who has not been charged and who invoked her right not to testify at the trial. Sentencing is set for October 11th, when the firm could face a $500,000 fine. The jury determined that Nancy Temple, an Anderson attorney, had criminal intent when she ordered the shredding of certain Enron documents. However, Temple has been officially forgotten, and the criminal/financial in parentheses commercial charge is being leveled against Anderson, an artificial person with no capability of physical action. Even though corporate Anderson can act only through its attorney, the idea in the mind, ink on paper corporation, has been convicted of criminal acts and will soon be fined for crimes committed by the actual flesh and blood perpetrator who enjoys the benefit of a title of nobility, in parentheses, immunity from prosecution. The legal system has officially equated men and women with a corporation via instigation of and insistence upon the trade name, and now selectively, criminally/financially, in parentheses commercially, charges either in accordance with its immediate needs. In the above example, as with countless others, the officer of the state, British title of nobility holding criminal, remains free to continue serving the crown in its rape of America via the judicial system and bar association without interference. 80. New footnote, last paragraph, 10th line, after the phrase, retirement age. White House Press Secretary Ari Fleischer took a swing at the existing Social Security program, calling it dangerous to let people pay a lifetime of high taxes for a Social Security benefit that under current projections they'll never receive. In parentheses, White House says Bush still backs benefit plan. LA Times, Thursday, July 25th, 2002. 92. Immediately before, Black's Law Dictionary, 4th edition. Black's Third equals Black's Law Dictionary, 3rd edition, 1933. 100. After last definitions of attorney, strictly one who is designated to transact business for another. Black's Law Dictionary, 7th edition. 146. Add the following definitions and note Under money, money, a general, indefinite term for the measure and representative of value. Currency, the circulating medium, cash. Money is a generic term and embraces every description of coin or bank notes recognized by common consent as a representative of value and affecting exchanges of property or payment of debts. Hobson v. Fountain, 5, Humph, Tennessee, 140. Money is used in a specific and also in a general and more comprehensive sense. In its specific sense, it means what is coined or stamped by public authority and has its determinate value fixed by governments. In its more comprehensive and general sense, it means wealth, the representative of commodities of all kinds, of lands, and of everything that can be transferred in commerce. Paul v. Ball, 31 TEX. 10. In its strict technical sense, money means coined metal, usually gold or silver, upon which the government stamp has been impressed and indicate its value. In its more proper sense, money means any currency, tokens, bank notes, or other circulating medium in general use as the representative of value. Kennedy v. Breyer, 45 TEX. 305. Black's Law, 3rd edition. Congress can exercise no power by virtue of any supposed inherent sovereignty in the general government. Indeed, it may be doubted whether the power can be correctly said to appertain to sovereignty in any proper sense as an attribute of an independent political community. The power to commit violence, perpetrate injustice, take property by force without compensation to the owner, and compel the receipt of promises to pay in place of money, may be exercised, as it often has been, by irresponsible authority, but it cannot be considered as belonging to a government founded upon law. But be that as it may, there is no such thing as a power of inherent sovereignty in the government of the United States. Juilliard v. Greenman, 1884, 110, U.S. 421. Note: gold, which is actually portable land, is the money of sovereigns and consists of value. Before the 1933 declared bankruptcy of the U.S. government, money consisted of gold and silver specie, as well as its equivalent in certificate form, and was representative of value. Today's so-called money, in parentheses, Federal Reserve notes, is fiat money, i.e., money by decree, monopoly money, is not representative of value, but rather debt / liability, and is the money of artificial persons, called banks, governments, corporations, trusts, and individuals, in parentheses, see individual, etc. In block parentheses, please also note the use of the word public in the expression public authority that appears in the 6th line of the first definition above. Although Big Brother very cleverly disguises the true meaning of this term contemporarily, this 1933 usage makes it very clear. Public equals government.
Side note: it is generally accepted that an attorney is an officer of the court and, as such, an officer and arm of the state. 7. Corpus Juris Secundum. 4. Virgin Islands Bar Association vs. Dench. D.C. Virgin Islands 124 F.SUPP. 277.
157. Add the following definitions and note under public. Quote, money is used in a specific and also in a general and more comprehensive sense. In its specific sense, it means what is coined or stamped by public authority and has its determinative value fixed by governments. Black's Law, 3rd edition. Note: try as it may, Big Brother cannot completely disguise the true meaning of the word public. The leopard cannot change its spots. There is nothing altruistic about contemporary employment of the term, as is discernible from its 1933 usage in Black's Law Dictionary 3rd edition and the last definition above. The real meaning of public is government. 184. Add the following definition and modify note under value as follows. Quote, the utility of an object is satisfying, directly or indirectly, the needs or desires of human beings, called by economists value in use, in block parentheses SIC, or its worth consisting in the power of purchasing other objects, called value in exchange. Also, the estimated or appraised worth of any object or property calculated in money. Black's Law, 3rd edition. Note, there was a time in America when the currency represented value because it could be exchanged for a fixed amount of precious metal, in parentheses, gold or silver. When we lost the gold standard, the definition of value had to be debauched so as to accommodate the new valueless money, Federal Reserve notes. This perversion of the term is evidenced clearly by comparing the Black's Law 3rd edition, in parentheses 1933 definition of value, and the UCC definition, in parentheses 2002. A necessary provision of law is remedy, in parentheses, see remedy. Modern operation of acceptance for value is by deduction remedy. When you file a UCC financing statement and redeem your original birth document and claim ownership of the trade name, no one can dispute/challenge the claim, and a reconveyance of title is effected. You have, by definition, the supreme right in the title of the birth certificate, straw man/trade name, over all others because its very existence is derived entirely from you, thereby evidencing value, as the term is used contemporaneously in the UCC. In fact, all of the above UCC definitions apply directly in the case of you and your trade name. A good exercise would be to work through all the definitions until you understand how the value aspect applies. Subparagraphs A, B, and C of the sample private agreement on page 237 are taken directly from the above definitions of value. Once you fully understand how you have given and continue to give value, you will know how you acquired your rights, and you will also achieve an unshakable certainty of your true standing in the societal scheme of things. The fact that you have given value is confirmed every time a bank accepts your promise to pay, in parentheses, and uses it to issue a so-called loan, and tacitly acknowledged and validated by government in its silence and registration of the UCC financing statement. Among other things, the instrument, in block parentheses, your birth document, is transferred, in block parentheses, redeemed by you, as security for an antecedent claim against any person, in block parentheses, your trade name, based on your pre-existing claim. 198. Replace, as signified by, with, subscribed with, in both the 6th and 12th line. 200. Replace, as signified by, with, subscribed with, in both the 8th and 15th line. 204. Replace paragraph I.A. with the following. A. Source book for UCC filings. It is recommended that you obtain the source book, Uniform Commercial Code and Related Procedures Guide, 242 pages, published by Registre, Incorporated, and available directly from BB&C of America. This book tells how to obtain forms from every state/territory, as well as instructions for filing in every American and Canadian UCC filing office. It includes both mailing and street address, website, email address, phone, and fax for each filing office, as well as other pertinent information for each particular jurisdiction. Order online at www.bbcoa.com or send $39.95 plus $4 shipping and handling to BB&C of America at the mailing location appearing at the beginning of this book. 204. Replace the last sentence of paragraph ID with the following: transmitting utility status is beneficial and that the filing is permanent and need not be renewed every 5 years. As with all other types of debtors, in parentheses, more evidence that this is the right path, but is not a requirement for filing. Do not hesitate to omit checking this box if your filing is rejected because of it, in parentheses, and then just renew every 5 years or file anew after office personnel have changed. 216. Replace the last paragraph under IB with the following: once you know the original filing number, you can order a certified copy of your filing using the procedure in Section 7. Even though you may save time by ordering a certified copy at the time of filing, this is not always advisable. Filing offices consider it normal to provide a certified copy of a filed record, in parentheses, usually for use in a court case, but may regard a request for such at the time of filing as unusual. If time is not a consideration, you may want to consider ordering after you have filed. 217. Replace the second paragraph under ID with the following: the new cover sheet offered herein, in parentheses, a sample appears on page 236, a blank form on page 389. Lets the filing officer know that you are a knowledgeable filer, but because of its association with this process, can also act as a signal for the filing officer and cause him/her to reject your filing arbitrarily. You need to decide what is best for you in getting your financing statement filed. Filing officers are not free to reject filings at their whim and are restricted by the limitations imposed by UCC 9-520, which states: 221. Replace paragraph 12B with the following: B. Optional redemptor filing. Complete true name, in parentheses, given name, surname, initial letters only capitalized, appearing completely within the box marked individual's last name. This is unusual and should be done only where the filer was confident that the filing would not be rejected because of it. Note: because the indexing of the secured party's name is not as crucial as that of the debtor, a filing officer may let this slide. Some people prefer not to enter their true name military style in the 3 boxes, as is done with trade names and other corporately colored entities, but we, however, recommend it. There appears to be no advantage in doing it otherwise. 223. Replace paragraph 29 with the following: 29. Addendum Box 18. Unless you are certain that your state will reject a transmitting utility filing, always place an X in the box marked debtor is a transmitting utility. A transmitting utility filing is permanent and need not to be renewed every 5 years, as with all other types of debtors. A non-transmitting utility filing is just as valid, but must be renewed, in parentheses, by amendment in a continuation filing within the last 6 months of each 5-year period, in parentheses, resubmitting an original filing after filing office personnel have changed may also result in acceptance. The remaining 2 boxes in box 18 are not applicable for our purposes and so should be left blank. 230, 234. Modify data in box B as follows: common law, English spelling and pronunciation, John Henry Doe, Post Office Box 9999, Los Angeles, CA 90010. 230, 234. Modify data in box 3C as follows: Post Office Box 9999, Los Angeles, CA 90010. 230. Replace data in box 4 with the following: all of debtor's assets, land, and personal property, and all of debtor's rights in said assets, land, and personal property, now owned and hereafter acquired, now existing and hereafter arising, and wherever located, described fully in security agreement number JHD-050690-SA, dated the 6th day of the 5th month in the year of our Lord 1990. Inquiring parties may consult directly with debtor for ascertaining in detail the financial relationship and contractual obligations associated with this commercial transaction identified in security agreement referenced above. Adjustment of this filing is in accord with UCC Statute 1-103, 1-104, and House Joint Resolution 192 of June 5, 1933. Secured party accepts debtor's signature in accord with UCC Statute 1-201, Section 39, 3-401. 234. Replace data in box 4 with the following: all of debtors' assets, land, and personal property, and all of debtors' rights in the real property commonly known as 123 Elm Street, Los Angeles, CA 90011, now owned and hereafter acquired, now existing and hereafter arising, described fully in security agreement number JHD-050690-SA, dated the 6th day of the 5th month in the year of our Lord 1990. Inquiring parties may consult directly with debtor for ascertaining in detail the financial relationship and contractual obligations associated with this commercial transaction, identified in security agreement referenced above. Adjustment of this filing is in accord with UCC Statute 1-103 and 1-104, and House Joint Resolution 192 of June 5, 1933. Secured party accepts debtor's signature in accord with UCC Statute 1-20139 and 3-401. 236. See revised cover letter 237 through 251. Replace document number in parentheses in heading and footer, and common law date of private agreement. Hold harmless an indemnity agreement. Attachment sheet. See paragraph 9 of attachment sheet as well, and private collateral list with 050690. 6th day of the 5th month in the year of our Lord 1990. 237, 239, 241. Modify name and mailing location at top under creditor as follows: common law, English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, Post Office Box 9999, Los Angeles, CA 90010. 241. Replace definition of claim in words defined, glossary of terms with claim. In this security agreement, the word claim means 1A, right to receive payment in the form of any of the following: a judgment, damages in any of the following forms: liquidated, unliquidated, fixed, contingent, matured, unmatured, disputed, undisputed, legal, equitable, secured, unsecured, a ruling derived from an equitable remedy for breach of performance if such breach results in a right to receive payment, both in the form of a judgment as well as in the form of debts / obligations, in any of the following forms: fixed, contingent, matured, unmatured, disputed, undisputed, secured, unsecured. 1. Section B. A challenge of property, any challenge of ownership of a thing that is wrongfully withheld. 2. Section A. To demand as one's own. 2. Section B. To demand as one's right. C. Hill v. Henry, 66, N.J. EQ. 150, 57, ATL. 555, Douglas v. Beasley, 40, ALA. 147, and Prigg v. Pennsylvania, 16, PET. 615, 10, L.ED. 1060. 260, 262. Modify data in box B as follows. Common law, English, spelling and pronunciation, John Henry Doe, Post Office Box 9999, Los Angeles, CA 90010. 260. Modified data in box 7C as follows. Post Office Box 9999, Los Angeles, CA 90010. 260. Modified data in box 8 as follows. Revisions in bold. Secured party herewith executes a full assignment of collateral, i.e., all of debtor's assets, land, and personal property, and all of debtor's rights in said assets, land, and personal property, now owned and hereafter acquired, now existing and hereafter arising, and wherever located, described fully in security agreement number JHD-27AX, in favor of assignee, new secured party of record, common law, English, spelling and pronunciation, John Henry Doe. Acquiring parties may consult with debtor directly for ascertaining in detail the financial relationship between debtor and new secured party of record, identified in security agreement referenced above. 262. Modified data in box 8 in parentheses and box 13 if length of text requires it, as follows, in parentheses, revisions in bold. All of debtor's assets, land, and personal property, and all of debtor's rights in said assets, land, and personal property, now owned and hereinafter acquired, now existing and hereafter arising, and wherever located, described fully in security agreement number JHD-050690-SA, dated the 6th day of the 5th month in the year of our Lord, 1990, in favor of assignee, new secured party of record, common law, English, spelling and pronunciation, John Henry Doe. Inquiring parties may consult with debtor directly for ascertaining in detail financial relationship between debtor and new secured party of record, identified in security agreement referenced above. Adjustment of this filing is in accord with UCC Statute 1-103 and Statute 1-104 and House Joint Resolution 192 of June 5th, 1933. Secured party accepts debtor's signature in accord with UCC Statute 1-201, Section 39, Statute 3-401. 271. See revised version of handling presentments instructions for additions /updates /corrections. 287. Replace as signified by with, subscribed with, in fifth line of fourth paragraph. 288. Replace as signified by with, subscribed with, in sixth line of first paragraph. 290. Immediately before common law, English, spelling and pronunciation, John Henry Doe, and words defined, glossary of terms, insert the following. All capital letters ens legis, John H. Doe. In this notice by written communication, the term all capital letters ens legis, John H. Doe means all capital letters ens legis, John H. Doe, superscripted copyright symbol, a derivative of all capital letters ens legis, John Henry Doe, superscripted copyright symbol, common law copyright, superscripted copyright symbol, 1973 by common law, English, spelling and pronunciation, John Henry Doe, superscripted copyright symbol, all rights reserved. 295. In uppermost left-hand corner, insert military-style name and address of debtor in capital letters, ens legis, Jones, Jacks. 5143, Tunnel Vision Drive, Columbus, Ohio, 43222. 295. Replace as signified by with, subscribed with, in next to last line of second paragraph, in sixth line of third paragraph. 376. Update Florida contact data as follows. Florida UCC Inc. P.O. Box 5588, Tallahassee, Florida 32314. Phone 850-222-8526. Website www.dos.state.fl.us/doc/FAWUCC.html. Email corphelp@mail.dos.state.fl.us. Cracking the Code 3rd Edition, Arata/revisions, December 27th, 2002. New entries in red. Page, correction/revision, 3, in parentheses, copyright notice/security agreement. The phrase, interest in property, which appears numerous times in this document, in parentheses, and throughout the book, should be rights in property. 20. Footnote 5. how to sign your signature when demanded, should be how to sign your signature without liability. 5. Fifth paragraph, first line, in parentheses, and elsewhere throughout the book, true name should be true name. 12. Quote from Burt's Latin English Dictionary in middle of page, appellat, SIC, should be appellatio. 13. Second paragraph, first line, appellato, SIC, should be appellatio. 43. Last paragraph, second line, second instance of Statute 6125 should be Statute 6002. 57. Delete last sentence of footnote 52. 65. Replace last sentence of first paragraph with the following. The U.S. government is a bankrupt front operation for these miscreants, propped up for no other reason than to financially bilk and politically, in parentheses militarily, subjugate any and all who mistakenly do business with it. 68. First paragraph, third line, in parentheses and elsewhere on the page. HOEVLER should be HOEVELER. 195. Replace paragraph 3A with the following. A. Manner of dating the document. The date of the copyright notice is reflected in the date of another document cited within the copyright notice called the Hold Harmless and Indemnity Agreement, and is spelled out common law style, e.g., the 6th day of the 5th month in the year of our Lord, 1990. The common law designation for May 6, 1990, in parentheses, done so for removing the document from the statutory dating system, which is also an indication of grant of jurisdiction, however slight. The numerical designation of the number of the hold harmless and indemnity agreement would also match up with this date, e.g., quote, JHD-050690-HHIA, i.e., in block parentheses, Redemptor's initials, in block parentheses, MMDDYY, in block parentheses, document initials. Note, the date of the sample hold harmless and indemnity agreement on page 239 matches up with the Finley copyright notice, not the single copyright notice. 196. Replace last sentence of first paragraph with the following. All events implied within the copyright notice must come before the cited date of the hold harmless and indemnity agreement, in parentheses, private agreement and security agreement have the same date. 196. Second paragraph, seventh line, copyright should be security agreement. 198 and 199. Replace the term interest with rights in the following places. Under self-executing contract / security agreement in event of unauthorized use, paragraph 1, second line, paragraph 2, fifth line, and paragraph 4, fourth line. Under default terms, modify both third and ninth lines to read rights and property. Under terms for curing default, second line and fifth line, and under terms of strict foreclosure, fourth line. 199. Under default terms, third line, delete and property. 200 and 201. Replace the term interest with rights in the following places. Under self-executing contract / security agreement in event of unauthorized use, paragraph 1, third line, paragraph 2, fifth line, and paragraph 4, fourth line, it reads rights and property. Under default terms, third line and ninth line. Under terms of curing default, second line and fourth line. And under terms of strict foreclosure, fourth line. 200 and 202. Replace third from last sentence with ownership subject to copyright of common law, trade name / trademark, and security agreement and UCC financing statement filed with the UCC filing office. 201. Under terms for curing default, add the bolded portion of the text below as follows. Upon event of default, as set forth above under default terms, irrespective of any and all of user's former property and rights in property described above in paragraph 2, and the possession of. 220, last paragraph, last line, replace all capital letters first name with all capital letters middle name. 222, under 14a, standard filing. In the first line of the quoted text, replace interest with rights. 222, under 14b, cross-filing. In the first line of the quoted text, replace interest with rights. 223, paragraph 20, second line, replace 5 with 4. 238, boxed in legal citation, quote, under non-abstente, should be under living, breathing, flesh and blood man. 271 through 286, see revised version of handling presentments, instructions for additions /updates /corrections. 287, in uppermost left-hand corner of page, in parentheses header, replace all capital letters ends legis, Doe, John Henry, superscripted copyright symbol, P.O. Box 9999, Los Angeles, CA 90010, with all capital letters ends legis, Mitchell Lawrence D. 9500 Wilshire Boulevard, Beverly Hills, CA 90212. 287, in upper right-hand corner of page, replace USPO with USPS. 287 through 291, when referencing the common law copyrighted trade name, replace trademark with trademark throughout the document. 288, replace interest with rights as follows. Paragraph 1, first line. Paragraph 2, third line from end. Paragraph 4, third line. Paragraph 9, B1, first line. Paragraph 9, B3, fourth line. Paragraph 9, C, second line and last line, and paragraph 9, D, third line. 290. Replace first sentence of first paragraph with ownership subject to copyright of common law trade name /trademark and security agreement and UCC financing statement filed with the UCC filing office. 291. Boxed in legal action, quote, under sentient, living being, goes under living, breathing, flesh and blood man. 291. Last line before signatures, add superscripted copyright symbol after Doe. 294. Replace post office with postal service in middle section. 295. Under title of document, replace USPO with USPS. 295 through 308. When referencing the common law copyrighted trade name, replace trademark with trademark throughout the document. 297. Replace second from last sentence in first paragraph with ownership subject to copyright of common law trade name /trademark and security agreement and UCC financing statement filed with the UCC filing office. 300. In second line of paragraph 3, replace also known as in with accompanied by. 309. In uppermost left-hand corner of page, in parentheses header, replace all capital letters ends legis, Doe, John Henry, superscripted copyright symbol, P.O. Box 9999, Los Angeles, CA 90010, with all capital letters ends legis, Mitchell Lawrence D. 9500 Wilshire Boulevard, Beverly Hills, California 90212. 311. Paragraph 9 should be paragraph 8. Renumber accordingly from that point on. 311 through 312. In paragraphs 5 through 11, replace for using with to use. 312. Paragraph 18, first line, quote, and any should be, quote, any and. 313. Paragraph immediately following paragraph 21. First line, replace rebutting with to rebut, and superscripted copyright symbol after do, and next to last line, replace, quote, defendant with, quote, default. 313. Last paragraph before date, first line, delete, common law, trade name, / trademark, copyright, superscripted copyright symbol, 1973. 314. Second line, replace, November 12th, 2001, with March 25th, 2002. 358. Third paragraph from bottom, delete entire paragraph.
Handling presentments. Instructions.
Introduction. A. Understanding presentments. The dictionary definition of presentment concerns both criminal matters and financial matters, and descriptive terms within the definition of each type are synonymous for the most part. Presentments fall into two categories: demands for payment and demands for acceptance, in parentheses, a responsibility for payment / performance, defined as follows: a formal written accusation returned by a grand jury on its own initiative without a prosecutor's previous indictment request. Quote, a grand jury has only two functions, either to indict or to return a no bill. The Constitution speaks also of a presentment, but this is a term with a distinct historical meaning, now not well understood. Historically, presentment was the process by which a grand jury initiated an independent investigation and asked that a charge be drawn to cover the facts should they constitute a crime. With United States attorneys now always available to advise grand juries, proceeding by presentment is now an outmoded practice. Charles Allen Wright, Federal Practice and Procedure Statute 110 at 459, in parentheses, 3rd ed. 1999, Black's Law Dictionary, 7th edition, in parentheses, 1999, hereinafter Black's Law, 7th edition. The formal production of a negotiable instrument for acceptance or payment. Presentment and dishonor occur, for instance, when the holder of a check attempts to cash it at the drawee bank, but payment is refused because the drawer lacks sufficient funds on deposit. The demand for payment is the presentment. The bank's refusal to pay is dishonor. James J. White and Robert S. Summers, Uniform Commercial Code, Statute 16-8, at 100, in parentheses, 4th ed. 1995, Black's Law, 7th edition. Presentment is a demand for acceptance or payment made upon the maker, acceptor, drawee, or other payer by or on behalf of the holder. UCC Statute 3-504, 1, Black's Law Dictionary, 6th edition, 1990, hereinafter, Black's Law, 6th edition. In criminal matters, a bill, i.e., charges, in parentheses, like financial charges, in the form of a formal written accusation of a crime called an indictment, in parentheses, presentment, is presented to a court, in parentheses, by the prosecutor for prosecution. A true bill is a list of charges that is sworn true, correct, and complete, in parentheses, affidavit, by a grand jury. Based on the sworn charges of the grand jury, the prosecutor is indemnified for whatever action he takes based thereon. The prosecutor then draws up his own presentment, called a criminal complaint, based on the indictment, in parentheses, true bill, and demands that the named party accept responsibility for the charges.
Side note, drawee, one to whom a bill of exchange or a check directs a request to pay a certain sum of money specified therein. In the typical checking account situation, the bank is the drawee. The person writing the check is the maker or drawer, and the person to whom the check is written is the payee. Barron's Law Dictionary, 3rd edition, 1991. End side note.
Because of the U.S. bankruptcy and the institutionalization of fiat in parentheses by decree money called Federal Reserve Notes, FRNs, there have been commensurate changes in the realm of jurisprudence. American tribunals are now Federal Reserve Note tribunals dealing exclusively in FRNs and enforcing the private, copyrighted, corporate policy of the owners of the FRNs, known as code. In parentheses, all U.S. code/law is copyrighted by British corporations. See footnote 13 on page 41 of The Truth About Esquires for details. Notice, in the quoted case under the first definition above, that because of the influence of the United States attorneys, proceeding by presentment, in parentheses, of the grand jury, is now an outmoded practice, we now operate in summary proceeding, in the vast majority of legal undertakings in America, traffic court being the most common.
Summary proceeding.
Any proceeding by which a controversy is settled, case disposed of, or trial conducted in a prompt and simple manner, without the aid of a jury, without presentment of indictment, or in other aspects out of the regular course of the common law. Black's Law Dictionary, first edition, 1891, hereinafter, Black's first. A demand for acceptance is a demand for acceptance of responsibility, in parentheses, for payment or for performance of some act, and may also entail payment of some kind at a later date. A traffic ticket is a combination criminal/financial instrument. The traffic cop issues an order, and the motorist makes a promise. Negotiable instruments consist strictly of orders to pay and promises to pay, and traffic tickets are negotiable instruments. The cop issues an order for acceptance, in parentheses, of responsibility to pay against the credit of the trade name, and the motorist signs a promise to, in parentheses, accept responsibility for the charge and appear, in parentheses, and if necessary pay the ticket. If the motorist fails to accept responsibility for the ultimate payment of the ticket at any point in the process, he is arrested and jailed, in parentheses, put in debtor's prison. When anyone in government demands that you accept responsibility to perform some act, he is issuing a presentment, concerning which there are monetary charges associated with a failure to perform said act. Presentments come in oral, written, and electronic form. Acceptance of any presentment executes a contract. In the private sector, presentments usually come from attorneys, but since all attorneys are officers of the state, we are faced with essentially the same situation. The court system would not be a profitable enterprise without attorneys, who are endowed with a special property right, in parentheses, right to practice law, granted a title of nobility, in parentheses, esquire, via letters patent, and elevated above common men, in parentheses, fees enforced by judicial decree, win or lose, in exchange for bird-dogging customers into the courtroom. In order to issue a presentment, a prospective issuer must have an account where a charge can be lodged. For example, if police cannot determine the trade name of a detainee, in parentheses, party held for questioning, within a brief period of time, they must release him. The trade name is the account name under which a sovereign conducts business, albeit unwittingly. The trade name, as well as the true name, comprises property. Registration of your trade name, in parentheses, via birth, etc., constitutes the voluntary surrender of legal title / custody of the property and establishment of an account. When a government actor says, "May I have your name, please?" he is literally asking you to turn over your property, the trade name, for him to use however he pleases, and to charge the account. The flesh and blood man, as surety for the party in whose name the account appears, is held accountable for any charges levied or leveled against the trade name. The reason criminal and financial charges seem to run together, overlap, and mirror the other is that they are both commercial in nature. This is the Admiralty jurisdiction mentioned in Part 1, in parentheses theory of this manual. In Admiralty, the military, in parentheses the executive branch, in its many forms, is used to enforce criminal penalties for civil offenses. The money changer merchants have foreclosed on the U.S. government and use it liberally, via the chief executive to prosecute their own private commercial interests. We are under military rule, literally, by the commander-in-chief of the military, not the president. A primary reason for the broad appeal and workability of the common law is that each man is in control of his own destiny in the social scheme, as long as he does not harm another, and thereby form a contract with an obligation. He is free to live his life as he sees fit, without interference from government. These days, however, people are penalized for an act even when no one is harmed and no property is damaged, e.g., traveling at 35 miles per hour in a 30 miles per hour zone. The police power is thereby employed for penalizing behavior, in parentheses, such as thought crimes, not acts and deeds of substance, for the purpose of raising revenue. When someone violates his own sense of moral rightness in his conduct as a member of society, no matter how justified, he is weakened under the police power of the state. For this reason, it is a good idea to reassess your life as you embark on this stage of the journey and begin using and relying on the power of the documents and processes offered herein, which is formidable, and make sure that you are giving yourself the best chance for a worry-free existence. Betraying your own sense of fair play is the quickest way to undermine all progress. In the end, it is your own sense of decency, ethical behavior, and honest interaction with others that determines your fate. Just by trying to do the right thing on a moment-to-moment basis brings about clarity of perception not otherwise available, and can easily turn out to be your saving grace in the time of need. These documents are all based on the power of the common law, private property rights, and consensual contracts, and are enormously successful in crushing assaults on your fiscal integrity. Their efficacy has been acknowledged at both the lowest and very highest levels of government in this country. They have changed the course of every proceeding in which they were introduced, including criminal cases where the accused was already convicted. That is because the common law still exists and is in full force. It has just been covered over. People have been so severely hoodwinked that many do not even believe there is hope of reversing the oppressive, all-engulfing practices of the system. There is hope. It lies in the common law and in your ability to maintain in the face of the mendacious bent of Big Brother's operatives. Side note, because of the disappearance of substance money, where each man is accountable and there is no private limited liability, we now have a mutant financial system that runs strictly on accounting principles. Because all money is artificial, in parentheses, no substance / reality as with gold. And debt can no longer be extinguished, but merely discharged. See letter for State Registrar, Ray birth certificate, an appendix for one approach to thwart governmental monopolization of the use of your name, both true name and trade name, in forming accounts. C. Crime is Commerce, 27 CFR 721.11, an appendix. Subsection entitled Co-suretyship Obligations Incurred via Acceptance of Free Delivery of Mail in section The Curse of Co-suretyship. B. Scope of presentment handling documents contained herein. What has taken many thousands of dedicated collaborators over thousands of years to put into position will not be fully unraveled in a few hundred pages of exposition, nor do we pretend to be able to fully accomplish such a feat. We do, however, get results, and consistently, because our approach is based on the timeless principles of human dignity and interaction as embodied in, primarily, the common law. The chosen masters are not pleased that their wealth confiscation and freedom usurpation machinery can be rendered ineffective, and even more upset that their own device, in parentheses the UCC, can be used to victimize them. Even when you are completely right, a presenter will sometimes go down kicking and screaming all the way, abusing his influence over the utterly corrupt judicial system and its army of charlatan whore esquires to challenge every shred of knowledge about what you are doing, because such actors are inherently dishonest. They have weaknesses that can be exploited. The documents as offered herein have paved the way for stopping collection activity by effecting strict, in parentheses, non-judicial foreclosure against those who would happily swindle you out of everything you own. However, this manual does not propose to be able to guide someone through the legal minefields that can arise when one goes to foreclose, but there are people who can assist when it comes time for finishing off the job. It is one thing to be able to stop a collection proceeding. It is quite another to foreclose on the while foreclosure, but it can be done. Instructions for such enterprise are not included herein. However, please contact UCC Services Group at www.uccsg.com for a referral when this time arrives. C. A note on pressure situations and criminal cases. The material set forth herein is private in nature. There is no attempt to give legal advice of any kind because we are not licensed to dispense such. This material may be applied, however, in any circumstance where your private common law copyrighted property is being used for commercial gain without your authorization. You are the only one who can decide what should be done. If you are faced with a pressure situation, a demand for a signature, or even a criminal charge, you can still take action in the non-statutory, in parentheses, non-judicial realm against the individual players coming against you by using the private, contractual, consensual measures set forth in the items at the end of this section, beginning on page 18 of these instructions, under Part 7, Protecting Oneself in Pressure Situations and Criminal Proceedings, one essay in particular, How to Sign Your Signature Without Liability, proves utterly the correctness of what we are doing here. 2. Creating your response documents for handling presentments. A. Demands for acceptance. Such presentments are generally from government agents and officers, but can also come from attorneys and individuals, in parentheses, citizen of the United States, trade names, and basically constitute unauthorized use of your common law copyrighted property, regardless of the fact that there may be potential criminal penalties and fines associated with the presentment if from a government actor. You have the unalienable common law right to demand and obtain compensation for the, in parentheses, unauthorized use of your property as set forth in your published copyright notice. This is strictly a private matter between you and any party who is using your property for financial gain without your authorization. 1. Notice by written communication / security agreement. Entitled in non-judicial terms so as to align with tenets of the Uniform Commercial Code. The notice by written communication / security agreement, hereinafter notice by written communication, is recommended for handling presentments that do not demand immediate payment of money. The document is self-explanatory, contains no judicial / statutory jargon, consists of everyday common law language, and is written with a mind toward augmenting the non-judicial foreclosure process of the UCC once the debtor defaults on payment after being invoiced for charges, in parentheses, in the form of a verified statement of account, private equivalent of a grand jury's true bill. It is used against those who issue presentments demanding acceptance, in parentheses, of responsibility for specific performance, or for payment at a later date. 2. Converting sample document. As with all other documents in this manual, there is no other way to generate your personal notice by written communication on your own other than by going through the sample document word by word, learning as you go, and replacing the common law English spelling and pronunciation John Henry Doe's information with yours. 3. Mode of sending. We always use registered mail, sent, restricted delivery, return receipt requested, in parentheses, PS Form 3811, the green card, with an affidavit of mailing exclusively, but, in parentheses, as always, final choice rests with you. 4. Important optional text in 2 segments. There are 2 versions of procedure to opt out of consensual contract on page 2 of the Notice by Written Communication and a subsequent segment entitled Self-Executing Security Agreement. You will need to choose between the 2 options each time a presentment comes your way. Basically, the first one gives the unauthorized user a quick and easy way out with no muss and no fuss, thus ending the confrontation. The second is far more stringent and really puts the unauthorized user in a pickle, and it is doubtful if he/she will get out of it. Note, you are not prohibited from adjusting this paragraph however you see fit, but if you make changes, you should be absolutely certain that they do not contain any statutory/judicial language, and that the parameters that you set are in harmony with the UCC for non-judicial foreclosure. A. Simple opt-out procedure, in parentheses, with subsequent self-executing paragraph. The obligation for payment is no less binding than when a customer looks at the menu, places an order, and then consumes the meal that is served. Procedure to opt out of consensual contract. All capital letters ends legis. Lawrence T. Mitchell's unauthorized use, i.e. counterfeiting of secured parties common law, trade name/trademark and copyright. Consensually, contractually binds, all capital letters ends legis, Lawrence D. Mitchell was secured party as of, all capital letters ends legis, Lawrence D. Mitchell's initial unauthorized use of secured parties common law, trade name/trademark and copyright, in respect of fair compensation due, secured party for use of secured parties private property. All capital letters ends legis, Lawrence D. Mitchell can opt out and withdraw from all capital letters ends legis Lawrence D. Mitchell's consensual contract with secured party and retain no obligation associated therewith only by immediate cessation of any and all further unauthorized use of secured parties common law copyrighted property. Self-executing security agreement. By the act of any single instance of unauthorized use of secured parties common law copyrighted property by all capital letters ends legis Lawrence D. Mitchell, following all capital letters ends legis Lawrence D. Mitchell's receipt of this notice by written communication, all capital letters ends legis Lawrence D. Mitchell, hereinafter user only in this self-executing security agreement section, accepts the obligation of this consensual contract. This notice by written communication concomitantly becomes a security agreement, hereinafter security agreement, wherein user is debtor, and common law, English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, is secured party, and user. B. Difficult opt-out procedure, in parentheses, with subsequent self-executing paragraph. The time period referenced within this segment is the 72-hour Regulation Z Federal Truth in Lending Act period that is initiated when someone voluntarily incurs an obligation. The party has 72 hours from midnight of the day after execution of the transaction to back out of the deal. Procedure to opt out of consensual contract. All capital letters ends legis Lawrence D. Mitchell's unauthorized use, i.e. counterfeiting of secured parties common law trade name/trademark and copyright consensual contracted bind. All capital letters ends legis Lawrence D. Mitchell was secured party as of all capital letters ends legis Lawrence D. Mitchell's initial unauthorized use of secured parties private property in respect of fair compensation due secured party for use of secured parties private property. All capital letters ends legis Lawrence D. Mitchell, can opt out and withdraw from all capital letters and legis Lawrence D. Mitchell's consensual contract with secured party and retain no obligation associated therewith, only by all capital letters and legis Lawrence D. Mitchell's delivery at the hereinabove designated mailing location for secured party no later than 12:01 of the 5th day following user's receipt of this notice by written communication. This notice by written communication concomitantly becomes a security agreement hereinafter. Security agreement wherein user is debtor and common law, common English spelling and pronunciation, John Henry Doe, superscripted copyright symbol is secured party and user. B. Validation of debt package. Respondent's private, international, administrative remedy demand. Presentments demanding payment are the most common because the current financial system is expressly designed to generate defaults, foreclosures, and bankruptcies. Civilization is on a conveyor belt to hell, courtesy of the instigator owners of the duplicitous banking system, using government agents called attorneys at law. People are sitting ducks against the might of the state as concentrated in the judge-attorney brotherhood. There are a few Achilles heels, however, and respondents' private, international, administrative remedy demand. Hereinafter, administrative remedy demand exploits one of them. 1. Loans of credit. Credit lenders flourish only because of interest payments. The borrower is always the source of the principal amount of any alleged loan by virtue of his promise to pay, in parentheses, promissory note, credit application, which becomes a negotiable instrument, i.e., money, per UCC 3-104, which the credit lender then converts into another form, in parentheses, bank draft, cashier's check, in accordance with Federal Reserve lending policies, and reissues, calling it the loan. This is strictly an accounting procedure. The bank loans nothing of substance. Indeed, is forbidden to loan true assets of any kind by banking regulations. This can all be verified with any certified public accountant. Credit lenders do not profit from the principal loan amount, only the interest. This is why, on many loans and in all mortgage contracts, the borrower makes payments on interest charges only for the first many years. This is all gravy for credit lenders. The principal amount never comes into play for the financial institution because that sum is always the property of the borrower, and remains so till the end of the cycle, even if the so-called loan is never paid off. Loans that end in default are simply charge-off, i.e., discharged by bookkeeping entry, with no loss incurred by the bank, which is the precise reason that the techniques delineated in this section are effective in nullifying demands for payment from debt collectors. No risk in the loan process equals no valid claim. Banks, mortgage companies, and credit card companies lend only credit. From the Latin credere, believe, trust. Credit lenders believe in you and trust that you will make all interest payments as you have been legally suckered into. The entire American financial system, engineered and developed into its current state over the last 2,000 plus years by the chosen masters, is an exercise in deceit and treachery of incomprehensible magnitude, predicated on the willful and wanton wholesale destruction of the life of one and all, and the peace and dignity of mankind, based on the worship of money, in parentheses, wealth, mammon, and a psychotic impulse to subjugate and dominate the existence of all others. 2. Fair Debt Collection Practices Act, FDCPA. Per the Act as codified in 15 U.S.C. Statute 1692 ETSEQ, and as abundantly pointed out within administrative remedy demand, a debt collector must, if requested, provide a verification of the alleged debt, i.e., validate the debt. Per FDCPA, the debt collector is mandated to cease all collection activity until verification is provided. A. Verification/validation. Verification is defined as confirmation of correctness, truth, or authenticity by affidavit, oath, or deposition. Affidavit of truth of matter stated, and object of verification is to assure good faith in averments or statements of party. Black's Law, 6th edition. What this means is the debt collector must swear true, correct, and complete in parentheses equivalent of the truth, the whole truth, and nothing but the truth, i.e. testimony, that verifies exchange of valuable consideration that allows the debt collector to demand payment. A sworn affidavit that simply verifies all balances due, cites that correct billing procedures were followed, and other such poppycock is irrelevant. The debt collector must verify the consideration in parentheses substance provided the alleged debtor that validates the debt collector's claim of debt. Since the alleged debtor received no consideration from the debt collector in parentheses and likewise from the original creditor, the debt collector is foreclosed from truthfully claiming such in a sworn affidavit. This is why IRS prosecutes for failure to file an income tax form. A sworn Form 1040 is a validation of the debt. IRS is a debt collection agency. IRS cannot substantiate any debt unless IRS has a sworn statement from the taxpayer that validates the debt. As cited above, banks do not loan substance, only credit, in parentheses air. No third-party debt collector attorney and no other debt collector has any knowledge of a loan of substance, in parentheses valuable consideration. Hence, such are foreclosed from issuing a counter affidavit of any relevance. The system is fraudulent by nature and cannot be made legitimate by false affidavit. The truth is, the only one who can validate a debt is the borrower.
B. Parties exempted from FDCPA.
Government officials, in parentheses IRS personnel, are not government officials, and in-house debt collection personnel of an original creditor are exempted from FDCPA. However, per public policy as codified House Joint Resolution 192 of June 5, 1933, no one can require payment in a particular kind of coin or currency, i.e., no one can require payment in Federal Reserve notes, FRNs, including government collectors and original creditors. This is why you find the statement must be paid in U.S. funds on parking tickets and other demands for payment. There is more than one kind of U.S. funds. If FRNs were the only kind of U.S. funds, the statement would read must be paid in Federal Reserve notes. But this is not the case. If your signed promissory note, in parentheses negotiable instrument U.S. funds, can be used to fund a so-called loan from the bank at the beginning of the process, it is no less legitimate a source of funds at a later point in the cycle. So even though government officials and in-house collection personnel of an original creditor are not required to validate the debt, per public policy, any bona fide negotiable instrument discharges a debt. The usefulness of the certified promissory note on page 304 should be coming into focus. Many times, the corporate entity seeking to collect the debt will have a name that bears similarity with that of the original corporate creditor, which is exempt from FDCPA. If the name of the collector's principal is not the exact same as that of the original creditor, you are dealing with a different corporate entity, a debt collector who is bound by the provisions of FDCPA. If you are uncertain if it is the original creditor demanding payment, go ahead and treat any such personnel as a debt collector, in parentheses in your written communication. Tender of payment is rendered no less valid even if one is dealing with the original creditor. 3. Other avenues of attack. As well as the impossibility of providing a bona fide verification of the debt, debt collectors are hit with other constraints besides FDCPA. A. Privacy Act of 1974, as lawfully amended, 12 U.S.C. Statute 3401. B. Right to Financial Privacy Act of 1978, as lawfully amended, 5 U.S.C. Statute 552A. And C. Third Party Summons Act, Special Procedures, 26 U.S.C. Statute 7609. 4. Line up of component documents within the administrative remedy demand. The package is a combination of documents of many avenues of attack, any one of which is sufficient to stop the entire proceeding.
A. Internal notice by written communication.
Same notice by written communication used with demands for acceptance, except that 1. It is specially enclosed in its own box within the administrative remedy demand, and therefore legally separate from the main document, and 2. Secured party is the author, not the debtor trade name, in parentheses as with the other documents. Recipient incurs a $500,000 unauthorized use fee for each and every subsequent use of the name after having been noticed, in parentheses, enough encouragement to cease all further communication in itself. And 3. The Privacy Act notice further restricts options for the debt collector.
B. Notice of tender of payment.
Notice of tender of payment gives official notice that payment has been tendered. C, D, and 2. Immediately below for customizing certain data. C. Sworn offer of performance tells debt collector that if debt collector can prove that the debt exists, i.e., verify / validate the debt, debt collector may retain the accompanying payment submitted in the form of a certified promissory note, in parentheses, bona fide negotiable instrument, per UCC 3-104. C. 4D2 immediately below for customizing certain data within this document.
D. Certified promissory note.
Fulfills the legal definition of a negotiable instrument per UCC 3-104 and discharges any alleged debt. If said alleged debt is verified / validated, in parentheses, which it is not, this is merely a promise to pay and not a cite draft, forged document, bogus instrument, etc. 1. If possible, use certificate paper to print up the note, and 2. Find debt collector's internal data appearing on the presentment and plug this data into the note. Example are alleged market code, alleged R file number, alleged FHA case, alleged loan number, etc. In other words, customize the promissory note. And the other 2 documents within this package that mention same, i.e. 4B, notice of tender of payment, and 4C, offer of acceptance, immediately above, using the data contained within the presentment. E. Sworn and witnessed verification of tender of payment. Proof of tender of payment under Public Policy, in parentheses, House Joint Resolution 192 of June 5, 1933. A debt is discharged upon tender of payment, even if it is not accepted. F. Debt collector disclosure statement contains numerous lawful requests for information, all of which debt collector is obligated to provide, any one of which can invalidate debt collector's attempt to collect on his bogus claim.
3. Sending your written communication.
A. Selecting the correct party to receive your written communication. 1. RAID computer printouts. We do not recommend corresponding with computers, but it is important to respond. If you get a computer-generated presentment, call up the sender organization, feign a cooperative attitude, and find someone who will either admit that he / she sent you the computer printout, or will issue another with his / her name on it. If you have no name, use the appropriate senior executive within the organization. Hopefully you will not see many of these. 2. Notice by written communication goes to A. Any party, in parentheses, governmental or non-governmental, demanding acceptance, in parentheses, of responsibility for specific performance / possible payment at a later date, but generally not demanding immediate payment, as well as 1. The appropriate senior official / executive over any such party, and 2. The principal / employer, in parentheses, e.g., bank, law firm, etc., of any such party, and B. Any government official demanding payment, in parentheses, e.g., county tax assessor demanding property tax. Government officials are exempt from the Fair Debt Collection Practices Act, and therefore would not be sent a validation of debt package. In parentheses, see paragraph 3 below. IRS personnel, however, are not government officials, do not enjoy such immunity, are not so exempted, and therefore would be sent a validation of debt package. In the case of a bona fide government official demanding payment, send a notice by written communication along with the normal attachments, plus the following. 1. Offer of performance. 2. Certified promissory note. And 3. Verification of tender of payment. And C. Any appropriate senior official / executive over, as well as the principal / employer of any party who is sent a validation of debt package.
3. Validation of debt package, the administrative remedy demand.
Used to handle non-government and non-in-house collection personnel demanding payment for loans of credit and other unsubstantiated non-governmental debt of some type, e.g., income taxes, as long as you have not already inadvertently validated the debt by sworn statement.
A. Proper usage.
This package will not work when a creditor has given you substance in exchange for your promise to pay, only credit. An example of this is buying a used car from a dealer who does not use an outside creditor, but carries the paper himself. He can validate the debt because he personally gave you substance. If the same dealer were to obtain financing, or you, from a credit lender who later attempted strict foreclosure, the so-called credit lender could be defeated because he incurred no risk of loss in the transaction, only the loss of anticipated gain. In parentheses, invalid claim. 1. Important note on auto loans. Contemporary auto loans are issued with the proviso that the lender can take the car, in parentheses, strict foreclosure, if you fail to make payments as agreed. However, if you loan the car, are out of town, in parentheses, but not out of the state, on business, vacation, etc., they have no way to enforce this clause. In parentheses, they can only sue for the alleged balance, plus costs and attorney fees. It is a good idea to keep this in mind until the matter is concluded, because they will swipe the car if given half a chance, thus forcing you to deal with their tag team partners down at the local courthouse if you want to get the car back without forking over Federal Reserve notes. B. You are current on your payments, but want to terminate the loan anyway. In this circumstance, you can call in and ask for a payoff balance. Written notification of a payoff balance is not a presentment, in parentheses, not a demand, but can be used to ascertain a correct dollar figure. Request a payoff balance that is good until a certain date, in parentheses, 2 to 3 weeks from date requested. Inform the agent that you need the balance in writing, in parentheses, not verbally, and you need someone to verify the figure because you do not want to then come back afterwards and say, "Oh, there is this other charge we forgot to mention," etc. Just tell them that you need the written verification by a responsible party that the payoff balance is accurate. He should have no problem complying.
1. Correct recipient for sending in payoff balance.
Even though you have a verified payoff balance, the sender will generally not know what to do with the certified promissory note. However, there is another officer that is well acquainted with such, the head of collection department. For this reason, it is best to send your package to the head of collection department. Since a payoff balance is not a presentment, reword pertinent mentions of presentment to read written communication. C. Behind on payments, threats of foreclosure. Even in extreme circumstances, credit lenders like to refrain from sending out actual presentments. They especially like to withhold the name of the agent sending the correspondence. Instead, using the name of the principal, in parentheses, the name of organization, a generality, a department within it, etc., instead of that of the flesh and blood man / woman. The purpose is to get you into the 11th hour, and then bring in a government agent, i.e., an attorney, to finish you off. Use any available written communication, in parentheses, presentment, monthly statement, etc., and request validation the debt. If an outside attorney / law firm threatens to sue / sues on behalf of an alleged creditor, It is safest, in parentheses, in case the collector is also the original creditor, to send the attorney/law firm its own VOD package with a new promissory note and debt validation request. All collection activity must cease, at least according to the Fair Debt Collection Practices Act, until said validation is provided. However, shyster judges and attorneys do not like being told that they can no longer pillage and plunder as they have for their entire career, and may try other tactics to get you to trip up. Keep putting their nose back into the validation.
D. Courts and attorneys that ignore the FDCPA requirement to validate.
This issue cannot be addressed in this manual because neither we nor the publisher are licensed to practice law and, accordingly, do not give out legal advice. However, if you run into such a situation, the folks at www.uccsg.com may be able to help recommend a consultant that can assist you.
4. Preparing your package for transmittal.
A. Copyright notations. Please always consult sample filings for a proper display of copyright notations for both true name, superscripted copyright symbol, and trade name, superscripted copyright symbol. Each time either name appears within your documents, in parentheses, except in entry designations and the glossary of terms, it should always be qualified with one of the following. 1. Superscripted copyright symbol. The symbol, i.e., superscripted copyright symbol, is touching the last letter of the surname for both true name, superscripted copyright symbol, and trade name, superscripted copyright symbol, when not set in quotes. 2. Quotation marks. True name, superscripted copyright symbol, and trade name, superscripted copyright symbol, should be set in quotation marks when the superscripted copyright symbol is not used. B. Signatures. Closely follow sample documents when applying a signature. Vital note, all signatures. See how to sign your signature without liability in this section. 1. True name, superscripted copyright symbol, more closely approximates who you are than trade name. Always sign in red ink, in parentheses, symbolizing the blood of a living, breathing man/woman. 2. Trade name, superscripted copyright symbol, should always be printed in capital letters, preferably in blue ink for ease of identifying the original document. In parentheses, black ink can sometimes be indistinguishable from a photocopy without close examination. 3. Witnesses. Have your witnesses sign their normal cursive, longhand signature in blue ink where needed. Not necessary for your witnesses to have a copyright symbol with their signature, in parentheses, but nothing prohibiting it either. C. Attachments. Attach a copy of the following with both of the 5-page standalone notice by written communication and the 14-page validation of debt package. 1. Presentment/payoff balance document. In parentheses, when using a payoff balance document, be certain to replace the term presentment with written communication, so the payoff balance document is properly identified and not misnamed. 2. Affidavit of publishing, in parentheses, from the newspaper, of your copyright notice. 3. Filed UCC financing statement. Your financing statement. Please also note, A. There will be more than one financing statement/amendment to be attached if you have done a cross-filing, and B. For those handling a mortgage situation, 1. Be certain to use the financing statement filed at county/not state level, and 2. Based on what is at stake, it is not a bad idea to use a certified copy, in parentheses, use the copy certification by document custodian form of your filed financing statement rather than a plain photocopy. 4. Private agreement. 5. Hold harmless and indemnity agreement. 6. Security agreement. D. Debtor name and address notation at top of page. Place debtor's trade name, military style, in top, left-hand corner of page, in parentheses, generally a requirement for inclusion of any attachment page in a filing. E. Photocopy entire final stack of signed documents before sending. Once you have fully assembled the entire package, make a photocopy of everything. Stapleable sets, Place the original in the envelope for mailing and file the copy in your records. F. Registered mail envelope and mailing. Best procedure for using registered mail is described in the instructions appearing at the top of sample registered mail receipt on page 293. Please read these instructions before sending by registered mail. A. Return receipt requested provides a signature and date of receipt of package by recipient, proof that the package was received. B. Restricted delivery. Check this box and pay the extra fee. More evidence of full disclosure on your part and, hopefully, an original receipt signed by the debtor. C. Affidavit of mailing. Proof of the contents of the envelope, an indispensable component in the process of proving your position and effecting foreclosure on any unauthorized user. Always have someone do an affidavit of mailing in these matters. Proof that recipient actually received the package is then uncontestable. Mail the original affidavit of mailing. Retain a photocopy of your records. 5. How to deal with former creditors after paying by promissory note. A. Typical responses. There are a couple of typical responses that a former creditor will give upon receipt of a certified promissory note. 1. Congratulatory letter for paying off the loan. 2. Urgent phone calls, phone messages, or correspondence asserting, demanding, or pleading that you call them and speak with them immediately. B. Former obligation is discharged. People can be tricked and conned into unwittingly re-accepting the obligation if they discuss anything with a former alleged creditor / debt collector once the promissory note has been tendered. The debt is discharged upon tender of the instrument. It matters not, it is accepted or rejected. See UCC 3-603. Typically, the such will seek a telephone conversation to try to convince the former alleged debtor that the debt must be paid in Federal Reserve notes, FRNs, per public policy at House Joint Resolution 192 of June 5, 1933. Nobody has any obligation to pay in FRNs. The promissory note is a negotiable instrument, in parentheses, money, constructed in strict accordance with the UCC, in parentheses, Statute 3-104, and allegedly discharges the debt. Once tendered, the debt is discharged. Period. C. Vital information. There is no good that can come from discussing a former alleged debt with a former alleged creditor / debt collector after payment has been tendered. D. Handling phone calls from former creditors. 1. Sample telephone conversation. In the following transcript, we have the former creditor referencing all capital letters ens legis John Doe, and the common law proper English spelling and pronunciation John Henry Doe. The former creditor references John Henry Doe as the all capital letters ens legis John Doe or Mr. Doe. Former creditor. Is this John Doe? John Henry Doe. Who's calling? Former creditor. This is Jack from Bank of Texas. Is this John Doe? John Henry Doe. What's the purpose of the call? Former creditor. I need to speak with John Doe about a payment we recently received on his John Henry Doe. I don't do business over the phone, Jack. If you could put your questions in writing and send me a letter, I would be happy to take a look at them. Former creditor. I just want to go over a couple of things. John Henry Doe. Like I said, I don't do business over the phone. If you will kindly put your questions in writing, I will have a look at them. Former creditor. I understand, Mr. Doe, but this will only take a few minutes. If I could just ask you, John Henry Doe. I'm being as clear as I can, Jack. I only deal with such matters in writing. Former creditor. You've made that very clear to me, Mr. Doe. But the thing is your last payment on the John Henry Doe. What is your surname, Jack? Former creditor. I don't give out my last name. John Henry Doe. Sorry, Jack, but if you're not willing to tell me who you are, I am not willing to continue this conversation. I'm hanging up now, Jack. Former creditor. Wait, Mr. Doe. Why do you need my last name? John Henry Doe. Goodbye, Jack. Former creditor. Wait. Okay, my last name is Jones. John Henry Doe. Home address? Former creditor. Home address? Why do you need my home address? John Henry Doe. I need to know where to send the bill. Former creditor. What bill? John Henry Doe, the bill for the use of my property. Former creditor, what are you talking about? John Henry Doe, I need your address so I can send you a bill for the use of my property. Former creditor, what are you referring to, Mr. Doe? John Henry Doe, the name you have been using in this conversation to address me is private, copyrighted property. So far in this conversation, you have used my property 7 different times without my authorization. I need to bill you for the use of my copyrighted property. I prefer sending the bill to your home rather than at the bank. Home address, please? Former creditor, you've got to be kidding. John Henry Doe, I'm not kidding. Jack. If you're not willing to provide your home address, this conversation is over. Former creditor, you'll be hearing from us, Mr. Doe. Click.
2. Your objective.
Take it as far as necessary to get the caller to hang up. If he gives you his home address, ask him for his home phone number. If he gives you his home phone number, ask for his social security number, SSAN. Tell him you don't know who he is and that you need to cross-check all the previous data he gave you with the SSAN. He will not call you again.
3. Caller's objective.
Someone else might call again at a later time, but it will be the same story. The debt is discharged and their legal department knows it. They are only calling for the purpose of trying to persuade you that you can only pay in FRNs. If you actually mistakenly engage in conversation with the caller, he/she would try to make you feel bad and scare you with bogus threats. Anyone who is assigned to call you after you have sent in such an instrument knows exactly what he/she is doing and has been briefed on how to get you to pay in FRNs. Handle any such caller as above, and he/she will stop calling.
4. Key points to remember.
A. Never answer a question. B. Never identify yourself. C. Never discuss anything that the caller brings up. D. Always interrupt if the caller pursues a conversation / questions you after having been noticed that you don't do business over the phone. E. There is no need to be hostile, but you must be firm and not tolerate any attempts at getting you into a conversation. And F. Do not consent with anything the caller wants. You can even tell him /her that you do not consent with him /her using your copyrighted property, using your telephone number, calling you at home, etc.
E. Correspondence urging you to call.
The choice is yours, but anyone who uses your copyrighted property (for profit) deserves a notice by written communication.
F. If you receive a presentment (demand for payment afterwards).
If a follow-up presentment comes in the mail, you should 1. Mail the sender (agent) a personalized notice by written communication / security agreement and a copy of the served 14-page administrative remedy demand and its proof of mailing (green card and affidavit of mailing). And 2. If you also serve the principal with notice of the fees for use of your private property, you may commence the collection process on the principal using the last correspondence (presentment or not) as proof of execution of the contract. These instructions begin in Part 6, immediately below.
6. Steps to take after execution of consensual contract by unauthorized user.
A. How and when the contract is executed. It is vital that you recognize the moment the presenter / debt collector executes the consensual contract and incurs the obligation. For this reason, you need to be familiar with the everyday language and the notice by written communication that spells out the non-judicial terms of the contract for use of your common law copyrighted property. A presenter / debt collector can voluntarily enter the consensual contract and incur the obligation in either of the following ways. 1. For both simple and difficult opt-out procedure, any single instance of additional use of true name or trade name for commercial gain after having been noticed. 2. For difficult opt-out procedure only, Debtor's failure to surrender all originals and all copies of any and all records in any form of recorded media in parentheses, written, electronic, magnetic tape, containing your common law copyrighted property within 72 hours of midnight the day after debtor was noticed. B. Steps immediately after presenter/debt collector executes consensual contract. 1. Begin locating debtor's assets. The security interest in the debtor's property is perfected by filing a UCC financing statement at state level, and, in the case of real estate holdings, at county level. It is best to itemize all of debtor's property in the financing statement. In all real estate filings, require the legal description of the property be entered in box 14 on the addendum page. Do whatever you can to begin locating all of debtor's property as soon as possible. In parentheses, UCC Services Group can assist you in this task. 2. Generate the invoice, verified statement of account. Immediately upon presentors/debt collectors execution of the consensual contract, draw up an invoice to bill your new debtor for the unauthorized use of your property. This is a dollar figure calculated by multiplying the total number of uses of your true name and trade name, and this particular collection cycle only, both before and after debtor was noticed, by $500,000. Debtor had the chance to opt out and walk away, but chose to go forward and challenge your right of ownership of your own property. Once the contract is executed, all earlier unauthorized uses of your property in this particular collection cycle become billable. Debtor is accountable for each one. When you plug in your particulars in the sample invoice, be sure you A. Precisely identify the documents and the number of uses of your property. B. Make an exact accounting of the number of unauthorized uses of your property, leaving no margin for error. And C. Make certain that you can back up with verifiable, bona fide documentary evidence everything that is stated in the invoice regarding unauthorized use of your property. The only way you can follow up is if you cannot prove the veracity of the facts stated in the invoice, which is a notarized affidavit, the most powerful private/legal/commercial instrument in the world. You cannot afford to make a false attestation, nor bear false witness, in parentheses, perjury. So be sure you can legally prove that is stated in your invoice/affidavit. Each invoice has attached only a copy of the documentary evidence used in calculating the total amount due, in parentheses, original invoices are retained for future filing. Originals of documentary evidence are retained permanently by you. D. Give your debtor 10 days from the date invoice is sent to tender payment in full. There is no rush on this. The days will fly by. E. Make as many originals of each notarized invoice as you will need for each separate filing to be done both at state and county level. In parentheses, each piece of real estate needs its own filing, and only originals of affidavits are accepted. 3. Send the invoice. After notarizing, make a photocopy of the original invoice and attached proof of use of your property, as well as any page attached by the notary. Debtor gets only a photocopy of the original notarized invoice and attachments. Retain the original invoice for later use. Send a photocopy of the invoice, in parentheses, plus attachments, by registered mail, affidavit of mailing, as described above in paragraph 4F, registered mail envelope and mailing. 4. Get familiarized with default provisions. Be sure you understand the default provisions in the notice by written communication. Defaults are inevitable, and debtor will be in default 10 days after invoice is sent, not 10 days after debtor receives it. Per UCC, it is debtor's responsibility to monitor receipt of mail and make sure all financial obligations are met. Before the 10-day period expires, you may contact UCC Services Group and let them know you are approaching the time to initiate foreclosure proceedings described in paragraph D. 5. Begin generating the affidavit of debt. The affidavit of debt is the sworn document that empowers you to foreclose non-judicially on the debtor, in parentheses, strict foreclosure, and also indemnifies all others, in parentheses, such as the sheriff and judge and clerk of court, who assist you, in parentheses, as plaintiff, in enforcing the private consensual contract that was voluntarily executed, defaulted upon, and then ignored by the debtor. The affidavit of debt is a precise recital of all events in the course of the debtor's initiation and execution of the consensual contract and subsequent failure to meet the financial obligations associated therewith. Contract makes the law, in parentheses, ancient and universal maxim of law. When you know the law, in parentheses, terms of the contract, you can enforce it, in parentheses, default and strict foreclosure provisions, with impunity based on certainty of the correctness of your position, affirmed by affidavit. If the need for, in parentheses, deadly force enters in, it is best to enlist the help of the courts and the sheriff. Begin generating your own custom affidavit of debt as soon as possible by using the instructions and sample documents provided in Section 13, Supplemental Instructional Material for Handling Presentments, beginning on page 391. C. Non-judicial strict foreclosure and collection. This is an extremely serious undertaking, however simple the final execution may end up being, and must be approached with the utmost respect for procedure. This is the step that reverses the statist, totalitarian communistic property confiscation machinery developed and institutionalized by the legal masters of the world over the last 2,000 plus years, and they are not pleased with our progress. For these and other reasons, it is not recommended that anyone attempt this process on a first-time basis without help from someone who has already successfully done it. It is not enough just to be right. You must be perfectly right to avoid retaliation from Big Brother. Legal experts at the UCC and revised Article 9 have written entire books on just this subject to guide their fellow Esquire mercenaries, because it is so significant and so easily misunderstood. Even some judges do not understand the default provisions contained in revised Article 9. Believe it or not, the strict foreclosure procedure discussed in this book is the same procedure that is undertaken thousands of times every single day by mortgage companies and banks who request the help of a Federal Reserve Note Tribunal, in parentheses, court, in authorizing the use of deadly violence, in parentheses, sheriff, to evict those parties who have failed to meet their alleged private contractual financial obligations and have also failed to adhere to the agreement to vacate the premises in such case. There is no reason that you cannot access the same procedure, including even using an attorney to request a hearing and getting the judge to issue an order authorizing the sheriff to use as much force as necessary to get someone to comply with the private Federal Reserve note contract. UCC Services Group has been instituted to help in such matters. So as soon as you know when you will be ready to proceed with strict foreclosure, it is time to make contact. 7. Protecting oneself in pressure situations and criminal proceedings. A. Speaking and acting on your own behalf. See the essays, Helpful Notes for Pressure Situations, and How to Sign Your Signature Without Liability, an appendix for real-life solutions for everyday confrontations with Big Brother. 1. Affidavit of Common Law, Proper English Spelling and Pronunciation, John Henry Doe, by Special Visitation. A. Meaning of special visitation. This affidavit does not constitute appearance, rather visitation, based on the nature of the relationship between the sovereign constituency, of which you are a member and can claim such standing, and the slave artificial person, corporation known as government. These two words are defined as follows. Special, relating to or designating a species, kind, or sort, designated for a particular person, confined to a particular purpose, object, person, or class. The opposite of general. Black's Law, 1st edition. Visitation, inspection, superintendence, direction, regulation. As applied to corporations means, in law, the act of a superior or superintending officer who visits a corporation to examine into its manner of conducting business and to enforce an observance of its laws and regulations. Black's Law Dictionary, 4th edition, 1951. B. Purpose. Used to obtain a common law judgment of non prosecutor, also called non pros. Non prosecutor, non prosecutor, or pro. Latin, he does not prosecute. The judgment rendered against a plaintiff who has not pursued the case, often shortened to non pros. Black's Law, 7th edition. C. Description. Places parties on notice of who you are, what you never granted permission for using, nor authorized use of, your property, and parentheses, true name, superscripted copyright symbol, and trade name, superscripted copyright symbol. Requires response in like kind, in parentheses, affidavit. And that response be sent via a notary public of your designation, in parentheses, explained below. Both agent and principal are included. Such notice can be sent by registered mail and can be filed in person as well, depending on the advantage of each method. Generally, agents are served by registered mail, principals in person. Some principals will prefer that the document is presented in a different format, in parentheses, i.e., legal pleading format, with a heading and captions at the top and numbered lines running down the left side of each page. Document is dated, common law style. D. Notary public. A notary is an officer of the state with international jurisdiction. Notary public. A public officer whose function is to attest and certify by his hand an official seal certain classes of documents in order to give them credit and authenticity in foreign jurisdictions, to take acknowledgments of deeds and other conveyances and certify the same, and to perform certain official acts, chiefly in commercial matters, such as the protesting of notes and bills, the noting of foreign drafts, and marine protests in cases of loss or damage. Black's Law Dictionary, 1st edition. Notaries are of very ancient origin. They were well known among the Romans and exist in every state of Europe, and particularly on the continent. Bouvier's Law Dictionary, 6th edition, 1856. An officer appointed by the executive or other appointing power under the laws of different states. Their duties are generally prescribed by such laws, the most usual of which are 1. To attest deeds, agreements, and other instruments in order to give them authenticity. 2. To protest notes, bills of exchange, and the like. 3. To certify copies of agreements and other instruments. Bouvier's, 6th edition. Their acts have long been respected by the custom of merchants and by the courts of all nations. Bouvier, 6th edition. Noting the title of the 14-page validation of debt package, i.e., Respondent's Private International Administrative Remedy Demand, we are in the international realm when dealing with the current de facto government. Coincidentally, a commercial enterprise overlorded by a lineage of former merchant shippers on the high seas who employed heavily the services of notaries as an aid in international commerce, primarily for the handling of notes, in parentheses, promissory notes, and bills, in parentheses, bills of exchange, i.e., orders to pay. The office of notary public is far more powerful than even the average notary is aware of. Cultivated so by Big Brother for maintaining governmental control in all economic matters. 2. Notary's certification of non-response. A notary is an officer of the state, and, as such, a notary's word carries great weight. When the notary attests that no correspondence was received from any of the agents and principals that have charged, in parentheses, dual criminal / financial significance, you for an alleged crime, a common law judgment of non-pros is obtained. Agents and principals can avoid the $500,000 name use fee by using the term secured party instead of the sender's true name superscripted copyright symbol / trade name superscripted copyright symbol for addressing correspondence, but nearly all reject this option. The notary confirms non-receipt of correspondence with a simple form called Certification of Non-Response, a sample of which appears in Appendix under Notaries, Certification of Non-Response. You draw up the form listing each party that you want the notary to acknowledge as not having heard from and bring it to the notary for his/her seal and signature. Enlisting the help of a notary. Ideally, you will have a notary public among your friends, family, and associates. If not, it is a simple matter to enlist the help of a notary for a certification of non-response. A. Speaking with the notary. In a friendly fashion, let the notary know that 1. You are handling a matter in which you need outside, third-party verification that your requests for a written response from certain people are being ignored. 2. His/her word as a notary would remove all doubt in the matter. And 3. You would just drop by in a couple of weeks with a short list of people to see if the notary had received any correspondence from any of them and pick up any such correspondence that had arrived. And 4. For those who had not sent anything, you would be happy to pay, in block parentheses, you choose a number, dollars, in parentheses, a realistic and agreeable fee, for a simple one-sentence acknowledgement that nothing had come in from the parties the notary had not heard from. B. After securing notary's certification of non-response, serve each agent and principal in the same fashion the original affidavit was served. You now have profound evidence on the record that nobody ever had any right to use your common law copyrighted property without your authorization, and that no such authorization was ever given. Besides the financial charges for use of your property, the attackers are in no man's land, up the creek without a paddle, because there is no legal foundation/basis for their attack. B. Suggestions on what to say when challenged by Big Brother's operatives. C. Helpful notes for pressure situations on page 322 in this section for ideas on how to avoid dealing with Big Brother altogether and how to cope with its operatives in unavoidable situations. C. Doing business with any and all who use your private property. Upon receipt of any presentment bearing your common law copyrighted property for both civil and criminal matters, immediately serve each and every involved party proceeding against you, in parentheses including judges, clerk of courts, prosecutors, attorneys, and others, with his/her own personal notice by written communication. Use difficult opt-out procedure, in parentheses with subsequent self-executing paragraph, text described under paragraph 11.4b of these instructions and send by registered mail. You can also send one to the presiding/chief judge of a particular courthouse and thereby place the entire courthouse on notice. Those who do not surrender all originals and copies containing your private property, in parentheses, in any form of recorded media, into your possession within the 72-hour Truth in Lending Act period, thereby execute the consensual contract. Immediately file a UCC financing statement against all such parties both at state level and, after obtaining a legal description of all their real estate holdings at county level. Each piece of real estate needs its own separate financing statement, in parentheses, you can only file against one property in a single real estate filing at county level. Draw up an invoice for each party and bill them by registered mail, in parentheses, send a copy of the notarized original invoice, retain the original, based on the number of uses of your copyrighted property multiplied by 500,000. D. Assistance. If despite all of the above, you are still having a tough time of it and would like assistance from someone familiar with these kinds of situations, you may want to contact UCC Services Group, which may be able to recommend a consultant who can help you. Supplemental instructional material for handling presentments. 1. The Affidavit of Debt. A. Introduction. The affidavit of debt is your sworn statement concerning all events that have transpired and brought about the indebtedness, and stands as the truth in commerce unless rebutted by the debtor point for point by counter affidavits sworn true, correct, and complete. Because of the inherently fraudulent nature of the legal, financial, and taxation systems, actors within these arenas must remain in the shadows in order to continue their duplicitous practices and avoid general detection. Accordingly, it is highly unlikely that the affidavit of debt will ever be rebutted, because to do so would require a sworn statement that cannot be supported by fact. The UCC filing office requires that an original / not a copy of the affidavit of debt accompanying any UCC financing statement, so there may be a need for multiple original affidavits of debt. Debtor does not get a copy of the affidavit of debt. It is strictly for filing with a financing statement in the UCC filing office. B. Generating the affidavit of debt. Begin creating your own personal, customized affidavit of debt against your debtor by following the sample affidavit of debt provided in this section, following these supplemental instructions, and plugging in your particulars for the use of common law, proper English spelling and pronunciation. John Henry Doe's. 1. Attachments. Generally, filing offices require the debtor's military-style name, in parentheses, all capital letters ends legis, last, first, middle, and address to appear in the uppermost left-hand corner of all attachment pages in the same format as the financing statement, in parentheses, see page 287 for an example. Although this is not strictly enforced, it is still recommended that you place the debtor's name and address in this style on any attachment whenever possible. The notarized affidavit of debt is most effective when it has the following attachments. A. Copy of either the 5-page standalone notice by written communication / security agreement or the notice by written communication / security agreement contained within the 14-page validation of debt package, in parentheses, attach the complete document, all 14 pages, along with the following. 1. Copy of the presentment / written communication containing debtor's initial unauthorized use of your common law copyrighted property, in parentheses, that prompted this entire cycle to be undertaken by you. 2. Copy of the newspaper affidavit of publishing your copyright notice. 3. Copy of your certified UCC financing statement. 4. Copy of the affidavit of mailing for whichever version of the notice by written communication / security agreement you used. 5. Copy of USPS green card, in parentheses, PS Form 3811, proving debtor's receipt of whichever version of the notice by written communication / security agreement you used. B. Original notarized invoice, a photocopy of which was sent debtor demanding payment along with the following attached documents. 1. Copy of all proof of unauthorized use of your common law copyrighted property that was sent debtor as an attachment with the invoice. 2. Copy of the affidavit of mailing for invoice. 3. Copy of USPS green card, in parentheses, PS Form 3811, proving debtor's receipt of invoice. 2. Non-attachments. Please note that your personal private agreement, hold harmless, and indemnity agreement and security agreement are private documents and do not get filed as attachments with the affidavit of debt in the filing process, even though the debtor was sent a copy of each in your initial mailing. These 3 documents are not needed to prove the indebtedness of the debtor and are withheld from filing in the public record for privacy reasons. 2. Filing a UCC financing statement against presentor / debt collector. A. Public notice of a private contract. Until a financing statement is filed against the debtor, no one else knows about your private, consensual contract with said debtor. A filed financing statement is general public notice of the debtor's indebtedness and the collateral pledged as security for the obligation. A sworn affidavit of debt attached thereto is detailed public notice of the debtor's illicit attempts at using your common law copyrighted property for commercial gain without authorization, and the subsequent debt incurred thereby. Sworn statements, in parentheses, testimony, evidence, placed in the public record, cannot be summarily invalidated and brushed aside by anyone. B. When to file. The financing statement should be filed in as soon as possible as the 11th day from the date of mailing of the invoice. In parentheses, note, the 10-day clock starts ticking when the invoice is mailed, not when it is received by the debtor. Debtor is responsible for monitoring his mail traffic after incurring the obligation. C. Where to file. For purposes of filing correctly, you must determine presentor's/debt collector's location and parentheses residence in accordance with the UCC 9-307 in parentheses see paragraph 4A on page 225 for an explanation. Note, corporate debtors have different criteria than those for individuals. Financing statements should be filed as follows. 1. At state level in the UCC filing office of the state where the debtor maintains residence, and 2. At county level in any county in any state where debtor has real estate holdings registered in debtor's name. Each piece of real estate requires its own separate UCC financing statement with an original affidavit of debt and an original invoice in parentheses as explained above, in order to be accepted for filing. D. Completing the form. The financing statement is virtually the same for filing at both state and county level. However, please take note of the following points. 1. Box 4. Collateral description. A. Box 4 text. No matter which version of the notice by written communication/security agreement you used, the collateral description in Box 4 is the same. All of debtor's assets, land and personal property, and all of debtor's rights in said assets, land and personal property now owned and hereinafter acquired, now existing and hereafter arising, and wherever located, described fully in security agreement entitled, all capital letters, notice by written communication/security agreement, dated, in block parentheses, date of the particular notice by written communication/security agreement that you used, by and between debtor and secured party, to secure debtor's obligation in favor of secured party in the sum certain amount of, in parentheses, dollar amount of indebtedness. Inquiring parties may consult directly with the debtor for ascertaining, in detail, the financial relationship and contractual obligations associated with this transaction, identified in security agreement referenced above. Secured party accepts debtor's signature in accord with UCC Statute 1-201, subsection 39, and UCC Statute 3-401. B. Security Agreement. The security agreement referenced in the text of the Box 4 collateral description described immediately above in paragraph 1, section A, is whichever one you use to notice the presentor/debt collector, i.e., 1. The 5-page, standalone notice by written communication/security agreement, or 2. The notice by written communication/security agreement contained within the comprehensive 14-page validation of debt package. 2. Box 6. For all real estate filings at county level, check Box 6. Real estate records. Do not check this box for filings at state level. 3. Box 13. Place an X in the last check box in Box 13. Fixture filing for both state and county level filings. 4. Box 14. County filings only. If you are doing a real estate filing at county level, place the legal description of the property in Box 14. Leave this box blank for state level filings. 5. Box 18. There is no assertion that the debtor is a transmitting utility. This is not a transmitting utility filing, so do not make a mark in Box 18. E. Assembling the package. Place the appropriate 2-page UCC financing statement on top of each completed original affidavit of debt with all its attachments, and make at least one copy of each entire stack. Staple each original stack together after photocopying and place it with its envelope. Store your copies in an orderly fashion in a safe place. F. Preparing your filing for transmittal. Decide on how you will transmit your package for filing. and then contact the appropriate state at county level filing offices and find out 1. The filing cost to get your package filed. 2. How to obtain an acknowledgement copy. In parentheses, you may need to enclose a second copy of the 2-page financing statement along with the SASE. 3. The cost of and exactly what you need to do to obtain a certified copy of your filing. In parentheses, if ever asked why you need a certified copy, a good answer is for court or for a court case. G. Transmitting your filing. Get your completed UCC financing statement filed the fastest way possible at both state and county level.
Sequential steps of a presentment handling.
Demanding acceptance or performance. Notice by written communication / security agreement sent to any party involved in enforcing the presentment. Attach CN UCC financing statement PA HHIA SA. Demanding money 14-page validation of debt package sent to a party demanding payment. Attach CN UCC financing statement PA HHIA SA. Send NBWC / SA with copy of 14-page of attachments to principal. Invoice sent after one additional use of the name with easy opt-out after 72-hour Reg Z period with difficult opt-out contains proof of execution of the contract, notarized. Invoice sent after one additional use of name contains proof of execution of contract, notarized. UCC financing statement sent after one additional use of the name with easy opt-out after 72-hour Reg Z period with difficult opt-out contains proof filed on 11th day after sending files at the state level against debtor, as well as the county level against debtor, as well as at county level against each piece of real estate of debtor. Standard general statement describing debtor's assets, land of personal property, that also lists specific property of debtor, in parentheses, obtained with an asset search. Attachments. Original notarized affidavit of debt, in parentheses, file original, retain copy. Copy of NBWC / SA or VOD package plus attachments. Copy of affidavit of mailing for NBWC / SA or 14-pager. Copy of proof of receipt of NBWC / SA or 14-pager. Attachments. Original notarized invoice, in parentheses, file original, retain copy. Copy of proof of use of copyrighted property. Copy of affidavit of mailing for invoice. Copy of proof of receipt of invoice by debtor. Strict foreclosure proceedings against each debtor. Demanding money. 30-day written demand for title. Lawsuit for title for property. 1. Important note. Purposes of maintaining privacy when filing a UCC financing statement do not include the PA, HHIA, and SA that were attached with the NBWC / SA or 14-page validation of debt package. Only the other attachments that were sent, PA, HHIA, and SA, need not be filed for financing statement to be valid.
How to secure a bank account from levy.
Objective. The primary objective in securing a bank account from levy is to obtain the bank's agreement that you, the flesh and blood man / woman, are the authorized representative of the account holder, the artificial person trade name. This reality is spelled out in detail in your security agreement and is echoed in the UCC financing statement filed with the Secretary of State. But you must also obtain the bank's acknowledgement of this fact. Once documented on the bank's signature card as an authorized representative on the account, control of the collateral, in parentheses the funds in the account, is established. thus perfecting your security interest in the account. At that point, your other relationship with the account holder / debtor, i.e., that of secured party, can be impressed upon bank personnel, and such are obliged to honor the perfected security interest, thus securing account funds from third-party levy. Pertinent sections of the Uniform Commercial Code. Here are the sections of the Uniform Commercial Code governing such matters. Statute 9-314, Perfection by Control. A. Perfection by control. A security interest in deposit accounts must be perfected by control of the collateral under Section 9-104. Statute 9-104. Control of deposit account. A. Requirements for control. A secured party has control of a deposit account if 2. The debtor, secured party, and bank have agreed in an authenticated record that the bank will comply with instructions originated by the secured party directing disposition of the funds and the deposit accounts without further consent by the debtor. The signature card (property of the bank), signed by both account holder (debtor) and authorized representative (secured party), constitutes an agreed upon authenticated record that the bank will comply with instructions originated by the secured party (authorized representative), directing disposition of the funds in the deposit account without further consent by the debtor (account holder). Signing this signature card. With one exception, the bank signature card should be signed exactly as shown in How to Sign Your Signature Without Liability on page 315 of Cracking the Code 3rd edition, superscripted copyright symbol CTC3, with signature of both debtor and secured party appearing. Signing in this manner differentiates between the contracting parties, i.e., true name and trade name, corresponds with the documentation you provide, and satisfies the requirement of UCC 9-104, subsection A, 2. Select from the sample signatures appearing on page 319 of CTC3 that contain both debtors and secured party signature, but do not place a copyright symbol, i.e., superscripted copyright symbol, after either of the two names. The copyright symbol, and likewise the copyright notice, is not used here. It is more important to establish the account and be acknowledged as the authorized representative than it is to assert the copyright, which can always be called into play later if necessary, but is not likely. For an existing account, a request to examine the signature card for the account will usually be granted, but bank personnel may not be too delighted with your new self-proclaimed status as authorized representative / agent and the accompanying artwork you render on the card to prove your point. If you are able to modify the signature card on your account without causing any friction, by all means do so. However, if this is not feasible, the easiest thing to do is simply to close the account and open another. Opening a new bank account is a simple matter, and there is nothing wrong with using the same bank as long as no undue antagonism is generated in the process. The most hygienic method, however, is to open your new account with another bank and start afresh. Documenting your position. At the time you sign the bank signature card, you should have with you a certified copy of both your UCC financing statement and the security agreement referenced within the text of the collateral description of the financing statement. Use the copy certification by document custodian form to make a certified copy of the security agreement. These certified copies are to be left with the bank after the signature card is completed. Upon signing the signature card, inform the bank personnel assisting you that the account holder is also your debtor and that you are the secured party, and then produce the certified copy of your financing statement and security agreement. The identifying number of the security agreement appearing within the collateral description box (box 4 on the UCC financing statement, box 8 on a UCC financing statement amendment, in the case of a cross-filing of the financing statement and the section entitled Authorized Representative on page 7 of the security agreement (page 247 of CTC3) should be highlighted for ease of inspection. Bank personnel are only too familiar with such kinds of documents. so there should be no difficulty in understanding what you are presenting. As long as bank personnel can see that you know what you are doing, there will be no problem. Guaranteeing success. It is vital that you thoroughly understand that you are not the account holder and can never be the account holder. The name of all account holders appears in all capital letters in all bank records and documents. All account holders are artificial persons, e.g., your trade name. This policy is purely of the bank's own choosing. All you are doing is respecting the bank's selection / designation of the account holder. If bank personnel balk at all, have the girl / guy pull out a sample personal check from his / her drawer and point out the name on the account holder printed on the check. The name is set in capital letters. If the Secretary of State recognizes the distinction between the two names on your financing statement, it is reasonable to expect that the new accounts officer will too. In the event there is further resistance, have her / him examine what appears to be the signature line on the sample personal check using the magnifying glass that you produce. In parentheses, bring one with you if possible. Even though the check is a personal check, and therefore theoretically would only have one signatory, said line is for any authorized signatory of the account holder, i.e., an authorized representative, and you are such an authorized signatory / representative. These facts should quell any doubts on the part of bank personnel. However, as always, the senior factor is your personal certainty of what you are doing. The Federal Reserve literally owns the U.S. government and covertly asserts ownership of all property in America by claiming that the state, i.e., its bankrupt slave, owns everything. This absurdity is enforced based on the justification that Federal Reserve notes, in parentheses, private property of the Fed, were used as the valuable consideration in the acquisition said property. Banks, in parentheses, Fed instrumentalities, do business with only artificial persons whose names appear in all capital letters. Any party that volunteers to act as a surety and give anomalous endorsements and sign as an accommodation party for the account holder, however, is never turned away. It is also wise to familiarize yourself with the section of the security agreement entitled Event of Default, which can also be highlighted if desired. This paragraph appears just below Authorized Representative, at the bottom of page 7 of the security agreement. Any attempt by any third party to remove any of the debtor account holder's funds, in parentheses, your secured collateral, constitutes an event of default on the part of the debtor and allows you to foreclose on the collateral, i.e., withdraw the funds if necessary. Because you provide the bank with certified documentary evidence of your secured party status at the time the signature card was signed, no other party can have a prior security interest in those funds, and all bank personnel must acknowledge this fact and honor your perfected security interest or risk both civil and criminal charges. As a final note on securing your position, a certified copy of your UCC financing statement and security agreement left with bank personnel could conceivably be misplaced / lost, although this is unlikely based on the potential liability attendant with such oversight. However, it is nevertheless a good idea to send the manager of the bank an additional certified copy of both financing statement and security agreement by registered mail, in parentheses, restricted delivery, with an affidavit of mailing. A cover letter confirming your perfected security interest in the collateral in the account and the bank's responsibility in protecting this secured collateral should also be enclosed. As long as you can prove that the manager received the above cover letter and the certified copies of the documents, in parentheses, evidence, the bank is liable for any pilferage of the account. Note: Senate Document Number 43, 73rd Congress, First Session, in parentheses, March 9th, June 16th, 1933. The ownership of all property is in the state. Individual so-called ownership is only by virtue of government, i.e., law amounting to mere user, and must be in accordance with law and subordinate to the necessities of the state. If these terms are not readily understood, it is vital that you reread how to sign your signature without liability, beginning on page 315 of CTC3, and get them cleared up.
How to get paid all of your earnings.
Disclaimer: the following information is not legal advice and cannot be construed as legal advice. If the reader is in need of legal advice, the reader is advised to contact a legal professional authorized to dispense such. The information contained herein is not provided to assist anyone to evade taxes. Rather, it is offered to enlighten those who may be unaware that application for and use of a Social Security account number is, per the Social Security Administration, strictly voluntary. To remain the reader that voluntary compliance, in parentheses, RAID, the payment of income tax, is expected of those who decide to enroll / participate in the income tax system. To reveal the mechanics of exactly how one volunteers to take part in either of these two programs, and to offer another lawful alternative for those who may no longer wish to continue to volunteer.
Social Security account numbers.
The Internal Revenue Service, in parentheses IRS, personal income tax scheme is utterly dependent upon the continued submission of Social Security account numbers, in parentheses SSANs, collected from new employees by employers. New employees routinely provide a SSAN on a signed IRS form W-4 employees withholding allowance certificate when requested by an employer, and the employer dutifully forwards the W-4s in accordance with the IRS wishes. Without such unparalleled largesse, in parentheses SSANs, volunteered by new employees and then submitted by employers, IRS has no lawful basis for the assessment and collection of Social Security payroll tax from said new employees, and likewise for every other kind of tax routinely levied from a paycheck. Most people think that they have no choice, i.e., that they must provide a SSAN when asked for one by their new employer if they want to have a job. This is not true for a number of reasons, but possibly the most significant one is the official stance of the issuer of all SSANs, the Social Security Administration. The following excerpts are taken directly from the official SSA website at www.ssa.gov. Specifically, questions. Then Social Security number and card, then page 2. Questions number 23. When do I have to provide my Social Security number? The following passages, in parentheses as well as others, appear. Question. Must I provide a Social Security number, in parentheses SSN, to any business or government agency that asks? Answer. If a business or other enterprise asks you for your SSN, you can refuse to give it. Giving your number is voluntary. Even when you are asked for the number directly, the decision is yours. The Internal Revenue Code, in parentheses IRC, requires only that an employer requests a SSAN from each new employee and can levy a fine if the employer fails to obtain / ask for a SSAN. However, the IRS also provides for a waiver of such penalty if the employer fulfills the request requirement but fails to obtain a SSAN because the new employer declines to provide one, in parentheses, no willful neglect on the part of the employer. If there is ultimately no penalty / fine if the employer fails to obtain a SSAN from a new employee, there is no requirement that a new employee provide one in the first place. No penalty equals not required. Similarly, IRS contains no provision for the assessment and collection of income tax from a new employee for whom it has no SSAN. Accordingly, IRS contains no provision that allows / requires / instructs an employer to refuse to continue to employ the new employee, to refuse to pay the new employee his / her earnings, to withhold a portion of the new employee's earnings, or permit any other such unlawful measures. Employees who do not provide a SSAN, in parentheses, on a signed W-4, the only authorized way in IRS, when requested to do so, are simply not eligible for any benefits, in parentheses, Social Security, and other associated with the earnings they collect from that particular employer. Any retaliatory action taken against a new employee by the employer, such as any of the ones listed above, is unlawful and can be immediately vindicated via lawsuit, and the new employee will win. This is why the new employee is hired first and then only subsequently asked to provide a SSAN, in parentheses, on a signed W-4. At the time this is requested of the new employee, he/she is already employed. This fact is echoed in the prescriptions of IRS, in that IRS authorizes requesting a SSAN only of an employee. Since providing a SSAN on a signed W-4 is voluntary, in parentheses, the only valid signature is one that is signed freely, the employer cannot lawfully coerce the new employee into doing what is otherwise a voluntary act. The matter of providing a SSAN, in parentheses, on a signed W-4 is strictly between employee and employer. It does not involve any outside third party, such as IRS and SSA. Quote, "We do not have the authority to require an employer to provide or deny employment or services to anyone who refuses to disclose his or her number. This is a matter between the individual and the employer." Dorcas R. Hardy, Commissioner of Social Security. Letter of response to Rodney Rickman, July 19, 1986. Quote, "There is no law prohibiting a person from exercising his right to work without possessing a Social Security number." Harry Reid, United States Senator, in parentheses, Nevada, response letter to Kevin Passow, April 24, 1990.
The nature of benefits.
Though not as straightforward in the matter of a government agency asking for a SSAN, the same official SSA website does not contain one single passage that unequivocally states that anyone is ever required to provide any government agency with a SSAN upon request. The text of SSA website, created by the same word wizards that write IRS and every other code in existence, is masterfully cloaked in ambiguity in order to cause the reader only to believe it is mandatory to provide a SSAN when requested by a government agency. But since the only conscionable purpose behind the use of a SSAN is the acquisition of a benefit, no one can ever be compelled to provide one. An ancient and timeless maxim of law states, no one can be compelled to accept a benefit against his will. And so it is with SSANs. The official SSA website fully acknowledged this fact as shown above. Accordingly, no one is ever required to provide a SSAN under any circumstances unless, of course, someone is desirous of a Social Security related benefit and the account number is necessary to verify eligibility.
Employer leeway in obtaining a SSAN from an employee.
No matter what an employer believes an employee's responsibilities may be in the matter of providing a SSAN, the employer is not authorized by IRS, nor by any other code to take any action against the employee in an effort to induce the employee to provide a SSAN and seek a benefit against the employee's will. Once the employer requests a SSAN and the employee declines to provide one, neither United States Code, in parentheses USC, nor Code of Federal Regulations, CFR, provides any instruction for any further communication with the employee on the subject of SSANs once the request is made, and likewise for any retaliatory action against the employee for refusing to provide one. Whatever the employer does in such case is based only upon the employer's unfounded belief of what the employer is authorized / supposed to do, combined with ignorance of the law. And, as we all know from Big Brother's cheerleaders, ignorance of the law is no excuse. Similarly, no employer is authorized by any code to abrogate the terms and conditions of the employment contract with the employee. Again, the employment contract is executed first. Only afterwards does the employer request a SSAN and tried to induce the employee to seek Social Security benefits and enter into a separate contract with a third party, in parentheses, IRS. Common sense, in parentheses, as well as contract law, tells us that neither party can subsequently introduce new, arbitrary terms and conditions that must be fulfilled by the other party before the instigating party will honor its obligations as agreed upon in the contract, in parentheses, a form of breach of contract. When a contracting party claims the existence of a law that mandates such perfidious conduct, that party is talking through his hat, as the Constitution expressly forbids the enactment, i.e., existence, of any such law. Quote, no state shall pass any law impairing the obligation of contracts. Constitution of the United States of America, Article 1, Section 10, Clause 6.
No one required to seek benefits.
Even in those cases where a SSAN is required in order to receive a benefit, such as for unemployment compensation, welfare, and food stamps, the decision to apply for any such benefit and provide a SSAN, in parentheses, method by which a sovereign forfeits his/her sovereignty and cements his/her subjugation, is always voluntary. It cannot be any other way, because there is neither a penalty for failure to initiate a request for a benefit, nor a penalty for failure to follow through and acquire any such benefit. No penalty equals not required. As an employee, the only official way to seek eligibility for Social Security benefits in respect of earnings with a particular employee is to provide that employer with a SSAN on a signed IRS form W-4. No other way is authorized in IRS. Therefore, if one does not wish to be eligible for Social Security benefits based on one's earnings with a particular employer, one would not submit the SSAN on the prescribed form, i.e., a W-4. To decline eligibility for Social Security benefits based on one's earnings apparently is a very commonplace event because the whole of the matter is taken up and concluded in a single sentence in IRS with a simple mandate for the employer. Sign an affidavit stating you requested a SSAN, but the employee did not give you one. Per IRS, no further action by the employer is authorized.
Voluntary compliance.
IRS officials and media pundits harp incessantly about voluntary compliance with income tax, and rightfully so. People who voluntarily acquire a SSAN, in parentheses, even via a parent, and then voluntarily sign a statement, in parentheses W-4, swearing that they are a taxpayer and liable for the income tax, and listing a SSAN, voluntarily obligate themselves for income tax on earnings they make with the employer that collects the sworn statement, in parentheses W-4. Such people should, therefore, voluntarily comply with IRC mandates re the payment of income tax on earnings with that employer. Employees for whom an employer has no SSAN on a signed W-4 would, of course, have no such obligation re their earnings with that employer. Quote, a person with no Social Security number would have no taxable income. Penny Payton, Claims Representative, Department of Health and Human Services, response letter to Jerome T. Shifen, January 10, 1990. For all intents and purposes, there is no substantial difference between an employee with no SSAN, in parentheses, as suggested in the above quote, and an employee who declines to provide a SSAN when requested of him/her. Once IRS receives a SSAN on a signed W-4, in parentheses, collected and sent in by an employer, however, IRS converts the SSAN into a taxpayer identification number, in parentheses, without authorization, and then the charade of providing for all the employee's purported future Social Security related benefits commences, and IRS begins expropriating whatever funds it wants from the paycheck today. The SSAN, the foundation and indispensable component of the income tax scheme, is acquired voluntarily and provided voluntarily, in parentheses, even in the case of government agencies, every step of the way for the purpose of participating in the advertised aims of Social Security, i.e., so-called retirement benefits. Making provision to realize said future retirement benefits by signing a W-4 today is a sovereign, self-determined, voluntary act that can be conscionably undertaken only for the purpose of acquiring a benefit. In parentheses, there can be no other reason. If no benefits are desired, no such action need be taken. When no SSAN is volunteered via the W-4, there is no Social Security payroll tax, and no other kind of tax associated with the earnings received from that employer. The reason one is asked, and not ordered, to do these things is because it is unlawful to force someone to do something against his/her will. The only way to become eligible for Social Security benefits is to acquire a SSAN and voluntarily go into contract with IRS by providing a SSAN on a signed IRS Form W-4. No one can be penalized for not seeking Social Security benefits.
Nuts and bolts proof. Federal codes.
The above arguments are not mere speculation and are confirmed in entirety in United States Code in parentheses USC and Code of Federal Regulations in parentheses CFR. An employer must request a SSAN from a new employee. Quote, any person required under the authority of this title to make a return, statement, or other document with respect to another person shall request from such other person and shall include in any return, statement, or other document such identifying number as may be prescribed for securing proper identification of such person. 26 USC 6109, subsection A, subsection 3. Regulation in parentheses positive law, interpreting the above 26 USC 6109, section A, section 3, prescribes procedure for an employer that does not know a new employee's SSAN even after having requested such. Quote, if the person making the return, statement, or other document does not know the taxpayer identification number of the other person, such person must request the other person's number. The request should state that the identifying number is required to be furnished under authority of law. When the person making the return, statement, or other document does not know the number of the other person and has complied with the request provision of this paragraph, C. Such person must sign an affidavit on the transmittal document forwarding such returns, statements, or other documents to the Internal Revenue Service so stating. A person required to file a taxpayer identification number shall correct any errors in such filing when such person's attention has been drawn to them. 26 CFR 301.6109-1 C. Penalty for an employer's failure to obtain a SSAN from a new employee. Quote, in the case of a failure by any person to comply with a specified information reporting requirement on or before the time prescribed therefor, such person shall pay a penalty of $50 for each such failure. 26 USC 6723. Waiver of penalty for failure to obtain a SSAN if employee refuses to provide a SSAN, in parentheses, purpose of the affidavit provision in 26 CFR 301.6109-1C. Quote, no penalty shall be imposed under this part with respect to any failure if it is shown that such failure is due to reasonable cause and not to willful neglect. 26 USC 6724, Section A. It is very simple. An employer is required to request a SSAN from a new employee, in parentheses, on a W-4, the only authorized way. If the new employee refuses to provide a SSAN, the employer is required by regulation, in parentheses positive law, to submit an affidavit attesting that the request was made, thus eliminating the possibility of willful neglect on the part of the employer and ensuring a waiver of the $50 penalty the employer would have incurred without it. What is the new employee's role in all this? The new employee plays almost no part in this process. The new employee has no contact and no relationship with IRS, only the employer, who merely requests a SSAN. Once the new employee declines to provide same, his/her role in the process is complete. At that point, the employer has no other lawful option than to send IRS an affidavit, in parentheses as prescribed by law, and honor the employment contract with the employee. IRS is satisfied. The new employee is satisfied, and therefore the employer should be satisfied. Employer versus IRS slave. The reason the current income tax scheme is so effective is that IRS enlists an outside third-party volunteer, the employer, to work without pay, i.e., as an unwitting slave, to ensure that people who draw a paycheck from said employer pay Social Security payroll tax, in parentheses, and income tax, by virtue of submitting the SSAN on an IRS Form W-4. Everything the employer does in this wise is voluntary. IRS assumes no liability for the actions of the employer, removal of funds from the employee's paycheck, or does IRS compensate the employer for his/hers labor. Since the employer already erroneously believes that it is his/her its duty to calculate, collect, in parentheses levy, and distribute taxes from employees' earnings without compensation, it is easy to imagine the difficulties that one might encounter in educating the employer the actual facts of the law. Therefore, it is an imperative that one be as prepared as possible to deal with any eventuality that might arise at the moment of truth.
Two different situations.
People who draw a paycheck for their living fit into one of two categories. 1. Currently employed. 2. Currently unemployed. Folks in the latter category will have an easier time of things when they start their next job because the employer will not know their SSAN. People currently employed who want their employer to change horses in midstream and forget their SSAN and sign W-4 may have a little more work ahead of them. In such case, moving on and looking for a new job may be more appealing than sticking with a current employer who refuses to mend his/her its ways, comply with the law, and do the right thing, despite the apparent disadvantages that come with seeking new work. We shall deal with both of these situations, the simpler of the two first, new employers. A most critical decision. The reader that decides to continue to participate in the Social Security retirement program in order to be eligible for Social Security and other types of benefits derived from his/her earnings via employment will have no use for the remainder of this essay. However, the information that follows immediately below is nevertheless offered, so those who are undecided are better equipped to make an informed decision.
The nature of Social Security.
The Social Security Retirement Benefits Program fits the definition of a Ponzi scheme and therefore should be carefully considered by those who intend to partake in it. Quote, Ponzi scheme, a fraudulent investment scheme in which money contributed by later investors generates artificially high dividends for the original investors, whose example attracts even larger investments. Money from the new investors is used directly to repay or pay interest to old investors, usually without any operation or revenue-producing activity other than the continual raising of new funds. This scheme takes from Charles Ponzi, who in the late 1920s was convicted for fraudulent schemes he conducted in Boston. Black's Law Dictionary, 7th edition, 1999. Social Security is the most massive Ponzi scheme in the history of the world, siphoning off literally tens of trillions of Social Security payroll tax dollars from unwitting volunteers since 1935. Presently, only people born before 1940, in parentheses old investors, can expect to receive a full payout of Social Security benefits for the duration of their life after they retire. Most others, in parentheses new investors, can only hope for partial benefits, and people born after 1970 have no hope of ever receiving any Social Security benefits in their lifetime. White House Press Secretary Ari Fleischer confirmed Social Security's nature as a Ponzi scheme in the Thursday, July 25, 2002 edition of the Los Angeles Times in an article entitled, White House Says Bush Still Backs Benefit Plan. Quote, White House Press Secretary Ari Fleischer took a swing at the existing Social Security program, calling it dangerous to let people pay a lifetime of high taxes for a Social Security benefit that under current projections they'll never receive. Those who do not wish to continue to take part in Social Security are invited to continue on with the addendum attached here too. Others may stop at this point. How to get paid all of your earnings. Addendum instructions. 1. How to handle a new employer if you do not want Social Security benefits. A. Rule 1. The very first thing that you need to be aware of is the text of the positive law, i.e., 26 CFR 301.6109-1, subsection C, that instructs an employer how to go about obtaining a SSAN from a new employee. Per the text of that section, once the employer knows the SSAN of an employee, the employer is purportedly compelled to provide IRS with such number, even if the new employee withholds consent, disagrees, and forbids any such use of the SSAN. Without placing oneself in a position to have to rectify such a wrong, it is easier simply to avoid the possibility of any such circumstance arising from the beginning. Therefore, the first rule to follow whenever a SSAN is requested of you is, never provide a SSAN unless you want to obtain Social Security benefits. B. Application for employment. It is very likely that the employment application will have a slot for a SSAN. If you do not want Social Security benefits, do not enter your trade name's SSAN. In block parentheses, note, the account holder is your trade name, not your true name. Examine the card if you do not believe this. In the slot on the application for a SSAN, place one of the following. Not applying for credit. Privacy Act. Credit check not required. Not an employee yet. Not applying for SS benefits.
C. How to respond to verbal demands.
If employer personnel tell you that they need a number to process your application, any of the following replies can work without generating friction. I can't remember it. I'll have to get it later. Do you want to run a credit check for the purpose of issuing credit? If not, a Social Security account number has no bearing on an application for employment. Unless you are willing to guarantee that I will be hired, I am not willing to provide a Social Security number ahead of time based on privacy concerns. I'm not applying for Social Security benefits. I'm applying for a job. The issue of Social Security benefits can be taken up later, after I'm hired. The Internal Revenue Code does not authorize requesting a Social Security number until I am hired. I am afraid of identity theft and prefer to withhold my Social Security account number for privacy reasons until it is confirmed that I am hired.
D. One possible exception.
In the most extreme cases where the employer insists that it is absolutely vital that an applicant's credit report be checked, in parentheses, even though the official SSA website says that there are no alternative methods to check on someone besides using a SSAN and that businesses do not need it, and it seems impossible to get to the next step without revealing it. Are you willing to take the chance in order to get the job? A SSAN might be provided under the following circumstances. Applicant. Okay, I can see that you are sincere, and therefore I am willing to allow my privacy to be compromised just this one time in order to accommodate your needs. However, the application will have to be noted and signed by a company officer that your company will use the number just this one time, and this time only, and for this purpose, and for no other purpose, and that no company employee will retain any record of that number after the credit check is complete, as long as you are willing to guarantee those things on behalf of the company on the face of the application, and as long as I keep the original application and you take a copy, I am willing to allow you to use the Social Security number to run a credit check. Employer. Okay. Never seen anyone that was so concerned about his privacy, though. E. Name and address of the job applicant. The last sentence of 26 CFR 301.6109-1 subsection C is very important and reads as follows. Quote, a person required to file a taxpayer identifying number shall correct any errors in such filing when such person's attention has been drawn to them. 1. IRS databases. What this means is that even though the employee may be successful in starting work without applying for Social Security benefits, and the employer sends IRS an affidavit as instructed, IRS can come back with a SSAN that matches up with the name and address, in parentheses, obtained by the employer from the new employee's job application, provided in the employer's affidavit, and demand that the employer then correct the errors in such filing, in parentheses, that IRS provides the employer. Now that the employer's attention has been drawn to them, and begin withholding taxes from said new employee's paycheck. If IRS knows the SSAN, count on them to intimidate the employer into withholding your earnings no matter what you say. 2. Sworn statements. A different name and address that minimizes the possibility of IRS matching up your trade name's SSAN from a previous employer is best. Never do anything illegal, such as swear out a false statement, in parentheses under penalty of perjury, etc. Any such act weakens your position whether discovered or not and should always be avoided. 3. Variations in the name. There are many ways that the name can be lawfully modified / abbreviated. In fact, creditors regularly use corruptions, in parentheses, derivatives, and variations in the spelling of the trade name on legal briefs when they come after an alleged debtor, and the court never has a problem in ruling against the alleged debtor. Turnabout is fair play. You can utilize this technique for your own advantage. 4. Addresses. Though strictly lawful means, it may be possible to cite an entirely different address than most people think is appropriate for your trade name, both historically and currently. You need to score the recesses of your mind and get creative. The more creative, the better chance of avoiding being linked up with a SSAN based on an address in an IRS database. P.O. boxes, especially those in the name of another party, work well. If one were living in a hotel room as of the date appearing on an employment application, one could arguably cite the address of the hotel on the application, even if it were out of town and out of state. These are personal choices based on personal conviction and, ideally, could be backed up with documentary evidence if the need ever arose. In parentheses, highly unlikely. F. Taking care of business. Shortly after you are hired, someone instructs you to go on down to personnel sometime today and sign all the forms, or some such thing. Follow through and make the visit as instructed. When you are confronted with the Social Security Benefits Eligibility Form, i.e., the W-4, look it over very studiously, and then politely hand it back. 1. Plausible exchange. Here is a sample conversation that might ensue in such an encounter. New employee. No thanks. I prefer not to seek any Social Security benefits. Personnel clerk. Oh, but we need that filled out in order to hire you. New employee. That's not what I was told by Mr. Smith. Personnel clerk. What do you mean? New employee. He told me I was already hired. Personnel clerk. Well, technically that's true, but IRS requires us to give them a signed W-4 from every new employee. New employee. Are you sure about that? Personal clerk. Oh yes, I've been working here for over 5 years, and every employee must give us a completed and signed W-4. New employee. Are you saying that what you are asking me to do is governed by the Internal Revenue Code? Personnel clerk. Yes. New employee. Well, I believe you are mistaken because the Internal Revenue Code gives explicit instructions on the procedure to follow when a new employee declines to provide a Social Security account number, and it does not involve trying to persuade the new employee to participate in Social Security. Personnel clerk. This is getting out of control. I am not here to argue. Either fill out and sign the W-4, or I will have to recommend that you not be hired. New employee. I'm already hired. Personnel clerk. Well, then I will have to recommend that you be fired. New employee. On what grounds? Personnel clerk. On the grounds that you will not do what I'm asking you to do. New employee. You are free to do that if you like, but you will be named as an interested party in a lawsuit, along with your company, for wrongful termination and numerous other crimes and violations of the Constitution. And I will win because what I am saying is backed up by the Social Security Administration, the Internal Revenue Code, and the Code of Federal Regulations, and what you are doing is unlawful, arbitrary, and not supported in law. Would you like to see the law that governs such matters? Personnel clerk. This conversation is over. Please wait here, in block parentheses, leaves the room for a few minutes and returns with Mr. Cooper, the head of the personnel department. New employee. Hi, Mr. Cooper. Personnel chief. What seems to be the problem, Mr. Doe? New employee. No problem for me. Miss Stewart just wanted me to sign up for Social Security benefits, and I declined her offer. Personnel chief. You mean you are unwilling to fill out a W-4 for our records? New employee. The purpose of a W-4 is to keep track of Social Security benefits on the money I earn here. Seeking benefits from Social Security is voluntary, and I choose not to seek such benefits. Personnel chief. I'm surprised at you, Mr. Doe. You impressed me as a very conscientious fellow, but I'm afraid I'm going to have to recommend your dismissal. New employee. You mean fire me? Personnel chief. That's correct. New employee. For what? Personnel chief. For being unwilling to follow the law and attempting to work in this country illegally. New employee. So, are you saying that in order for me to work in America legally, I am compelled to disclose a Social Security number and seek Social Security benefits? Personnel chief. Yes. New employee. Are you an attorney, Mr. Cooper? Personnel chief. No. New employee. Did you know that practicing law without a license is illegal, and that you just gave me a legal opinion? Do you know that you can go to jail for practicing law without a license? In block parentheses, silence, because Cooper does not know what he is talking about. What you just stated is completely outside the prescriptions of the Internal Revenue Code and the Code of Federal Regulations regarding an employee that does not provide the employer with a Social Security account number. Personnel chief. I am not going to put up with this nonsense any longer. If you are not willing to fill out a W-4, you will be fired. New employee. Very well, but you will be named as an interested party in a lawsuit that will be immediately filed against you and your company for wrongful termination, denying employment without due process, and other crimes and violations of the Constitution. And I will win because what I am saying is backed up by the Internal Revenue Code and the Code of the Federal Regulations and the Social Security Administration. And what you are proposing is unlawful, arbitrary, and not supported in law. However, all that unpleasantness can be avoided if you will show me the courtesy of a few minutes of your time to show you the law governing these matters. I have a copy of the applicable sections of the Internal Revenue Code and the Code of Federal Regulations, as well as the official position of the Social Security Administration. We could wrap up this whole conversation in as little as 5 minutes. Personnel chief. Are you trying to tell me that the Internal Revenue Code supports what you are saying? New employee. I am. Would you like to see it? Personnel chief, in block parentheses, hesitating. Okay. I'm willing to take a look at what you've got, but the first instance of any foolishness, and this is over. New employee. Fair enough. First of all, here is what Social Security says I can do when you request a Social Security number from me. This is a printout from the official Social Security Administration website telling people what to do when a business or other enterprise asks for their Social Security number. Here is the question, in parentheses, points at the highlighted question, and here is the answer, in block parentheses, points out the highlighted sections at the top of page 2 of the printout, copy enclosed here. Personnel chief. That's all fine and dandy, but we are forbidden to allow anyone to work here that does not have a SSAN on file. New employee. Is that company policy? Personnel chief. No, that's what the IRS requires us to do. New employee. Allow me to show you the Internal Revenue Code and the implementing regulations of the Code of Federal Regulations that instruct the employer exactly what to do. The employer does not have a Social Security account number for the employee. This is Section 2613, USC 6109, subsection A, Section 3 of the Internal Revenue Code, and block parentheses shows a printout of the actual code, copy enclosed here. Notice that the employer is only authorized to request a Social Security account number. No other action by the employer is authorized by the code. This is Section 26 CFR 301.6109-1, subsection C of the Code of Federal Regulations, which prescribes exactly how the employer is required to implement Section 6109, Section A, Section 3 of the Internal Revenue Code, irrespective of anything else that may apply in the case of the employee. This is the extent of what the employer is authorized to do. Please read it carefully. In block parentheses, Personnel Chief reads, notice that the employer's only lawful recourse is to sign and submit an affidavit on the transmittal document forwarding returns, statements, and other such documents to the IRS. There is no provision for the employer to take any action, such as firing the employee or refusing to pay him. Since I do not wish to apply for Social Security benefits, and since the W-4 is the only official form on which the Social Security number can be submitted, there is no reason to fill out the form. Personnel Chief. This all looks very official, but I know for a fact that IRS would come down on us if we allow you to work here without a Social Security number. New employee. You mean be penalized? Personnel Chief. Yeah. New employee. Do you know what the penalty is for an employer who fails to get a Social Security account number from a new employee? Personnel Chief. Not exactly. New employee. A $50 fine. But the $50 only comes into play if you fail to report that you don't have a number for a particular employee. Here is the section of the code that lays out the penalty, and here is the code that provides a waiver of that penalty for those employers that follow the code and send in an affidavit. In block parentheses, shows Personnel Chief a highlighted printout of sections 6723 and 6724, subsection A. Personnel Chief. This is too incredible to believe. You made your point, so I'm not going to fire you. But this has got to go above my head. I can't deal with this. New employee. Your CPA should be able to verify everything. Personnel Chief. Right. You're still an employee for the time being. But this will have to go through him, or our attorney, or both of them, as well as the boss. New employee. No problem. Here are the printouts of the code we looked at. You are welcome to keep them. Meanwhile, I'd like to get started. Personnel Chief. You are still hired provisionally, but that is subject to a final ruling on the outcome of all of this. You can work with Curtis Johnson until this is settled. He is in room 201 on the second floor. He's expecting you. New employee. Thank you. I'll head on up there. 2. Demeanor. Some cases will be much simpler, and others much more difficult, if not seemingly impossible. But pertinent issues always remain the same. That is why it is relatively easy for anyone to be able to grasp the concepts and, using only the 4 code sections cited above, become fluent in the subject. The most important thing is to maintain a cordial, genuine tone with those you speak with. Getting someone mad at you can wreck all the understanding you have established in an instant. 3. Sequence of events. Once someone is hired, he/she cannot be casually fired for an unfounded reason without risking serious legal action. As shown just above, such agencies as the Equal Employment Opportunity Commission may even get interested in helping you. The fact that one is officially hired and called employee is hard evidence of the illegitimacy of any attempt to then introduce a new arbitrary condition of employment after the fact of being hired. If providing a SSAN were truly a requirement for employment, no one could be hired until he/she divulged a SSAN and signed a W-4, an impossible state of affairs. 4. Extortion. What you are up against is true organized crime. The legal masters of the world have artfully convinced the employer that the employer is a slave and is obligated to coerce and extort its employees on behalf of an uninvolved third party, in parentheses IRS, and overwhelm employees with an offer they can't refuse. G. Case precedent. In a famous case involving a young man that did not want to obtain a SSAN based on religious convictions, as a condition of employment at Taco Bell after being hired, the court ruled that the boy did not have to obtain a SSAN in order to retain his right to work. The boy, 16-year-old Bruce Hansen, won a $10,000 judgment, but also agreed not to work at Taco Bell, thus preserving Big Brother's secret. In the court's dismissal of the defendant's motion to dismiss of March 9, 1992, the court stated, quote, "However, the court is unaware of, and ISC does not cite any federal law that requires termination of an employee because he or she refused to obtain a Social Security number." End quote. Equal Employment Opportunity Commission vs. Information Systems Consultant, case number CA3-92-0169-T. U.S. District Court, Northern District of Texas, Dallas Division. There is no inherent difference between an aversion to apply for a benefit, in parentheses, i.e., obtain and provide a SSAN, based on religious convictions, and one based on any other reason. This is why Social Security Administration informs people, even after the SSAN is acquired, that use of the number is always voluntary. If use of the number is always voluntary, then no employer can lawfully introduce a new condition of employment, in parentheses, to use / obtain a SSAN, after the fact of hiring someone and entering into an employment contract. H. The ultimate argument. The Constitution says that no state shall pass any law impairing the obligation of contracts, in parentheses, Article 1, Section 10, Clause 6. 1. Unconstitutionality. After someone is hired, such as the boy in the Taco Bell case, contractually speaking, the employer is bound by the agreed upon terms and conditions of the contract of employment with the new employee. If the Constitution has anything to do with this, there can be no law, in parentheses, i.e., no law can be introduced that impairs the obligation of the contract of employment between employer and employee. But this is what occurs every time one is coerced into providing a SSAN in order to keep from being fired. 2. Non-existent law. The above reveals the pure unconstitutionality of one contracting party, the employer, seeking to coerce the other contracting party, the new employee, into applying for Social Security benefits by extorting a second contract with an unrelated outside third party, in parentheses, the IRS, by claiming existence of a law that mandates such act and making such act a requirement in order for the employer to honor the terms of the original contract. Constitutionally speaking, after entering into an employment contract with a new employee, no employer can claim the existence of any law that impairs the employer's contractual obligations in the contract. The reason this is true is because there is, in fact, no such law that allows it. The disinformation inculcated into the collective consciousness of American employers, in parentheses, vigorously assisted by esquires, cannot be supported by the factual existence of any such law. 3. Supreme Court. This issue has never been asserted in a court of law, but its time has come, and this is what must be claimed. Based on the truth and gravity of this issue, any such move will undoubtedly invoke maximum resistance. But the simple truth of this contention cannot be denied, and a jury should be able to be convinced of it based on the evidence. The Supreme Court would blow IRS's cover by making a ruling on the unconstitutionality of such practice. Blatant use of a non-existent law, in parentheses IRC, that impairs the obligation of a contract, and that bridge will likely have to be crossed as the issue continues to arise with employers. I. The task at hand. This is not a fair fight, and it was never intended to be a fair fight. We have been under martial law since March 27th, 1861, when representatives from the 7 southern states walked out of Congress, in parentheses, leaving Congress without a quorum to adjourn, and Lincoln took over as commander-in-chief of the military and issued the first executive order, in parentheses, command. Things have gone downhill since then. Our gold has been swindled, and we have been converted into indentured servants and given a number to use in order to obtain credit and benefits, and work our whole life on the new plantation to pay off an ever-increasing imaginary debt, in parentheses, the so-called national debt. J. Ingredients for success. If you are to prevail against the odds and not be forced into volunteering for Social Security benefits against your will in order to keep from being fired by an employer, it may require a Herculean effort, including an explanation of what legal steps you will take if the employer does not follow the law and do the right thing. When you keep insisting that the employer follow the law and are unwavering in your resolve, many antagonists will eventually hear the truth in your urgings and capitulate and honor your wishes. Unfortunately, there will always be a small few that do not, but there is already a multitude of successes from people with much less ammunition to work with than is revealed here. In nearly every instance, their success stems from their unflagging certainty of the rightness of their position, combined with enough evidence to convince the employer of the legitimacy of what they were proposing.
K. IRS bait and switch.
The income tax hook is baited with the Social Security benefits, i.e., if you want eligibility for Social Security benefits, you have to do business with IRS, who then converts the SSAN into a taxpayer identification number and compels the employer to waylay your paycheck however IRS sees fit. The IRS Form W-4 is the official vehicle for an employee to apply for the Social Security benefits at his/her place of employment, and, per IRC, there is no other way for an employee to notify IRS. Therefore, both theoretically and practically speaking, if an employee does not want Social Security benefits on his earnings, there is no reason to notify IRS and provide a SSAN. This decision also happens to short-circuit Big Brother's dreams, as of much as 40% to 60% of an employee's paycheck is an unavoidable consequence. If an employee does not want Social Security benefits that can only be obtained through voluntary enrollment and participation in the Social Security retirement program, no law can compel the employee to volunteer a SSAN on a IRS form and seek such benefits.
L.
Following through. Let us say things result in a meeting with an executive of the firm. The exec can be handled via registered mail affidavit of mailing, maybe more easily than he/she can with a personal meeting. But when the time comes, you need to be fully prepared for anything and armed with the original of at least one letter from one of your congressmen and a certified copy of said letter, in parentheses, using a copy certification by document custodian form for any company officer you may have to deal with.
1. Write your congressman now.
Upon reading these words, it is critical that you immediately draft and mail a letter for each of your senators and your U.S. representative that contains no more than 2 of the questions listed below. Each letter should be as brief as possible and have a simple, plausible, compelling theme encapsulated, in parentheses ideally, in 1 sentence, in parentheses, not more than 2, that is deserving of an answer. In block parentheses, note, the terms American citizen and America may be interchanged with United States citizens and United States, respectively. Question. Is a United States citizen required to obtain a Social Security number in order to live and work in the United States? Question. Is an American citizen required to provide a Social Security number in order to live and work in America? Question. If I already have a Social Security number, is there any law that requires that I participate in any Social Security where I work? Question. Is there any law that requires a United States citizen to provide a Social Security number to be eligible for a benefit if he does not desire? Question. Is there any law prohibiting a United States citizen from working in the United States if he does not desire Social Security benefits? Question. Does an employer have the right to compel an employee to provide a Social Security number? Question. Is there any law that allows an employer to compel an employee to provide a Social Security number in order to retain his job? Question. Is there any law that allows an employer to refuse to pay an employee all of his earnings if the employee does not provide a Social Security number? Question. Is there any law that authorizes an employer to fire a new employee or withhold any of his pay if the new employee declines to provide a Social Security number and participate in Social Security? Question. Is there any law that allows an employer to compel a new employee to provide a Social Security number and participate in Social Security if the new employee does not want Social Security benefits? Question. Is there any law that requires a U.S. citizen to reveal his Social Security number in order to participate in the Social Security program where he works if he does not want to accumulate credit toward and be eligible for Social Security benefits on the money he earns there?
2. Properties of your letters.
The above questions are well thought out and are designed to elicit a meaningful answer by piercing any veneer that might be used to gloss over such inquiries. Therefore, it is recommended that you not introduce alterations. Notice that the subjects of IRS and W-4 are never mentioned, only Social Security related issues. Since Social Security is the advertised reason for filling out a W-4, the issue of Social Security is all that is addressed. The shorter and more coherent, courteous, and ingenuous the letter, the better the response you will receive. And it is an unwritten policy that all letters from constituents be answered in parentheses usually within 30 days. Antagonistic letters may be met with a polite, hollow reply or ignored altogether, so avoid such approach.
3. Official overwhelming validation.
Do not be surprised if the answer you receive contains the exact statement you are hoping for. Response letters from congressmen can be sent in and posted on the UCCSG website for all to see and benefit from. Letters can then be downloaded and printed out in parentheses on a color printer ideally by anyone, and a whole book of congressional responses can be compiled to use in convincing even the most stubborn of employers.
M. Handling things in writing.
An employer, in parentheses i.e. any of the employer's officers, can be handled with either / both of two types of written communication if necessary, affidavit and letter.
1. Affidavits.
The purpose of any affidavit used herein is twofold. A. To establish a paper trail of evidence proving one's intent, i.e., that one does not wish to volunteer for eligibility for Social Security benefits from the earnings one collects from a particular employer. And B. To let the employer know that one cannot be muscled into volunteering to participate in Social Security and is capable of seeking legal remedies against the employer, foremost of which is breach of contract. 2. Letters. The purpose of any letter is to state demands based on official policy of SSA, applicable sections of IRC and CFR, and personal responses from congressmen. Such demand letters should also have a, in parentheses color, photocopy of all documents cited within, in parentheses, SSA policy and IRC and CFR sections are attached herewith, as well as a certified, in parentheses color, copy of any letter from a congressman, in parentheses, using a copy certification by document custodian form as mentioned above.
3. Documenting your position.
Even when a company officer is personally handed written communication by you, if there is any doubt whatsoever concerning the eventual outcome of the employment situation, cover yourself by sending the same written communication by registered mail, restricted delivery, return receipt requested, affidavit of mailing, thus enabling you to prove that the company officer received it. Remember, no matter how easy this may turn out to be in the end, you must be prepared for the absolute worst in the beginning and every step of the way thereafter. And building a paper trail of evidence is the most prudent way to go about it. You are showing the employer that the actions taken by the employer against other reluctant SSAN holders for all these years is strictly on the employer's own determinism and is not authorized by law. There cannot be too many employers that are happy to discover this, but many who will be heartened to do the right thing and follow the law from here on out.
2. Current employers and voluntary compliance with the law. A. Currently employed.
Although this can be a much more difficult situation to remedy than one discussed in Part 1, in parentheses where the employer does not have a SSAN for a new employee, the fundamental issues are the same, and anyone in this latter category that has not read pages 1 through 16 in entirety needs to do so before continuing with this part.
B. The nature of the beast.
Nearly all people who are currently employed and want to withdraw from participation in the Social Security Retirement Benefits Program are seeing between 30% and 50% of their paycheck disappear, in parentheses, some are losing more, as a direct result of their employer having their SSAN on a signed IRS Form W-4 Employees Withholding Allowance Certificate. This apparently innocent little document is exactly the cornerstone of the entire Federal Reserve System confidence game, in parentheses, initiated November 22, 1910 in Jekyll Island, Georgia, and memorialized December 23, 1913 in the Federal Reserve Act of 1913. Because without ongoing, unfettered exploitation of unwitting volunteers via the W-4, the inherently fraudulent nature of the financial system is exposed. As revealed in Cracking the Code 3rd edition, all money is literally borrowed into existence, i.e., no bank actually ever loans anything of value, in parentheses, is forbidden to do so by banking regulations in a so-called loan transaction. The so-called loan is funded by the alleged borrower's promise to pay, in parentheses, promissory note, credit application, which is treated as a deposit, in parentheses, just like any other deposit and demand deposit account, e.g. checking, savings, and then converted into Federal Reserve notes without the alleged borrower's knowledge or consent, and returned as the loan, in parentheses, the foregoing procedure is verifiable with any CPA, unless vast sums of Federal Reserve notes, in parentheses FRNs, are regularly extracted from circulation in the form of income and other types of taxes, in parentheses, various fines associated with use of FRNs that accrue for the benefit of the owners of the FRNs. The money supply goes out of the roof and rampant inflation ensues. Such events do not take place in a substance-backed monetary system, in parentheses, such as the gold-backed system that this country enjoyed until as recently as 1913, and reflect on the intentions and activities of the custodian of the private money supply, in parentheses, Fed owners and operators, and can lead to serious demands for accountability from the constituency, in parentheses, such as recently as seen in Argentina and other South American countries, all of which now embrace other lawful alternative forms of money, money substitutes, and systems of barter. Federal Reserve notes extracted from the paychecks of hundreds of millions of American employees constitute the bulk of the foundation of Big Brother's ability to continue to operate the Federal Reserve confidence game. Deciding to opt out of the Social Security Ponzi scheme and completely and lawfully remove all of one's earnings from the realm of taxation is not something that is looked upon kindly by Big Brother's legions, in parentheses, e.g., CPAs, attorneys of all kinds, judges, government officials, etc., whose economic existence is predicated on the survival of the system, and can generate massive resistance, in parentheses, because it signals the beginning of the end of the Federal Reserve domination and control. When you undertake to handle a current employer and get the employer to honor your wishes to seize participating in Social Security, this is the monster that you seek to escape. Its propensity for blind hatred and lawlessness toward upstart slaves, in parentheses you, is not to be underestimated.
C. The root out.
You have volunteered to participate in the Social Security Retirement Benefits Program by placing your trade name's SSAN on a signed W-4, a sworn proclamation that you are taxpayer and liable for the income tax. Your saving grace, in parentheses and root out, is the fact that this is an unconscionable bargain, established not via just one, but all 5 factors that vitiate a contract by nullification of the consent factor, duress, menace, fraud, undue influence, and mistake, in parentheses attached herewith. Your task is to show your employer how each of these points is binding you detrimentally against your will, and thereby obtain the employer's agreement to honor the fact of the legal non-existence of the ink, marks, and data on the W-4.
D. Documents.
The following can be undertaken both verbally and in writing. The magnitude of the opposition one is faced with dictates which method is more appropriate, if not both. 1. Official endorsement. Immediately draft a letter for your senators and representative in Congress as described in paragraphs L1 through L3, beginning on page 15 of this essay, and obtain as many favorable responses as possible. There is nothing prohibiting you from also writing the Commissioner of Social Security, the General Counsel of the Social Security Administration, and any other similarly involved official, because all are hamstrung by the nature of the questions appearing on page 15 and cannot answer truthfully without helping your cause. A. Send in favorable responses from congressmen and government officials by scanning and emailing or by color photocopying and snail mailing such letters for posting on the www.uccsg.com website under Congressional Responses in the Document Archives section. B. Check under Congressional Responses in the Document Archives section at www.uccsg.com for letters from government officials confirming the voluntary nature of the use of a Social Security account number, and download and print a color copy for use in handling your employer. 2. Affidavit. Immediately begin composing an affidavit that is in conformity with affidavit properties and sample affidavit with instructions in the Document Archive section of www.uccsg.com. A sworn affidavit constitutes evidence, in parentheses, testimony, and this affidavit must document. A. Vitiating factors. The fact of duress, menace, fraud, undue influence, and mistake, each taken up individually in its own separately numbered paragraphs in intimate, moment-to-moment detail, in parentheses, unfolding like a motion picture in sequence, clarity, and vividness, that is responsible for W-4A SSAN, currently on file at IRS, courtesy of the employer. Consult the dictionary for the exact meaning of each of the above 5 terms to ensure absolute accuracy in the affidavit. Include all events and all parties, in parentheses, e.g. media articles / stories, school teachers, politicians, IRS personnel / literature, etc., influencing your decision to provide a SSAN and sign the W-4. If you are unable to determine exactly how one of the 5 factors bears upon your situation, omit any discussion of such point in the affidavit. B. Void W-4. The fact that the ink, marks, and signature appearing on the original subject W-4 in question, in parentheses, and the toner marks on any photocopy of the original W-4 in the possession of the employer, are not your ink marks, and signature per all applicable points listed in subparagraph 2, section A, immediately above, thus nullifying any alleged effectiveness of said document. The affidavit must positively state these facts.
C. No authorization.
Now that the W-4 contract is voided, any use / disclosure of the SSAN by the employer is not authorized, and any and all unauthorized use / disclosure of the SSAN is expressly forbidden and so stated. 3. Demand letter. Although some employers/employer personnel can be successfully handled on the points discussed below using only dialogue, nothing is guaranteed, and generally this is not known until after the fact. Therefore, to maximize chances of success, construct a demand letter in accordance with paragraph M2 on page 16, and also consider the following. A. Heading. Generally not advisable to place any type of heading on a letter, but there may be circumstances where this is appropriate. B. Contents. The letter needs to cite applicable sections from attached in parentheses and certified/notarized where possible/appropriate documentation and must make definitive demands based on 1. Statutory code Ray contracts in parentheses citing the 5 points that can vitiate a contract. 2. SSA policy from the official SSA website in parentheses Ray the fact of mistake. 3. Applicable sections of IRC and CFR in parentheses. Granted, this may appear to be a moot point and may be omitted if desired, but these issues can be used to show the employer what the employer needs to do from this point forward and may cause the employer to reconsider the employer's stance on the W-4 currently on file. 4. Favorable quotes in any letter from any government official. 5. Article 1, Section 10, Clause 6 of the Constitution of the United States in parentheses of America, and 6. Evidence contained in the affidavit described immediately above in paragraph D2. C. Intention. Without provoking the employer unduly, your written communication should reflect a quiet resolve to pursue matters via legal means if necessary. D. Transmission. Different types of personnel present different obstacles. Sometimes it is sufficient to hand over documentation in person in parentheses as in a meeting, and other times it is best to use registered mail. Analyze your options carefully and choose the most advantageous approach with each personnel. Generally, if there is any doubt whatsoever about the outcome of your situation, including a potential reversal of a positive current state of affairs, you must, in order to create a paper trail, you can rely on documenting your position, and to keep the employer on the employer's best behavior. Immediately send any and all concerned personnel the same documentation by registered mail, restricted delivery, return receipt requested, affidavit of mailing. You never want to shoot yourself in the foot by giving the impression of overkill, however, so any such mailing is best tempered with a simple cover letter citing the meeting, and that this is merely your way of obtaining official confirmation of receipt of documents.
D. Preparedness.
Remember what is at stake and never underestimate what objections may need to be fielded and diffused through documentary evidence in any meeting with any personnel. In short, you need to be fully prepared for the absolute worst from the very beginning. E. Demeanor. As stated in Part 1, get someone mad at you and you can destroy all the positive gains you make. You do not want to come across as a milquetoast, but you also do not want to use any more effort and insistency than is necessary to get the desired result. Always conduct yourself in a calm, courteous manner, no matter the provocation. The party that shows the most level-headedness usually prevails. You are holding all the aces. The only way to blow things is if you do not know it. F. Legal fiction. The main wrong being committed by an employer in such a situation is violation of privacy via unauthorized use of the SSAN. The WA4 is invalidated by the affidavit in parentheses evidence and lawfully cannot be superseded by anything less than a point-for-point counter affidavit sworn true, correct, and complete. In the event the employer chooses to continue to conspire with IRS and use and disclose private information after notification of lawful negotiation of the alleged W-4, in parentheses, the alleged W-4 is no longer signed and the SSAN no longer appears on the alleged W-4 once the affidavit is notarized and served on the employer and goes unrebutted. It is not unreasonable to consider legal action based on the correctness of your position as established in the documents referenced in paragraph D3, section B on page 19 of this essay.
G. Criminal matters.
Once any alleged authorization to use/disclose the SSAN is nullified by vitiating factors that are attested in sworn affidavit, the employer has no legal basis to continue to use/disclose said SSAN irrespective of any acts apparently compelled of the employer by IRC, and any such further unauthorized use / disclosure is willful. Title 42, United States Code, Chapter 7, Subchapter 2, Section 408 is very clear on the penalties for illegal use / disclosure of a SSAN. Quote, A. In general, whoever, Section 8, discloses, uses, or compels the disclosure of the Social Security number of any person in violation of the laws of the United States shall be guilty of a felony and upon conviction thereof shall be fined under Title 18 or imprisoned for not more than 5 years or both. 42 U.S.C. 408 Penalties. Also, should an employer illegally seek to compel a new employee to disclose a SSAN, e.g., to compel the employee seek Social Security benefits against his / her will as a condition of employment, the above statute also appears to have applicability. Social Security Online answers to your questions. Answers: Social Security numbers and cards, all subcategories. Phrases: Answer ID 78. Date of last update 7/03/2002, 3:29 p.m. When do I have to provide my Social Security number? Question: Must I provide a Social Security number (SSN) to any business or government agency that asks? Answer: The Social Security number (SSN) was originally devised to keep an accurate record of each individual's earnings and to subsequently monitor benefits paid under the Social Security program. However, use of the SSN as a general identifier has grown to the point where it is the most commonly used and convenient identifier for all types of record-keeping systems in the United States. Specific laws require a person to provide his / her SSN for certain purposes. While we cannot give you a comprehensive list of all situations where an SSN might be required or requested, an SSN is required / requested by Internal Revenue Service for tax returns and federal loans, employers for wage and tax reporting purposes, states for the school lunch program, banks for monetary transactions, Veterans Administrations as a hospital admission number, Department of Labor for workers' compensation, Department of Education for student loans, states to administer any tax, general public assistance, motor vehicle or driver's license law within its jurisdiction, states for child support enforcement, states for commercial driver's licenses, states for food stamps, states for Medicare, states for unemployment compensation, states for temporary assistance to needy families, U.S. Treasury for U.S. Savings Bond. The Privacy Act regulates the use of SSNs by government agencies. When a federal, state, or local government agency asks an individual to disclose his or her Social Security number, the Privacy Act requires the agency to inform the person of the following: the statutory or other authority for requesting the information, whether disclosure is mandatory or voluntary, what uses will be made of the information, and the consequences, if any, of failure to provide the information. If a business or other enterprise asks you for your SSN, you can refuse to give it. However, that may mean doing without the purchase or service for which your number was requested. For example, utility companies and other services ask for a Social Security number, but do not need it. They can do a credit check or identify the person in their records by alternative means. Giving your number is voluntary, even when you are asked for the number directly. If requested, you should ask why your number is needed, how your number will be used, what law requires you to give your number, and what the consequences are if you refuse. The answers to these questions can help you decide if you want to give your Social Security number. The decision is yours. For more detailed information, we recommend the publication at http://www.ssa.gov/pubs/1002.html. Laws, Cases and Codes, U.S. Code, Title 26, Section, Title 26, Internal Revenue Code, Subtitle F, Procedure and Administration, Chapter 61, Information and Returns, Subchapter A, Returns and Records, Part 1. Records, Statements, and Special Returns. N. Section A. Supplying of identifying numbers. When required by regulations prescribed by the Secretary. 1. Inclusion in returns. Any person required under the authority of this title to make a return, statement, or other document shall include in such return, statement, or other document such identifying number as may be prescribed for securing proper identification of such person. 2. Furnishing number to other persons. Any person with respect to whom a return, statement, or other document is required under the authority of this title to be made by another person, or whose identifying number is required to be shown on a return of another person shall furnish to such another person such identifying number as may be prescribed for securing his proper identification. 3. Furnishing number of another person. Any person required under the authority of this title to make a return, statement, or other document with respect to another person shall request from such other person, and shall include in any such return, statement, or other document such identifying number as may be prescribed for securing proper identification of such other person. 26 CFR Chapter 1 Part 301 Statute 301.6109-1 Identifying Numbers. C. Requirement to furnish another's number. Every person required under this title to make a return, statement, or other document must furnish such taxpayer identifying numbers of other U.S. persons and foreign persons that are described in paragraph B. Section 2, 1, 2, 3, or 5 of this section as required by the forms and the accompanying instructions. The taxpayer identifying number of any person furnishing a withholding certificate referred to in paragraph B, 2, 5 of this section shall be furnished if it is actually known to the person making a return, statement, or other document described in this paragraph C. If the person making the return, statement, or other document does not know the taxpayer identifying number of the other person, and such other person is one that is described in paragraph B, 2, 1, 2, 3, or 5 of this section, such person must request the other person's number. The request should state that the identifying number is required to be furnished under authority of law. When the person making the return, statement, or other document does not know the number of the other person and has complied with the request provision of this paragraph, C, such person must sign an affidavit on the transmittal document forwarding such returns, statements, or other documents to the Internal Revenue Service, so stating, a person required to file a taxpayer identifying number shall correct any errors in such filing when such person's attention has been drawn to them. USC Title 26, Internal Revenue Code, Subtitle F, Procedure and Administration, Chapter 68, Additions to the Tax, Additional Amounts, and Subchapter B, Assessable Penalties, Part 2, Failure to Comply with Certain Information Reporting, Statute 6723, Failure to Comply with Other Information Reporting Requirements. In the case of a failure by any person to comply with a specified information reporting requirement on or before the time prescribed therefor, such person shall pay a penalty of $50 for each such failure, but the total amount imposed on such person for all such failures during any calendar year shall not exceed $100,000. Laws, Cases, and Codes. U.S. Code, Title 26, Section 6724. United States Code, Title 26, Internal Revenue Code, Subtitle F, Procedure and Administration, Chapter 68, Additions to the Tax, Additional Amounts, and Assessable Penalties, Subchapter B, Assessable Penalties, Part 2, Failure to Comply with Certain Information Reporting Requirements, Section 6724, Waiver, Definitions and Special Rules. A. Reasonable cause waiver. No penalty shall be imposed under this part with respect to any failure if it is shown that such failure is due to reasonable cause and not to willful neglect. B. Payment of penalty. Any penalty imposed by this part shall be paid on notice and demand by the Secretary and in the same manner as tax. C. Special rule for failure to meet magnetic media requirements. No penalty shall be imposed under Section 6721 solely by reason of any failure to comply with the requirements of the regulations prescribed under Section 6011, Section E. 2. Except to the extent that such a failure occurs with respect to more than 250 information returns, in parentheses, more than 100 information returns in the case of a partnership having more than 100 partners. D. Definitions. For the purposes of this part, 1. Information return. The term information return means A. Any statement of the amount of payments to another person required by 1. Section 6041A or B, relating to certain information at source. 2. Section 6042A, 1. Relating to payments of dividends. 3. Section 6044A, 1. Relating to payments of patronage. California Codes, Civil Code, Section 1565 through 1590. 1565. The consent of the parties to a contract must be 1. Free, 2. Mutual, and 3. Communicated by each to the other. 1566. A consent which is not free is nevertheless not absolutely void, but may be rescinded by the parties in the manner prescribed by the chapter on rescission. 1567. An apparent consent is not real or free when obtained through 1. Duress, 2. Menace, 3. Fraud, 4. Undue influence, or 5. Mistake. 1568. Consent is deemed to have been obtained through one of the causes mentioned in the last section only when it would not have been given had such cause not existed. 1069. Duress consists in 1. Unlawful confinement of the person of the party, or of the husband or wife of such party, or of an ancestor, descendant, or adopted child of such party, husband or wife. 2. Unlawful detention of the property of any such person, or 3. Confinement of such person, lawful in form, but fraudulently obtained, or fraudulently made unjustly harassing or oppressive. 1570. Menace consists in a threat, 1. Of such duress as is specified in subdivisions 1 and 3 of the last section, 2. Of unlawful and violent injury to the person or property of any such person as is specified in the last section, or 3. Of injury to the character of any such person. 1571. Fraud is either actual or constructive. 1572. Actual fraud, within the meaning of this chapter, consists in all capital letters ends leges. Jones, Jack. 5143 Tunnel Vision Drive, Columbus, Ohio 43222. March 28th, 2002. Non-negotiable. Common law. Proper English spelling and pronunciation. John Henry Doe. Superscripted copyright symbol. Post Office Box 9999. Los Angeles, California 90010. Respondent's Private International Administrative Remedy Demand Number JHD-032802-JJ. For all capital letters ends leges, Jack Jones, a debt collector, via USPS, registered mail, article number RR 777-888-999, US. 4. All capital letters ends leges, Jack Jones, a debt collector, Chase, Man and Hat Mortgage Corporation, 5143 Tunnel Vision Drive, Columbus, Ohio 43222. Ray, written communication from Chase, Man and Hat Mortgage Corporation, hereinafter debt collector, dated March 15th, 2002, a copy of which is attached herewith, made fully part hereof, and included herein by reference. Notice by written communication / security agreement. This notice by written communication / security agreement, hereinafter, notice by written communication provides, all capital letters and leases, Jack Jones, hereinafter, user, notice that alleged debtor, i.e., all capital letters and leases, John H. Doe, is a common law copyrighted trade name / trademark of common law English spelling and pronunciation John Henry Doe, superscripted copyright symbol, hereinafter, secured party, and that any unauthorized use of, all capital letters and leases, John H. Doe, superscripted copyright symbol, by user constitutes copyright / trade name / trademark infringement, and all such uses is strictly prohibited. All rights reserved. Ray, common law, copyright of trade name / trademark, all capital letters and leases, John Henry Doe, superscripted copyright symbol, as well as any and all derivatives and variations in the spelling of said trade name / trademark, copyright, superscripted copyright symbol, 1973 by common law, English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, said trade name / trademark, all capital letters and leases, John Henry Doe, superscripted copyright symbol, may neither be used nor reproduced, neither in whole nor in part, nor in any manner whatsoever, without the prior, express, written consent and acknowledgement of common law, proper English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, subscribed with the hand-signed red ink signature of common law, proper English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, hereinafter, secured party. With the intent of being contractually bound, any juristic person, e.g., all capital letters and leases, Jack Jones, and all capital letters and leases, Chase, Man, and Hat Mortgage Company, as well as any agent and any principal of said juristic person, consents and agrees by this notice by written communication that neither said juristic person, nor any agent, nor any principal of said juristic person shall display, nor otherwise use in any manner the common law trade name / trademark, all capital letters and leases, John Henry Doe, superscripted copyright symbol, nor any derivative of, nor any variation in the spelling of said trade name / trademark, nor the common law copyright described herein without the prior, express, written consent and acknowledgement of secured party, subscribed with secured parties, hand-signed, signature in red ink. Secured party neither grants, nor implies, nor otherwise gives consent, nor authorized use of, all capital letters and leases, John H. Doe, superscripted copyright symbol, and all such unauthorized use is strictly prohibited. Secured party is not now, nor has secured party ever been, an accommodation party, nor a surety for the alleged debtor, i.e., all capital letters and leases, John H. Doe, nor for any derivative of, nor for any variation in the spelling of said name, nor for any other juristic person, and is so indemnified and held harmless by, all capital letters and leases, John H. Doe, superscripted copyright symbol, in hold harmless and indemnity agreement number JHD-050690-HHIA, dated the 6th day of the 5th month in the year of our Lord 1990, against any and all claims, legal actions, orders, warrants, judgments, demands, liabilities, losses, depositions, summonses, lawsuits, costs, fines, liens, levies, penalties, damages, interest, and expenses whatsoever, both absolute and contingent, as are due and as might become due, now existing and as might hereafter arise, and as might be suffered by, imposed on, and incurred by, all capital letters and leases, John H. Doe, superscripted copyright symbol, for any and every reason, purpose, and cause whatsoever. Self-executing contract / security agreement in event of unauthorized use. By this notice, by written communication, both, all capital letters and leases, Jack Jones, and, all capital letters and leases, Chase, Man, and Hat Mortgage Corporation, hereinafter jointly and severally referenced as user in this paragraph, consent and agree that any use of, all capital letters and leases, John H. Doe, superscripted copyright symbol, other than authorized use as set forth above, constitutes authorized use. Counterfeiting of secured parties, common law, copyrighted property, contractually bounds user, renders this notice by written communication a security agreement, hereinafter, security agreement, wherein user is debtor and common law, proper English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, is secured party, and signifies that user, 1. Grants secured party a security interest in all of user's assets, land, and personal property, and all of user's rights in assets, land, and personal property, and the sum certain amount of $500,000 per each occurrence of use of secured parties, common law, copyrighted, trade name / trademark, all capital letters and leeches, John Henry Doe, superscripted copyright symbol, as well as for each and every use of any and all derivatives of and variations in the spelling of said common law, trade name / trademark, not excluding common law, proper English spelling and pronunciation, John Henry Doe, plus all costs, plus triple damages. 2. Authenticates this security agreement wherein user is debtor and common law, proper English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, is secured party, and wherein user pledges of all of users' assets, land, motor vehicles, aircraft, vessels, ships, trademarks, copyrights, patents, consumer goods, firearms, farm products, inventory, equipment, money, investment property, commercial tort claims, letters of credit rights, chattel paper, electronic chattel paper, tangible chattel paper, certificated securities, uncertificated securities, promissory notes, payment intangibles, software, healthcare insurance, receivables, instruments, deposit accounts, documents, livestock, real estate and real property, including all buildings, structures, fixtures, and appurtenances situated thereon, as well as affixed thereto, fixtures, manufactured homes, timber, crops, and as extracted collateral, i.e., all oil, gas, and other minerals, as well as any and all accounts arising from the sale of these substances, both at wellhead and minehead, accessions, increases and additions, replacements of and substitutions for any of the property described here and above in this paragraph, products, produce, and proceeds of any of the property described here and above in this paragraph, accounts, general intangibles, instruments, monies, payments and contract rights, and all other rights arising out of sale, lease, and other disposition of any of the property described here and above in this paragraph, proceeds including insurance, bond, general intangibles, and accounts proceeds from the sale, destruction, loss, or other disposition of any of the property described here and above in this paragraph. Records and data involving any of the property described here and above in this paragraph, such as in the form of a writing, photograph, microfilm, microfiche, tape, electronic media, and the like, together with all of users' rights, title, and interest in all computer software and hardware required for utilizing, creating, maintaining, and processing any such records and data in any electronic media, and all of users' rights in all such foregoing property in this paragraph, now owned and hereafter acquired, now existing and hereafter arising, and wherever located, as collateral to secure users' contractual obligation in favor of secured party for users' unauthorized use of secured parties' common law copyrighted property. 3. Consents and agrees that secured party may file a UCC financing statement wherein user is debtor and common law proper English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, is secured party. 4. Consents and agrees that said UCC financing statement described above in paragraph 3 is a continuing financing statement, and further consents and agrees with secured parties' filings of any continuation statement necessary to maintain secured parties' perfected security interests in all of users' properties and rights in property pledged as collateral and security agreement as described above in paragraph 2, until users' contractual obligation theretofore incurred has been fully satisfied. 5. Authorizes secured party to file any UCC financing statement as described in paragraphs 3 and 4, and any security agreement as described above in paragraph 2, both in the UCC filing office and at any county recorder's office. 6. Consents and agrees that any and all such filings described in paragraphs 4 and 5 above are not and may not be considered bogus, and that user will not claim that any such filing is bogus. 7. Waives all defenses. 8. Waives rights of presentment, notice of dishonor, and notice of protest. And 9. Appoints secured party as authorized representative for user, effective upon user's default, user's contractual obligations in favor of secured party as set forth below under payment terms and default terms, granting secured party full authority and power to engage in any and all actions on behalf of user, including, but not limited to, authentication of record on behalf of user as secured party, in accordance with secured party's sole discretion deems appropriate, and as regards any deposit account of any kind maintained with any bank in / under the name of user, and likewise any deposit account maintained with any bank in / under the taxpayer identification number of user, notwithstanding the absence of user's name as account holder, on any such deposit account maintained with any bank in / under the taxpayer identification number of user, grants secured party full authority and power to originate instructions for said deposit account bank and direct the disposition of funds in said deposit account by acting as signatory on said deposit account without further consent of user and without liability, and user further consents and agrees that this appointment of secured party as authorized representative for user, effective upon user's default, is irrevocable and coupled with a security interest. User further consents and agrees with all of the following additional terms. Payment terms, in accordance with fees for authorized use of, all capital letters and legis, John H. Doe, superscripted copyright symbol, as set forth above. User hereby consents and agrees that user shall pay secured party all unauthorized use fees in full within 10 days of the date user is sent secured party's invoice, hereinafter invoice itemizing said fees. Default terms, an event of non-payment in full of all unauthorized use fees by user within 10 days of date invoice is sent. User shall be deemed in default and A. All of user's property and rights in property pledged as collateral by user as set forth above in paragraph 2 immediately becomes, i.e., is property of secured party. B. Secured party is appointed user's authorized representative as set forth in paragraph 9. And C. User consents and agrees that secured party may take possession of, as well as otherwise dispose of, in any manner that secured party and secured party's sole discretion deems appropriate, including but not limited to sale at auction, at any time following user's default and without further notice. Any and all of user's former property and rights in property formerly pledged as collateral by user, described above in paragraph 2, now property of secured party, in respect of this security agreement, that secured party, again in secured party's sole discretion, deems appropriate. Terms for curing default. In event of default as set forth above under default terms, user can cure user's default and avoid strict foreclosure of any remainder of user's former property that is neither in the possession of secured party nor otherwise disposed of by secured party, only by tendering payment within 20 days of user's default, and only by payment in full of the balance of the sum certain amount owned by user, as noticed user in invoice, that is not already paid by secured party's possession, sale, liquidation, and the like of user's former property and rights in property pledged as collateral to secure user's obligation. Terms of strict foreclosure. User's non-payment in full of all unauthorized use fees itemized in invoice within said 20-day period for curing default as set forth above under terms for curing default authorizes secured parties immediate non-judicial strict foreclosure on any and all remaining property and rights in property formerly pledged as collateral by user, now property of secured party, which is not in the possession of nor otherwise disposed of by secured party upon expiration of said 20-day default curing period. Ownership subject to copyright of common law, trade name / trademark, and security agreement, and UCC financing statement filed with the UCC filing office. Record owner, common law, proper English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, autograph, common law, copyright, superscripted copyright symbol, 1973. Should any provision of this notice by written communication be unenforceable, said unenforceable provision is hereby severed from this notice by written communication, but every remaining provision continues in full force and effect, and this notice by written communication is deemed modified in a manner that renders this notice by written communication in full force and effect. In all cases, secured party continues without liability and is held harmless. Any prior communication, written document, and the like by and between user and secured party containing any mistake of secured party is invalidated thereby and of no force and effect, and may not be relied upon by user against secured party in this matter. No consent of any kind is granted, nor otherwise given, any matter offered, /alleged, /asserted by user, and secured party withholds all consent. Secured party will consider granting consent in favor of user only upon user's full disclosure of any and all consequences of any such granting of consent, accompanied by user's commensurate attendant liability for the veracity, relevance, and verifiability of any such disclosure, which liability is borne by user in the form of an unauthenticated security agreement, wherein user is debtor and, common law, proper English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, is secured party. That self-executes effective the moment of the secured party's confirmation of any material inconsistency, /deviation, /discrepancy, and the aforementioned resultant consequences avowed by user, as determined solely by secured party and secured party's sole discretion. Alleged debtor, i.e., all capital letters, ens legis, John H. Doe, superscripted copyright symbol, does not take issue with the amount of any alleged debt. Rather, alleged debtor asserts that the alleged debt is not valid. Secured party holds a claim / security interest greater than any claim alleged by user, a copy of which filed UCC financing statement evidencing such supreme claim and security interest is attached herewith, made fully part hereof, and included herein by reference. And, as stated above, secured party is neither a surety nor an accommodation party for alleged debtor, and may not be construed as functioning in such capacity under any circumstances. Further, this is a request for validation of any alleged debt and is not a request for a copy of any invoice, statement, bill, agreement, alleged contract, alleged contract, and the like. Nor is it a request for any copy of any notification of assignment, negotiation / transfer of rights. Nor is it a request for a copy of any other unverified document / presentment referencing said alleged debt. This request for validation of any alleged debt is a request for a bona fide verification of any alleged debt. In accordance with law, only sworn affidavits, oaths, and depositions qualified as verification of the lawful existence of any bona fide debt. Absent such verification validating the alleged debt, and absent proof of a claim greater than that of secured party, user fails to state a claim upon which relief can be granted. Wherefore, in accordance with the Fair Debt Collection Practices Act, effective immediately upon user's receipt of this notice by written communication, user must cease all collection / prosecution efforts against alleged debtor, secured party, and secured party secured private property. User is hereby notified of the following Privacy Act notice. Privacy Act notice. This written notice by communication constitutes user's due process notice and opportunity to be heard. Absent compliance with all requirements set forth herein, user is barred from using any defense of immunity from prosecution for user's actions, as well as the actions of user's agents. By this notice by written communication, user, as well as user's agents and principals, shall comply with the provisions of the Privacy Act of 1974, as lawfully amended, 12 U.S.C. Statute 3401. The Right to Financial Privacy Act of 1978, as lawfully amended, 5 U.S.C. Statute 552A, and the Third Party Summons Act, Special Procedures, 26 U.S.C. Statute 7609, as lawfully amended to assist secured party in keeping inviolate certain constitutionally protected privacy rights. By this notice by written communication, user, as well as user's agents and principals, shall comply with this demand. User shall provide secured party with a copy of any express written authorization from secured party whereby user is authorized to disclose / reveal / divulge / share with any third party in any manner, as well as by any means of communication, any information, documentation, data, property, effects, and the like ray alleged debtor, in all capital letters ens legis, John H. Doe, superscripted copyright symbol, and likewise concerning secured party. User's failure to provide said foregoing demanded authorization constitutes admission by user that user is in violation of the Privacy Act as well as other laws. User possesses neither express, written authorization nor consent from alleged debtor, in all capital letters, ens legis, John H. Doe, superscripted copyright symbol, nor secured party, to use, reveal / disclose / divulge / share with any third party, and the like, any secured information, documentation, data, property, effects, and the like of secured party. This notice by written communication is binding upon every principal and agent rate the subject matter set forth herein, and each principal and each agent is a. Barred from providing any credit reporting agency any derogatory credit information regarding the above alleged debt. B. Prohibited from contacting alleged debtor by mail, by telephone, as well as in person, both at alleged debtor's residence, as well as alleged debtor's place of employment, and C. Prohibited from contacting any other third party regarding the above referenced alleged debt until the user establishes the existence of a superior claim greater than that of secured parties, and until said alleged debt is verified and indicated above and the alleged debtor is provided with any such verification. Note: the Fair Debt Collection Practices Act at 15 U.S.C. Statute 1692 ET-SEQ states in relevant part that a debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt, which includes the false representation of a character or legal status of any debt, as well as the threat to take any action that cannot legally be taken, all of which constitute violations of law. Therefore, User, as well as any assignee, is prohibited from filing any lawsuit, notice of lien, notice of levy, and the like, as well as any other legal action against the alleged debtor, as well as against any of the secured parties' secured private property, which is exempt from lien and exempt from levy. 15 U.S.C. Statute 1692E, Section 8 states, quote, communicating or threatening to communicate to any person credit information which is known or which should be known to be false, including the failure to communicate that a disputed debt is disputed, is a violation of Statute 1692E. Further, users above reference written communication, if valid, constitutes an issue of public currency, and alleged debtor hereby requests from user, in accordance with the fundamental principles of American jurisprudence and law, bona fide documentary evidence that establishes the lawful basis of user's issue of said public currency, and user's claim for payment of the alleged debt liability referenced within user's written communication issuing the public currency and stating the claim, i.e., A. Bona fide identification of any person making requests for payment by, all capital letters as leaches, John H. Doe, superscripted copyright symbol, including a copy of said person's bona fide handwritten, legible, and notarized signature, and the thumbprint from either hand of said person making the request for payment by, all capital letters and leaches, John H. Doe, superscripted copyright symbol. B. Bona fide evidence of any said person's authority to make a request for payment by, all capital letters and leaches, John H. Doe, superscripted copyright symbol, if said person is acting on behalf of another, and C. Exhibition of the bona fide instrument, i.e., the bona fide commercial contract bearing the bona fide signature which supports user's demand for payment of alleged debt by, all capital letters and leaches, John H. Doe, superscripted copyright symbol, that operating publicly establishes user's issue of public currency alleged collectible from any of 1. Alleged debtor, 2. Alleged debtor's assets, 3. Secured party, 4. Secured parties, secured private property, and D. Positive law in support of user's written attempt to collect alleged debt that, operating publicly, establishes user's issue of public currency collectible from any of 1. Alleged debtor, 2. Alleged debtor's assets, 3. Secured party, 4. Secured parties, secured private property. Alleged debtor and secured party can and will lawfully construe user's failure to comply with and satisfy essential requirements of the Fair Debt Collection Practices Act in the above 4 requests, i.e., A, B, C, and D, and the paragraph immediately above, within a reasonable time, i.e., 21 days following user's receipt of this written communication, as user's self-invalidation of user's demand for payment, verification of the alleged debt and satisfaction of the aforementioned 4 specific requests must be duly affirmed in the form of one of the following: A. Affidavit, B. Oath, C. Deposition. Until the alleged debt is verified in accordance with the Fair Debt Collection Practices Act, and said verification is sent alleged debtor and received by alleged debtor, each and every contact in violation of the Fair Debt Collection Practices Act constitutes harassment and defamation of character and makes user, as well as any and all agents and principals who take part in such harassment and defamation, a subject of liability for damages, as well as statutory damages and legal fees for each and every violation in private capacity. User, all capital letters and leaches, Jack Jones, tacitly consents and agrees that, all capital letters and leaches, Jack Jones has a duty to prevent this alleged account from damaging both alleged debtor and secured party, and further consents and agrees that alleged debtor and secured party each reserve the right to initiate a counterclaim, as well as a claim against any of the following, all capital letters and leaches, Jack Jones's bond, all capital letters and leaches, Jack Jones's guarantor, any of, all capital letters and leaches, Jack Jones's principals, agents, and assignees whose acts, omissions, result in either of the following: A. Tort damages against alleged debtor. B. Tort damages against secured party. Due process of law is guaranteed both alleged debtor and secured party at Debt Collector's Office of Risk Management and is codified at 18 U.S.C. Statute 1581, 242, 241, 4 at 15 U.S.C. Statute 1692 and elsewhere. The attached written communication is respondent's response, Ray, user's attempt via written communication to collect an alleged debt. This notice by written communication /security agreement is herewith executed this 28th day of the 3rd month in the year of our Lord 2002 by and between the undersigned parties. Debtor, all capital letters and leges, Jack Jones. Jack Jones, debtor's signature. Secured party accepts debtor's signature in accord with UCC Statute 1-201-39-3-401. Secured party, common law, English spelling and pronunciation, John Henry Doe, superscripted copyright symbol. Secured party signature, autograph, common law, copyright, superscripted copyright symbol, 1973, by common law, proper English spelling and pronunciation, John Henry Doe, superscripted copyright symbol. All rights reserved. No part of this autograph, common law, copyright may be used, nor reproduced in any manner, without prior, express, written consent and acknowledgement of secured party. Subscribed with secured parties, hand, signed, signature in red ink. Authorized use of common law, proper English spelling and pronunciation, John Henry Doe, incurs same unauthorized use fees as those associated with, all capital letters and leges, John Henry Doe, superscripted copyright symbol, as set forth above in paragraph 1, under self-executing contract /security agreement in event of unauthorized use. Enclosures, copy of written communication from Chase, Mann and Hat Mortgage Corporation dated March 15th, 2002. Published copyright notice filed. UCC financing statement, private agreement, hold harmless, and indemnity agreement, security agreement. All capital letters, ens leges, John H. Doe, superscripted copyright symbol, P.O. Box 9999, Los Angeles, California, 90010. Respondents, private, international administrative remedy demand number JHD-032802-JJ. This private international administrative remedy demand number JHD-032802-JJ is binding upon every principal and agent Ray, the subject matter set forth herein below. Date, March 28th, 2002. Via USPS, registered mail, article number RR 777888999, US. 2. All capital letters ends leges, Jack Jones, doing business as a debt collector, hereinafter debt collector. All capital letters ends leges, Chase, Mann and Hat Mortgage Corporation, 5143 Tunnel Vision Drive, Columbus, Ohio, 43222. Ray, debt collectors, written communication, hereinafter, written communication dated March 15th, 2002, referencing alleged creditor, all capital letters, ens leges, Chase, Mann and Hat Mortgage Corporation, alleged account number 001-234567889-96, alleged amount due $135,458.21. Subject, tender of payment and notice of reservation of rights to initiate a counterclaim and file a claim against bond. 1. Let it be known by these presents that, all capital letters, ens leges, John H. Doe, superscripted copyright symbol, respondent, is in receipt of debt collectors above referenced written communication, a true and correct copy of which is attached herewith, made fully part hereof, and included herein by reference. 2. Respondent hereby gives debt collector notice that this written communication is not a refusal to pay the alleged debt implied by written communication, but constitutes express written notice that A. The above referenced alleged debt is not valid. B. Debt collector's claim is disputed. C. Respondent does not take issue with the amount of alleged debt claimed, and that D. Upon receipt of notice, debt collector must cease all collection activity Ray the alleged account /debt until respondent is sent the herein requested verification as required by the Fair Debt Collection Practices. Tender of payment. 3. Respondent, without waiver of any defense, and for the purposes of resolving this matter in good faith, hereby tenders payment in the form of a certified promissory note, accompanied by offer of performance, both of which are attached herewith, made fully part hereof, and included herein by reference for the purpose of discharging the alleged debt as stated within debt collector's above referenced written communication. 4. Respondent retains original of debt collector's written communication as proof respondent has not dishonored debt collector's written communication, nor in any way acted in bad faith. 5. Respondent gives debt collector notice that, in accordance with law as codified at 15 U.S.C. Statute 1692 G. B. If the consumer notifies the debt collector in writing within the 30-day period described in subsection A of this section that the debt or any portion thereof is disputed, or that the consumer requests the name and address of the original creditor, the debt collector shall cease collection of the debt, or any disputed portion thereof, until the debt collector obtains verification of the debt or a copy of a judgment, or the name and address of the original creditor, and a copy of such verification or judgment, or name and address of the original creditor, is mailed to the consumer by the debt collector. 6. Be advised that verification is defined in parentheses in Black's Law Dictionary, 6th edition, as follows: confirmation of correctness, truth, or authenticity by affidavit, oath, or deposition. Affidavit of truth of matter stated and object of verification is to assure good faith in averments or statements of party. 7. Debt collector is further noticed that this is not a request by respondent for a photocopy of any invoice, statement, bill, summary, agreement, and the like, and that any future communication received by respondent from debt collector, in written as well as any other form, absent the above cited requisite, verification of debt, irrespective of the inclusion of any photocopy of any related invoice, statement, bill, summary, agreement, and the like, constitutes debt collector's tacit admission, confession, and agreement that debt collector has no lawful, bona fide, verifiable claim, re the alleged account. 8. Respondent also includes, with this written communication, debt collector disclosure statement for the purpose of ensuring that debt collector's verification of the debt is executed in accordance with law as codified at 15 U.S.C. Statute 1692, Section G, and must be completed in full by debt collector and received by respondent within 21 days of debt collector's receipt of this written communication. Notice of reservation of right to initiate a counterclaim and file a claim against official bond. 9. If debt collector, such as by commission, omission, and otherwise, a. fails to give respondent full disclosure, re. the nature and cause of debt collector's claim concerning the herein above referenced alleged debt, b. makes a false representation of the character of the herein above referenced alleged debt, c. makes a false representation of the legal status of the herein above referenced alleged debt, d. makes any threat of action that cannot legally be taken in violation of any applicable law, such as the law codified at the Fair Debt Collection Practices Act. Respondent may initiate a counterclaim / claim against the official bond of debt collector, as well as the bond of any principal, agent, assignee, and the like, of debt collector, whose acts / omissions result in respondent sustaining any tort injury. 10. Debt collector is also hereby given notice that a. debt collector's unsubstantiated demands for payment, a scheme or artifice, caused to be delivered by mail, may constitute mail fraud under state and federal laws. In parentheses, debt collector may wish to consult with competent legal counsel before originating any further communication with respondent. And b. debt collector's failure to provide respondent with the requisite verification validating the above referenced alleged debt with the requirements of law as codified in the Fair Debt Collection Practices Act and the corresponding laws of each state signifies that debt collector tacitly agrees that 1. Debt collector has no lawful, bona fide, verifiable claim re the above referenced alleged account. 2. Debt collector waives any and all claims against respondent. And 3. Debt collector tacitly agrees that debt collector will compensate respondent for all costs, fees, and expenses incurred in defending against this in any and all continued collection attempts re the above referenced alleged account. 11. This is also an attempt to determine the nature and basis of a case / counterclaim against debt collector and any information contained within debt collector disclosure statement, as well as any information obtained otherwise, such as by debt collector's commissions, omissions, and the like, will be used for that purpose. 12. Due process of law is guaranteed both alleged debtor and secured party at debt collector's Office of Risk Management and is codified at 18 U.S.C. Statute 1581, 242, 241, and 4, at 15 U.S.C. Statute 1692, and elsewhere. All capital letters and legis, John H. Doe, superscripted copyright symbol, respondent. Enclosures, offer of performance, certified promissory note, verification of tender of payment, notice of reservation of right to initiate counterclaim and file a claim against bond, debt collector disclosure statement. Date, March 28, 2002. Recording requested by, and when recorded returned to, Common Law, English, Spelling, and Pronunciation, John Henry Doe, superscripted copyright symbol, Post Office Box 9999, Los Angeles, California, 90010. Respondents, Private, International, Administrative Remedy Demand, Number JHD-032802-JJ. This notice is binding upon every principal and agent, the subject matter set forth herein. Via United States Postal Service, Registered Mail, Article Number RR777888999, U.S. For all capital letters ends legis, Jack Jones, doing business as a debt collector, hereinafter, debt collector, all capital letters, Chase, Man, and Hat, Mortgage Corporation, 5143 Tunnel Vision Drive, Columbus, Ohio, 43222. Ray, alleged creditor, all capital letters, Chase, Man, and Hat, Mortgage Corporation, alleged account number 001-234567889-96, alleged amount due $135,458.21. Subject, offer of performance. Offer of performance. 1. This offer of performance is tendered in good faith as full satisfaction of the claim referenced above, with the intent of extinguishing any alleged debt, duty, obligation, liability, and the like intended to obligate respondent, in all capital letters and legis, John H. Doe, superscripted copyright symbol, named in written communication from, all capital letters and legis, Chase, Man, and Hat, Mortgage Corporation, dated March 15, 2002, hereinafter written communication, a copy of which is attached herewith, made fully part hereof and included herein by reference. 2. Concerning this offer of performance, hereinafter, offer, Ray, alleged account 001-234567889-96, debt collector may, A. Accept offer, B. Reject offer, C. Object regarding the mode of offer. 3. This offer of payment of that certain sum of money that debt collector alleges / asserts via written communication constitutes respondent's debt, duty, obligation, and liability, including interest and penalties, is made dependent upon performance by debt collector of conditions precedent concerning the respondent / offeror, is entitled by the fundamental principles of American jurisprudence and law, namely, provision by debt collector of verification of alleged debt, accompanied by documentary evidence established the factual basis for debt collector's claim for payment asserted within debt collector's above referenced written communication, i.e., validation of debt collector's right to collect the alleged debt by providing the requisite verification including A. Copies of all agreements of assignment, negotiation, transfer of rights, and the like, and indicating whether debt collector is the current owner, assignee, holder, etc., with evidence of respondent's consent with any such agreement if a novation. B. All relative commercial instruments, contracts, and the like containing respondent's bona fide signature, in parentheses subject theory. C. Any evidence of an exchange of a benefit, as well as an exchange of a detriment, in parentheses implied contract. D. Any evidence of any series of external acts giving the objective semblance of agreement, in parentheses objective theory. E. all other documentary evidence between respondent of debt collector that debt collector relies upon in making debt collector's presumptive claim. F. Name and address of original creditor and G. A certified copy of any judgment. 4. Respondent/offeror expects a response offer within a reasonable period of time of receipt of offer, which is hereby set at 21 days, not counting day of service. 5. Respondent/offeror does not waive timeliness. If additional time is needed, however, debt collector must make a request in writing before expiration of said 21-day period described above in paragraph 4, setting forth debt collector's reasons for requesting such extension of time with good cause shown. Respondent/offeror will consider any such request for extension of time, the granting of which, however, is conditioned solely upon the decision of respondent/offeror. 6. Respondent/offeror hereby gives debt collector notice that, as an operation of laws codified at California Civil Code Statute 1485 and California Code of Civil Procedure Statute 2074, respectively. A. An obligation is extinguished by an offer of performance, made in conformity with the rules prescribed and with the intent of extinguishing the obligation. B. An offer in writing to pay a particular sum of money, as well as to deliver a written instrument / specific personal property, is, if not accepted, the equivalent of the actual production and tender of the money / instrument / property. 7. In the event that debt collector does not respond, offer within the prescribed time limit for response, and there has likewise been no request for extension of time, with good cause shown therein, within said time period, then debt collector tacitly agrees that debt collector has no bona fide, lawful, verifiable claim, this alleged account, that debt collector waives any and all claims against respondent, and the debt collector tacitly agrees that debt collector must compensate respondent for all costs, fees, and expenses incurred defending against any collection attempts by debt collector, the above referenced alleged account. 8. Respondent also expressly includes with this offer of performance debt collector disclosure statement attached herewith, made fully part hereof, and included herein by reference to ensure that debt collector clearly and conspicuously makes all required disclosures in writing in accordance with applicable portions of Truth in Lending Regulation Z. 12 CFR 226. Debt collector disclosure statement must be completed by debt collector and received by respondent within 21 days of debt collector's receipt of this offer of performance if debt collector wishes debt collector's claim considered by respondent. 9. Debt collector also tacitly consents and agrees that debt collector has a duty to prevent this alleged account from damaging respondent in any way. Debt collector confesses judgment and respondent reserves the right to A. Initiate a counterclaim against the debt collector. B. File a claim against the bond of any responsible party, including debt collector and all principals, agents, and assignees of debt collector, whose acts / omissions result in tort damages against respondent / offeror. 10. Due process of law is guaranteed both alleged debtor and secured party at debt collector's Office of Risk Management and is codified at 18 U.S.C. Statute 1581, 242, 241, 4 at 15 U.S.C. Statute 1692 and elsewhere. Dated March 28, 2002. Signed. Certified Promissory Note. Note number JHD-032802-JJ. Paid to the order of, all capital letters and Legis, Chase, Mann, and Hat Mortgage Corporation, $135,458.21. $135,458.21 over $100. This instrument is tendered by the undersigned respondent, all capital letters and Legis, John H. Doe, superscripted copyright symbol, hereinafter, maker, in good faith and in accordance with law as codified at UCC Statute 1-103, 1-104, 1-201, Section 4, Section 28, Section 30, 3-103, Section A, Section 6, 3-104, Section A, Section B, and Public Policy at House Joint Resolution 192 of June 5th, 1933, as full satisfaction of alleged debt claimed and allegedly owned in favor of payee herein, i.e., all capital letters and legis, Chase, Man, and Hat Mortgage Corporation, doing business as a debt collector as per payees/debt collectors written communication dated March 15, 2002, hereinafter written communication. Alleged creditor, all capital letters and legis, Chase, Man, and Hat Mortgage Corporation, alleged account number 001-234567889-96, alleged amount due $135,458.21. A true and correct copy of written communication is attached hereto, made fully part hereof, and included herein by reference. This statement constitutes makes promise to pay this instrument upon presentment and endorsement at maker's location. As an operation of law, payee/debt collector tacitly consents and agrees that there is accord and satisfaction by use of this instrument to satisfy payees/debt collector's claim, and maker is hereby discharged from liability on this alleged account, and the obligation is suspended in accordance with the laws codified at UCC Statute 3-310, Section B, 3-311, and 3-603. Maker does not waive timeliness. However, if payee/debt collector needs additional time, payee/debt collector must present maker with a written request for additional time within a reasonable time, setting forth the reasons payee/debt collector requests an extension of time, with good cause shown. The acceptability of any such request received by maker from payee/debt collector is conditional upon approval by maker. In the event this instrument is not presented for payment within a reasonable period of time, and there has been no request for an extension of time with good cause shown, payee/debt collector tacitly consents and agrees that payee/debt collector has a bona fide verifiable claim re this alleged account. Payee/debt collector tacitly consents and agrees that debt collector has a duty to prevent this alleged account from damaging maker in any way, and that debt collector confesses judgment and maker reserves the right to initiate a counterclaim against debt collector and file a claim against the bond of any responsible party, including debt collector and all principals, agents, and assignees of debt collector whose acts/omissions result in tort damages against maker. Dated March 28, 2002. All capital letters and legis, John H. Doe, superscripted copyright symbol, respondent/maker. Witness. Authorized person endorsed below. Print name and official title when presenting this instrument for payment. Government issued ID with photograph required, i.e., only the following types of ID accepted: state issued driver's license, state issued identification card, passport, print name of endorser, form of photo identification, official title of endorser, form of official identification, date of presentment and endorsement, signature of endorser, right thumbprint, recording requested by, and when recorded returned to, all capital letters, and legis, John H. Doe, superscripted copyright symbol, P.O. Box 9999, Los Angeles, California, 90010. Verification of tender of payment and notice of reservation of right to initiate a counterclaim and file a claim against bond. Respondent's Private International Administrative Remedy Demand, number JHD-032802-JJ. Introductory Certification. The undersigned, all capital letters and legis, John H. Doe, superscripted copyright symbol, hereinafter, declarant, does herewith solemnly swear, declare, and state that 1. Declarant can competently state the matters set forth herewith. 2. Declarant has personal knowledge of the facts stated herein. 3. Declarant has read and signed this verification of tender of payment and notice of reservation of right to initiate a counterclaim and file a claim against bond hereinafter tender and reservation of right. Plain statement of facts. 4. This tender and reservation of right is not interposed for purpose of delay. 5. This tender and reservation of right does not prejudice Chase, Man, and Hat Mortgage Corporation in this matter. 6. Declarant does not join in any merits of written communication of Chase, Man, and Hat Mortgage Corporation doing business as debt collector. Verification and certification. 7. The undersigned, all capital letters, ens legis, John H. Doe, superscript copyright symbol, i.e., declarant, does herewith swear, declare, and affirm that declarant executes this tender and reservation of right with sincere intent. That declarant can competently state the matter set forth herein. That the contents are true, correct, complete, and certain, not misleading, and the truth, the whole truth, and nothing but the truth, in accordance with declarant's best, first-hand knowledge and understanding. Further, declarant saith not, dated March 28th, 2002, signed, all capital letters, ens legis, John H. Doe, superscripted copyright symbol, declarant, witness, and witness. Debt collector disclosure statement. Ray, offer of performance. This statement and the answers contained herein may be used by respondent, if necessary, in any court of competent jurisdiction. Respondent's private international administrative remedy demand number JHD-032802-JJ. Notice, this debt collector disclosure statement is not a substitute for, nor the equivalent of, the herein above requested verification of the record, i.e., confirmation of correctness, truth, or authenticity by affidavit, oath, or deposition, in parentheses, Black's Law Dictionary, 6th edition, 1990. Ray, the alleged debt, and must be completed in accordance with the Fair Debt Collection Practices Act, 15 U.S.C. Statute 1692 G, applicable portions of Truth in Lending, in parentheses, Regulation Z, 12 CFR 226, and demands as cited above in offer of performance. Debt collector must make all required disclosures clearly and conspicuously in writing. Ray, the following. 1. Name of debt collector. 2. Address of debt collector. 3. Name of alleged debtor. 4. Address of alleged debtor. 5. Alleged account number. 6. Alleged debt owed. 7. Date alleged debt became payable. 8. Ray this alleged account. What is the name and address of the alleged original creditor, if different from debt collector? 9. Ray this alleged account. If debt collector is different from alleged original creditor, does debt collector have a bona fide affidavit of assignment to enter into alleged original contract between alleged original creditor and alleged debtor? Yes, no. 10. Did debt collector purchase this alleged account from the alleged original creditor? Yes or no? N/A, in parentheses, not applicable. 11. If applicable, date of purchase of this alleged account from alleged original creditor and purchase amount. Date, amount, dollar symbol. 12. Did the debt collector purchase this alleged account from a previous debt collector? Yes, no, N/A. 13. If applicable, date of purchase of this alleged account from previous debt collector and purchase amount. Date, amount, dollar symbol. 14. Regarding this alleged account, debt collector is currently the A. Owner, B. Assignee, C. Other. Explain. 15. What are the terms of the transfer of rights? Ray this alleged account. 16. If applicable, transfer of rights. Ray this alleged account was executed by the following method. A. Assignment. B. Negotiation. C. Novation. D. Other. Explain. 17. If the transfer of rights. Ray this alleged account was by assignment. Was there consideration? Yes, no, N/A. 18. What is the nature and cause of the consideration cited in number 17 above? 19. If the transfer of rights. Ray this alleged account was by negotiation, was the alleged account taken for value? Yes, no, N/A. 20. What is the nature and cause of any value cited in number 19 above? 20. If the transfer of rights. Ray this alleged account was by novation, was consent given by alleged debtor? Yes, no, N/A. 22. What is the nature and cause of any consent cited in number 21 above? 23. Has debt collector provided alleged debtor with the requisite verification of alleged debt as required by the Fair Debt Collections Practices Act? Yes, no. 24. Date said verification cited above in number 23 was provided, alleged debtor. 25. Was said verification cited above in number 23 in the form of a sworn or affirmed oath, affidavit, or deposition? Yes, no. 26. Verification cited above in number 23 was provided, alleged debtor, in the form of oath, affidavit, deposition. 27. Does debt collector have knowledge of any claims / defenses this alleged account? Yes, no. 28. What is the nature and cause of any claims / defenses this alleged account? 29. Was alleged debtor sold any products / services by debt collector? Yes, no. 30. What is the nature and cause of any products / services cited above in number 29? 31. Does there exist a verifiable, bona fide, original commercial instrument between debt collector and alleged debtor containing alleged debtor's bona fide signature? Yes, no. 32. What is the nature and cause of any verifiable commercial instrument cited above in number 31? 34. What is the nature and cause of this evidence of an exchange of a benefit or detriments as cited above in number 33? 35. Does any evidence exist of verifiable external acts giving the objective semblance of agreement between debt collector and alleged debtor? Yes, no. 36. What is the nature and cause of any external acts giving the objective semblance of agreement from number 35 above? 37. Have any charge-offs been made by any creditor or debt collector regarding this alleged account? Yes, no. 38. Have any insurance claims been made by any creditor or debt collector regarding this alleged account? Yes or no. 39. Have any tax write-offs been made by any creditor or debt collector regarding this alleged account? Yes or no. 40. Have any tax deductions been made by any creditor or debt collector regarding this alleged account? Yes or no. 41. Have any judgments been obtained by any creditor or debt collector regarding this alleged account? Yes or no. 42. At the time the alleged original contract was executed, were all parties apprised of the meaning of the terms and conditions of said alleged original contract? Yes or no. 43. At the time the alleged original contract was executed, were all the parties advised of the importance of consulting a licensed legal professional before executing the alleged contract? Yes or no. 44. At the time the alleged original contract was executed, were all parties apprised that said alleged contract was a private credit instrument? Yes or no. Debt collector's failure, both intentional and otherwise, to complete / answer points 1 through 44 above and return this debt collector disclosure statement, as well as provide respondent with the requisite verification validating the hereinabove referenced alleged debt, constitutes debt collector's tacit agreement that debt collector has no verifiable, lawful, bona fide claim the hereinabove referenced alleged account, and that debt collector tacitly agrees that debt collector waives all claims against respondent and indemnifies and holds respondent harmless against any and all costs and fees heretofore and hereafter incurred and related any and all collection attempts involving the hereinabove referenced alleged account. Declaration. The undersigned hereby declares under penalty of perjury of the laws of this state that the statements made in this debt collector disclosure statement are true and correct in accordance with the undersigned's best first-hand knowledge and belief. Date. Printed name of signatory. Official title of signatory. Authorized signature of debt collector. Debt collector must timely complete and return this debt collector disclosure statement, along with all required documents referenced in said debt collector disclosure statement. Debt collector's claim will not be considered if any portion of this debt collector disclosure statement is not completed and timely returned with all required documents, which specifically includes the requisite verification made in accordance with law and codified in the Fair Debt Collection Practices Act at 15 U.S.C. Statute 1692 ETSEQ, and which states in relevant part, a debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt, which includes the false representation of the character or legal status of any debt, and the threat to take any action that cannot legally be taken, all of which are violations of law. If debt collector does not respond as required by law, debt collector's claim will not be considered and debt collector may be liable for damages for any continued collection efforts, as well as any other injury sustained by respondent. Please allow 30 days for processing after respondent's receipt of debt collector's response. March 28th, 2002. Non-negotiable. Common law English spelling and pronunciation John Henry Doe. Superscripted copyright symbol. Post Office Box 9999. Los Angeles, California 90010. Respondent's Private International Administrative Remedy Demand. Number JHD-032802-JJ. For all capital letters ends legis, Jack Jones, a debt collector, all capital letters ends legis, Chase, Man, and Hat Mortgage Corporation, 5143 Tunnel Vision Drive, Columbus, Ohio, 43222. Via USPS, registered mail article number RR7778889999 US. Ray. Written communication from all capital letters ends legis, Jack Jones, hereinafter debt collector, dated March 15th, 2002, a copy of which is attached herewith, made fully part hereof, and included herein by reference. Notice by written communication / security agreement. This notice by written communication / security agreement, hereinafter notice by written communication, provides all capital letters ends legis, Jack Jones, hereinafter user. Notice that alleged debtor, i.e., all capital letters ends legis, John H. Doe, is a common law copyrighted trade name / trademark of common law English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, hereinafter secured party, and that any unauthorized use of all capital letters ends legis, John H. Doe, superscripted copyright symbol, by user constitutes copyright / trade name / trademark infringement, and all such use is strictly prohibited. All rights reserved. Ray, common law, copyright of trade name / trademark, all capital letters ends legis, John Henry Doe, superscripted copyright symbol, as well as any and all derivatives and variations in the spelling of said trade name / trademark, copyright, superscripted copyright symbol, 1973 by common law English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, said trade name / trademark, all capital letters ends legis, John Henry Doe, superscripted copyright symbol, may neither be used nor reproduced, neither in whole nor in part, nor in any manner whatsoever, without the prior, express, written consent and acknowledgement of common law English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, subscribed with the hand-signed red ink signature of common law English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, hereinafter secured party. With the intent of being contractually bound, any juristic person, e.g., all capital letters ends legis, Jack Jones, and all capital letters ends legis, Chase, Man, and Hat Mortgage Corporation, as well as any agent and any principal of said juristic person, consents and agrees by this notice by written communication that neither said juristic person nor any agent nor any principal of said juristic person shall display nor otherwise use in any manner the common law trade name / trademark, all capital letters ends legis, John Henry Doe, superscripted copyright symbol, nor any derivative of, nor any variation in the spelling of said trade name / trademark, nor the common law copyright described herein, without the prior express written consent and acknowledgement of secured party, subscribed with secured parties, hand-signed signature in red ink. Secured party neither grants, nor implies, nor otherwise gives consent for any unauthorized use of, all capital letters ends legis, John H. Doe, superscripted copyright symbol, and all such unauthorized use is strictly prohibited. Secured party is not now, nor has secured party ever been, an accommodation party, nor a surety for the alleged debtor, i.e., all capital letters ends legis, John H. Doe, nor for any derivative of, nor for any variation in the spelling of said name, nor for any other juristic person, and is so indemnified and held harmless by all capital letters and legis, John H. Doe, superscripted copyright symbol, in hold harmless and indemnity agreement number JHD-050690-HHIA, dated the 6th day of the 5th month in the year of our Lord 1990, against any and all claims, legal actions, orders, warrants, judgments, demands, liabilities, losses, depositions, summonses, lawsuits, costs, fines, liens, levies, penalties, damages, interest, and expenses whatsoever, both absolute and contingent, as are due and as might become due, now existing and as might hereafter arise, and as might be suffered by, imposed on, and incurred by, all capital letters and legis, John H. Doe, superscripted copyright symbol, for any and every reason, purpose, and cause whatsoever.
Self-executing contract / security agreement in event of unauthorized use.
By this notice, by written communication, both, all capital letters and legis, Jack Jones and, all capital letters and legis, Chase, Mann, and Hat Mortgage Corporation, hereinafter jointly and severally referenced as user in this paragraph, consent and agree that any use of, all capital letters and legis, John H. Doe, superscripted copyright symbol, other than authorized use as set forth above constitutes unauthorized use, counterfeiting of secured parties' common law copyrighted property, contractually binds user, renders this notice by written communication a security agreement, hereinafter security agreement wherein user is debtor and common law English spelling and pronunciation John Henry Doe superscripted copyright symbol is secured party, and signifies that user 1. Grants secured party a security interest in all of user's assets, land, and personal property, and all of user's rights and assets, land, and personal property in the sum certain amount of $500,000 per each occurrence of use of secured parties common law copyrighted trade name / trademark, all capital letters and legis, John Henry Doe superscripted copyright symbol, as well as for each and every use of any and all derivatives of and variations in the spelling of said common law trade name / trademark, not excluding common law English spelling and pronunciation John Henry Doe, plus costs plus triple damages. 2. Authenticate this security agreement wherein user is debtor and common law English spelling and pronunciation John Henry Doe superscripted copyright symbol is secured party, and wherein user pledges all of user's assets, land, motor vehicles, aircraft, vessels, ships, trademarks, copyrights, patents, consumer goods, firearms, farm products, inventory, equipment, money, investment property, commercial tort claims, letters of credit, letter of credit rights, chattel paper, electronic chattel paper, tangible chattel paper, certificated securities, uncertificated securities, promissory notes, payment intangibles, software, healthcare insurance, receivables, instruments, deposit accounts, account documents, livestock, real estate and real property, including all buildings, structures, fixtures, and appurtenances situated thereon, as well as affixed thereto, fixtures, manufactured homes, timber, crops, and as extracted collateral, i.e., all oil, gas, and other minerals, as well as any and all accounts arising from the sale of these substances, both at wellhead and minehead, accessions, increases, and additions, replacements of, and situations for, any of the property described here and above in this paragraph, products, produce, and proceeds of any of the property described here and above in this paragraph, accounts, general intangibles, instruments, monies, payments, and contract rights, and all other rights arising out of sale, lease, and other disposition of any of the property described here and above in this paragraph, proceeds, including insurance, bond, general intangibles, and account proceeds, from the sale, destruction, loss, and other disposition of any of the property described here and above in this paragraph. Records and data involving any of the property described here and above in this paragraph, such as in the form of a writing, a photograph, microfilm, microfiche, tape, electronic media, and the like, together with all of users' right, title, and interest in all computer software and hardware requiring for utilizing, creating, maintaining, and processing any such records and data in any electronic media, and all of users' rights in all such foregoing property in this paragraph, now owned and hereafter acquired, now existing and hereafter arising, and wherever located as collateral to secure users' contractual obligation in favor of secured party for users' unauthorized use of secured parties' common law copyrighted property. 3. Consents and agrees that secured party may file a UCC financing statement wherein user is debtor and common law English spelling and pronunciation John Henry Doe superscripted copyright symbol is secured party. 4. Consents and agrees that said UCC financing statement described above in paragraph 3 is a continuing financing statement and further consents and agrees with secured parties, filings, and a continuation statement necessary to maintain secured parties' perfected security interest in all of users' property and rights in property pledged as collateral and security agreement, as described above in paragraph 2, until users' contractual obligation thereto incurred has been fully satisfied. 5. Authorizes secured party to file any UCC financing statement as described above in paragraphs 3 and 4, and any security agreement as described above in paragraph 2, both in the UCC filing office and at any county recorder's office. 6. Consents and agrees that any and all such filings described in paragraphs 4 and 5 above are not and may not be considered bogus, and that user will not claim that any such filing is bogus. 7. Waives all defenses. 8. Waives rights of presentment, notice of dishonor, and notice of protest. And 9. Appoint secured party as authorized representative for user, effective upon user's default, user's contractual obligations in favor of secured party as set forth below under payment terms and default terms, granting secured party full authority and power to engage in any and all actions on behalf of user, including, but not limited to, authentication of a record on behalf of user, as secured party in accordance with secured party's sole discretion deems appropriate, and as regards any deposit account of any kind maintained with any bank in / under the name of user, and likewise any deposit account maintained with any bank in / under the taxpayer identification number of user, notwithstanding the absence of user's name as account holder on any such deposit account maintained with any bank in / under the taxpayer identification number of user, grants secured party in full authority and power to originate instructions for said deposit account bank and direct the disposition of funds in said deposit account by acting as signatory on said deposit account without further consent of user and without liability, and user further consents and agrees that this appointment of secured party as authorized representative for user, effective upon user's default, is irrevocable and coupled with a security interest. User further consents and agrees with all of the following additional terms. Payment terms in accordance with fees for unauthorized use of, all capital letters and letters, John H. Doe, superscripted copyright symbol, as set forth above. User hereby consents and agrees that user shall pay secured party all unauthorized use fees in full within 10 days of the date user is sent secured party's invoice. Hereinafter, invoice, itemize said fees. Default terms. In event of non-payment in full of all unauthorized use fees by user within 10 days of the date invoice is sent, user shall be deemed in default and A. All of user's property and rights in property pledged as collateral by user as set forth in paragraph 2 immediately becomes, i.e., is property of secured party. B. Secured party is appointed user's authorized representative as set forth above in paragraph 9. And C. User consents and agrees that secured party may take possession of, as well as otherwise dispose of, in any manner that secured party and secured party's sole discretion deems appropriate, including but not limited to sale at auction, at any time following user's default, and without further notice, any and all of user's former property and rights in property formerly pledged as collateral by user, described in paragraph 2. Now property of secured party, in respect of this security agreement that secured party, again in secured party's sole discretion, deems appropriate. Terms for curing default. In event of default, as set forth above under default terms, user can cure user's default and avoid strict foreclosure of any remainder of user's former property that is neither in the possession of secured party, nor otherwise disposed of by secured party, only by tendering payment within 20 days of user's default, and only by payment in full of the balance of the sum certain amount owed by user, as noticed user in invoice, that is not already paid by secured party's possession, sale, liquidation, and the like of user's former property and rights in property pledged as collateral to secure user's obligation. Terms of strict foreclosure. User's non-payment in full of all unauthorized use fees itemized in invoice within said 20-day period of curing default as set forth above under terms for curing default. Authorizes secured parties immediate non-judicial strict foreclosure on any and all remaining property and rights in property formerly pledged as collateral by user, now property of secured party, which is not in the possession of nor otherwise disposed of by secured party upon expiration of said 20-day default curing period. Ownership subject to copyright of common law, trade name / trademark and security agreement and UCC financing statement filed with the UCC filing office. Record owner. Common law, English spelling and pronunciation, John Henry Doe. Superscripted copyright symbol, autograph. Common law, copyright, superscripted copyright symbol, 1973. Should any provision of this notice by written communication be unenforceable, said unenforceable provision is hereby severed from this notice by written communication, but every remaining provision continues in full force and effect, and this notice by written communication is deemed modified in a manner that renders this notice by written communication in full force and effect. In all cases, secured party continues without liability and is held harmless. Any prior communication, written document, and the like by and between user and secured party containing any mistake of secured party is invalidated thereby and of no force and effect, and may not be relied upon by user against secured party in this matter. No consent of any kind is granted nor otherwise given, any matter offered / alleged / asserted by user, and secured party withholds all consent. Secured party will consider granting consent in favor of user only upon user's full disclosure of any and all consequences of any such granting of consent, accompanied by user's commensurate attendant liability for the veracity, relevance, and verifiability of any such disclosure. Such liability is borne by user in the form of an unauthenticated security agreement, wherein user is debtor and, common law English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, is secured party, that self-executes effective the moment of secured party's confirmation of any material inconsistency / deviation / discrepancy, and the aforementioned resultant consequences avowed by user, as determined solely by secured party in secured party's sole discretion. Alleged debtor, i.e., all capital letters and legis, John H. Doe, superscripted copyright symbol, does not take issue with the amount of any alleged debt. Rather, alleged debtor asserts that the alleged debt is not valid. Secured party holds a claim / security interest greater than any claim alleged by user, a copy of which filed UCC financing statement evidencing such supreme claim and security interest is attached herewith, made fully part hereof, and included herein by reference, and, as stated above, secured party is neither a surety nor an accommodation party for alleged debtor, and may not be construed as functioning in such capacity under any circumstances. Further, this is a request for validation of any alleged debt and is not a request for a copy of any invoice, statement, bill, agreement, alleged agreement, contract, alleged contract, and the like, nor is it a request for a copy of any notification of assignment, negotiation / transfer of rights, nor is it a request for a copy of any other unverified document / presentment referencing said alleged debt. This request for validation of any alleged debt is a request for bona fide verification of any alleged debt. In accordance with law, only sworn affidavits, oaths, and depositions qualify as a verification of the lawful existence of any bona fide debt. Absent such verification validating the alleged debt, and absent proof of a claim greater than that of the secured party, user fails to state a claim upon which relief can be granted. Wherefore, in accordance with the Fair Debt Collection Practices Act, effective immediately upon user's receipt of this notice by written communication, user must cease all collection / prosecution efforts against alleged debtor, secured party, and secured party's secured private property. User is hereby notified of the following Privacy Act notice.
Privacy Act Notice.
This written notice by written communication constitutes user's due process notice and opportunity to be heard. Absent compliance with all requirements set forth herein, user is barred from using any defense of immunity from prosecution for user's actions, as well as the actions of user's agents. By this notice by written communication, user, as well as user's agents and principals, shall comply with the provisions of the Privacy Act of 1974, as lawfully amended, 12 U.S.C. Statute 3401, the Right to Financial Privacy Act of 1978, as lawfully amended, 5 U.S.C. Statute 552A, and the Third Party Summons Act, Special Procedures, 26 U.S.C. Statute 7609, as lawfully amended to assist secured party in keeping inviolate certain constitutionally protected privacy rights. By this notice, by written communication, user as well as user's agents and principals shall comply with this demand. Users shall provide secured party with a copy of any express written authorization from secured party whereby user is authorized to disclose / reveal / divulge / share with any third party in any manner as well as by any means of communication any information, documentation, data, property, effects, and the like, Ray alleged debtor, all capital letters and legis, John H. Doe, superscript copyright symbol, and likewise concerning secured party. User's failure to provide said foregoing demanded authorization constitutes admission by user that user is in violation of the Privacy Act, as well as other laws. User possesses neither express written authorization nor consent from alleged debtor, all capital letters and legis, John H. Doe, superscript copyright symbol, nor a secured party to use, reveal / disclose / divulge / share with any third party and the like, any secured information, documentation, data, property, effects, and the like of secured party. This notice by written communication is binding upon every principal and agent, Ray the subject matter set forth herein, and each principal and each agent is A. Barred from providing any credit reporting agency any derogatory credit information regarding the above alleged debt. B. Prohibited from contacting alleged debtor by mail, by telephone, as well as in person, both at alleged debtor's residence, as well as alleged debtor's place of employment. And C. Prohibited from contacting any other third party regarding the above referenced alleged debt until user establishes the existence of a superior claim greater than that of secured parties, and until said alleged debt is verified as indicated above and alleged debtor is provided with any such verification. Note: the Fair Debt Collection Practices Act at 15 U.S.C. Statute 1692 ETSEQ states in relevant part that, quote, a debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt, which includes the false representation of the character or legal status of any debt, as well as the threat to take any action that cannot legally be taken, all of which constitutes violation of law. Therefore, user as well as any assignee is prohibited from filing any lawsuit, notice of lien, notice of levy, and the like, as well as any other legal action against alleged debtor, as well as against any of secured parties' secured private property, which is exempt from lien and exempt from levy. 15 U.S.C. Statute 1692 E8 states, quote, communicating or threatening to communicate to any person credit information which is known or which should be known to be false, including the failure to communicate that a disputed debt is disputed, is a violation of Statute 1692E. Further, users' above referenced written communication, if valid, constitutes an issue of public currency, and alleged debtor hereby requests from user, in accordance with the fundamental principles of American jurisprudence and law, bona fide documentary evidence that establishes the lawful basis for user's issue of said public currency and user's claim for payment of the alleged debt liability referenced within user's written communication, issuing the public currency and stating the claim, i.e., A. Bona fide identification of any person making request for payment by, all capital letters and legis, John H. Doe, superscript copyright symbol, including a copy of said person's bona fide, handwritten, legible, and notarized signature, and the thumbprint from either hand of said person making request for payment by, all capital letters and legis, John H. Doe, superscript copyright symbol. B. Bona fide evidence of any said person's authority to make a request for payment by, all capital letters and legis, John H. Doe, superscript copyright symbol, if said person is acting on behalf of another, and C. Exhibition of the bona fide instrument, i.e. the bona fide commercial contract bearing the bona fide signature which supports user's demand for payment of alleged debt by, all capital letters and legis, John H. Doe, superscript copyright symbol, that, operating publicly, establishes user's issue of public currency, allegedly collectible from any of 1. Alleged debtor. 2. Alleged debtor's assets. 3. Secured party. 4. Secured parties, secured private property. And D. Positive law in support of user's written attempt to collect alleged debt that, operating publicly, establishes user's issue of public currency collectible from any of 1. Alleged debtor. 2. Alleged debtor's assets. 3. Secured party. 4. Secured parties, secured private property. Alleged debtor and secured party can and will lawfully construe users' failure to comply with and satisfy essential requirements of the Fair Debt Collection Practices Act and the above four requests, i.e., A, B, C, and D, in the paragraph immediately above, within a reasonable time, i.e., 21 days, following users' receipt of this written communication as users' self-invalidation of users' demand for payment. Verification of the alleged debt and satisfaction of the aforementioned four specific requests must be duly affirmed in the form of one of the following: A, affidavit; B, oath; C, deposition. Until the alleged debt is verified in accordance with the Fair Debt Collection Practices Act, and said verification is sent alleged debtor and received by alleged debtor, each and every contact in violation of the Fair Debt Practices Act constitutes harassment and defamation of character and makes user, as well as any and all agents and principals who take part in such harassment and defamation, a subject of liability for damages, as well as statutory damages and legal fees for each and every violation in private capacity. User, all capital letters and leges, Jack Jones, tacitly consents and agrees that, all capital letters and leges, Jack Jones has a duty to prevent this alleged account from damaging both alleged debtor and secured party, and further consents and agrees that alleged debtor and secured party each reserve the right to initiate a counterclaim, as well as a claim against any of the following, all capital letters and leges, Jack Jones's bond, all capital letters and leges, Jack Jones's guarantor, any of, all capital letters and leges, Jack Jones's principals, agents, and assignees whose acts / omissions result in either of the following: A, tort damages against the alleged debtor; B, tort damages against secured party. Due process of law is guaranteed both alleged debtor and secured party at Debt Collector's Office of Risk Management and is codified at 18 U.S.C. Statute 1581, 18 U.S.C. 242, 18 U.S.C. 241, 18 U.S.C. 4, at 15 U.S.C. Statute 1692, and elsewhere. The attachment written communication is respondent's response, user's attempt, via written communication to collect an alleged debt. This notice by written communication / security agreement is herewith executed this 28th day of the 3rd month in the year of our Lord 2002, and by and between the undersigned parties. Debtor, all capital letters and leges, Jack Jones. Debtor's signature. Secured party accepts debtor's signature in accord with UCC Statute 1-201, Section 39, 3-401. Secured party, common law English spelling and pronunciation, John Henry Doe, superscripted, copyright symbol. Secured party signature. Autograph, common law, copyright, superscripted, copyright symbol, 1973 by, common law English spelling and pronunciation, John Henry Doe, superscripted, copyright symbol. All rights reserved. No part of this autograph, common law, copyright may be used, nor reproduced in any manner, without prior, express, written consent and acknowledgement of secured party. Subscribed with secured parties, hand-signed, signature in red ink. Unauthorized use of common law English spelling and pronunciation, John Henry Doe incurs same unauthorized use fees as those associated with, all capital letters and leges, John Henry Doe, superscripted, copyright symbol, as set forth above in paragraph 1, under self-executing contract / security agreement in event of unauthorized use. Enclosures, copy of written communication from, all capital letters and leges, Jack Jones, dated March 15, 2002, published copyright notice, filed, UCC financing statement, private agreement, hold harmless and indemnified agreement, security agreement. Affidavit of debt, by and from, common law English spelling and pronunciation, John Henry Doe, superscripted, copyright symbol, Post Office Box 9999, Los Angeles, California, 90010. Introductory certification. The undersigned, common law English spelling and pronunciation, John Henry Doe, superscripted, copyright symbol, hereinafter, affiant, does herewith solemnly swear, declare, and state that A. Affiant can competently state the matter set forth herewith. B. Affiant has personal knowledge of the facts stated herein. C. All the facts stated herein are true, correct, complete, and certain, admissible as evidence, not misleading, the truth, the whole truth, and nothing but the truth, in accordance with affiant's best first-hand knowledge and understanding. Plain statement of facts. D. Notice by written communication / security agreement, hereinafter, notice by written communication, attached hereto, made fully part hereof, and included herein by reference, sent by United States Postal Service registered mail article number, in block parentheses, registered mail number, on, in block parentheses, date sent, and received by, all capital letters and legis, Jack Jones, on, in block parentheses, date received. Notices, all capital letters and legis, Jack Jones, that 1. All capital letters and legis, Jack Jones does not have Affiant's authorization to use Affiant's private, common law copyrighted trade name / trademark, all capital letters and legis, John H. Doe superscripted copyright symbol, nor Affiant's common law copyrighted autograph, i.e. common law English spelling and pronunciation, John Henry Doe. 2. Any unauthorized use of Affiant's common law copyrighted property, as described above in paragraph D1, by, all capital letters and legis, Jack Jones, constitutes counterfeiting and common law trade name / trademark copyright infringement, that secured party neither grants, nor implies, nor otherwise gives consent for any unauthorized use of, all capital letters and legis, John H. Doe superscripted copyright symbol, and that any and all unauthorized use is strictly prohibited. 3. Any additional instance of unauthorized use of secured parties, common law, copyrighted trade name / trademark, not excluding common law English spelling and pronunciation, John Henry Doe, by, all capital letters and legis, Jack Jones. Following, all capital letters and legis, Jack Jones's receipt of notice by written communication accelerates, all capital letters and legis, Jack Jones's acceptance of the obligation of the consensual contract by and between, all capital letters and legis, Jack Jones and Affiant, initiated by, all capital letters and legis, Jack Jones's, as well as the unconditional promise of payment in full thereof, as of the date and time of the first instance of, all capital letters and legis, Jack Jones's additional unauthorized use, following, all capital letters and legis, Jack Jones's receipt of notice by written communication in strict accordance with terms set forth in paragraphs 1 through 9 in self-executing security agreement, section of notice by written communication wherein, all capital letters and legis, Jack Jones is user, and, in block parentheses, note, depending on which opt-out procedure was used in the notice by written communication / security agreement, there will be a particular paragraph, D4. The difficult opt-out procedure will require use of the first simple paragraph, D4, below. The simple opt-out procedure, in parentheses, includes notice by written communication / security agreement contained within the 14-page validation of debt package, will require use of the second paragraph, D4, below. 4. All capital letters and legis, Jack Jones can opt out and withdraw from, all capital letters and legis, Jack Jones's self-initiated consensual contract between, all capital letters and legis, Jack Jones and Affiant as described above in paragraph D, section 3, and retain no obligation associated therewith, only by, all capital letters and legis, Jack Jones's surrender at the mailing location designated for Affiant, and notice by written communication no later than 12 midnight of the fourth day following, all capital letters and legis, Jack Jones's receipt of the notice by written communication of any and all original instruments, documents, and records in any form of recorded media whatsoever, as well as any and all copies of all such originals in any form of recorded media whatsoever, containing both the signature of, all capital letters and legis, Jack Jones, and any counterfeit version of either of A. Secured parties private, common law copyrighted trade name / trademark, i.e. all capital letters and legis, John Henry Doe superscripted copyright symbol. B. Secured parties private, autograph, common law copyrighted property, i.e. common law English spelling and pronunciation, John Henry Doe. 4. All capital letters and legis, Jack Jones's, can opt out and withdraw from, all capital letters and legis, Jack Jones's self-initiated consensual contract between, all capital letters and legis, Jack Jones's and Affiant as described above in paragraph D, section 3, and retain no obligation associated therewith, only by immediate cessation of any and all further unauthorized use of secured parties, common law, copyrighted property. In block parentheses, note, depending on which opt-out procedure was used in the notice by written communication / security agreement, there will be a particular text for paragraph E. The difficult opt-out procedure will require use of the first sample, paragraph E. Below, the simple opt-out procedure, in parentheses, includes notice by written communication / security agreement contained within the 14-page validation of debt package, will require use of the second sample, paragraph E. Below. E. Notice by written communication also notices, all capital letters and legis, Jack Jones in section entitled Self-Executing Security Agreement that, absent, all capital letters and legis, Jack Jones's surrender of all original instruments, documents, and records in any form of recorded media, as well as all copies of any such original, containing both, all capital letters and legis, Jack Jones's signature in any version of any of secured parties, common law, copyrighted property, as cited above in paragraph D, section 4, all capital letters and legis, Jack Jones's accepts the obligation of, all capital letters and legis, Jack Jones's self-initiated consensual contract between, all capital letters and legis, Jack Jones and affiant at 12:01 a.m. of the 5th day following, all capital letters and legis, Jack Jones's receipt of notice by written communication. Said notice by written communication is rendered a security agreement. Hereinafter, security agreement, wherein, all capital letters and legis, Jack Jones is debtor and affiant is secured party, and, all capital letters and legis, Jack Jones. E. Notice by written communication also notices, all capital letters and legis, Jack Jones in section entitled Self-Executing Security Agreement that any additional instance of unauthorized use of secured parties common law copyrighted property by, all capital letters and legis, Jack Jones, following, all capital letters and legis, Jack Jones's receipt of notice by written communication as cited above in paragraph D, section 3, accelerates, all capital letters and legis, Jack Jones's acceptance of the obligation of the herein described consensual contract, as well as, all capital letters and legis, Jack Jones's unconditional promise of payment in full of said obligation, effective the date of said first instance of additional unauthorized use following, all capital letters and legis, Jack Jones's receipt of notice by written communication. Said notice by written communication is rendered a security agreement. Hereinafter, security agreement, wherein, all capital letters and legis, Jack Jones is debtor and affiant is secured party, and, all capital letters and legis, Jack Jones. 1. Grant secured party a security interest in all of, all capital letters and legis, Jack Jones's property and rights in property in the sum certain amount of $500,000 per each occurrence of use of common law copyrighted trade name / trademark, all capital letters and legis, John Henry Doe, superscripted copyright symbol, as well as for each and every use of any and all derivatives of and variations in the spelling of, all capital letters and legis, John Henry Doe, superscripted copyright symbol, not excluding common law English spelling and pronunciation, John Henry Doe, plus costs, plus triple damages. 2. Authenticate security agreement cited in paragraph 2 of notice by written communication wherein, all capital letters and legis, Jack Jones is debtor and, common law English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, is secured party, and wherein, all capital letters and legis, Jack Jones pledges all of, all capital letters and legis, Jack Jones's tangible and intangible property, and all of, all capital letters and legis, Jack Jones's interest in all such property, now owned and hereafter acquired, now existing and hereafter arising, and wherever located, as collateral to secure, all capital letters and legis, Jack Jones's contractual obligation in favor of affiant for, all capital letters and legis, Jack Jones's unauthorized use of affiant's common law copyrighted property. 3. Consents and agrees with affiant's filing of a UCC financing statement in the UCC filing office, as well as in any county recorder's office wherein, all capital letters and legis, Jack Jones is debtor and affiant is secured party. 4. Consents and agrees that any UCC financing statement as described here and above in paragraph E, section 3, is a continuing financing statement, and further consents and agrees with affiant's filing of any continuation statement necessary to maintain affiant's perfected security interest in all of, all capital letters and legis, Jack Jones's property and rights in property pledged as collateral and security agreement cited here and above in paragraph E, section 2, until, all capital letters and legis, Jack Jones's contractual obligation theretofore incurred has been fully satisfied. 5. Consents and agrees with affiant's filing of any UCC financing statement as described here and above in paragraph E, section 3, as well as paragraph E, section 4, and the filing of security agreement as cited above in paragraph E, section 2, in the UCC filing office, as well as any county recorder's office. 6. Consents and agrees that any of all such filings described here and above in paragraph E, section 4 and E, section 5 are not and may not be considered bogus, and that, all capital letters and legis, Jack Jones will not claim that any such filing is bogus. 7. Waives all defenses. 8. Waives rights of presentment, notice of dishonor, and notice of protest. 9. Appoints Affian as authorized representative for, all capital letters and leges, Jack Jones, effective upon, all capital letters and leges, Jack Jones's default re, all capital letters and leges, Jack Jones's contractual obligations in favor of Affian as set forth below under payment terms and default terms, with full authorization and power granted Affian to engage in any and all actions on behalf of, all capital letters and leges, Jack Jones, including but not limited to authentication of a record on behalf of, all capital letters and leges, Jack Jones, as affiant, and affiant's sole discretion deems appropriate, and as regards any deposit account of any kind maintained with any bank in / under the name of, all capital letters and leges, Jack Jones, and likewise any deposit account maintained with any bank in / under the taxpayer identification number of, all capital letters and leges, Jack Jones, notwithstanding the absence of, all capital letters and leges, Jack Jones's name as account holder on any such deposit account maintained with any bank in / under the taxpayer identification number of, all capital letters and leges, Jack Jones, grants secured party full authority and power to originate instructions for said deposit account bank and to direct the dispositions of funds in said deposit account by acting as signatory on said deposit account without further consent of, all capital letters and leges, Jack Jones, and without liability and, all capital letters and leges, Jack Jones further consents and agrees that this appointment of secured party is authorized representative for, all capital letters and leges, Jack Jones, effective upon, all capital letters and leges, Jack Jones's default is irrevocable and coupled with a security interest, and 10. Consents and agrees with all of the following additional terms set forth in self-executing security agreement, section of notice by written communication. A. Payment terms. In accordance with fees for unauthorized use of, all capital letters and leges, John H. Doe, superscripted copyright symbol, as set forth above. All capital letters and leges, Jack Jones hereby consents and agrees that, all capital letters and leges, Jack Jones shall pay Affian all unauthorized use fees in full within 10 days of date Affian's invoice. Hereinafter invoice itemizing said fees is sent. B. Default terms. In event of non-payment in full of all unauthorized use fees by, all capital letters and leges, Jack Jones within 10 days of date invoice is sent, all capital letters and leges, Jack Jones shall be deemed in default and 1. All of, all capital letters and leges, Jack Jones's property and rights and property pledged as collateral by, all capital letters and leges, Jack Jones, as cited above in paragraph E, section 2, immediately becomes, i.e., its property of affiant. 2. All capital letters and leges, Jack Jones appoints affiant as, all capital letters and leges, Jack Jones's authorized representative as cited above in paragraph E, section 9, and 3. All capital letters and leges, Jack Jones consents and agrees that affiant may take possession of, as well as otherwise dispose of in any manner that affiant, in affiant's sole discretion, deems appropriate, including, but not limited to, sale at auction, at any time following, all capital letters and leges, Jack Jones's default, without further notice, any and all of, all capital letters and leges, Jack Jones's former property and rights in property formerly pledged as collateral by, all capital letters and leges, Jack Jones, now property of affiant, in respect of said self-executing security agreement, section of notice by written communication, that affiant, again in affiant's sole discretion, deems appropriate. C. Terms for curing default. Upon event of default, cited above in paragraph E, section 9, section B, default terms, all capital letters and leges, Jack Jones can cure, all capital letters and leges, Jack Jones's default and avoid strict foreclosure, any remainder of, all capital letters and leges, Jack Jones's former property that is neither in the possession of secured party, nor otherwise disposed of by secured party, only within 20 days of, all capital letters and leges, Jack Jones's default and only by payment in full of the balance of the sum certain amount owed by, all capital letters and leges, Jack Jones's, as noticed, all capital letters and leges, Jack Jones in invoice that is not already paid by secured party's possession, sale, liquidation, and the like of, all capital letters and leges, Jack Jones's former property pledged as collateral to secure, all capital letters and leges, Jack Jones's obligation. D. Terms of strict foreclosure. All capital letters and leges, Jack Jones's non-payment in full of all unauthorized use fees, itemized in invoice within said 20-day period to cure default, cited above in paragraph E, section 9, section C. Terms of curing default authorizes affiant's immediate non-judicial strict foreclosure on any and all remaining property and rights in property formerly pledged as collateral by, all capital letters and leges, Jack Jones, now property of affiant, which is not in the possession of, nor otherwise disposed of by, affiant upon expiration of said 20-day strict foreclosure period. in block parentheses. Note, depending on which opt-out procedure was used in the notice by written communication / security agreement, there will be a particular text for paragraph F. The difficult opt-out procedure will require use of the first sample paragraph F below. The simple opt-out procedure, in parentheses, includes notice by written communication / security agreement contained within the 14-page validation of debt package, will require use of the second sample paragraph F below. F. Effective 12:01 a.m. in block parentheses, the 8th day following, all capital letters and letters, Jack Jones receipt of notice by written communication / security agreement. All capital letters and letters, Jack Jones accepts the obligation of the here and above described private consensual contract between all capital letters and letters, Jack Jones and Affiant, initiated by all capital letters and letters, Jack Jones, and F. Effective, in block parentheses, date of the first additional unauthorized use of Affiant's copyrighted property following, all capital letters and letters, Jack Jones's receipt of notice by written communication / security agreement or 14-page validation of debt package. All capital letters and letters, Jack Jones accepts the obligation of the here and above described private consensual contract between all capital letters and letters, Jack Jones and Affiant, initiated by all capital letters and letters, Jack Jones, and 1. Affiant is granted a security interest in all capital letters and letters, Jack Jones's property and rights in property by all capital letters and letters, Jack Jones, as cited above in paragraph E, section 1. 2. All capital letters and letters, Jack Jones authenticates security agreement cited above in paragraph E, section 2, wherein all capital letters and letters, Jack Jones is debtor and Affiant is secured party. 3. All capital letters and letters, Jack Jones consents and agrees with Affiant's filing of a UCC financing statement in the UCC filing office, as well as in any county recorder's office, as cited above in paragraph E, section 3, wherein all capital letters and letters, Jack Jones is debtor and common law English spelling and pronunciation, John Henry Doe superscripted copyright symbol, is secured party. 4. All capital letters and letters, Jack Jones consents and agrees that any UCC financing statement as cited above in paragraph E, section 3 is a continuing financing statement and further consents and agrees with Affiant's filing of any continuation statement necessary to maintain Affiant's perfected security interest in all capital letters and letters, Jack Jones's property and rights in property, pledges collateral and security agreement as cited above in paragraph E, section 2, until all capital letters and letters, Jack Jones's contractual obligation theretofore incurred has been fully satisfied. 5. All capital letters and letters, Jack Jones consents and agrees with Affiant's filing of a UCC financing statement as cited here and above in paragraph E, section 3, as well as paragraph E, section 4, and the filing of security agreement as cited above in paragraph E, section 2, and the UCC filing office, as well as in any county recorder's office. 6. All capital letters and letters, Jack Jones consents and agrees that any and all such filings as cited above in paragraph E, section 4 and E, section 5 are not and may not be considered bogus, and that all capital letters and letters, Jack Jones will not claim that any such filing is bogus. 7. All capital letters and letters, Jack Jones waives all defenses. 8. All capital letters and letters, Jack Jones waives presentment, notice of dishonor, and notice of protest. 9. All capital letters and letters, Jack Jones appoints Affiant authorized representative for all capital letters and letters, Jack Jones effective upon all capital letters and letters, Jack Jones's default, Ray, all capital letters and letters, Jack Jones's contractual obligations in favor of Affiant's as cited above in paragraph E, section 10, section A, and E, section 10, section B, and 10. All capital letters and letters, Jack Jones consents and agrees with payment terms and default terms, terms for curing default, and terms of strict foreclosure as cited above in paragraphs E, section 10, section A, section E, section 10, section B, E, section 10, section C, and E, section 10, section D, respectively. G. Total debt now due and owing by all capital letters and letters, Jack Jones in favor of Affiant is the sum certain amount of, in block parentheses, dollar amount spelled out in words, United States dollars, in block parentheses, dollar amount numerically, which amount is certified in invoice, verified statement of account, dated, in block parentheses, date of invoice, attached hereto, made fully part hereof, and included herein by reference, and, as of the date of this affiant of debt, consists of the following. 1. All unauthorized use fees. 2. All reasonable costs associated with enforcing the security interest in collecting the indebtedness, and 3. Total damages calculated in United States dollars and multiplied by a factor of 3, in parentheses, i.e., damages in the United States dollars times 3. H. The debt described here and above in paragraph G is a result of a private consensual transaction by and between, all capital letters and Z's, Jack Jones and Affiant, and is neither the result of a commercial transaction nor a consumer goods transaction. Verification of certification. I. The undersigned affiant, common law English spelling and pronunciation, John Henry Doe, superscript copyright symbol, does herewith swear, declare, and affirm that affiant executes this affidavit with sincere intent, that affiant can competently state the matters set forth herein, that the contents are true, correct, complete, and certain, not misleading, and the truth. The whole truth, and nothing but the truth in accordance with affiant's best first-hand knowledge and understanding. Enclosures / attachments. Attachment A. Notice by written communication / security agreement with attachments. Attachment B. Affidavit of mailing. Ray. Notice by written communication / security agreement. Attachment C. In parentheses, USPS. PS Form 3811. Ray. Notice by written communication / security agreement. Attachment D. Invoice. Verified statement of account with attachments. Attachment E. Affidavit of mailing. Ray invoice. Verified statement of account. Attachment F. In parentheses, USPS. PS Form 3811 Ray invoice. Verified statement of account. Date, the, in block parentheses, sequential. Day of the, in parentheses, sequential. Month in the year of our Lord 2000, in parentheses, year. Signed. Autograph, common law, copyright, superscripted, copyright symbol, 1973. By, common law, English spelling and pronunciation, John Henry Doe, superscripted, copyright symbol. EID number 1234-56789. All rights reserved. No part of this common law copyright made be reproduced in any manner without prior, express, written permission from common law English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, as signified by common law English spelling and pronunciation, John Henry Doe, superscripted copyright symbol, signature in red ink, unauthorized use of common law English spelling and pronunciation, John Henry Doe, incurs same unauthorized use fees as those associated with, all capital letters and letters, John Henry Doe, superscripted copyright symbol, as cited above in this affidavit of debt in paragraph E, section 1. The next following pages are references and duplicates and replicas of a lot of the information that has already been read out. I suggest purchasing the book or reading along through a PDF version. If you need a PDF version, please contact me. All the other manuscripts following forward will be examples to follow through with so you can achieve such greater successes in being secured party. I highly recommend picking up the PDF or the hard copy versions so you're eligible to be able to make duplicates for yourself. Downloading the Adobe Office software program so you can take scannable copies of the text within the documents, and you can be able to create the documents to fit your name and your fitting based off your own personal offers and security interests within the property owned and possessed by both the debtor and the secured party. Thank you so much for listening to this audio read, and I hope it has suited you guys well. Thank you so much, and have a wonderful, blessed, amazing life. God bless you all. I reserve all rights delegated by God and protected by the Constitution and recognized under the UCC 1-308 without prejudice.